Okay, done. Yes, people. So welcome to CS Executive Company La Marathon new syllabus. Yes, first thing, this is for recorded videos and all this people who are watching it on YouTube, as the case may be. Whatever are the materials used inside the class now in the marathon, please don't ask for it. Don't ask for, sir, can you please upload this material? It's not available because of the IP issues. Soft copies won't be available. But if you want a hard copy, the link will be available in the comments or in the description. You guys can order for a hard copy. Please don't ask for the soft copy. That itself need not become a trail of comments. So that's for your FII. And for the people who are present inside the class, this is something what we have already seen inside the class. So you guys have already written it. That only it will be in the form of digital notes. So you need not worry about it. Okay, so that's about it. We'll try to have this in a 2-day session. We'll try to have it the first half today and the next half tomorrow. That will be the agenda. And one more thing, I always suggest before you go to the exam, try to watch at least 2 amendment videos. That's 2 supplements, whatever is available. It will be uploaded. Uploaded by ICSI on your website. For June 2024, I've already recorded. It's available on the YouTube. So first watch that, irrespective of whether you were there in the class or not. Watch the supplement video, and one more will be done. We'll see tomorrow, probably after this entire thing is done. We'll also take up the supplements for December inside the class only as a part of your marathon itself. So watch that as well as this. Yes. The chances of the questions being asked from supplements are always there. You can expect at times 5, you can expect up to 10 as the case may be. Devar Prasada, Mahaprasada. Okay. Yes, Sam. So that's about the supplements part. Keep that in mind. And yes, I'll be trying to cover as much as possible. We'll be seeing even through the summary charts. Let us not leave even the theory part also. Let us even try to cover from our main material as well. I'll try to go in detail. If you guys have any doubts, you can ask me that specifically. If not, I'll try to cover as much as possible. But if there is any problem, you can stop me in between. Clear? Yes, Sham? Hello? Okay. And they recorded. Don't ask again that, sir, if I watch this, is it sufficient to pass the exam? This is just a supplement for your main course. Just this alone cannot help you completely. I might try, but no, not suggested. Try to have your regular course first and then watch this. Yes, people. So thank you so much. Let's start your marathon. You have totally how many chapters? 19 chapters. 60 marks, 40 marks. Yes, sir. So remember, if I have to tell you what and all are the important topics as such, first try to focus majorly on whatever is with regards to KMP, directors and meetings and share capital. This becomes your major part, very important. With regards to directors, KMPs, meetings and share capital, they have your major chunk. It will be very important from your exam point of view. I'm not saying rest and all they'll not ask you, but these topics you will definitely find questions. And sir, do we find question from every chapter? Need not be. Yeah, but always try to know every chapter and go. You never know. At times it may so happen that from one chapter they will put a bomb. It can come. 12 marks can come, 15 marks can come from one chapter. It may come. So always be prepared. You need to know everything. If not in detail also, but you need to know everything, and that's very, very important. Clear up? Yes, Sam. Okay. And be conscious when you write your exam. Try to make sure you guys attend for all the 100 marks. That becomes the majority part, because not everyone will be able to complete 100 marks. I'm just telling you the common mistakes the students do on the day of the exam. Completing 100 marks in 3 hours is like a difficult part only. People generally land up between 85 to 92. That's a maximum. So try to maintain your pace from the question 1. You need not write the questions in order. You can choose your own order. Clear, all of you? So keep this in mind. Yes. So with that, we'll start your first chapter, chapter 1, no? Introduction to company law, na? Yes, sir. Okay. The committee and all, okay. Yes, people, natures and characteristics, we should start from here, huh? Okay, tell da. We should tell what is this nature and characteristics of company, da? What are the characteristics of a company? It has a corporate personality and a separate legal entity. Any case law you guys remember? Solomon versus Solomon.
Yes.
And what is the separate legal entity concept? They can ask you in any way. They can ask you some basic related questions will also be there. Don't think that, as we go by, there are further more complicated chapters. They might not ask questions from this. Do not have that in mind. You can have these simple questions also being asked for like 3 to 4 marks. The question paper will have a provision for that 4, 6, 8, up to 8 marks. For such type of questions also, anywhere between 4 to 8. So have that in mind. Clear all of you? Okay. Yes, people. So corporate personality or separate legal entity means simple. A company is different from its shareholders, that's members. So whenever a company enters into a contract, a company can hold property in its names. The company can sue someone in its name. Someone else also can sue the company in the company's name only and not in the name of the shareholders. Whatever the property of the company is will be the property of the company only and not the property of the shareholders. Unlike the case of partnership. In partnership, whatever is the share of the firm is like the share of the partners directly. That's not the case in the case of company. You saw a case of Salomon versus Salomon, which said the first time the separate legal entity concept was even identified. They say that the shareholders and the company will be recognized as two different persons. Correct? Okay, next one. Artificial person, as I said, we can enter into a contract in the name of the company and you can hold properties and as the case may be. Company is not a citizen. Is company a citizen? The answer is no. But we saw one case here. If you remember, there was something called as bank nationalization case. That was a case of R.C. Cooper versus Union of India. What was this citizen whole concept? A company, even though is recognized as a person for taxation purpose, it is a person, so it is considered as a different identical person who can enter into contracts. But with regards to citizenship, a company is not considered as a citizen. However, in a company, if there are shareholders, that is members, if their rights are getting affected, if anything happens in a company, if their rights are getting affected, in the capacity of the shareholders, if any rights of yours is getting affected, that will still be recognized. You can still file a case in the court, even though you are not a citizen. One of the example was this R.C. Cooper versus Union of India. The case law is not there for you guys in detail, but on the gist what happened was, it was a bank nationalization case. All the banks was getting nationalized, but there was one bank's shareholder. That shareholder was called as R.C. Cooper. In this bank nationalization case, whatever the compensation that was paid to him as a shareholder was less when compared to be whatever was paid to the other shareholders. Can be of the same bank or a different bank. So whatever is the price he got was less when compared to the other banks. So he filed a case saying that my right to equality was affected. Now in this case, they held that it's a company right. Right to equality is not available to a company. That's what is the mean, because fundamental rights are available to citizens. A company is not a citizen, and how can you claim for right to equality? That was a whole issue. That's how it started. But it was at the end, it was held that if the right of a shareholder is getting affected, it's not the right of the company here. Company is not getting compensation. End of the day, the money goes to the pocket. If that is getting affected, then they said you can still come, it will still be counted. The rights of the shareholders will be recognized. So that's the exception. That's the R.C. Cooper case. So what I'll be writing when I'm writing in one of the attempt they've asked, can a company be considered as a citizen? Comment. They've asked 3 marks question. If you look at it, it's an easy provision. So you'll be writing that a company cannot be considered as a citizenship. He cannot be considered as a citizen. But wherever the rights of the shareholders are getting affected, If that case is there, then the company's right will always be identified. And one of the case law you can write is RC Cooper. So by default, no. If the shareholders' rights are getting affected, the answer is yes. In the capacity of the shareholder. Yes, sir. So important, remember. Next one is company has nationality and residence. Yes, it can be considered as Indian company or a foreign company as the case may be. It also has a domicile. Domicile is you might have 5-6 branches, but you will always have one registered office. That's called as residence or domicile. Okay, next one. Artificial person. There is one more case law also. If you remember, we have done Union Bank of India versus Kadir International Construction. What is the case law? What happened? Can the we'll see that. So in CPC, there is one provision. Whenever I don't have money, I can apply to the court as a pauper. Meaning, I don't have money, sir. I do not have money to appoint a lawyer. But can you please take care of me? I urge the government. Can you please take care of my interest? This, as an individual, I have a right. One day what happened? A company went to winding up, liquidation stage. Company does not have money. Company wrote an application that is called as indigent application or pauper application. That's the application. Now, if I don't have money, being an individual, I can write a plea to the court, to the government to consider my application. Can you please take care of my interest? Can you appoint a lawyer? So this application was written in this case law by the company. I don't have money. Can you please take care of my interest? So the question was, can a company appoint or can a company enjoy this right? In this case, it was held yes. Because the words used in CPC was any person. And company is identified as a person. So artificial legal person. So you can file the application. That application only is called as what people? Indigent person. Indigent person means nothing but a poor or a pauper. That's the name. That's called as pauper application. It's clear? Yes, okay, done. Next one is limited liability. Limited liability as an exception. Important question from exam point of view. 2 times they have asked. Generally, a company's liability will be limited. Generally, that's the rule. Agreed? But this rule has an exception. When? Okay. Yes, people. So, limited liability, generally all the liability of the shareholders generally are limited to the extent of whatever the shares they buy. But there are some exceptions. What are the exceptions, sir? The first exception, you know. What is the exception? When the number of members are reduced below the minimum requirement as per the type of company you are. You are a private or a public. So your number goes below the minimum requirement. What is the section? The section 3A. Important exam point of view. That alone can be asked as a independent question as well. Okay, let us imagine, sir, in a public company, what is the minimum number of shareholders required?
Public 7.
7 only, no? Sir, a public company should have minimum 7 shareholders. Let us imagine because of any reason, the 7 becomes 6. Why, sir? Now let us imagine there were 2 individuals. One individual sold all his shares to another individual. Now that 6th person is aware of the entire scenario. Now the question is, the number went below the minimum requirement. The minimum requirement was 7. But today it has become 6. Now, are all the 6 shareholders liable? No. Are all the 6 shareholders unlimitedly liable? That's the question, remember people. Only the person who are aware of the fact that the minimum number has been reduced less than what is required by the law, only they will be liable. The word you will use in the exam is cognizant of the fact. Yes, the person or the shareholders who are aware, cognizant of the fact, only they will be available. Only they will be liable for the contracts entered post 6 months. So the time limit given for you to increase the minimum number of shareholders is 6 months. If you do not increase it within the 6 months, post that period, people, all the shareholders who are aware of the fact will be unlimitedly liable. Correct? Yes, so that's an exception for limited liability. So generally it's limited liability. In this case, the liability of the shareholders will get unlimited. And what else is the scenario, sir? Next one is unlimited company. The company itself is unlimited company. So in that case, all the liability of the shareholders will be unlimited only. The third one, incorporated by giving incorrect information, no factual information. So when you are filing Spice Plus, you have not given the actual details. You have given hidden information, incorrect, untrue information. In such cases, people, the liability of the shareholders will become unlimited. Next one, business carried on for fraudulent purpose or with the intention to cheat creditors. In such case, again, the liability of the shareholders will be considered as unlimited. The next one, people, prospectus issued with the intent to defraud applicants, meaning we have issued a prospectus, but in the prospectus, we have not mentioned the accurate details. In such case, if at all anyone is suffering any loss because of the miscontent or information that is not adequately available in prospectus, again the shareholders liability will become unlimited. Not shareholders liability, the people who signed the prospectus. That's what they have given. Either the director or promoter or the authorized person or the expert. Who is an expert? If you remember the prospectus provision, we would have seen an expert will sign the prospectus. So whoever has signed the prospectus, their liability will become unlimited. Correct? Next one is the company fails to repay the deposit or interest with a fraudulent intention. So the company has raised deposits 73 to 76. The company does not repay that, sir. Their liability will become unlimited. That is specifically for the people who had accepted it during the transition period. Yes, sir. A report made by inspector that fraud has been done by director, KMP officer and taken undue advantage in the form of cash or property, then they will pass a disgorgement order. What is this, sir? Imagine inspection, inquiry and all that takes place, chapter 12, and according to that it is proven that any director or any KMP, they have been involved in a fraud. A order will be passed. That order only is called as what, people? A disgorgement order. What do you mean by disgorgement order? A disgorgement order means whatever is the illegal gain you have made, that entire money will be taken away from you. It can be a property, it can be a cash. So how much ever you have made, everything will be unlimitedly taken back. So in these cases, the liability of the people involved in the company can become unlimited. Exam point of view, important, remember and go. Next one is perpetual succession. Members may come and go. The company can go on forever. So if at all the shareholders die, the members, the nominees will take over the company. Correct? Nominee. Every company should nominate a person with section. If a shareholder dies, you need to nominate a person. Correct? Yes or no? I should tell that after me, there should be a person who should take care of my assets, including shares. So who will that person be? In which section you will appoint the nominee? Which farmer? Oh. This chapter only, no? Which one, Section 72. Every security holder will be appointing a nominee. Yes, sir. Yes or no? Yes, sir. Somewhere we remember, sir. Yella helakagata. Sorry, da. So every security holder, it can be any person, it can be debenture, it can be equity. Every security holder will have a right to appoint a nominee. Can the nominee be changed? Or once I appoint, it will be the same person. Nominee can be changed. Remember, do not confuse this with OPC nominee. This nominee is different. OPC's nominee is different. I mean, the provision is same, but how it is appointed and all, for OPC it becomes a part and parcel of its incorporation process. Correct? Transferability of shares, people. In the case of public company, the shares are freely transferable. In the case of private company, there is obviously a restriction. Limitation of action, a company can never go beyond MOA or AOA. Here we can write that 3 circles. What are the 3 circles? This 3 circles. What will come here? AOA, MOA, Companies Act. Which section says this? Section 6. Articles cannot go beyond MOA. MOA cannot go beyond Companies Act. Whatever I can do is always restricted in the circles. Remember. Entrenchment is possible, yes, provided you make the provision stricter. Okay, separate management, companies managed by directors, so voluntary association for profit only, exception is Section 8 company. Termination of existence can happen through winding up. Simple characteristics. Next one, sir, applicability of Companies Act. The Companies Act is applicable to all the companies incorporated under this act or any previous company law, like 1956 or 1930, no, as the case may be. It is applicable to an insurance company, banking company, companies engaged in generation or supply of electricity, companies governed by special act or such other body corporate as the central government may notify. The provisions of this act will be applicable. However, remember, whenever there is a conflict between a general act and a special act, always a special act will prevail. So if insurance law is there and a company law is there, in case of a conflict between these two laws, company law only shall prevail. I mean, insurance law only shall prevail with regards to an insurance company. Clear? Generic provision will be company law, specific provisions, the insurance law only will prevail. Yes, sir. Okay, the next one, sir. Types of companies, people. The private company. What is that private company? Na? Definition, no? Three things we saw. A private company has these three words. One is a company which by its articles of association restricts its transferability of share. What do you mean by that? They can build a question here in the case of public company. Can a public company, remember this, once they have asked this question, can a public company in its articles of association, can it have a point restricting the transferability of a company's, a shareholder's share? Now imagine all seven of us come together, we start a public company, we have a provision, you cannot sell the shareholders to an outsider. Can a public company have such provision? Everyone wrote yes. Yes, sir, because it is left to their individual interest what they can write. Public company can never have it because we clearly wrote what is the definition of public company? Which is not a private company. That's all. Don't use any brain there. When I say it is not a private company, these three restrictions should not be there. It's not or. All three should not be there. Agreed, huh? See in exam how a simple provision can be made into a indirect question. Yes, and you guys can write up answer also. You will write no, but according to which provision? Provision is wrong. Everything is wrong. Getting it? Yes. So restriction of transferability of share limits the number of members to 200. So then remember, members include only equity and preference. Debentures has no limit, and what is that? In this 200, there is one exception. That exception is people. The joint shareholders shall be treated as one. So if there are more than 2-3 people holding one share, or collectively whatever is the number of shares, you need to treat them as one. And the past employees and the present employees are not included in the limit when you are counting 200. Clear? Yes, sir. In the case of public company, are the employees counted? In the case of public company, are the employees counted? In the case of public company, joint shareholders, how do I count them as? One. And past and present employees, should I count them? No. Even in the public company also? I am asking public company, not private company.
But is the depository
Registered owner, beneficial owner. The beneficial owner, should I count them as number?
No, because already the registered owner will be counted, right?
Right. I'm asking to the count of number of shareholders. Quorum is there, no? The registered owner, only depository will come and sit. Is a valid meeting, No. So you need number of shareholders, no. So in that limit, should I count employees? Remember, the meaning of provision is it is applicable only to this section, not for entire company law. So this exception is only for a private company, not for all the companies. So in the case of a public company, an employee is an employee, he is counted if you are a shareholder. There is no difference. Why? This 200 is given to you because there is a limit. There is a higher cap. And if you go beyond that, you will not be able to raise more funds. So people might not give ESOPs. So to make them a provision, no, it's okay to give. We say do not count them. Remember with logic, it's not a section, it's always a provision. Provision is always applicable only to that section, not for the entire act. Okay. Prohibits invitation to public to subscribe the shares. So you cannot ask people to come and buy the shares of the company. Next one, sir, public company, section 271. Whenever there is a company which is not a private company, it's a public company. See, definition, that's all they say. But it is understood that those three restrictions are not there in this company. Only then it becomes a public company. And a subsidiary of a public company will always be deemed to be a public company only. Okay, next one, sir. Subject. Okay, what is this? Subsidiary company means a company in which a holding company controls composition of board of directors. Agreed? A company in which another company controls composition of board of directors, meaning the majority of the directors appointing or removal power is there with another company. You become a subsidiary of another company. Next one, controls more than one half of the total voting power, either on its own or together with its subsidiary. Question can come, subsidiary company, remember and go. Now what is that they're saying, people? Whenever there is a company X is directly holding in company Y 51% of the total voting power. Generally, which share has voting power? Equity. Generally, so here generally on a normal day it is equity they are telling, but need not be equity always. Why did they have to specifically write total voting power? To give a provision for DVR. Correct? Voting rights can be different, no? So to capture that also from the shares, they started using the word total voting power. Okay. So if X is holding 51% in Y, it's a subsidiary only. Sir, if X is holding in Z 51% and X is holding in Y, let us imagine, say for example 30%, and Z is holding in Y 25%. This is also considered as subsidiary company only. Sir, X is holding 51% in Y is holding 51% in Z. It is called as a deemed subsidiary company. Remember, what is the maximum layers that is allowed?
2 layers.
2 layers. Correct? Yes, so this provision, this you would have seen in chapter 2. What is that? A subsidiary company cannot have more than 2 layers of subsidiaries. What do you mean by 2 layers, sir? Company X is there. Company X can have one subsidiary. This is considered as first layer. Company Y can have another subsidiary. This is considered as second layer. Sir, can company Z have another subsidiary? Say for example, company B. Can we have it? This is not it is not allowed, you cannot have it. But this is not applicable to a few companies. Few companies are exempted. What are the few companies, people? One is a banking company. Next one is this provision we saw in setting up of business entities also. So this provision is not applicable to a banking company, a systemically important NBFC which is recognized by RBI. What do you mean by systemically important? A company which is having an asset size of more than 500 crore is considered as systemically important NBFC, a non-banking financial company. Third one is an insurance company. Fourth one is government company. For them people, this layers concept is not applicable. They can have more than 2 layers also. Exam point of view, remember and go. Yes, Sam. Okay. Next one, sir. That is also allowed, provided it is recognized as per their law. That is allowed. And one more thing, what we saw in again when we are doing ODI part, when you cannot go and invest outside, if at all, it is coming back to India. Now imagine I will invest in a company outside India, and that company is having one more subsidiary in India. You cannot have this chain. I will invest outside, they will again invest in India, and again it is going beyond 2 layers. Again, that is not recognized. If you want, you can have it more outside only. Yes, sir. You will see it in Gill's provision. One more thing, what is an exception? Where can you invest more than 2 layers? Investment company, and there was an exception specifically given. One is this, whatever you said. If at all you want to invest outside India, if their country's law permit, you can invest there. There is one more provision. Very nice. To fulfill the specific condition or any act under the country. So if some other law says you have to hold it this way only. To satisfy that, if I am holding, I can go beyond 2 layers. Agreed, huh? Yes, huh?
Could we write that as a fifth?
Where?
For that exception.
No, this is they have given you to which companies it is not applicable. That's a provision. Yes, huh? Okay. Next one, sir. Okay, what is an associate company, sir? Associate company means people, a company in which another company has a significant influence and it includes a joint venture. What do you mean by significant influence, people? 20% of voting power or control. So 20 to 50% is still considered as a associate company only. Agreed? Huh? Okay. What are the other types of company, people? Small company. What is a small company?
Where it's made of capital.
A company which is not a public company. Okay, a public company can never become a small company. Okay, and two limits are there. One is paid up equity capital, paid up share capital. Share capital, equity capital. Huh? Sir, ingella madre will walk out. paid up paid up share capital equity alla paid up share capital of 4 crore or more up to 4 crore less than 4 crore less than 4 crore. What if it's exactly 4 crore? Is it a small company? Sanjay is like, sir, beda. I came for confidence here.
Exactly.
Not exceeding 4 crore, not exceeding 40 crore is considered as small company. 4 is inclusive. Agreed? 4.1 will become a big company. Okay, so 4 crore capital, sir, and turnover, people, not exceeding 40 crore and it is not R. So both the conditions are to be satisfied. And next one is, few companies cannot be called as a small company. What are those few companies? One is subsidiary or a holding company can never be called as a small company. Next one is Section 8 companies can never be called as small. The third one is statutory companies. So LICs and all that, they cannot be called as a small company. Remember, agreed? Yes? Okay. And then we saw something with regards to MCA, introduction to MCA, and there were few authorities also, if you remember. So under MCA there will be few authorities. Who are the first one is called as ROC, the person who regulates the Companies Act, and the governance part of Companies Act is taken care by ROC. RD people, RDs supervise the work of ROCs. They come in the hierarchy above ROC. They supervise the work of ROCs, RD. Next ones are OL. OL is official liquidators. Whenever a company goes for winding up liquidation, they are the people who will be appointed. SFIO, Serious Fraud Investigation Office, will be seeing in detail inspection inquiry. NFRA, National Financial Reporting Authority. Sir, NCLT, NCLAT,
National Company Law.
why do we have NFRA? What is the main purpose of NFRA?
No. To regulate the
National Fraud Reporting, hello, Financial Reporting. Why do we have NFRA? Here and there?
tip of my tongue.
Tip of your tongue. Something standards and all? Then no, it's not there in tip of your tongue. Accounting standards and all, in consultation with ICSI, they will pass accounting standards. And next one is the main thing. They all see the. They'll oversee. They'll monitor, supervise, oversee the professionals. Whatever is the work. If there are any improvements to be given, specifically CAs. So their work, if there is anything, they will be monitoring NFRA. NFRA will be doing that activity. If at all they are doing any fraud, I told you some big companies are there. Their CAs are doing anything. Their books will be audited by them. They will check whether are they doing a good job. If not, they will be suspended. They can be debarred. Their licenses can be withdrawn. As the case may be, imprisonment can also be there. Correct, huh? Yes, huh? Okay, NCLT and NCLAT. What is NCLT and NCLAT? National Company Law Tribunal. Wherever there is an appeal, you will go to NCLAT. Okay. So important aspects of MCA 21. MCA 21 is not there for us. Okay. MCA 21 people, first one, what do you mean by front office? Front office and virtual front office are nothing but the same. Whatever is that, today everything is digitalized. Whatever we see on MCA 21, which will show us a web page of various things that you guys can do under MCA 21. That is called as virtual front office. Whatever is the page which we can access and know what and all are the works that can be undertaken under MCA. That is called as MCA office, front office. Next one is called as registrar's front office. What is registrar's front office? We'll see that. What is registrar's front office? Whenever there is a transition from digital era to the physical era to digital era, I told you to sort out the transition. There were a few people who were specifically appointed in the registrar's office. If I have a problem, now imagine this was happening in the year 2006. I did not know how to scan a document and upload it on the form. I did not know. So if we go there, they used to help us. Today's date, their intervention has been reduced, but still they are there. I told you one person also in ROC's ROC Karnataka office, Infosys appointed a person. His name is called as Vivek. Yes, he'll be there. Last cabin is his. And he'll be under the pay scale of Infosys, but he'll be working in the government office. If you guys have been to passport office, the last thing will be TCS appointed manager will be sitting in passport Kendra. If at all there is any technical problems, you guys can still go there and you can have a complaint over there. It's actually a public platform. But how come a private employee is sitting there? That is only called as registrar's front office. For the transition, that's when it was taken care. Clear? Huh? Next one, people, is called as back office. What is back office? Back office is where your work gets delegated. Now, I'll file a form, Spice Plus, I'll file a form, INC 22. It will go digitally to them, but it will be forwarded to the case workers. I told you, there are various departments. Few set of the departments will take care of mergers and amalgamation, as the case may be. So your form will be forwarded to them. That is only called as what people back office. Next one is called as certified filing centers. What is certified filing centers? CFCs were also people as a part of transition in 2006-2007. Now Infosys appointed one person in the registrar office. Can one person take care of the entire state? He will also go mad. So what did our institutes do? ICSI or Cost Accountants of India, we also certified some centers. You please come and get the work done here. We will help you for this transitional phase. But the only difference is registrar's thing, that is free. This was charged. Clear? But this was initiated by our institutes. Today's date, these numbers are almost no longer there. But it was a part of transitional period. Clear? Yes, sir. Okay. Benefits of MCA 21. What are the benefits? They can ask you, easy questions can come. Elimination of interface with offices of ROC, RD and MCA. Now you going to the physical office, that burden is reduced. No. Everything is happening online. We only open in the class MCA 21. How many times? Or else can I go so many times to the ROC office and bring those files for effective usage of database, charges we saw. Correct? No. So for the following websites were created. One is IEPF. IEPF says what is the amount outstanding, which shares are outstanding, how much money is transferred, everything you can see. So they are using the data and they created one website where you can monitor everything. Second one is people awareness to investors. If at all there is any companies under defaults, any directors under defaults, so their names will come here. That website is called as watchoutinvestors.com. So be cautious before you do any contracts or trades with such companies. The third one is called CSR portal. You can clearly see which company is spending how much, which projects are being undertaken, as the case may be. Next one is securities clearance online portal. My strong feeling, they can ask you a 3 marks question. What is securities clearance portal? What is it? Whenever you are coming from a country which shares land border with India, before you take up any investment in India, you need to take the approval of central government. That approval will come here. I hope you guys remember. It's an amendment. Even in this also it was there, Noda. If before you are investing money in PAS3, you need to give this security clearance. If at all you are coming from a place which is sharing land border with India, you can be a body corporate or you can be a citizen. If you are coming from China, if you're coming from, say, Nepal, Bhutan, if you're coming from any land borders, Pakistan, you need to take prior approval of central government. Without it, you cannot come. Where will I take? I need to have a website. No, that is this website. No land border, no? So excluded. Yes. Clear, huh? Yes, huh? Sir, where and all it will come? Remember, PAS3. Can you guys tell me where other place it will come? Where I have to make sure I tell, sir, I am not coming from land border, so I need not take CG approval, or I am coming from land border sharing. So hence I have taken CG approval. Where and all you will give this? Where? One is PAS3.
You're asking for a form?
Forms. Which other places? Incorporation. One is MOA, subscription. INC 9. You give declaration, no? Then you need to give a declaration. I am not coming from this country. Or if I am coming, I have taken CG approval. Next, share transfers. Directors. They are 212. For all of them, this provision will be applicable. Remember, important. So before you invest in any of these cases, you need to take prior CGA approval. Correct? Yes, sir. Remember and go, important. Directors. They. Okay, clear? Pakana. Okay, next one. Better supervision and monitoring of compliance. Okay, mutual benefit system, helping them also, helping us also. Speed to transparency. Speed antare, matte they give captcha. Okay. Effective due diligence. Correct? What is DD? I told you one paper, Macha NCS professional. What is DD? Effective DD means what? Sanjay, what is DD? Sujay, sorry. Sujay, tell what is DD? Due diligence, sir. I thought, sir, Munukogi, Hey, remember, if at all there is any mergers, acquisitions that happen, I need to check the details of the company. Where will I get data from? You can go and check. You can download public documents. MCA portal. Efficient service by professionals. You can also sign everything, file everything properly. Environment friendly, no papers being utilized. MCA services, sir. What and all I can take it. If you remember in the class, we had seen everything. Practically where which tab is there. You can register your digital signature. You can apply for dinner. One is as a part of your incorporation. If not, you can apply a fresh form. View master data. Hello. Half of our class we would have opened that only. View master data. Index of charges. Kingfisher. Remember, LLP services. Same website for both LLP as well as companies. E-filing. Everything is electronic filing only, no? Company services. What and all you can do. SIN. You can apply for incorporation, direct appointment. Everything will come here only. Complaints. You can file a complaint. Document related services, people, public documents, you can download. Fee and payment services, you can calculate. I told you, if a client comes, how much fees is to be paid, you can calculate. There is a clear thing that shows for this form, for this capital, how much fees the government will charge. Everything data is given. Public search of trademark, investor services, the EPF, track SRN status. You can know the status if at all you have filed any form. Now incorporation, whether it is true or not, how will you know? You can track the status. MCA 21 version 3.0, this you can expect a question. What is MCA version 3.0? There are some options. What is 3.0? Currently it was under 2.0 until last year. Now it is under 3.0. It is also called as version 3. What is version 3? They have tried to introduce few new things in version 3 in the website. What is that? One is called as e-scrutiny. What is e-scrutiny? E-scrutiny means people, there are a few forms called as STP forms. What do you mean STP form? Da? Straight through processing. What is the whole purpose of straight through processing? It's a time saving. How is it time saving? There is no checking involved. Why is there is no checking involved?
Profession.
Remember, try to link all these three things. What is that? You'll get the next thing also. Pre-certification of e-forms. They can ask you a commentary based question. Why is pre-certification of e-forms required? To reduce the burden of ROC. So, you guys are certifying and telling ROC, I have checked everything, so you need not worry. I have checked the forms. I have checked INC 22. I have checked the Spice Plus. I have physically checked their address. You don't worry. So, ROC won't check the form. Straight, they will take it in their database. They will not check it. Such type of forms are called as STP. Example, PS3 is the STP form. Directly it will go and sit. Getting it? Yes, sir. So remember, 3 points you guys can link. One is pre-certification. One is STP. There is no physical checking of data. Third one is called as this e-scrutiny. What is e-scrutiny? Sir, now people were taking it straight through. But what is the guaranteed? You are 100% professional. Not even 1% can do fraud. So can't ROC reserve a right to check them? That is only called as e-scrutiny. I have a right to go and check back today. They may check it. They can pull a random form. Correct? That's a version 3's update. Next one, e-adjudication. What is e-adjudication? Tomorrow if you guys screw up something, officer in default. Your officer in default only, no? You have to go to Chennai, RDA. If at all there is any hearing. Sir, why sir Chennai? You anyways tell me to pay money. I'll be in Bangalore only. You tell me online, sir. Let us connect through WhatsApping. Correct? E-adjudication is that where they are trying to convert hearings, whatever are with RDs and ROCs, they are trying to convert it into online. That is only called as e-adjudication. Today it is happening. 100%. Yes, sir. The third one is e-consultation. What is e-consultation, sir? Tomorrow, if I want to come up with any amendments, even today they have posted something on MCA. There is some amendments that is proposed. They will ask your approval. Approval alla, feedback, opinion. What do you think? You are free to give your comments. Yes, sir. Good only, no. Rather than crying after it is been made, cry now only. Yes, sir. They'll hear it out, sir. I don't know. But yes, you still have an opportunity. Next one is compliance management system. What is CMS compliance management system? For example, sir, every year a company has to file certain forms. Now, my question, what is a guarantee that the company has filed those forms or not? How will you know? AOC 4, every year you have to file. AMGD 7, every year you have to file. Sir, we don't know how many companies are not filing every year. So, the system is being updated in such a way that automatically a penalty email will be triggered. You had to do this, you have not done this. That's only called as compliance management system. Compliance management system means people, it's a way to scrutinize the companies. Whoever does any default, automatic trigger of emails will happen. Artificial intelligence, a company knows by this day you have to file. If it is not filed, a automatic trigger of email will happen. That's only called as compliance management system, part of version 3. Yes, sir. The last one is called as MCA lab. What is MCA lab? Nothing but there are a set of professionals called as corporate law experts. They make sure to identify and see whether compliance management system is working efficiently or not. Whether it is able to identify every company or not. That is what is the need of this particular company. Clear? Yes, sir. Feeling cold? I don't have remote. You guys only have it. That will not make it any good here. This one. Vishnu.
Yes, sir. Reduce the speed of it, sir.
ಅದೇ ಗುರು ಮಾಡಿದ್ದು 2 ನಿಮಿಷ ಇರಲ್ಲ. ಓಕೆ clear MCA lab STP forms and what else I said pre-certification of e-forms correct important remember and go. I'm telling you wherever it can come a question can come. I expect this to be a question. Version 3, what are the changes that version 3 is proposed to bring in as a part of MCA version 3? Remember, can be a question.
Next year they will change it.
Which one?
Next year they will change.
The amendments.
More will come.
Yearly it doesn't happen. Version 2 was there for I don't know how many years. Crazily years it was there. 6-7 years it was there. Yes, huh? What is the prerequisites for filing e-form MCA 21? Easy one. Basically, if you have to file, you need to have laptop, computer, that and all they will give. But it can be an easy question. So, what is that? A prerequisite for doing e-filings on MCA 21? You need to have a computer, laptop, efficient OS, operating system, latest browser. It doesn't open in any other browser, just within us. Information. Mozilla Firefox or it can open in Internet Explorer. Google Chrome has too much error. We don't know why. And that's how all the government websites are built. Okay. Adobe Reader. Why? Because every form you file is in a PDF version. Word document, Excel and all you cannot file. It is only PDF. That's why Adobe Reader. Next one is scanner if needed. Because everything is attachments, right? Scan documents. Next one is Java runtime environment. Basically the things that support your forms. Yes. So you need a Java reader. Okay. Necessity of pre-certification we saw. Okay, that's all. That's your chapter 1 now. Exam. Okay. Next one is legal status of a company. Legal status of a company. Okay, what are legal status? This and all we saw. Again it is repeating, no? Okay. Legal status of a company. Matthew, half I gone at ಬಾಯ್ಲಿ ಚುಚ್ಕೊಡ್ತೀನಿ ಬಾ. But are you getting what happens in marathons? We took 45 minutes. But did we touch every topic? So now today if you go back and try to read the same things again, your revision is done. That's what you guys need to do. And use that time to solve questions, to take up papers, write it. Yeah. Series and all. Yes. Series andre idu. Test series. Series andre matte bhaya aitu. Okay. Yes, people. Next one is corporate identity. We had seen here in second chapter. So legal status and types of registered companies. We saw types in the previous only. We'll see whatever is not covered. We'll take it up here. Lifting of corporate wheel. What do you mean lifting of corporate wheel, people? Whenever a company has been used for fraudulent purposes, the courts has a right to lift the corporate wheel and say the company and the shareholders are not two different identical individual person, they are same. So whatever is the fraud done by company, the shareholders has to be punished. And when can that happen, people? It can happen in the case of if at all a company is used to do a trade with alien enemies. Case law was Daimler Company versus Continental Rubber Tires. The case law was, if you remember, German citizens had opened a company in England, UK. So it was a World War time. England and Germany had declared each other as alien enemies. So the contract had come to an end. Next one was to evade taxes. Dinsha Manekji Petit case. He opened 3 dummy companies. Using that dummy companies, he further invested money in other companies to evade taxes. That money he took back as loan, which he never repaid. Again considered as what is that? Lifting of corporate whaler. Subsidiaries to act as an agent. Merchandise Transport Limited versus British Transport Commission. What is that? I tried to apply for the license in my name and didn't work. I tried to form a subsidiary company, tried to apply through that. Again, it is considered as lifting of corporate veil to avoid legal obligation. A company, according to the law, had to pay bonus to its employees based upon whatever is your revenue. This company, over a period of time, did not pay that revenue, did not pay that bonus. To avoid it, what did they do? They transferred all their investments into another company. So they reduced their profits. So indirectly, even the bonus payouts also reduced. They held it could not be done like that because they tried to transfer only to evade or avoid a legal obligation. So it cannot happen. The last one is company was formed for conducting improper or conduct a purpose which is not identified. Gifford Motor versus Horn. There was a non-compete clause. So they said I cannot start my own company. So what did I do? I opened a company in my friend's name. I will only control, but the name is in my friend's name. Can I do it? No. That was a case law of Gifford Motor Company versus Horn. Class of companies, types of companies, people based upon liability. Based upon liability, a company can be classified into company limited by share, company limited by guarantee, unlimited company. Okay, question was asked here, setting up of business entities. Can a company limited by guarantee declare dividend to the non-members? Is it allowed? The question is, can you declare? Matthew, can you declare dividend to your non-members?
No.
That's what was the answer. Remember, company declare, if it's a company limited by guarantee, you can still declare dividend. Yes, but you cannot give it to non-members. Agreed? Okay. Unlimited company, yes, your liability is unlimited, but you are not directly liable. The creditor should file a case on the company only. Company will recover the money and give it. The creditors cannot directly file a case on the shareholders. That is not allowed. Okay. On the basis of control, which we saw, on the basis of number of members, private to OPC. Okay. I need to streamline this. Okay. Next one, people, is OPC. Now, what is OPC, sir? 1% company, people who can start 1% company in India. First one is you should be a natural person. Next one, you are an Indian citizen. Next one, people, you should be a resident in India or otherwise. Now, what do you mean by resident, people? You should have stayed for 120 days. Okay, sir. Next one, nominee. OPC, a member should always appoint a nominee. Upon the death of the member, the nominee will take over that particular thing. And as and when you become member, you should further appoint a nominee. Nominee is appointed in which form? We saw this in setting up of business entities. MGD 13? It will come in INC only. INC 4? INC 4 only, no? This only, no? 9 only, no?
9, I guess. Yeah, even I feel informed, that's fine.
Who else for INC 9? INC? Okay. INC 9 was declaration, not nominee details. You would have seen this when you are doing conversion also. INC 6 is a conversion form. Yes, sir. Which one? 4 only, Fix, Fix. Okay. Sir, he may be changed at any time, sir. He has a right to withdraw the consent also. Next one, people, one person can be a shareholder in 2 OPCs possible? Can one member be a shareholder in 2 OPCs? Only one? Pakka na? In other companies they can be a shareholder? Not OPC, other companies. That is possible? That is possible, sir. Remember, there is no restriction, but one person can be a shareholder of only one OPC. And one person can be a nominee of also only one OPC. One person at the same time can be a member and a nominee of one OPC. I can be a member of one OPC, I can be a nominee of one OPC at the same time, possible. But if one member dies, Now I become a member of two OPCs. Then I need to satisfy the condition within 180 days. So next one, sir, a OPC cannot carry on a few activities. That is, NBFC activities cannot be done, and you cannot form a OPC for doing charitable business. And a OPC cannot get converted even into a Section 8 company. Even otherwise also not possible. Correct? Remember this. Okay, other companies, what is a government company? A company in which
Central government, state government.
how much?
51.
At least minimum of 51 percentage of paid up capital is held by government, so that is state government, central or state, all that. And a subsidiary of a government company is also considered as a government company. Company or a body corporate incorporated outside India and has a place of business in India, either physically or through electronic mode, is called as what people? Foreign company. More relevant in the case of setting up of business entities. Agreed? Okay, Section 8 company is a company which is formed for the purpose of promoting charity, science, commerce, arts, all that. So, can a Section 8 company declare dividends?
No.
Not allowed, sir. And at the time of winding up and all, we saw that again in detail in setting up of business entities. You have to give up your status, and Section 8 company will function under a special license given by central government, but that power has been now delegated to ROC. ROC only gives you that special license. If at all you are doing any violation, people, that license will be taken back, and you will be merged with some other similar objects, or the excess money will be transferred to Section 8 company, or you will transfer it to IPF fund. And Section 8 company, if at all you want to make any alteration to your MOA or AOA, you cannot do it without central government approval. Very, very important. Agreed? This entire thing will become the main points in your setting up of business entities when you are seeing conversion chapter. Agreed? Yes, sir? Okay. Okay. Separate property. Most of it we saw in first chapter only. Advantage of private company, public company and all. Transferability, lifespan, all that is manageable, no? What are the advantages of small company? Advantages of small company, remember and go, can be important. Advantage of small company, people, when you are filing your annual return, PCS certification is mandatory. No, remember, if at all you do not have a CS, PCS certification is not required in the case of small company. Whereas if you are a normal company, PCS certification becomes mandatory. If a in-house CS is not there, that is not required, so cost savior for you. Next one, people,
Board meeting.
board meeting, how many?
Two.
Two.
90 days is this.
90 days is the maximum gap. Okay. Board's report. So there is something called as abridged board's report, people. What is abridged board's report? For a normal company, you will give a board's report. For a small company, you will give something called as abridged board's report. What do you mean by that? Nothing but summary. Why do you have to give so much in detail? Same provision. For a normal company, you will file annual return in MGT 7. But if you are a small company, you will file it in MGT 7A. If you remember. Correct? So that was for small company. So they can ask you these advantages, or it can even be asked as a exemptions available to a small company. Remember. Agreed? The first one is, people, filing of annual return. So one I'm saying in terms of certification now. Both will come there only. Certification, PCS not required. Next one people, I will give a summary form only. That is only called as MGD 7A. Next one is board's report, abridged. Abridged means people summary. Okay. Next one, board meeting. A normal company will have 4 board meetings in a year. A small company will have 2 board meetings in a year. Such that the maximum gap between 2 board meetings,
Should not exceed.
maximum minimum, maximum gap should be 90 days.
Minimum gap.
Minimum gap should be 90 days.
Minimum.
Hey, Matthew, there has to be a minimum gap of 90 days. And remember, people, whenever you are writing in the exams, do not use the word minimum, maximum. Use the word not less than, not exceeding. Very important. Clear? Okay. Next one, sir. Cash flow statement. They do not have to prepare cash flow statements. So, in your financial statements definition, cash flow statement will also come, but they need not have to prepare your cash flow statement. Reduced penalties for non-compliance. This I think I told you also. What is this reduced penalty for non-compliance?
As it's a small company, they did not pay as much.
So people, if at all the section says people, let us imagine the penalty is 10 lakh rupees. If you are a small company, and if when we did the same thing even when we are doing startup also,
Yeah.
what is that? Exemptions available to startup. I told you one exemption with regard to penalty in setting up of business entities. What is that? Whatever are the penalties applicable for a normal company, for a startup it will be half. You need not pay full. So if the penalty, imagine you have done some non-compliance. If the penalty is 10 lakh rupees for you, if you are a startup or if you are a small company, then they are telling you that penalty will not be 10 lakh, it will be half of it. But Sanjay says, sir, 5 lakh is also too much. No. Remember that half also is capped, meaning restricted at 2 lakhs.
2 lakhs for the company.
Company. Sir, what if officer in default? Again for you also half only, which is capped at 1 lakh. Which is capped at 1 lakh. In the case of penalties, remember and go important. Correct? Yes, sir. Okay. ఏ ఈరోజు ఏం రా రోజు what was it, Matthew? What was it with regards to?
Good morning.
Good morning, mom. I've come to the class. I've reached.
When to go, sir?
Why didn't you go to Matthew?
So I have cats at home.
I thought you would say like. I got exams after 30.
I have cats at home, so I have to take care of them. Visual mechanism we'll see when we are doing committees. Huh? How many cats you have, Matthew?
2. I told you no.
Correct, correct.
Sure, okay. Okay.
Okay.
These provisions we'll do it when we are doing that specific places only. Yes, sir. So that's your second chapter. Any doubt in second chapter, huh? Okay. Okay, let's take up your third chapter. What am Matthew? Break ಬೇಕೇನೋ ನಿಂಗೆ?
It's not that let's take then you will give a long.
So you assume it is break. Matthew ಬರೋದೇ ಬ್ರೇಕ್ ನೋಡ್ಗುರು. Okay. We'll do of chapter 3. Yeah? Okay. Chapter 3, people. Memorandum, articles, basically charter documents, and its alteration. So we have just split it into two parts, part 1 and part 2. Important, concentrate. So the first one is called as people MOA. So in charter documents, the first document is called as Memorandum of Association. Memorandum of Association will have various clauses. The first clause is called as name clause. What is the peculiarity of name clause, sir? Name clause will indicate whether it will tell you type of company and the name of the company. Whenever there is a change of name, it shall indicate its old name also up to a period of 2 years. In all the documents, wherever it is writing its new name, it should also write its old name as well. There were some cases also, people. Atlas case cycle, what is that? Peculiar cases I have given here. Even though it is a family name, for example, we will have our own family name. Once there is a registered trademark, another company formed with the same name. The registered trademark holder filed a objection on the usage of that name because he said, I have taken a trademark on this particular name. Even though it was a family name, the company was told to change the name of the company. They could not use the word Atlas. They can ask you a case-based scenarios. Remember, if there is a case law, you are expected to write the case law. Okay, next one, Halifax case, people. What is Halifax case? A court told, let us take in the first scenario only. A court told you to change the name of the company. Now, can I just use that order and can I just change of the company? The answer is no. That is only the court's order. You should still follow the complete procedure to change the name of the company. What is the procedure to change the name of the company? You have to file basically run only and you have to take CG approvals, INC 24, all that you need to file. That's how the process is. You need to follow the procedure still. Understood? Yes. Okay, next one. There is one more case, sir. What is this? Whatever is a foreigner that is coming and doing a trade in India, it can be a foreign company. Even for them also, our rules with regards to name clause shall apply. You cannot come to India if there is a similar name existing in India. There can be these things, they can ask you a question. Remember and go. Yes, sir. Okay. The next one is called as people situation clause. Situation clause always tells you the state where the company is registered. That's why whenever shifting of registered office clause comes, only in one case MOA gets altered from one state to another. Remember, important. Next one is called as object clause. What is object clause, sir? It tells us the scope or purpose of the company. A company can never go beyond that purpose. If it goes, it is called as ultra vires transaction. We study something called as ultra vires the directors, but intra vires the company. What do you mean by that?
The directors are given the in terms of like loans and all. They cannot specify.
So whenever a director is specified some power, you cannot go beyond that power generally. But if you go beyond that power also, the shareholders can still ratify that decision. It is possible. Okay. Next one, sir. Regarding object clause, we'll see even in detail. Liability clause, limited by shares, limited by guarantee, unlimited company. That is what it will signify. Capital clause, authorized capital. What is the maximum capital of the company? Next one is called as subscription clause. That clause is the only clause which will never change the life of the company. Who are the initial shareholders of the company will be given in this particular subscription clause. Okay. Articles of association, people, internal document which will define the rules and regulations of the directors or shareholders of the company. And can you change your articles of association? The answer is yes. And how many people have to agree? You should pass a special resolution. But can you do an entrenchment of articles?
Yes.
How many of them should agree?
Private company, all the members.
Very important, remember and go. If it's a private company, all the members have to agree. If it's a public company, you need to pass a special resolution. In the case of entrenchment, clear? Yes, sir. Now, what do you mean by entrenchment, people? Making the provisions more stricter than what is prescribed under the law. Agreed? Okay. Contents of AOA. Okay. Okay, there are a few doctrines, sir. What is the doctrine, sir? Doctrine of ultra vires. Whenever any act goes beyond your MOA or AOA, such acts does not bind the company. It does not create a creditor or debtor relationship. But remember, if the company has taken the benefit of it, then an outsider will always have a right over you. You cannot say it is an ultra vires transaction. What do you mean by that? I borrowed some loan. Imagine it is an ultra vires transaction, but using that money, the company repaid some other existing loan. This transaction will not become ultra vires. It will bind the company to the outsider. Is this clear? Yes, sir. Okay. Company cannot go beyond its AOA, the MOA and AOA. That's called ultra vires. Such transactions are void and does not bind the company. But remember, that's an exception. Where the company has taken the benefit of it, you cannot say it does not bind me. It will bind you. Next one, an act which is intra vires the company, but ultra vires the directors can be ratified by the shareholders. If you go beyond the power of the directors, the shareholders can still ratify it. Effect of ultra vires transaction. It's a void ab initio. It does not bind the company. Members can get injunction, stay order. Next one is personal liability of the directors. That is only called as what? Doctrine of alter ego. Next one is the company will have right over such property if at all any property has been purchased with that money. It will have a right. It does not create creditor and debtor relationship. You are not bound to the outsiders. Okay. Next one is doctrine of constructive notice. What do you mean by that? All the documents are available in the public domain. In one chapter, you directly see this provision. Which chapter? Chapter 3 we are doing. Somewhere I clearly directly tell you, once it is there in the public domain, doctrine of constructive notice will come. Which one? Charges. Once a charge is registered, it comes as a section only. If at all a charge is registered, it becomes a public document. No. That's only doctrine of constructive notice. Indoor management, sir. Whatever are the provisions, procedures, which is not available to outsiders, where they are not allowed, such will not be binding the company. It will always bind the shareholders only. That is only called as doctrine of indoor management. Doctrine of constructive notice protects the company from the outsiders. Doctrine of indoor management protects the outsiders from the company. Doctrine of alter ego is nothing but a wrongdoer will always be punished. Correct? That can be directors. So doctrine of indoor management has some exceptions. What is that? The first one is outsider has the knowledge of irregularity. He knew that there was no power. Still they did it. You still gave them a loan. It will not be protecting you. Next one, no knowledge of MOA. You do not know that MOA even exists. You can't ask this particular exception. Third one is forgery. I told you forgery will never give you a right. Correct? Okay, next one is negligence. It is your duty to also have some, R&D. You should also do your research. Existence of agency, precondition not satisfied. Basically, people, you do not do your work. You cannot say doctrine of indoor management. We always try to protect the company only. That's the exception, right? Correct? Yes, sir. Okay, that's your first part, and next part is people alteration. So can we alter? Yes, sir. The first one is people, you can alter your name clause. Name clause can be altered in two ways. The first way is voluntary. Next one is mandatory. Voluntary is given in section 13, subsection 2. Mandatory is given in section 16. Voluntary and mandatory. Mandatory. How will it happen, sir? Whenever a registered trademark holder or a company with a similar name, they think that, sir, this name is already registered in my name. How can another company be registered with a similar name? If I think so, I can write an application to the central government. Correct? Sir, and I need to write an application within how many years? I need to write an application within 3 years of the duplicate company, the second company getting incorporated. The central government, if satisfied, they will issue an order to change the name of the company. You need to change the name within 3 months. If at all I do not change the name within 3 months, what is going to happen now? The CG only will pass an order. CG, basically the power has been delegated to RDA. What will be the name of the company? See, I was been telling you throughout the class. This will be the name of the company. order of RD not complied, year of passing the order, plus serial number of order, plus SIN of the company. That will be the name of the company. Yes, sir. A new certificate of incorporation will also be issued to you. But sir, can a company further change its name? The answer is yes. You can further change your name to your desired name. Correct? Yes, sir. Okay. What is the procedure to change the name of the company? You will first call for a board meeting. You will seek the name availability. How will you seek the name availability? You will file a run application. The run application, the name will be reserved for a period of 60 days. Within 60 days, conduct a board meeting, call for a general meeting, pass a special resolution. Whenever you pass a special resolution, you will file a form MGT 14. You need to take approval of central government. Remember, change of name requires central government approval. You will be filing a file form INC 24. If everything is fair enough, people, ROC will issue a new certificate of incorporation. Sir, old name to be printed in every document for a period of 2 years. One more important thing here, effect of name change, people, whatever are the cases will not come to an end, it will still continue in your new name only. Okay, the company is not dissolved, it will still continue. That's okay. Very, very important, regulation 45 SEBI LODR. What does it say? Imagine if you are a listed company, and if listed company wants to change the name, they have some provisions it seems. What is that? First one, can I keep changing my name, sir? Illa. There is a cool off period. You can't keep changing the name. The change of name can happen only yearly once. If you change it today, there is a 1 year cool off period. This is applicable only for a listed company. Try to read the regulation also and go. Yes, sir. Okay. Next one, sir. 50% of its total revenue in previous year should be from activity suggested by new name. Why do you think Infosys, when it's changing its name, why do you think they removed the word consultants from its name? Foodie Media, Zomato Media Private Limited was the name. Why they took away the media word? Why are they taking away the activity? Because to keep the object neutral. Tomorrow they can change the name to whatever they want. If not, it will be a problem. Why? This is a provision. See, 50% of its total revenue in the previous year should be from the activity suggested by new name. Arivu, Educational Consultants Private Limited. Now tomorrow if I want to change it to Arivu, say for example Study Center Private Limited, Arivu Finance Private Limited, the condition they are telling is, if I have to use the word finance in my name, in my previous year, out of the total revenue I earned, at least 50% I should have earned from that new activity. I want to use the word finance in my name, I should have earned at least 50% from finance activity. Only then I will be allowed to use the word finance in my name. It is very simple. I should not go with that activity and cheat the people. That's the whole purpose. If you see, it is not in the case of private company, it's in the case of listed company. Getting it? Sir, tomorrow if Zomato wants to change it to Pomato, that also doesn't have meaning, this also doesn't have meaning. This provision will not come at all. Only where the activity is involved it will come. Correct? Now Sujay will ask, sir, how can you take up finance activity? So what is the right way? I have to first call for a general meeting. I have to change my object clause. In my object clause, I need to add finance in my name. I mean in my object, if I do not have it. Clear? Yes, sir. Sir, or what if I am not able to meet this? Then they are telling you, at least meet the requirement of investment. Meaning, sir, take your total assets, people. In that, at least 50% of your total assets, you should have invested in that activity you are indicating in your name, finance. So, out of your total assets, 50% should be in that finance activity. Then you are free to add the word finance in your name. It is either that or this. Either earn or invest. Okay. Next one, sir. Old name plus new name shall be disclosed on website of the stock exchange for 1 year from the change. So NSE, BSE will have both the names. Next one, sir. if listed company changes its activities, it shall change its name in line with activities within 6 months. So if I change my business also, I have to change my name in line with my activity. So if at all I have been doing something, food delivery, if I change that, they are telling I need to change my name also in line with my activity. Whatever is my new business, that should be indicated in my name within 6 months of that change of the business. Clear? Yes, sir. Okay. Next one, sir. Shifting of register office clause. How? Shifting of register office clause can happen in 4 ways. The first one is within city. Next one, within the same state. Third one, same state from jurisdiction of one ROC to another. Fourth one, from one state to another. Only in the fourth case, people, MOA gets altered. In no other case, don't write off attachments, altered MOA, or don't write off the provision for altering MOA and all. Remember that and go. Okay, what is the procedure, sir? Within the local limits, people, you just have to pass board resolution. Special resolution required? No. No, within city, not required, people. INC 22, you have to file it within 15 days of the name change. Office change. Change within the state. Board resolution plus a special resolution. Bangalore to Mysore. Sir, I need to pass board resolution, special resolution, intimate to ROC with, in INC 22. And because I have passed a special resolution, I need to also file form MGT 14. Next one, if at all I am changing from jurisdiction of one ROC to another, it can happen only in 2 states, Maharashtra and Tamil Nadu. So first pass board resolution, special resolution, file MGT 14, and you need to file form INC 23. What is INC 23? You are taking the approval of RD. Sir, now before I take RD approval, sir, 1 month before filing RD application, I have to do certain things. What is that? I need to give a newspaper advertisement that I am changing my address. Anyone has an issue, come and file your issue with RD. And I have to give individual notices to my creditors, my debenture holders, my depositors. I need to give them independent, individual notices. If you have any objection, let me know. Yes, sir. So 1 month prior, attachments to INC 23, board resolution, special resolution, declaration by KMP and 2 directors. What are the declarations, sir? We have not defaulted in payment to any creditors or workmen, and we will not seek any change in jurisdiction of court for the pending cases. We are giving a declaration that, sir, no creditors were harmed, we did not skip anyone's due, or we have taken their no objection. Sir, workmen also we don't have any, we have not removed them from the jobs and all. We have safeguarded their jobs. Sir, next one, sir, you are not seeking a change in jurisdiction for the existing cases. Sir, tomorrow if any new cases comes, that's okay. What about existing cases? We will still come and fight back in the same jurisdiction. Okay, sir, we will file it with the
Notice to Chief Secretary of State.
That also will come, yes, because the same thing will come even in the 4th scenario also. You will be telling that we did not remove any employees from our company. It is a notice to the Chief Secretary of the state. Yes, it will come basically, they have given yes. Same thing will come even in the RD's case also. Yes, sir. Within 30 days, RD will give you an approval. RD's order upon approval, you need to forward it to ROC. You will use the form INC 28. I told you INC 28 is nothing like a courier. One authority's order, you will show it to ROC in a form called as INC 28, and you will file the INC 22 to change your address in the ROC records using the form INC 22. Correct? Sir, in one state to another, sir, almost same people. Earlier we used to write in the 3rd scenario as RD and 4th scenario as CG. Now even in 4th scenario also, people, the power has been delegated to CG only. So whenever you want to change your register office, people, from one state to another, you will still file your application with RD only. The power has been delegated to RD itself, and the application form is same only, INC 23. There is no much change that will come into picture, except that, yes, I mean same thing only. Chief Secretary's approval will be taken. What is Chief Secretary's intimation? What are you telling? Sir, we did not remove anyone's job, sir, you need not worry. And you can see some case laws also here, people. What is a case law? Bharat Commerce and Industry Limited employee union would have legal right for objecting this shifting of registered office. Can employee union come and fight a case on behalf of the employees? The answer is yes. Next one is people, Satyashri Balaji wires and cables, shifting of office from one state to another, the loss of revenue. So can a state say, I have given you so much, you cannot go to another state? Can I say that? No. It's a company's decision, state cannot poke its nose. The third one, Usha Beltron, interest-free loans, sales thing, same thing. You cannot say that I have given you all the benefits, you cannot shift your registered office. It's always a company's decision. They will always do whatever is right in the interest of the company. You cannot say that the state will lose its revenue. That cannot be a ground for giving a no for a shifting of registered office. Clear? Okay. Alteration of object clause, people. Generally, board resolutions. One more thing, it is to be done by postal ballot. Remember, important. Wherever you need to shift your registered office beyond the city, outside the city, in all the cases, people, it will come as postal ballot. Correct? Section 110. Alteration of object clause, people, board resolution plus special resolution only. But wherever you need to alter a object clause, but imagine if at all a company has gone for IPO or FPO, you have issued prospectus and you have raised money from public, and you have unutilized money left. Zomato has raised 9,000 crores, I have spent 6,000 crores, I still have 3,000 crores left, unutilized money left. Now, if I have to change any, object clause, then this provision will apply. What is the provision, sir? I need to pass a special resolution. I need to give an exit opportunity for all my dissenting shareholders. In the explanatory statement, I need to clearly tell them what is the utilized money, what is the unutilized money, what is the new activity that you are going to undertake. All these things I need to give them in the explanatory statement. And I need to file form MGT4. Special resolution is to be passed by postal ballot. Correct? Exit opportunity, remember, important. Correct? Okay. The next one is alteration of capital clause. Capital clause can be altered in 5 ways. One is increase in authorized capital. Whenever you increase authorized capital, by default you will file one form. Which form? SH7. When and all you will file SH7. Redemption of preference share and increase of authorized capital, you will file form SH7. Section 64. Hello? Section 64 says, whenever you alter your capital or redemption of preference share, you need to file a form called SH7 within 30 days. Correct? Okay. Second type of alteration can happen. How? Consolidation and division into a larger amount. What do you mean by that? Imagine, people, I had 10 shares of 10 rupees each. Now I will make it 5 shares of 20 rupees each. My face value will go up, but this will never change. Agreed? Next one, sir. Conversion of fully paid shares into stock and vice versa. I told you the face value concept will be removed. Next one is subdivision. Nothing but, people, share split. Sir, I had 10 shares of 10 rupees each. Total is 100 rupees. They will make it as 20 shares of 5 rupees each. The second one and fourth one are opposite to each other. Clear? The last one is, people, cancellation. What do you make cancellation of shares? Whatever is the issued shares, in that if there is any unsubscribed shares, that will be removed off. And that's called as cancellation. Remember, cancellation will never amount to reduction of share capital. They can ask you a commentary based question. Alteration of capital, section 61. Yes, okay. SH7, no, 30 days. This is nothing but section 64. Agreed? Okay, alteration of AOA, which we saw. Okay, we'll just see if we have covered everything. We have covered everything, huh? Ultra wires.
Implied powers.
What is implied power? Not everything can be written in MOA. By default, as a directors, they will enjoy some implied power. But implied powers does not include certain things. What is that? So, implied power includes all this. Enter into an agreement, all that. Implied powers does not include certain activities. Where is that? Yes, sir. So, implied powers does not include these things. So directors cannot do this by default. What is that? Acquire any business similar to the company's own business. Without the shareholders' approval, you cannot take any decision here, which is having similar business. Next one, entering into an agreement with other person or companies carrying on business for sharing profits, joint venture or joint agreements, meaning I need to take the shareholders' approval. This is what we'll see in 232.
I think it has to be written in object clause.
Object clause, yes. Specifically, it should be written. People, what do you mean by implied power? Implied power means, I think I had given you an example.
It has to be expressed.
Matthew can arrange one cup, correct? Cricket, cricket, what is that? Tournament, correct? So I told you what and all you will do. I just told you to organize a cricket tournament. You did so many things. That's what is implied power. Implied power is we will tell our directors you can do anything with regards to education business. Correct? Whatever is related to education business they can do. Probably expansion of this class. It's actually a civil work. But education related they have to do. Tomorrow as a shareholder we cannot come and question them. That power is called as implied power. It comes within your object clause, but they cannot do everything it seems. What and all they cannot do these things. Correct? Okay. Third one, taking shares in other companies having similar objects. We'll go and buy Unacademy, Byju's and all, not allowed. Taking shares of other companies where such investment authorizes doing indirectly that which will not be intra-wires if done directly. What do you mean by that? Now we have put some restrictions on our directors. You cannot go and acquire some company where we have told you not to do something in our company. You are trying to do that through some other company. That cannot happen. Such investments are prohibited. Getting it down. Next one is power to sell and dispose of the whole of company's undertaking, which we have seen also. Section 181. A company to you. This is where you will see. 180. 180 subsection 1. We will see a restriction on the power of the board. Specifically, we will say that you need to pass a special resolution. 180, right? Power to give gifts and make donations, contributions and all. We again saw 182 and all. Political contribution, charity contribution and all that. Acting as surety or as a guarantor on behalf of the company, you cannot do it. It is not your implied power. Correct? Yes, sir. Doctrine of ultra wires, doctrine of indoor management.
For the foreign company trading in India, also
The object clause and all. Object clause and all will not apply.
only main.
Correct. Why? Because when a foreign company is coming to India, they will come either as three things. Bopolo. Okay. Bopolo is basically whatever activities you want to do. Accordingly, you will come. Doctrine of alter ego, liability clause. Subdivision, registration. Okay. Members bound to company and all. Once the articles are registered, members are bound to company. Company is bound to members, but members are not bound to one another. What do you mean by members are bound to company means? Whatever the shares you have agreed to take up, you have to take up. Whatever the restrictions given in AOA, you are bound by it. One of the case was, whenever, if you become an insolvent, there was a case. Your shares can be sold at the price as determined by the company. It was held that once it is written in articles, members are bound to the company. Next one is company is bound to members. You cannot deny the fact that you are not a shareholder. Once you have issued a share certificate, he is a shareholder. Notices, all your power, all your rights, everything you are entitled. But members are not bound to members. You cannot go and personally enter into a contract to bind another shareholder. Together you can take a collective decision, but not like a partnership firm. Mutual agency concept is not allowed. Correct? Company not bound to company not bound to outsiders.
Lawyer.
Lawyer's case. Correct? What is the case?
The AOA doesn't mean lawyer. He should be the lawyer.
Very good.
The company is the lawyer.
In company's articles, it had written that the company will not remove the lawyer on any grounds other than misappropriation. Meaning, if at all you do any fraud, we have a right to remove you. The company's lawyer did not do any fraud, but still the company removed him. Now the question was, the lawyer filed a case on the company. Its articles clearly say that they cannot remove me under any grounds other than misappropriation. I did not do. Then how can they remove me? In this case, they held that AOA is an internal document. AOA does not bind the company to the outsiders. So whatever is written in AOA will not bind the company and you. One more example you can write here is SHA, shareholders agreement. That's why whenever there is a conflict between AOA and SHA, which one will prevail? AOA will prevail. According to one of the decisions passed by Supreme Court. That's what you will write. Article 141 of Constitution of India. Whatever is the Supreme Court's decision will bind on all the other courts. If Supreme Court has said somewhere, we'll see when we are doing the SHA provision. Correct? Alteration. Effect of altered articles. What is pre-incorporation contracts? Preliminary contracts. Can the preliminary contracts bind the company?
But if they are ratified.
So first thing, people, the power of ratification should be there in MOA. You have to give a power of ratification. If that is the case, people, yes. After the company is incorporated in the first board meeting, they will specifically call for a board meeting. There they will ratify whatever are the preliminary contracts, pre-incorporation contracts. After that activity, it will bind the company, not before that. Clear? Yes, sir. Yes, sir. Does forfeiture of share affect the capital clause? It will be reissued, right? But yes, sir. Should I file PAS3? The answer is no, not required. Okay. Correct. That's all. That's all we saw here. Procedure for ratification, all that. Effect of altered. Okay, that's what we saw. Okay. Yes. Fourth chapter, lengthy chapter. You want a break or we'll continue? You want a break? Go for a break and come. 15 minutes.
Yeah. I mean, you're the one who is saying.
Okay, go and come.
He won't.
He was the one who told me to ask, and not his reply.
Trust man.
Yes.
So will you be sending that?
No. Okay. Yes, people. Okay, we'll start now. Okay, fourth chapter, people. Fourth chapter. Okay. Share capital and concepts. We'll first see, and if we'll see again in the PDF if we have missed something, and we'll again go back. Okay, so the first ones are with regards to share capital. What and all are the laws applicable whenever a company wants to raise its capital? It depends upon the type of company. With a private company, then only the Companies Act will apply. If it's a public company in the process of listing, or if you're a listed company, then Companies Act as well as SEBI will apply. So, section 23 will tell you what are the different types of or ways are there for you to raise a capital. One is, people, depending upon whether you're a public company. Next one is whether you're a private company. If you're a public company, you can raise money through public offer. When I say public offer, it includes IPO, FPO, further public offer, OFS. OFS is offer for sale. Next one is private placement, rights issue, bonus issue. What is that? We'll see in detail. If you are a private company, you can do rights issue, bonus issue, and private placement. We wrote one more thing also as an amendment 23.3. What is that? What is 23.3? Whenever a company wants to directly list its securities in the foreign jurisdiction, they can do it. Now they are giving you a power. Correct? If you remember, we wrote listed company definition. The last definition will be that only. If at all there is a company which has listed its equity but not in India, but as per the jurisdiction given in 23.3, the 23.3 is this only. So if correct, yes, I told you that listed company definition. Correct? That is the definition I'm talking about. Clear all of you? So 23.3 is nothing but listing your securities in the foreign jurisdiction. Clear up? Yes, sir. Okay. Okay, the first one is called people. Okay, let us see prospectus. What is prospectus? Any document issued as prospectus. It includes shelf prospectus and red herring prospectus. What do you mean by red herring prospectus, people? With section?
32.
Section 32 speaks about red herring prospectus. What is red herring prospectus?
It is like cannot determine the final valuation.
A prospectus which does not has the complete information. So it has complete information except two. Something will not be there. One is quantum or the price of the shares. This will be missing. The rest of the information will be as it is. This such type of instrument is called as red herring prospectus. Generally, whenever a company wants to do a book building offer, when you are not sure of your price, then the companies will go for red herring prospectus. Correct? So everything will be first issued, but 3 days prior to the issuing of the opening of the offer, you will be issuing your price band. If you remember, what is the lower price, higher price, and all you will tell. That's called as red herring prospectus. Okay. The next one is called as people shelf prospectus. What is shelf prospectus?
In a year.
So in a year, basically the word shelf prospectus is just like your shelf life. You generally take any product, that product will have a shelf life, right? So it will be valid for a certain duration. That's how the entire name was derived. So a shelf prospect will always have a timeline. So today, if I issue a prospectus, shelf prospectus, using the same document, I can do multiple offers. How many ever offers I want, I can do it within a year. So this prospectus will be valid for 1 year. But sir, what if there are change in financial information, or if we have created any new charges? Only this will be again intimated through one document. That document is called as information memorandum, and in the form PAS2. And this document is called as shelf prospectus. It is valid for a period of 1 year. In this 1 year, you can make multiple offers. Correct, Tom? Okay. Okay. That's your red herring prospectus, shelf prospectus. Okay. The next one we studied was people section 25 deemed prospectus. What is deemed prospectus? What if people to avoid the civil liability, criminal liability, or the provisions of public offer, what if they try to avoid the public route? So instead of me directly issuing it to public, people will appoint an intermediary. That intermediary will issue to the public. What if we are trying to do this indirectly? So what did they say? What cannot be done directly cannot be done indirectly also. Even you should also be regulated, and that's why they brought a concept called as deemed prospectus. What is the gist of deemed prospectus? Simple. If there is a company, the company is giving its shares to a third party. The third party is further giving it to the public. Now, how is a third party giving it to the public? Using some document. That document will also be deemed as prospectus, provided some conditions are satisfied. What is a condition? So, you are issuing the shares within 6 months of purchase. Now, what do you mean by that, sir? Let us imagine there is a company A, there is company B, this is a third party company, there are public. Now, if at all company A is giving securities, its shares to the company B, and company B will issue those shares only to the public. Now, they will use one document and they will issue shares to the public. The question is whether this document will be called as a prospectus. To be called, there are two conditions. Either one, any one satisfied also, yes, it will be called as a prospectus. Now, what is that condition? The condition one, when did you give the securities to company B? If it is today, within 6 months, if they are selling it to public, I gave it today, and tomorrow only they are issuing it to the public. Basically, within 6 months, if they are issuing this prospectus, this document will be called as a prospectus. Condition 2, whenever, forget within 6 months, Allah, it took them 1 year. After 1 year, they are issuing it to the public. But my question is, have you paid the complete consideration to company A? You have taken 9,000 crore worth shares. Have you paid the money? If the answer is yes, then we don't have a problem. If you have not yet paid the complete money, then if you are giving the any document to the public, you are raising money. That means you are utilizing that money to repay this debt, whatever you agreed to pay. Then people, this document will be considered as prospectus. So if it is considered as prospectus, what will be the conditions? The condition is simple. Whatever is the liabilities we saw in this chapter, civil liabilities, criminal liabilities. What is civil liability? Whatever is the loss the shareholder will suffer, you will have to pay that loss personally. That will apply to this document. Criminal liability, intention to defraud, 447, fraud will apply to this prospectus. Correct? Sir, okay. So it is called as a prospectus. Who should sign this document? Because it is a prospectus, someone has to sign. So sir, now the company, this B is there. No, my question is, what is this B? Is it a company or is it a partnership firm? If it's a company, people, at least 2 directors of company B should sign. Sir, what if it's a partnership firm? At least half of your partners has to sign this document. Correct? Yes, sir. Yes, sir. So this is called as deemed prospectus. That's what is written in the definition of prospectus. Any notice, circular, advertisement or any other document inviting offer from public. Example is 25. Understood? Clear? Any doubts? Pakka? Okay. Next one, sir. Sir, can we write RBI or SEBI in the exam? Like full forms like that. Better to always write Reserve Bank of India, then write in the brackets RBI, and after that in the same answer you can use the word RBI, but do not directly write. Clear? Okay. Sir, what is 447, sir? Fraud. 447, if you remember people, if the amount involved is at least 10 lakh or 1%, not more than at least 10 lakh or 1% of turnover of the company, whichever is less. Now, what is the amount involved in the fraud, people? That amount or 1%, whichever is less. Take that. Is it coming whichever is less? Is it coming here or is it coming here? If the amount involved is less than 10 lakh or 1% of turnover of the company, whichever is less. So, what is the amount that is coming? Is it, now take people, amount is 10 lakh or 1% to the turnover of the company. Now, let us imagine the fraud, whatever you did, is 6 lakh. What is the turnover of the company? Let us take the turnover of the company is 500 crore. How much is 1% of 500? 50 is 10%. 1% is 5 crore. Yes, sir. Sir, 6 lakh or 5 crore, whichever is less. Which is less? 6 lakh. Sir, the amount involved is 10, at least 10 lakh or less than 10 lakh. Where is it coming? Second. Yes, sir. So, sir, then what will be the punishment, sir? Your punishment will be imprisonment up to 5 years or fine up to 50 lakhs or both. Sir, what if, sir, the amount involved is more than that? Or it is 10 lakh or it is 11 lakh or 1 crore? Then people, the punishment will be imprisonment minimum 6 months, maximum can be 10 years and fine is minimum amount involved in the fraud, maximum 3 times of the amount involved in the fraud. Sir, and if fraud involved public interest, sir, minimum imprisonment shall be 3 years. Understood this one? All of you? Any doubts? Huh? Which one? Yes.
Imprisonment plus fine.
Correct. Now, when will that happen is, let us imagine if the fraud amount is, say for example, 20 lakhs. Now what is the turnover of the company? Let us imagine same thing, 50 crore. 1% is 5 crore, whichever is less. How much? 20 lakh. Does it come under this category? Yeah, this category. You should see that. Is it less than 10 lakh? No. Your amount is 20 lakh. So you will come here. So what will be your penalty? Penalty will be minimum imprisonment is 6 months, maximum can go up to 10 years. And minimum amount involved in the fraud. What is the amount involved in the fraud? 20 lakh. Or it can go up to 3 times of amount involved in the fraud, 60 lakh. So minimum will be 20. It can go up to 60 lakhs. Imprisonment will also be there. This also will be there. Imprisonment is minimum 6 months. Now my question is, what is the fraud you did? You did something fraud in the prospectus. Public are affected. The answer is yes. Then the minimum imprisonment will not be 6 months. It will be 3 years. Clear? Somehow not even once they have asked how to calculate it. But according to me, it's very important to calculate the 447. But not even once they have asked. Clear? Okay. That's your punishment for fraud. Next one, sir, offer for sale. Section 28. What do you mean by offer for sale, people? Offer for sale means
Already existing.
there are existing shareholders. These existing shareholders only, through the company, they will sell their shares to the public. Existing shareholders through the company will sell their shares to the public. Generally, when I say this existing shareholders, it will not be some random shareholders. It will generally be promoters or the majority shareholders. They will sell their shares to the public. Why? I told you one of the scenario also. Whenever they want to achieve minimum public shareholding, in case of listed companies, public should have minimum 25% of shareholding. Promoters can hold up to 75%. If this ratio comes down, the promoters will give their shares to the public and they will take that money. That money will not belong to the company. The money will go to the shareholders only. That is the promoters only. Yes, sir. Example also, people, this happened in the case of Patanjali. Their minimum public shareholding came to 19%. And SEBI issued a notice that you have to increase your minimum public shareholding to 25%. Time limit was also given. They did not do it within time. SEBI issued a prohibition order on Baba Ramdev that until this particular provision is fulfilled, you cannot sell your shares. His shareholding was freezed. That is this provision. Understood? Because it's a listed company, this will also come. SEBI regulation will also come. You will study this again when you are doing ICDR in your capital market. Yes, sir. Clear? So see, where certain members of a company, members, that means they are already a shareholder, propose in consultation with the board to offer their shares to the public. Correct? Okay. Such members shall authorize the company whose shares are offered for sale to take all actions in respect of offer for sale and reimburse the company for all the expenses incurred. So what they are telling you, now if a company uses any document to sell the existing shareholders share only to the public, the document used will still be called as prospectus only. Correct? Yes, sir. But some provisions applicable to a prospectus will not apply to this. What is that? Very good. Minimum subscription of 90% will not apply here, and minimum application value, very good, will not apply here, and utilization declaration is not applicable. Vishnu is like, you are right next to me and you are not telling me that you are studying. Yes, sir. Yes, declaration to be given. People remember, in prospectus, whenever you are raising money, you need to give a declaration how you are going to utilize that money. This, where are they utilizing? It is given to the promoters only. So that is also not coming. Correct? So remember, okay. Any document by which offer of sale to the public is made shall be deemed to be prospectus. Okay. All the provisions of this chapter will be applicable except what is that? Minimum subscription. Minimum subscription is 90%. Minimum application value is
25.
So what will write?
5%.
5% or any other percentage as prescribed by SEBI. That is what is written in Companies Act. When you are seeing ICDR, you will again see it is 25%. But don't write out 25 in your exam. You have to write these words only. 5% or any other percentage as prescribed by SEBI. Here, okay. Statement to be made by BOD in respect of utilization of money. You are not utilizing only. You are just repaying. Any other information which cannot be complied and justification along with that. Why you did not comply should be given in the document. That is a prospectus. Yes, sir.
The CAS3 applicable. CAS3 not me.
No, not applicable because the capital will not go. Remember, whenever OFS, whenever forfeiture and reissue, in all these cases, PS3 will not come because capital is unaffected. Capital will remain as it is. Okay. Next one, public offer of securities to be in dematerialized form. We saw this after 2018 people, everything. Even if you are listed company, to mandatory. All your shareholding has to be in dematerialization. Now I told you public company. Now I told you recently private company. We saw that provision also.
We saw it with that there was this transition period of 18 months, right?
Correct. Correct. So we had seen that also. Earlier, a provision was introduced for unlisted public companies. Now the provision has been introduced even for a private company. Good thing for us as professionals because more stricter provisions, the more compliances. That is when it becomes serious. That is when Nandan will be happy. Nandan already is smiling when I say more good for us. Okay, clear? Yes, sir. So you have to make sure that whatever the fees to be paid the stock exchanges, you need to file. And what else? The existing promoter shareholding or KMP shareholding has to be dematerialized. And after 2018 people, even if you want to transfer your shares, it has to be in dematerialized form. If it's a public company, you cannot do it in a physical form. Okay, next one people, allotment of security section 39 by a company. Whenever a company wants to allot people, there are some conditions you need to satisfy. What is that? Within certain time, you need to receive the money. If you issue the prospectus, and what is the form, what is the minimum application size, everything. Okay, we'll see that. Minimum subscription, sir, it has to be stated in the prospectus. You cannot make the allotment if minimum subscription is not met. You have to clearly specify in your prospectus what is that number you are looking for. Remember, you cannot have anything less than 90% because it is prescribed by SEBI. Okay. The received amount shall be refunded if it is not subscribed within 30 days. So you have to refund it. Remember, private placement will be 60 days. To be refunded within 15 days from the date of closure of the offer. Failure people, 50% interest to be paid by the directors. Correct? Okay. Minimum application money people, it shall not be less than 5% of the nominal value or such a percentage as may be prescribed by SEBI. That is 25%. Return of allotment people, whenever you are filing or you are allotting the shares to the people, you need to intimate it to the stock exchange, to the ROC. Sir, we have raised 5 lakh capital, 10 lakh capital, 20 lakh capital as the case may be, along with a list of allottees, meaning whom we have allotted. This will be filed in the form PAS3. Along with the list of allottees, registered valuers report. Why registered valuers report? How did you arrive at this number, the price? And the last one, sir, consideration other than cash. What is consideration other than cash? Preferential issue. Basically, whenever there is non-cash consideration. What is non-cash consideration? Someone has given you value, sweat equities. Such cases, this will come. Yes, sir. Penalty, it's okay. Do not remember. Next one is section 40, sir. Securities to be dealt within stock exchange. Meaning before you become a listed company, you should at least file an application to at least one stock exchange where your shares has to be dealt. Yes, sir. In principle approval it is called. You should at least file an application at least with one stock exchange when you're going for IPO. It can be NSE, BSE, as the case may be. So every company making a public offer shall make an application at least to one or more recognized stock exchange. All money received from public offer shall be kept in a separate scheduled bank account. It shall be used only for allotment and repayment of money. You cannot utilize it for any other thing. Rate of commission important from exam point of view. Sir, whenever we can engage underwriters, right? What is underwriters? So whenever you cannot fall below minimum subscription, you cannot go below 90%. So these people will come and say, if at all your subscription is below 90%, we will come and subscribe an additional number. That is called as underwriter. Sir, for doing that we have to pay some commission. How much commission you will pay? They are telling you the maximum you can pay depends upon are you issuing shares or debentures. If you are issuing shares, you cannot pay more than how much? 5% of the issue price, whatever the total price, or the rate you have given in your AOA, whichever is less. That's the maximum, you cannot go beyond that. Sir, if it is debenture, sir, 2.5% or rate given in AOA, whichever is less, you cannot pay more than that. Here, hello, Pakka? Okay. Next one, sir, private placement. Private placement, people, section 42. Okay, what is private placement? What do you guys remember? It is a offer made to a specified group of individuals. Okay, I mean specific group of people. Okay. Okay. The maximum you can give a private placement is 200. Is it in a year or at once?
Both. It can be both, sir.
Security.
Per security 200. Is it at once or in a year? In a year. In a year I cannot do 200 or every time I can do 200. In a year.
In a year per security.
In a year per security. So for every security I can give it to 200 people. Equity 200, preference 200, like that. Okay. Yes, people, remember the private placement is an aggregate in a year cannot be more than 200, and 200 is per security, and the 200 is a per year limit. Yes, if at all you do a private placement beyond 200 in a year, people, it will be considered as a public offer. You need to comply with all the prospectus provision. We had seen the class Sahara, here only they have done it. Okay, and whenever I am counting that 200, I need not count a few people in that 200. And who were there? One is qualified institutional buyers. The next one is ESOP. If at all you have given it to any of your employees, you need not count them in the limit of this 200. And sir, what else you saw? What is the process? What are the forms you need to maintain under private placement? PS 543.
Not 3. 4.
3 won't come. Matthew said 3 won't come. 3 will come, sir. Huh? Why will 3 come, Matthew? Return of allotment you should file in private placement.
4.
Only 4?
4 and 5.
4 and 5. 4 and 5. 3 will come?
Yes.
They are all telling Matthew.
Yeah.
Okay. Yeah. They are only doing like PS 3, 4, 5. Matthew answers like this only. Sir. Okay. So there are 3 forms you need to maintain under private placement, people. One is called PS3. That's a return of allotment. PS4. If I have to tell you in the order. PS4, 5 and 3. 4 people is people. Private placement offer letter. Private placement come offer letter it is called. Yes, so that offer letter will be in the format PAS4. PAS5 is nothing but record of the offers you have made. Whom and all you have made. Private placement offer letter should be specifically addressed to the individual in his name. Yes, okay, and PAS5 is that After the entire allotment is made, people, you will file Form PAS3, return of allotment, intimating to the ROC what is the total capital you raised, how much was the securities premium, who and all were the allottees. I will intimate everything. Clear? Yes, sir. Sir, and whenever I go for a private placement, I need to pass a special resolution. Every time I do it, I have to pass a special resolution. Only exception when you are raising money from QIBs, that special resolution will be valid for 1 year. You can raise any amount of money in any number of transactions with the QIBs for a period of 1 year. Correct? Yes, sir. Okay. And one more thing, sir. PAS3 or this entire private placement, within how many days should you give the allotment? Within 60 days. If within 60 days I am not able to give the allotment to the people, then within 15 days I need to refund the money. Within 15 days, if I do not refund the money, then what is going to happen? You need to pay interest at the rate of 12%. Sir, even beyond this 15 days, if I still keep the money, what will happen to this money? It will be considered as deposits. Clear? This is what you see in a deposit provision. Any money received, allotment not made within 60 days, refund not made within 15 days, and it will be considered as deposits post this period. Correct? Hello? 61st day. I mean, see, 60th day, you have to allot. If within 60 days, if you do not do it, 15 days, you have time to give the refund. If at all it is not made, the rate of interest and all will start from the 61st day only. Because this is a time period given for you to give the refund. That is what you guys would have studied also. So everything will start from 61st day. Clear? Okay. Next one, sir. People, this is very important. Can a company, a company did a private placement, people, of equity shares. The private placement offer is going on. Can the company simultaneously do a private placement of debentures? Security also we cannot. Different security I cannot. Can I do equity only? Private placement of equity is going on. Can I do a private placement of equity only again?
No.
When it is going on?
No. It has to be allotted and also.
Yes, no two simultaneous private placement offers can be held. So it's irrespective of security. Clear? You cannot do it. Remember, they can ask a question there. No fresh allotment until existing ones are completed. Clear? Yes, sir. Okay. And a company shall not utilize the money. They can ask a question here also. The company's private placement offer is still going on. They have not yet filed the PAS3, but the company started utilizing the money. Can they do it? The answer is no. Until allotment is made, you cannot utilize the money. Everything because of Sahara. Clear? Yes, sir.
So what is sector of business? What is that? Can we try to relate both of these?
100%. 100%. Yes. So wherever charter documents come, wherever conversion comes, all that is yes. 100%. Yes, sir. Sir, procedure of private placement, how does it happen, people? Bold or special. You will start offering your private placement offer letter, people. You have to open a separate scheduled bank account. The money will be kept in that until the entire process is complete. You should not utilize that money. Okay. People PS4 and complete record of offer letter sent to PS5. The names will be maintained. You will receive the application money. Within 60 days, you need to make the allotment. And within 7 days, people, you will enter the name in the register of members. And within 15 days, people, you need to file form PS3 to ROC. Correct? Yes, sir. Within how many days should I give the share certificates? If it's a private company. 2 months, or within 1 month?
Transfer only one.
Okay, within 2 months. Okay, types of share capital people. What are different types of share capital people? Different types of share capital: equity, preference. Equity can be with voting rights, with the differential voting rights. With the differential voting rights, people, you have some conditions to be satisfied. What is that? The first one is it has to be authorized by ordinary resolution. First, your articles of association should allow you to do it. Next one, what is the maximum DVRs you can have at any given point of time? It cannot exceed 74% of your total voting power at any given point of time. Whenever a company has not filed its annual returns and your financial statements in the 3 preceding financial years, if there is a default, you cannot go for DVR. Next one is you should have not made any default. There should not be any subsisting default in payment of preference share. Yes, where is it? Filing no subsisting default in redemption of preference share or debentures or payment of declared dividend, repayment of deposits. There should not be any subsisting default. However, sir, what if there is a default in payment of preference dividend, or we have taken any loans from public financial institutions, banks? If we have taken a loan, we have made a default. But what if I made good the default? I had taken a loan, I had to repay this year, I did not repay. I repaid it the next year. Whenever you repay people, from the end of that financial year, 5 years school of period is 5 years school of period is there. Clear? Yes.
I don't know such close.
Correct. Visuals can be deceiving. Yes, so there is school of period of 5 years. After 5 years of making good the default, you can go ahead and issue DVRs. You should have not been penalized during the last 3 years from any of these authorities, that is RBI, SEBI, SCRA, Securities Contract Regulation Act, FEMA. And always remember, existing shares cannot be converted into DVR and vice versa. Not possible. And rest of all the rights are same like a normal shareholder. He also has a right to vote. Proportion will be different. He also has a right to attend the meeting. Everything will be same to same. Clear? Yes, sir. Okay. Remember, DVR important. Exam point of view. Next one, sweat equity. Matthew, what is sweat equity? What is sweat equity? You didn't revise that. You revised ESOP. No.
I started doing a random chapter.
Hey, random I'll ask you. Sweat equity shares, people. Okay, what is sweat equity shares? What is the difference between sweat equity and ESOP, sir? Sweat equity?
Exercise period will be given for it.
So there is some conditions to be fulfilled. Exercise period is there and all. Okay. And what are the main differences? Sweat equity? Price. Both are predetermined only, but main difference is something discount. Remember, sweat equity is the only equity that can be issued at discount, except if there is a conversion of loan into equity. That's a different story. But that's the only case where you can give the equity at a discount. That's a sweat equity. ESOPs can never be issued at a discount. Prohibition of shares, issue of shares at discount is prohibited. Issue of shares at discount is prohibited. Exception you would see is sweat equity and that conversion of debt, loan to debt. Loan into equity. Correct? Okay. Sweat equity, people, you have to pass a special resolution. That special resolution will be valid for 12 months. Within 12 months, you need to issue the sweat equity. Limit on issue, how much I can issue? It is depending upon one time or whenever in the lifetime of the company. One time, people, at a time, you cannot issue more than 15% of the paid up equity capital in a year. You cannot go beyond 15% or issue value of rupees 5 crore, whichever is higher. So you take the total paid up equity capital 15% or the value 5 crore, whichever is higher, you can issue it. Sir, during the life of the company, It should not be more than 25% of the paid up equity capital at any time. Remember, this is where we had seen advantages of startup. In startup, in setting up of business entities, whatever are the exemptions that is available under company law, that is where you wrote this. Correct? For a period of 10 years, 50%. And I told this also, it's not paid up equity, it is paid up capital. Equity plus preference it is. Agreed? Okay. Next one, lock-in period of 3 years. What do you mean by lock-in? What is the difference between lock-in and vesting?
Lock-in means you cannot sell it.
You have been given right. Share a member right you can.
Okay, good.
Exchange.
Vesting period, no rights.
Correct? Yes, lock-in period people, after you become a shareholder, whatever are the restrictions that can be imposed after you become a shareholder is called lock-in. Vesting is for you to become a shareholder only, you should wait for some time. That's a vesting. Difference, vesting period you will not get any rights. Lock-in period you will get every right. That is what you see under ESOP. No right to vote, no dividend. Here everything yes, there everything no. Clear? Okay, price of issue is determined by registered valuer. Correct? No. Sweat equity. They have given us something valuable, we are giving it in return. What are they given us in sweat equity? What would they have given? Yeah, but something like know-how, intellectual property rights, technical know-how, value addition. Correct? For that we are giving them. Sir, next one. Treatment for non-cash consideration. Remember, twice they have asked this. How do you treat it in your balance sheet? Now, if it's a cash coming in, easy to show it in your journal entries, easy to show it in your records. But if at all there is a non-cash consideration, what do you mean by non-cash consideration? Imagine if our employee has given us a patent and in return we are giving him equity. Now, how do we record this in our balance sheet? Money is not coming in. How do you do LHS equals RHS? That's what they're telling you. What is that the shareholder has, what is that the employee has given you? Is it a depreciable or amortizable asset? Depreciable means he has given you a physical asset. Amortizable means he has given you an intangible asset which can be carried to a balance sheet. Then carried to balance sheet. If what the employee has given is not depreciable or not amortizable, then you need to treat it as an expense. So carry it to P&L. That's how you need to treat the non-cash consideration. Is this clear? Exam question can come. Register of sweat equity, SH3. Register of ESOP, SH6. So sweat equities are issued to the directors or employees at a discount or for consideration other than cash for providing no IPR or value addition. Correct? Okay. Okay, next one there. Transfer and transmission of securities. Section 56. What is transfer and transmission of securities? Whenever a person wants to transfer his shares or securities, they need to sign. Transferor and transferee needs to sign one transfer deed. It is called SH4. SH4 is your transfer deed. Once you sign it, people, within 60 days, you need to give this share transfer form along with share certificates to the company to register the transfer. The company should register the transfer and they will issue the new share certificates to the transferee within 1 month. Correct? Yes, sir. Pakana. What if it is debentures? Pakana. With the register of, if the transfer of equity, you will give it in 1 month. If the transfer of debenture, you will give it in 6 months. Was that 6 months for allotment of debentures or transfer of debentures? Transfer is common. Transfer will be your, how many days transfer? 1 month. It will be 1 month only. In the case of allotment is 6 months. In the case of debentures, clear? Why? Clear? Yes, na? All these are those points which इससे डाल के एग्जाम में हिरोशिमा नागासाकी बम डालते हैं. Yes, na? So try to pay maximum attention in these places. It'll just go, will not realize what just went. Yes or no? Okay. So how do we do? So we'll file SH4. Along with that, we'll give share certificates. If share certificate is not there, we'll give letter of allotment. We have to give it to the company to register this transfer deed. This happens only in a private company, not in a public or a listed company. Yes, sir. Okay. Now, sir, 60 days of execution you have to do this. What if the shares are partly paid? If the shares are partly paid, the company will write one application to the transferee. Do you know that the shares you are buying is partly paid? Tomorrow when I make further calls, you need to pay that. And sir, this person has a right to we'll see that. So this person has to reply to it within 2 weeks, 14 days. You have to reply this, that I know or I don't know. If you do not reply within 2 weeks, people, it will be considered as a deemed approval. Clear? Yes, sir. Okay. That is with regards to your share transfer. Okay. So next one, refusal of registration and appeal against refusal. What is this, people? Sir, I gave my transfer instrument to the company. The company did not register the transfer. This is given in section 58. What is the section 58, sir? I gave my transfer form SH4. The company did not register it. Now what is the right I have? What can you do? You can go to tribunal within how many days? What is the total timeline you saw? 90 days, huh?
90.
For the public company it is 90 days. For a private company it is 60 days. What is the total timeline you guys saw? 30 plus 30, something like that? Well, somehow there only we have the provision. Somehow we are seeing also, but still we are not able to tell. Huh? We'll see that. Okay. So what happens here? Now the day private company gives. Now I have given the what is that? SH4 for registering the transfer. They have 30 days to register the transfer. That's the first 30 days. Within 30 days of delivery of instrument, they have to either register it or they have to reject and they have to intimate us. They have to give us a notice that we have rejected your transfer. Now they have rejected it. Sir, I have 30 days time. That they have sent me the notice. Within 30 days, people, I can go to tribunal. Sir, I have applied, sir. They did not approve my transfer. They neither sent me a notice of rejection. They did not intimate me at all. Now, you just go to tribunal within 60 days of you filing your SH4 with the company. So that's the timeline you would have seen. 30A plus 30A. If not, 60A. Correct? In the case of public company, this 30 will become 60A. This 60 will become 90. Correct? Yes, sir. Okay. And the tribunal will pass the order accordingly, and accordingly they will take a call. Okay, before we go to ESOP. Okay. Next one is preference shares. What is section of preference share? Section 55. Preference share. What is the maximum tenure of preference share? 10 years or 20 years? 10 years?
For infrastructure,
30 years.
30 years.
10 or 20 years, Matthew?
20.
Matthew said 10, 20 years, sir. Huh? 10 or 20 years, Matthew? 10, the 10 is for whom? One security cannot have redemption period more than 10 years. Which security it is? That only. Debentures, remember preference is 20, debentures is 10. Here, so sir, preference shares cannot be issued for a. See, first thing, you cannot issue a irredeemable preference share. It has to be redeemable, and the maximum tenure people cannot exceed 20 years. But there is an exception. Infrastructure companies can go beyond 20 years. They can go up to 30 years, provided there is one condition that every year you need to repay after 21st year 10 percentage, that is 1/10 of the total capital that you have raised as preference shares. Another 21st year, Kusha. Okay, so by the end of the 30th year, you'll be in a situation that you will redeem the entire preference share. And what else you saw? Whenever you're redeeming or whenever you're issuing preference shares, should I file PAS3 for preference shares? Remember, people, for any security, you have to file form PAS3. Important, required. Okay, and what else we saw under preference share?
Not payment guidance, they'll get voting rights.
So, if at all preference shares, do they have a right to vote? The answer is yes.
Yes.
In the case of any matters affecting them, in the case of capital reduction, in the case of winding up, in rest of the case, people, they do not have voting rights. But if at all a preference dividend is not paid for 2 consecutive financial years, then for the 3rd financial year, the preference shareholder are treated at par with equity shareholder. They can have a right to vote on everything, just like an equity shareholder. Yes, okay. And what else we saw? First you need to paid up, fully paid up it has to be. You cannot do it with a partly paid. Okay. And
Profit.
only profit, proceeds of fresh issue. Can I utilize securities premium?
No, redeeming
So tell me what and all I can use a securities premium account for?
Bonus, buyback.
Redemption on? Okay. Buyback, okay. Redemption, bonus, okay. ಕೇಳ್ತಿರೋದೇ ಸೆಕ್ಯೂರಿಟೀಸ್ ಪ್ರೀಮಿಯಮ್.
Issue expense, we can.
Issue expenses.
Preliminary expense.
Whatever the preliminary expenses can be written off. What is the redemption part? Premium on redemption on preference share and debentures. And 4 I think you guys told. 5 also you told. Bonus, buyback.
Issue expense.
Okay, issue of debentures and all that. Okay, and discount on issue also in terms of debentures that can be set out. And next one is writing of preliminary expenses and your redemption of premium on redemption of preference and debentures. These are the things why you can utilize your securities premium account for. Section 54. 52 ಸರ್ ಅಲ್ಲೇ ಅನ್ಸ್ತು, ನಂಗೂ ಅದೇ ಅನ್ಸ್ತು. ಇವನ್ ಐ ಫೀಲ್ಡ್ ಸರ್ 52 ಅನ್ಸುತ್ತೆ. 52, 53 prohibition of issue of shares at a discount. Yes, 54 very good. 55 preference share. 56 transfer. Yes, that's what we saw. Okay, next people. Okay, ESOP. Section 62, ESOP. Section 61, alteration of share capital. ESOP people, section 62. Now section 62, I can classify into 3 things. What is that? One is called as people rights issue, and next one is called as ESOP, and next one is called as conversion of debt into equity. Yes, okay, Westfield, that is 4th one. Then we'll have 4. One is your preferential issue also. Let us see that also. And next one is conversion of debt into equity. So one is rights issue. What is rights issue? Whenever an offer is made to a existing shareholders. That's preemptive right. Rights issue means an offer given to the existing shareholders. It's called as right issue. Why are we calling it as a right? Because that's a preemptive right. Before asking an outsider, as an insider, it is your duty to ask me first. Yes, sir. Okay, rights issue, tell me the provision. But how many days should the letter of offer be open for? First it was 15 days or such other time period. Now they have prescribed 7 days. So now minimum offer period shall be 7 days. Maximum is 30 days. And letter of offer can open within how many days?
For 3 days.
3 days before the opening of the offer, you have to give them the letter of offer. So from the day you get the letter of offer and that letter of offer opens, there has to be at least 3 days time period. So minimum is 7 days offer, maximum is 30 days. But you have to get the letter at least 3 days before the offer opens. Okay, renunciation. A director by default says a company has by default a right to renounce. And he is asking your opinion as a company secretary. Does the shareholder by default enjoy a right to renunciation? Can a company restrict the right to renunciation? If yes, how?
AOA.
AOA. Correct? Remember, so you can restrict it by your AOA. If not, people by default, the shareholder will enjoy the right to renunciation. Agreed? So you can give your part of shares to someone else. They can buy in your name. They need not be a shareholder. It can be a random person also.
How's it different?
Forfeiture is you not paying the call money. Right share is we are not telling you to. It's not a mandate. That's why we are saying it is your right. If you want, you will buy. If not, you can give it to someone else. Only members, not to any other person. You have to be an existing shareholder. That's a criteria. Yes, correct. Okay, next one, people. ESOP. What do you know, ESOP people? ESOP people, there are 3 periods that we can tell. One is called as people granting of options. Next one is called as people vesting of options. Third one is called as people exercise of options. First one, you will grant the option, you will identify the employee, you will tell them that you are entitled for so many shares. So it's an offer made to exercise your shares at a predetermined date, at a predetermined price. I'll tell what price you can buy the share after 1 year. Today only I will freeze it. After 1 year, if it is feasible, if it's good for you, you can buy. If not, you will let it go. That's why it's called as employee stock option. Correct? Yes, okay. And after I give you the letter, that is, after I identify the employee, I have something called as vesting period. Vesting period means people waiting period. In the waiting period, you will not be entitled for any rights, any shares, you will not get any dividends, nothing. You will not get voting rights, nothing. It will be freezed. Once you exercise it, you may exercise your voting rights, dividends, as the case may be. And this is called as ESOP. Minimum waiting period is 1 year. Minimum lock-in period as per ESOP means sweat equity is
3 years.
3 years. Do not get confused between this. Register of ESOP
8, 7, 6.
7 4 transfer 7 alteration of capital asset 6 correct now. Okay, preferential issue. Whenever convertible securities are issued, if at all convertible securities are issued, then you need to follow preferential issue also. You will follow private placement also. Rest of it will be as per private placement only. Non-cash consideration can come here as well. Remember that one thing in mind. The last one is conversion of debt into equity. Remember, whenever you want to convert your debt into equity, before you have taken the debt, at that time only you should have passed special resolution. You should have taken shareholders approval. But one person is an exception. Who? If at all government is a scenario, if government has given loan to any company, in the interest of public, they can convert the debt into the equity, whether you have passed special resolution or not. What if the company is not okay with it? You can go for an appeal. Correct? Remember that. This is your section 62. Okay, next one. Okay, we'll see of reduction of share capital. What is reduction of share capital? When and all you will reduce the share capital, what are the circumstances under which a company might have to go for reduction of share capital? Whenever there is losses, meaning people, whatever are the assets present in the company are not matching with your liabilities. LHS is not equal to RHS. Okay, and overpricing, Allah, probably you can put it as excess of capital taken beyond your needs. If you have taken, you have a choice, you can give back the capital, reduce your capital. That is one way. And three, you can do it in 3 ways. So people, imagine people, your face value is 10 rupees. 5 rupees is partly paid. Another 5 rupees is not paid. You can say don't pay this. Next one, they have already paid entire 10 rupees. You will give back 5 rupees. In both the ways, you can reduce the capital. One of the directors says for the reduction of share capital, he says that tribunal approval is not required. What do you think? What is your opinion as a company secretary? Is the opinion of the director, is it right? Is it valid? For reduction of capital, is tribunal approval required?
Yes.
Is it required? Reduction of capital.
Only
SEBI approval is required? Or SEBI or with SEBI? Whose approval required? Approval required, huh?
Yes, sir. So it has it.
Total tribunal approval is required. You required, huh?
Yes, sir.
Specialization is not required.
Yes, sir.
So remember that board special tribunal approval mandatory.
Yes.
Procedure will be more. You have to remember important capital reduction. Yes, sir. Okay, our director says that cancellation of share buyback is equivalent to capital reduction only. So even for cancellation of share, tribunal approval is required. One of the director is of this opinion. You as a company secretary advise.
is wrong. Right is
Wrong,
wrong.
huh? For cancellation, no tribunal approval is required.
Cancellation, alteration of.
So that's how you need to write it. Cancellation is deletion of unsubscribed capital from your issued capital. Hence, it is not considered as capital reduction, and hence tribunal approval is not required. Clear? Pakka na? Okay. So how will you do capital reduction now? One is extinguish the capital which is not called, uncalled. Cancel paid up capital which is lost. This is losses. Next one, pay off the paid up capital which is in excess. 10 rupees, everything you have paid up. Pay back 5 rupees. Next one, apply to tribunal for confirmation. It will forward the application to CJ, SEBI, ROC, creditors. If they have any problem, representation should be made within 3 months. If they don't have any representations, then no objection. No objection is considered as no problem. We'll go ahead. Tribunal, after being satisfied people, they will allow for capital reduction. However, what if you have left out the name of any of the creditor? If at all any of the creditor comes in the future, comes and says, sir, my name they have left out, sir. In this list of creditors, my name is not there at all. So I have not given my approval at all. So whatever is your capital reduction, you have reduced, no. Your amount will be as if the capital reduction has not taken place. So if your liability was 1 lakh, you have reduced it to 50,000. Now after this, your liability will become 1 lakh only until his money is repaid. Clear? Yes, sir. Okay. Next one, sir. Buyback of securities. Buyback people, section 68. Tell me, what are the provisions? Taka. From what and all you can do buyback? Free reserves, securities premium, profits of my pocket. Other free reserves. Proceeds of fresh issue. You can buy back by issuing preference. You can buy back equity. You can buy back preference, equity, equity preference, whatever you want. Possible, but you cannot issue the same security. Yes, sir. What is the cool off between 2 buybacks? 1 year or 6 months?
6 months.
I don't know. I'm asking.
6 months.
6 months. I'll ask you one more question. If I do a buyback today, within how many days I cannot further issue the same security? Sir, Israel one sir. If that is 6 months, this is 1 year. If this is 1 year, that is 6 months. 6 months is for what? ಅದು ಹಿಂಗ್ ಸ್ವಲ್ಪ ಈ ಕಡೆ ತೋರಿಸಿ ಸರ್ ನೋಡ್ಕೊಂಡ್ಬಿಡ್ತೀವಿ.
Security.
So cool off period between two buybacks is 1 year. You cannot further issue the same security within 6 months. Correct? Chandramole? What Matthew? What do you think? Sir, go with them, sir. Nan bitpudi. Yes, people. Cool off is 1 year. If it is the same security, you cannot issue it within 6 months. Where is it? No further buyback shall be made within 1 year. Company shall not issue same kind of securities within next 6 months. Remember. Exception is there. Bonus, conversion, sweat equity. If that time it is coming, you can do it. Next one, source. Free reserve security proceeds. Post debt equity ratio should not be more than 2:1. All security shall be fully paid up. Register of buyback SH10. What is the extent? What is the maximum buyback you can do? If it is a buyback by passing board resolution, the maximum buyback you can do is 10% of paid up equity share capital plus free reserves. If at all you are passing special resolution and you are buying back equity, then you can buy back 25% of paid up equity capital. If at all you are buying back any other security, 25% of paid up share capital plus free reserves. Yes, sir. Did we do one question here in the class? I think we did it on debt equity ratio. On this we did. We didn't do. Okay. 2 we did or 1 we did. That I think we would have done on debt equity. Okay. Free reserve doesn't include revaluation reserve, securities premium, and statutory reserve. Yes, sir. This is securities premium you can include. This is you cannot include revaluation reserve and statutory reserve. Clear? Yes, sir. Okay. Next one, declaration of solvency. What is declaration of solvency? Given by directors. What is that? Company will not be insolvent in the next 1 year after going for buyback. Why? Because you are having excess money and you are repaying. And if you go for insolvency, it's your problem. So if anything happens, the directors will be personally liable. So declaration of solvency, within 1 year you will not be insolvent. SH9.
So that thing is not there in the
This one. Then write on this. Revaluation reserve and statutory. We would have seen somewhere. Statutory reserve and revaluation reserves are not included. Dividends. Bonus we didn't do. Correct. Going in. Share capital mata simply it will be complicated. More provisions. Okay, next one, sir. SH9, declaration of solvency. That's a format. Return of buyback. Unlisted company, you have to file it only with ROC. Listed company, ROC plus SEBI. Format SH11. Extinguishment of security. That is extinguishment. Once you buy back, you need to just tear off those securities. Sujay, understood? You have to tear off the securities within 7 days. If not, it becomes an investment. You cannot invest in your own securities, no? Can you? No. Okay. That's all. Did we miss anything in chapter 2? Sorry, chapter 4. Did we miss anything else? Bonus. What are the sources of bonus? That's section 63. Yes, sources of bonus. Free reserves.
Preference security premium.
Securities premium. CRR account. Very important. Capital reduction can be utilized only for bonus. Okay. And what else in bonus? It has to be fully paid. Okay. And article should authorize. Okay. And no default in payment of statutory dues. Dividends, declared dividends, deposits, repayment of preference, debentures. There should not be any defaults. Yes. Correct? That's what we had seen in bonus. Okay. And what else we saw in 4th chapter? Share certificates, people. Subscribers to memorandum. You have to give the share certificate within 2 months. Any allotment within 2 months. Transfer within 1 month. Any allotment of debenture is 6 months. So, that comes in dividends only, no? That we see in dividends chapter only, no? Noah? 126. We'll see in that only. Duplicate share certificate. What is duplicate share certificate? What is the format of duplicate share certificate? Format 1 only. What is the register? SH2. So duplicate share certificate will be in the format SH1 only. In the share certificate it will be written as duplicate. Yes, sir. When will you get duplicate share certificate? Whenever your instrument is lost, torn, defaced, mutilated, as the case may be. If it is defaced, mutilated, you have to submit your original share certificate. If not, there are other procedures involved. You need to give your letter of allotment. At times, to one extent, up to 5 lakh rupees, they have exempted you from some filings. If it is beyond 5 lakh, FIR reports, newspaper advertisement, all that is mandatory. You have to give up notice in a newspaper that I have lost my securities. This is the number. All that up to 5 lakh is not required as such. Yes, sir. Okay. And what is the amount I can collect from the shareholder for issuing duplicate share certificate? You cannot do it beyond 50 as per your AOA, but it cannot be more than 50 rupees per certificate. Okay. Anyone applying fraudulently, people, you will be 447. Okay.
Joint shareholders.
What is splitting of share certificate? Splitting sir, adenge. What is?
If they are joint shareholders.
Whenever there are 2 shareholders, they will apply for splitting of share certificate.
No, jointly. They're holding shares.
When there are joint shareholders, you will apply for split of share certificate.
Single shareholder.
Single also can do that. Hey, Matthew. Whenever I have 500 shares, I want to sell only 100 shares. How will I sell? Sir, you kelsa madi. Mail new tagonbidi. Can I do that? No. Then I will apply for a company to split it into 100 and 400. That 100 I will transfer. The 400 I will keep it. That's why you will go for a share split. Clear? Share split, company's approval. You will give it to the company, but special resolution, all that is not required for share split. Remember that. Yes, sir. Hello.
Yes, sir.
Legal effect of share certificate and all. What is that? Estoppel as to title, estoppel as to payment. You cannot say that I didn't pay. And whosoever name is given, you cannot go back. You cannot say, no, he is not my shareholder. On a normal scenario. Yes, sir.
Expulsion of shareholder.
Expulsion of a shareholder. Can you have it? No. Why?
Violates the constitution.
Violates the constitution. Expulsion of shareholder from the company is not allowed. It is prohibited. Expulsion is a removal. You cannot do that.
Can we mention the constitution?
Yeah.
Right to equality. Like in the previous case law.
Yes. Go for it. Okay. Any other thing, da?
We can rearrange the name.
Joint shareholders, da? You can have something called as transposition. Correct? So joint shareholders, they can have, if they want people, remember, share split can come in 2 ways. One, joint shareholders, they can say, please divide it into 250, 250. Split it, one way, possible. Next one is single also possible. Now, in the case of joint shareholders, whoever is the person whose name is written first will be entitled for all the benefits. Correct? Sir, I can rearrange, yes possible, and that is only called as transposition. 4.48. This one is it, the stamp duty. .48, which one? This one? Stamp duty, is it? Okay. So here, do not worry about these two. This is like that, what do you say? Trading and all will come, so you do not have to worry that. That you leave. This one you can concentrate. Whenever I'm transferring a security, a debenture or a whatever it is, I need to pay stamp duty, right? And how much will the stamp duty be? This is the percentage on your value of consideration, purchase consideration. On that you need to pay this much to the government. These two, don't worry, leave it. Absolutely leave it. Clear? There's non-delivery ways and all, they are talking about trading. Yeah? Not there in a directly, let's leave it. It's okay. Individual depository penalties, transfer of shares to a minor. Can I give it to a minor, Ada? This we'll see when we are, who can be a member. We'll anyways cover everything. Correct? No? Transposition, okay. Death?
That you can, yeah.
Before,
Transmission.
if the company does not know about the death, they can transfer it off. If they know about the death, they cannot transfer it, they need to consult it. Directly, they cannot write the name of the legal representative. They need to consult with both and then only they can write death. Correct? Transfer and transferring all we have seen, Nora. Rights of transfer, effects of transfer. Checklist of company secretary. What and all you will check? Everything will check, sir. In oh my God. You will basically check the stamp duty, whether it is signed, whether it is dated, whether the securities are given. SH4 has been given within 60 days. Partly paid. SH5 is there. Is it a minor? If yes, guardian should be there. So all this will become your responsibility. Correct? And along with SH4, have they given all the required documents like share certificates and all that? Okay, what is transmission?
Involuntary.
So it's not, it's by operation of the law, it's not voluntary, it's an involuntary act. It can happen in the case of death, insolvency, lunacy, as the case may be. Clear? Yes, sir. Dematerialization of shares. How does dematerialization work? You'll open a demat account. So you will, if I have a physical security, I will go everything, I'll give it to the depository, demat account holder. He will write a letter to the depository. He will write it to the company. He says, hey, in your register of members, you have written someone's name as a shareholder. He has come and asked for dematerialization. So remove his name and write my name. And I will credit the shares to him. So sir, the physical securities will be converted to the demat form. The form you will file is DRF, dematerialization request form. The process is opposite for rematerialization. You had electronic shares, you want physical shares. The form you file is called as RRF, rematerialization request form. Clear? So first you will give it to Zerodha. Zerodha will forward it to CDSL. That's what you would have seen here. DP to depository. DP is your Zerodha, depository is your CDSL or NLP. Clear? And the same thing with RRF. 9A we saw compulsory transfer and of unlisted shares. Correct? Yes, sir. That's your 4th chapter. Any doubts? Hello. Rule B I had made you write in the class for private companies, right? I had given you a note for 9B. I had made you write. You guys took it, right? What is 9B? 9B. What is rule 9B? ಅದು ಯಾವುದು? Private companies, yes. Few people were exempted. Who are the few people? Small companies, OPCs need not have to convert their physical securities into demat form. But if you are any other company, it is mandatory for you. 18 months time was given to you. The order came in the year 2023. I think, if I'm not wrong, March. 31st March 2023. From that time, 18 months time was given. And within 18 months, they had to do it. That I think is somewhere around September. That's the September 2024. That's the last day for you to convert your physical securities in the case of private company into demat form. That's your rule 9B. Correct? Yes, sir. Okay. Next one, sir. What do you next chapter? Okay. Members and shareholders. Okay. We'll do this off. Yes, people. The next chapter, people, members and shareholders. First of all, tell me, people, is the members and shareholders, these two terms, are they one and the same? So, sir, only in this chapter, people, they are not the same, but in for rest of this chapter, they are the same. But what is the difference, sir? A person becomes a member only after your name being written in register of members. Until then, people, you will not be considered as a member. Until your name is written in register of members, you will not be entitled for all the benefits. Then who is a shareholder? Shareholder is a person who is having shares in his name. Now there is a transfer, SH4. I have given all my shares to Chandramouli. But he will give it to the company. Company has 30 days to register it. Now this time taking is there. He is a member, I am a shareholder. I am a member, he is a shareholder. I have transferred all my shares to his name. In the shares, his name will reflect. Meaning, within us, I have told you are the shareholder. You have all the shares. But in company's records, my name is there. I am considered as a member. That's the difference. Understood? Clear? Okay. Okay. Modes of acquiring membership. How do you know you can become member, people? A person can become member by subscribing to MOA. So you can subscribe your name to MOA. That is during the incorporation of a company. Next one is person who agrees in writing to become member and whose name is entered in the register of members. So who is agreeing to become member? This is nothing but, people, after the company is incorporated, I am agreeing to buy more shares in the form of acquisition, transfer, or further allotment, as the case may be. Yes, sir. So making an application for allotment by transfer, by transmission, or estoppel. Estoppel is once I promise, I cannot go back. I have to buy it, I don't have a choice. And next one, people, person holding shares in name entered as beneficial owner in records of depository. Correct? RO, BO. Registered owner, beneficial owner. Whoever is the beneficial owner, he is still considered as a member of, Remember, member important. They can ask you. Clear? Hello? Okay. Next one, sir. Who can become member? You only tell me. Partnership, can they become member or not? Matthew?
No.
No.
No, it cannot be. Only the individual.
So, sir, partners in their name directly they can become a member, sir, but not in the case of partnership firm. The reason is partnership firm is not recognized as a different person. Agreed? Yes, sir. No separate legal entity. LLP, yes, sir, possible. Section 8 company, yes, possible. It's also any other company only. Foreigner, subject to FEMA, you can do it, but subject to alien enemy, that also you need to keep in mind. Minor, not directly, but with the help of guardian. But minor will not be liable for anything. If it's partly paid share also, someone else only should pay, not the minor. Clear? HUFO, possible through Karta. Karta's name will be written. Tawny, Who is a pawnee? Pledgee. So you have taken a loan. Someone has given you a loan. Until you repay, he is considered as a pledgee. The shares you have given as a collateral. Just giving a collateral will not make him a shareholder. Clear? Yes, sir. Okay, next. Insolvent. Can an insolvent become member?
Yes, but no benefit.
He will not have a beneficial rights, but he will have voting rights until the shares are liquidated. Who is an insolvent? A person who loses everything. A liquidator will be appointed. The liquidator will enjoy all the money related rights, but all the voting related rights will still be with the insolvent only. Correct? Okay, next. Society. Yes, sir. They are not considered as a body corporate, but still they can be a shareholder. Fictitious name, liable under 447. Trade union, yes, sir. Identify as a different person. GDR, a GDR holder, can he be a shareholder or not?
Yes, when they converted to
Converted to equity.
GDR holder is a shareholder or not?
yes.
Until conversion, no. After conversion, yes, sir. Oh, okay. People, company. Can a subsidiary company hold shares of its holding company? Can a subsidiary company hold shares of its holding company?
No.
No?
No.
Any exception? One I'll tell. Death. You can hold it as a diseased person. You can hold it.
Previously.
Before you became a subsidiary, you were already holding and as a trustee. Oh. Okay. Next one, people. Register of members, section 88. Tell me, taka, everything tell me.
MGT wants.
Okay, the register of members in the format MGT1. Preference shareholder?
MGT wants.
MGT1 only. Okay. Other security holders? Debenture holders? Register of members is maintained for. Okay, register of members is MGT1. Preference also MGT1. Debenture is MGT2. Other securities also MGT2. Register of members is maintained for how many years? Permanently. MGT2 is maintained for how many years? 8 years from which date?
Redemption.
8 years from the date of redemption. And the next one, within how many days you need to make the entry in the registers? Within 7 days. Can the registers be open for inspection? Can it be open? Can anyone come and inspect? Members can inspect. Debenture holders? Creditors? Any other person?
Yes, but
Fees have to be.
With the fees. You remember one thing I showed you there. Any other person cannot be a random person. We've seen one case law also there. If you remember, I told you something called as what is that? Interpretation of statutes. I think I told you. It says any debenture holder, any member, or any shareholder, and they are written any other person. Ejustim generous. I told you this. I think I had told you, and I told you. Remember that jurisprudence will come. Yes, correct. So any person cannot be a random person going on road. It can be a creditor or any other person whose interest is involved. They can come and check. Can I charge anything for them? For inspection, can I charge? How much I can charge? 50 rupees I can charge.
Not exceeding.
free, sir.
Inspection is free.
Copy, sir. Copy.
Extracts I can take.
Extract it. Yes, sir.
Yes, sir, you can.
Yes, sir. So remember, sir, if it's an outsider, I can take 50 rupees per inspection. If at all it's a member people, they are free. You cannot take anything. If you are only taking an extract, you are only writing, no, how can I charge? For everyone, it's free only. If you're asking for a print, for a member, member. For outsiders, same. Sir, remember, sir, print out, who cares who you are? I have to charge you, not exceeding 10 rupees. Yes, sir. Okay. Tell me about foreign register. What is the register? MGT3 is the?
MGT1 format, sir.
Yes, no, sir. MGT1 is the format. MGT3 is the intimation given to ROC. Within how many days you have to give intimation? 30 days of when?
Opening
opening and Hey, when I discontinue, should I intimate ROC? Discontinuing. First of all, can I discontinue my foreign register?
You can. You can. You can.
Is it mandatory for me to open a foreign register?
No. No.
It's an option, people. It's not an obligation. Whenever you open a foreign register, you need to intimate the details to the ROC in the form MGD3 upon the opening also, closing also. Whenever any entry is made in the foreign register, within how many days you will maintain it in the Indian register? Option 7 days, 15 days, 30 days, 15 days. Okay. Next one, sir. Can I close my registers? Indian registers, can I close it? Can I close my Indian registers anytime? Not permanent. Temporarily, can I close it? I can close it. 45 days in a year. At once?
30 days.
At once, you cannot close it beyond 30 days. Maximum you can close it in a year is 45 days. Should I give any intimation for closure?
7 days.
Which section all this?
91.
91. So should I give intimation? To whom? To the members. How will you give? Newspaper advertisement for all the companies. If you are a listed company, you will give 7 days notice before your closure of registers. If you are a private company, independent individual notices are sufficient. Yes, that's your closure of registers. And who will maintain the registers? Company secretary or any other person authorized by the board. Where should you maintain the registers? Register office of company or any other place. Now imagine I want to maintain my registers within the same city. Is special resolution required?
Yes.
In city. No.
Within the same city. Special resolution is required.
The same city.
In the same city I am shifting it. It was in electronic city, now I am keeping in Koramangala. Required?
Yes, sir.
Oh. Huh?
Special resolution is required.
Required? Special resolution required? Pakkana? Beyond the city? Needed. So, can I pass special resolution and can I keep my registers in, say, for example, Kerala? Can I keep it? So, remember the moment you take it outside the register office, special resolution is mandatory. But if at all you want to take it beyond your registered office or the state, then people, you need to check for the population. You can keep it in that place where more than. Okay, now the question is it more than or exact 1/10? Exactly 1/10 is there. Can I keep it or not?
No, sir. No.
Someone was screaming, tell her.
For the population.
They can keep it, is it?
No, sir. No.
Is it at least or exceeding?
Exceeding.
Exceeding.
More than 1/10.
Gottila sir, I don't know sir, bitpidi sir, bittiting sir.
More than
more than 1/10 ಪಕ್ಕಾನಾ ನೋಡ್ಬಿಟ್ಟೆ ನೀನು ಚಂದ್ರಮೌಳಿ ನೋಡ್ಬಿಟ್ಟೆ ಸರ್ ಬಿಟ್ಬಿಡಿ more than okay people index
50.
people exactly my company has 50 shareholders should I maintain index or not for 50 required or not 50 required or not rethink you might be wrong
51.
exactly 50 index of members required or not
51.
yes people you are wrong less than 50 not required that means 49 50 required yes sir ನಂಗೆ ಅಯ್ಯೋ ಸರ್ ಇವೆಲ್ಲ ಹೇಳಿದ್ರೆ ಹೇಳ್ತೀರಾ authentication any other person authorized by the board notice of closure foreign register we saw everything okay people tell out the taka 89 declaration in respect of beneficial interest in shares this section cut copy paste has been given to LLP also we saw even SB also correct okay register holder of shares people who is not a beneficial owner it's in my name when will 89 come into picture? I am the register holder, but the shares are not in my name. Money was given by someone. On behalf of him, I am operating it. So, sir, the register holder who is not a beneficial owner, I need to come and tell who the beneficial owner is in MGT4. In my name, I am investing, but the ultimate benefits belong to him. I need to give him his details. In the same way, he need to give the company my details in MGT 5. Yes, sir. Whether I gave or him gave, whoever gave, within 30 days, people, I will file of MGT 6. Who? Company has to file to ROC. Yes, sir. Correct? Yes, sir. Okay. MDT 6 ROC. Consequence of no. Consequence of non-filing people. The rights on that shares cannot be enforceable. Penalty is there. Okay. For now, forget. Did I tell any amendments here? In this place?
No, sir.
Any amendment? Hello? Sure. Okay, people, see here, this is one of the amendment, because it is relevant here only, I'm telling you here only. What is the amendment, sir? Okay, so people, this is the amendment, part of your supplement sheet only. What is the amendments here? The MCA, while its notification dated 27th October 2023, has notified the companies which has come into force on date of its publication under Rule 9, Declaration in respect of beneficial interest in shares, Section 89, correct? Now what is that? To designate a responsible person for providing information to the registrar or any authorized officer regarding beneficial interest in the company share. Now the question was, we are telling that the company has to file MGT 6 to the ROC. Now when I say company, who will take the responsibility? People were not taking, officer in default, everyone were there, but the information required we were not getting. So what did they do? They passed an amendment saying, I can't do this, you nominate a person, I will directly question him. Who is that person who will take the in charge of letting me know the beneficial interest? That MGT 6, the company has to intimate, no? Who is that person who will intimate me the details? You let me know who that person is. So you need to tell ROC who will that person be authorized to file this beneficial interest. Who will that be? Obviously, who will that be? So our next one, to designate, okay, second one, options for designating a responsible person, which may include a company secretary. Sir, every company will have company secretary, yeah, may not be. They can also appoint a KMP. Sir, we are KMP, no, other than company secretary, others are there, no, CEO, CFO, even they can be there. Okay, next, or every director, if there is no company secretary or KMP. Sir, what if we have not nominated company secretary also, KMP also? That's all, every director will be the designated person. Correct? Okay, next one. Until a responsible person is designated, certain specified individuals under rules are deemed to have been designated. Sir, now what is that? See here, sub rule 6, can you see? Sub rule 6, this one. Here. Okay. So, ಯಾವುದು ಗುರು ಇದು ಬಿಟ್ಬಿಡೋ ತಪ್ಪಾಯ್ತು ಏನ್ ಗುರು ಓಪನ್ ಆಗುತ್ತೆ okay sub rule 6 you see noda sir now sir first it has to be CS if no CS KMP no every director sir now what if we have not nominated anyone then by default who will that person be they have said until a person is designated the following persons shall be deemed to have been the designated persons by default, whether the company nominated or not. Who is that? First one, company secretary. If the company has a requirement to appoint a company secretary, if a company has company secretary, whether the company has nominated you or not, because in the previous rule, the words used was a company may. If you are there, company has not nominated anyone, you will by default become that person, designated person. It is your duty to intimate everything to ROC. Understood? Sir, but will every company will have? No. Then every MD or manager, in case a company secretary has not been appointed, every MD or manager, managing director or manager, if a company does not have company secretary. Next one, sir, every director, if there is no company secretary or a managing director or a manager, understood? CSO, if no CSO, MD or manager, no CSO, no MD, no manager, then every director. Pakana? Yes, sir. So now the question is, how do I intimate that who this person is? From where do I intimate? How do I intimate? You need to intimate the details of the designated person in a company shall inform the details. Can you say fourth rule? The company shall inform the details of the designated person in the annual return. What is the annual return? MGT 7 or 7A. In that form, you need to write these details. The details about the designated person. Clear? Look at the next one. Further, in case of any change, can we change this, sir? Yes, sir. Should I intimate any form again? Yes, sir. The form is people GNL2. GNL stands for general. There is no specific form. That form will be GNL2. GNL1 and 2 is the form that is filed when there is no other specific form prescribed. Here, hello, amendment. Read and go. Here, I can send this, but just meanwhile take one picture. If you forget, you just have it somewhere. Take it, this one. Online, if you guys can click a picture and send it, please. Done? Yes, sir. So this is the amendment. Any doubts? Okay. So sir, you'll be filing amendment. Okay. Hello, Duro. To okay. Yes, people. Next one is people section 98. Section 90 is people. SBO. What is SBO? Significant beneficial owner. What is the whole purpose of SBO, people? To identify the individual person. When will it come, sir? Imagine there is a company X. Company X is called as reporting company. In company X, if an artificial body is invested the money, what is artificial body? Imagine a LLP. Imagine a body corporate. Imagine a company. Imagine a HUF trust. If these people have invested money, HUF, artificial person only, no. Now we do not want them. We need to know the detail of the individual. Now let us imagine who has invested. A company has invested. How much you have invested? More or less, exacta. Exactly 10%. Is SPO provision applicable?
Yes.
Exact 10.
Exactly 10 applicable.
She will tell and she will confirm with Sanjay. Okay. Yes, people, 10% it is applicable. Yes, 10% of what? Voting rights, capital, voting rights, capital, out of the total dividend, whoever is entitled for 10% of dividend, and the person who has significant influence over the company. If you have any of this, if company, say for example, company A has 10% of voting rights, 10% of capital, is getting 10% of total dividends, or if company A has a significant influence over company X, in such case, people, SPO provision will trigger, start. But we need to find more also. Now I will go and see who is hiding behind company A. Who is hiding?
Individual.
Any individual. Now my question is, how much is this person holding in company A?
He's holding 10%.
If he is holding 10%, should I give his details or not, Matthew? Matthew? No? 20?
Yes.
20 yes, sir. 30? 30 no.
Yeah, yes. Yeah.
40?
Goes beyond.
Beyond 10 I have to give, correct? No people, beyond 50 you need to give. You have to have control.
So 51%.
51%, beyond 51. That's why you need to have 51%. Basically, the company should be in someone's control. So let us imagine in this company A, there are two shareholders. One holding 51, one more holding 49. This 49, we don't need him at all. Act 2. We don't want him. We want हमको ये चाहिए कौन ये understood so his details will intimate in which form then one correct within 30 days of acquiring the beneficial interest and what will the company do
Company
Ben-
When 3.
Ben 2 Ben 3 format ಯಾವ್ದಿದು
Registered holder will.
Ben 2 is the form utilized to file it to the ROC. Ben 3 is the register. Ben 4 is the notice. Company X will give a notice to company A. Hey, you are an artificial person, Oda. Give me your details. Ben 4, if at all they don't give, company X will apply to tribunal. Sir, please, this person is not responding. Freeze his shares. You will have 1 year time, macha. In 1 year, if you do not give sufficient information, tribunal will transfer your shares to IEPF account. Here, pakana. Okay. Okay. Penalty ಬೇಕಾ ಬೇಡ ಸರ್ ಅಯ್ಯೋ ನಮ್ಮ ನೋಡಿ ಒಂದ್ಸರಿ ಕಣ್ಣಲ್ಲಿ ಕಣ್ಣಿಟ್ಟು ನೋಡಿ ಕರೆಕ್ಟ್ ಐ ಆಮ್ ಸೋ ಸಾರಿ ಬೇರೇನಾರು rights of members can be two types of rights one is individual one is collective individual whatever you can enjoy individually collective whatever you can enjoy collectively individual what all you have the right to vote right to get notices right to participate in the decision making dividends all this will cover individual rights what is collective right to call for EGM operation and mismanagement special notices now all these becomes a collective individually you are not doing you are doing everything collectively correct okay next what is veto power
Overriding ability.
veto power is nothing but veto power means veto means I forbid it's a right of being consulted first before doing anything section 180 restriction on power of board they cannot do everything what they want without consulting the shareholders okay next
Majority, it's
okay majority there we'll see in fast versus hard model we'll see in the what is that corporate restructuring this one and we will what is casting vote casting vote
chairman gets
a chairman gets a second vote that's called as second vote also so in the case of equality of votes the chairman of the meeting will always have a casting vote to say the second vote whatever he says will go through and veto power is done second was done shareholders agreement we saw here SHA we saw shareholders preemptive right means what before asking outsiders right shares okay variation of shareholder rights can I vary however I want then first thing to vary you should have a right in MOA or AOA next one issued shares of 3/4 of that class or special resolution should be passed if variation of one shares affect the rights of other security holders even their special resolution should also be taken 10% of issued shares if they have any objection they can go to tribunal tribunal's order will be final remember these four what is that One right to variation should be there in MOA, AOA. 3/4 of issued shares or special resolution of that class whose you want to change. If at all variation of one share has an effect on some other share, you need to take their approval as a special resolution. Whosoever shares are getting affected, if 1/10 of the issued shares of that value, if they go to tribunal, they can go and object the scheme. Whatever tribunal says, that will be final. Clear?
Sir, this debenture holders included in provision. Dividends in the
Okay. Now see,
the preference is dividend is increased. That's the interest of the debenture holder.
how they will get fixed dividend? No, that's not okay with equity. No, you see this also. Correct? Yes, Sam. So what is that, sir? Imagine if I want to alter anything with regards to preference shares. I want to increase their rate of interest or I want to decrease their rate of dividend. It's affecting your right. I need to call you for a meeting and this right should be given to me in my MOA or AOA. If right of variation is not given, I cannot change any right or anything I've given to them. That is what I have to stick. Now, sir, how many people have to agree? First thing, MOA, OA has to authorize. Next one, the total issued shares of that class, meaning preference shares. How many issued shares are there? In that, 3/4 of the issued shares has to agree or pass a special resolution. If they agree, you can change their right. Sir, 3/4 have agreed, but 10% people are objecting. They feel it is not right. They can go to tribunal and object. Sir, if I alter preference shares, the equity shareholders are coming and telling, sir, you are increasing their dividends. The profit availability for us will reduce and we are not okay with it. So if at all alteration of one class affects the other class also, you need to take the approval of equity also now. Now you need to take special resolution here as well. Clear? That's your complete variation of shareholders' rights. Voting rights of members. People, section 72, nomination no. SH, what is the nomination? SH 13. Correct? Yes or no? What is shareholder democracy? That is only veto power and all that. Whatever they say, you have to consult. 180 is the best example. Last one, people, shareholder agreements. What is shareholder agreements? We have done n number of times. Whenever you are raising investments from any new investors, they come with their own terms and conditions. The terms and conditions between the company and them will be written in an agreement called as shareholders agreements. Sir, in a case where shareholder agreements and AOA, there is a conflict. Which one will prevail? There is a Supreme Court judgment, people, which says VB Rangaraj versus VP Gopala Krishnan. In this, they have said, people, if at all there is a conflict between SHA and AOA, AOA shall prevail. And according to Article 141 of Constitution of India, whenever there is a Supreme Court judgment has to be followed by all the lower courts. You can write this as a complete provision. Clear? Yes, sir. Veto power, I forbid. Casting out shareholder. Assignment we'll see in the next. That's a resolution and the shareholder agreement. That's all, huh? Yes, sir. Okay. Can you guys sit for another 1 hour, or you want to go for a lunch and come?
We can take half an hour.
No, I'm saying if before I start the chapter, if you want, because we can't end the chapter in between marathon.
Then we'll take a break.
You'll go for a break and come, huh? Okay, go and come. Huh? How much you want? 10, 15 minutes? 20? He is telling, sir, lunch, sir. 30 minutes, go and come. Okay. We'll do a general meeting first. Yes, people. So, we'll do 13 chapter and then go back. Let us do up the connected chapters. Okay, so general meeting we will. So there are three types of general meetings. One is called as AGM, one is called as EGM, and next one is called as class meetings. The class meeting, whatever we saw, the variation of shareholder rights, that can come as an example here for a particular class. It can be preference alone. In equity, it can be one category alone. Imagine DVR alone. They can come under class meetings. And whenever we are reading general meeting chapter, we need to make sure we also have to follow SS2, Secretarial Standards 2. And where is that given? That you have to mandatorily follow Secretarial Standards 2 when you are conducting your general meetings. Where is that given? It is given under section 118, subsection 10, which says that whenever you are conducting meetings, you need to mandatorily follow your Secretarial Standards. Clear? Yes, sir. So SS2. Okay, sir. The first ones are meetings. Okay, first let us start with the AGM only. Okay, section 96 AGM. Now, what does the law say with regards to AGM? They say, people, whenever you need to conduct, every company, irrespective of who you are, except OPC, has to conduct a general meeting, annual general meeting every year. If it's their first AGM, they need to conduct it within 9 months of closure of financial year. If it is their subsequent general meeting, they need to conduct it within 6 months of closure of financial year. And they have to make sure that the gap between the two meetings, the two annual general meetings, should never be more than 15 months. And of course, remember, whenever there is a scenario where you could not conduct your AGM on time, you always have an option for extension. You can ask for one-time extension with ROC. You will be granted a 3 months extension. That is not available for the first AGM. It is only available for the subsequent AGM and onwards. Sir, once I claim it, can I not further claim it? For that year, once you will get it. But next year, you can again claim it. That's absolutely fine. And with regards to AGM, you cannot conduct your AGM on when?
National holiday.
National holiday. And what are the national holidays, sir? Only 3 days. Republic Day, Independence Day, Gandhi Jayanti. And you can conduct your AGM on Sundays, Saturdays, public holidays. Every day you can conduct it. Sir, that's about your AGM. And where should I conduct the AGM, sir? You can conduct the AGM at the registered office of the company. That's your first by default place. Sir, if I'm not able to conduct at the registered office, you can conduct it in the same city, town or village. So it has to be within the same city, town or village. The example is your Christ College. They conduct their Infosys conduct their AGM in Christ College campus. So that's a possibility. It's allowed. Sir, if you are an unlisted company, then you can conduct it anywhere in India with the prior consent of all the members. If you are top 100 listed companies, you need to conduct your AGM within 5 months of the closure of financial year. Agreed? Yes, sir. Okay. Sir, if at all you are a listed company, people, you need to file something called as report of AGM. You need to file it with the ROC, section 121. What is this report of AGM, people? It's a summary of whether you conducted your AGM in time or not. That is, you are within 5 months or not in MGT 15. So, sir, report of AGM. It is applicable only for the listed companies and not everyone. Yes, sir. Okay. Date, national, okay. It has to be within 9 to 6 p.m. It has to be between that. Gap extension, okay, when at least once every mandatory. Okay. With regards to OPC, people, this is not required. Why? In the case of OPC, you can directly enter it in your minutes of the meeting, more than sufficient. Which section says so? Section 122 says that a OPC need not conduct general meeting. It is fair enough. You just open your minutes of the meeting, enter whatever you want to discuss. That itself will be considered as the resolution, and that is sufficient. You need not conduct another meeting as such. Correct? This was your AGM. Next one, sir, EGM. a company can conduct EGM people technically in 4 ways. And how is that? First one, people so moto. Whenever the directors feel in between AGMs they still have something more to discuss, they will call for an extraordinary general meeting. And EGM can be called by the board of directors on their own whenever they want to do it. If a company is a wholly owned subsidiary of a owned of company of foreign company, EGM can be held even outside India. This is good. Remember. Next one, sir. A EGM can be conducted by the board upon the requisition made by the shareholders. What do you mean by requisition, sir? Requisition is nothing but the particular request. It's a particular number of shareholders. They have to make a request. They feel they have something to discuss. They will ask the company to conduct a EGM. That is called as requisition conducted meeting. So how will that happen? The shareholders will give their request to the company. The company has to take steps to conduct the meeting. Within 21 days, you have to take steps. Within 45 days, you need to convene the meeting. What if they did not conduct people? Then within 3 months, whoever made the request, they can only conduct the meeting. But sir, how many people can make the request? It depends upon whether the company has share capital or doesn't have a share capital. Company having share capital, members holding 1/10 of the total paid up share capital. If they make a request, then yes, you can conduct a requisition meeting. Next one is not having share capital, 1/10 of the total voting power. So if they make a request, then you can go for a EGM. Sir, what if even after the request, if the company did not conduct the EGM, then within 3 months from the date of request, the shareholders themselves can conduct the meeting, provided the expenses has to be reimbursed by the company. Technically, that company also, why should they pay? That money will be deducted from the remuneration of the directors. Sir, and whenever I'm telling you, you can conduct it by yourself. How will you conduct? Even you don't have any details. So remember, whenever the company, the directors itself are conducting, they need to get the record of your registers, quorums, proxies. All this should be handed over to those requisionists, and they will conduct the meeting accordingly. Correct? Sir, whenever in a meeting, within half an hour, if the shareholders are not present, what will happen to the meeting? Adjournment. Correct, sir, but what if it is a requisitioned meeting? If at all within the 30 minutes, if the shareholders are not present, the meeting shall be cancelled. Agreed? Yes, sir. And adjournment will happen automatically to when? Next week, same time, same place. Unless until something else is decided. And that's about adjournment. Adjournment, people, whenever a duly conducted meeting, does chairman has a power to postpone a duly present meeting?
Yes, sir.
If quorum is present,
If quorum is present,
He cannot.
he cannot.
he can, he cannot.
He can.
He cannot.
He can.
He has the right to.
When a quorum is present, can the chairman postpone the meeting?
No,
Consent
sir.
of him.
But arbitrarily possible?
Yes,
The meeting cannot be done.
No,
With the
no,
approval
sir.
of members,
Arbitrarily
it is
possible, sir.
not,
You will not see.
if the meeting is not able to conduct, help approval of
Arbitrarily? Without asking, can I postpone?
Yes.
Not possible.
No, sir. Generally,
Do Anant, marathon came da. When will you study company law? Huh?
but in general, it will be happening.
In general, it will be happening. So you cannot do it. You cannot postpone a duly conducted meeting. If a quorum is present, you cannot postpone the meeting unless there is any situation arises which makes the conducting of a meeting impossible. Then yes, you can do it. If not, arbitrarily not possible.
Like, is it possible if all the agendas on the meeting is not completed? That can.
Yes, possible. Yes, that's fine. Yes, sir. Okay. And next one, sir. Adjournment of a meeting, people. Should I give a fresh notice again for a adjourned meeting?
If it is within a week, then no.
Within a week, then not required.
Within 30 days, there is no need.
Within 30 days, no need.
If Meeting is to be conducted in
If the meeting is to be conducted within 30 days, then no need of a specific adjournment notice to be given. Yes, people, if at all a meeting is conducted within 30 days or next week also, you need to give minimum 3 days notice. If it is more than 30 days, people, you need to conduct the provision fresh. Okay, now next. Whenever resolution is passed in an adjourned meeting, what will be the date of resolution? Is it the actual date of the meeting or the adjourned date of the meeting? Because you need to file MGT 14, PS3 and all within 30 days. The 30 days is from when? Is it adjourned meeting or the original meeting? Adjourned meeting, huh? Oh, yeah. Yes, it's always from the date of the adjourned meeting. Okay. So that's about your adjourned meeting, huh? If a proxy is given for the original meeting, is the proxy valid for the adjourned meeting also? Or should I should I freshly appoint a proxy again for the adjourned meeting? Is the proxy given for the initial meeting valid for the adjourned meeting? ಏನು ಒಂದು ಹೇಳ್ರೋ
It's not valid.
Not valid. Not valid.
No, sir.
Okay, yes, people. So whenever there is an adjournment of a meeting, the proxy will be valid even for the adjourned meeting as well. Why? Adjourned meeting is a continuation of the original meeting. So whatever was there will continue. Yes, you are all right.
Cancel meeting.
Clear? Yes, okay. That's your EGM. Next type of meeting, sir. Requisitioners themselves. Next one is by tribunal. Either so moto or an application made by the director or member, you can conduct for a tribunal conducted general meeting. So, in that, what is section 97? Tribunal conduct AGM. 98?
EGM.
What is 97?
Conducted AGM.
97 is tribunal?
Tribunal conducted AGM.
EGM, AGM? AGM. 97. 98?
EGM.
99?
Penalty.
It is a ನೋಡಿ ಹೇಳ್ತೀನಿ.
Penalty.
What is the penalty? That I didn't write, sir.
25.
Huh?
The company 1 lakh.
Up to 1 lakh, huh? Up to 1 lakh, huh?
25,000.
5,000 per day.
1,000 per day.
Up to?
Up to 1 lakh maximum.
Extend 1 lakh.
Maximum 1 lakh.
Huh?
maximum 1 lakh.
ಏನು ಹಂಗೆ
Maximum.
ಮ್ಯಾಕ್ಸಿಮಮ್ 5 lakh. ಇನ್ನೊಂದು ಬಂತು. ನೆಕ್ಸ್ಟ್ you only wrote that. She is asking what did you write. You only wrote 1 lakh. Nandan is saying, sir, confidence, sir. 1 lakh, sir.
Every company.
ನಂದನು ಎಲ್ಗೋದ್ಯಾ?
It's for both of them. Both of them. It is for both of them, sir.
Minimum.
It's for both of them. Both the company and the office director.
Ananta, what do you think?
Maximum 1 lakh, sir.
Maximum 1 lakh, sir. Most of the people said 1 lakh. No, sir, even I also say 1 lakh only. Not important as such, but whenever there is a common penalty which defines more than one, that try to remember. If not, I'll not stress on remembering your penalties. Yes, sir. More than more than okay, see here. If any default is made in holding order 96, 97, 98 and directors with any direction of the tribunal and every officer of the company who is in default should be punishable with fine which may extend to 1 lakh, and in the case of continuing default with a further fine which may extend to 5,000 rupees for every day during which the default continues. ಏನದರ ಅರ್ಥ?
Company.
इसका परमार्थ क्या है? Where is maximum returned? Then 5,000 rupees per day until you conduct Correct, huh?
Sir, you repeat that point.
Which one? Look at the last one. Who is in default shall be punishable with fine which may extend to 1 lakh rupees. Punishment 1 lakh rupees it may extend. And so you made a default. That day 1 lakh penalty I can impose. Up to 1 lakh I can impose. And in case of continuing default, 1 day, 2 days, 3 days, 10 days I didn't conduct. With a further fine which may extend to 5,000 rupees for every day during which such default continues. 1 lakh is there. In addition, 5,000 rupees, it can keep on going. Clear? Ananta? Okay. Clear? Okay. By tribunal conduct meeting is 98 and 97. Power to call for AGM. In tribunal conducted meeting, they can say that the quorum can be even one person. It can be person personally present or even proxy can also be considered as quorum. Agreed? Okay. The next one, sir, is your notice of general meeting. A company to call a general meeting, people should give minimum 21 days clear notice. It can be by post. It can, if it is by post, it is add another 48 hours to it, and it is always clear days. The day of giving the notice and the date of the meeting should not be considered. Okay. And next ones are person entitled to receive the notice who and all. Every member. Preference shareholder also? Yes, sir. And debenture holders? We'll give it to debenture trustee. Directors we will give? Directors? Directors will give? Here sir, note biಡ್ತೀವಿ. Directors also will give. Without them, how will you conduct general meeting? Only shareholders will come and do what? They'll pay goli? They should do something. No? Someone has to talk to them. Huh? ಇವನೇನೋ ಜೋಕ್ ಹೇಳ್ದ ಆ ಜೋಕ್ ಅರ್ಥ ಆಗಲ್ಲ ಇಲ್ಲ. Okay. Yes, people. So it is directors, auditors. What if auditors is not in a position to attend the meeting? We can send someone else also, provided they should be from the same profession possible. Okay. Next one, people. In case of Nidhi company, notices to be served individually on members holding shares more than 1,000 in face value or holding more than 1% of paid up share capital, which is less. More than 1,000, more than 1%, whichever is less, they will be entitled for a individual notice. Rest all people, newspaper. Clear up, and it can be even published on the notice board of the Nidhi company. Allowed. Okay. Next one, sir. Shorter notice people possible. How? In the case of AGM, in the case of EGM, how is in the case of AGM? How is it? 95% of paid up share capital, voting rights, number of members,
Voting rate.
or it says majority in number and 95%.
That is for some other time. The voting rate, sir.
ಅಯ್ಯೋ ಕಡவுளே what am I doing okay, now tell me what if it's for AGM? Can you connect in can a AGM be connected in shorter notice? AGM
Yes, sir.
AGM
Yes, sir.
possible how 95% ಇವಾಗ ಹೇಳಿ voting power
Voting power.
Yes, sir. What if it's the other general meeting? Majority number ಆಮೇಲೆ ಹೇಳ್ದ ಅನಂತ if company has share capital, voting rights or capital? ಆಯ್ತು 95% capital doesn't have capital, then no voting power. Correct? Okay. Next one, people. Explanatory statement mandatory. Explanatory statement is mandatory only. No. For special business, it is mandatory. What is special and ordinary? Whatever is appointment of auditors, appointment of directors, declaration of dividend, adoption of accounts is considered as Ordinary business. This has to be mandatorily discussed in AGM only. Anything other than these four is by default considered as special business. For this, explanatory statement is mandatory. In explanatory statement, technically what will we give? We'll be giving them the details. Imagine a shareholder is coming for a meeting and we are going to discuss a resolution. He needs to be completely aware of what we are going to discuss before he says yes or no. For that, whatever is required, we are going to give it in the explanatory statement. It can be like, if at all we are going to say yes in this resolution, our directors might be benefited because it is his company also. So details like this will be disclosed. And in addition to that, what is the pros and cons of this decision will also be disclosed in the explanatory statement. Correct? What if we do not disclose everything in the explanatory statement, people? Any benefit derived should be returned back to the company by the person who took or who derived the benefits. Agreed? Yes, sir. Over audio business, what to disclose? So you'll be disclosing director, nature of concern or interest of every director, KMP, relatives of KMP and directors. Imagine in the resolution, whatever we're discussing. Imagine a director's wife is to be appointed as a CS. It comes here, no? So I'll be benefited out of it. I need to disclose that. Sir, an indirect. If business relates to any other company, we are going to enter into a meeting with other company. We are going to enter into a probably contract with other company. In my company, this person does not have any interest. But in that company, my directors have interest. I need to disclose that. Provided the shareholding is not less than 2% of the paid up share capital. I need to say this person will be benefited if we enter into a contract with that other company because he has a shareholding in that other company. Clear? Yes, sir. Okay. That is explanatory statement 102. What is 103? Quorum. What is the quorum?
2 is also 2 is sufficient.
2 is sufficient, or 1/3 or 2, whichever is less. 2 only,
Personally present.
Personally present. 2, okay, private company 2. What is the
Public company depends on number of members.
up to 1000?
15 members, 3
Up to 1000, less than 1000.
Sir, up to 1,000.
Up to 1,000.
Even 1000 also included.
Comes under next lab. No.
ಅಲ್ಲಿಂದಾನೆ ನೋ ಹೇಳ್ಬಿಟ್ರು.
5 members personally present.
ಅಪ್ ಟು 1000, 1000ಗೆ 1000 and less 1001
Sir, 1,001.
next lab.
Sir, 1,001 to 5,000, 15 personally.
Okay, 5 is up to 1000, 1001 to 5000 is 15, 5001 and above will be 30 personally present. Yes, sir. That is your quorum. Okay, quorum should be present throughout the meeting. Correct only, no? Interested people cannot participate. That is what we'll see in related party transactions. Exception is private company, but other companies, if at all you are a related party, you cannot participate. You need to tell that you need to walk out, and for that you will not be counted for the purpose of quorum. Correct? Okay. And a quorum should always be present throughout the meeting. Next one. Proxy is not counted for the purpose of quorum. And whenever there is a governor or president of India, 112 and 13, if they are appointing someone else on behalf of them to attend the meetings, they will be considered as authorized representatives and not as proxies and hence counted in the purpose of quorum. That is 103. What is 104? Chairman of a meeting. It can be decided by the company by its articles or whoever. Every meeting you can nominate one amongst yourself as a chairman of the meeting. Next. If the chairman is absent, the board of directors will nominate one amongst themselves as a chairman. What if directors also absent? The members will appoint one amongst themselves as a chairman of the meeting. In the case of equality of votes, there will be casting out. That is 104. 105, proxy. A proxy cannot speak. A proxy cannot vote on show of hands. A proxy cannot do something else also. What? Cannot speak in the meeting. He can only vote by poll. He can demand poll. He can vote by poll. And in case of multiple proxies, by when should I deposit my proxy form? 48 hours. My article says it can be deposited before 72 hours. Is it valid? Sanjay? Sujay? Article says that for a proxy to be valid, you have to deposit 72 hours prior. Is it valid or not?
No.
Entrenchment.
Cannot.
So article's provision cannot be entrenched. It has to be 48 hours only. Proxy form
MGT.
11.
Yes.
11 or 13.
MGT 11. Proxy form has to be deposited 48 hours prior and it has to be dated, it has to be signed. What if there are more than 2 people nominated? Whichever is later will be valid. Visuals can be deceiving after lunch. So whichever is later will be valid, provided it has to be given 48 hours prior to the meeting. But a proxy can vote on poll, a proxy can demand for a poll. But if at all it is a tribunal conducted meeting and if tribunal has passed an order, then people, even a proxy can also be considered as a quorum. Clear up? Yes, sir.
One proxy cannot.
What is the maximum of one proxy can represent? How many votes can he represent?
50 members.
50 members. Voting
10%.
not exceeding 10. Yes, sir. Not exceeding 10. But can one shareholder holding more than 10 appoint one person as a proxy?
It can be only.
Then in such cases, you cannot appoint anyone else as, you cannot represent anyone else as proxy. You can only represent one person in case if you are representing a person holding more than 10% as of voting power. Yes, sir. That was your proxy. Yes, sir.
Yes, sir.
Yes, sir. Okay. Anything else in proxy?
Proxy can.
That's all, no? Covered everything, no? 112, 113, okay. Huh?
So there's a question that asks, can AGM be conducted outside India?
No.
It's a subsidiary of wholly owned subsidiary of a foreign company.
If it's a wholly owned subsidiary of a foreign company, then a AGM cannot be conducted outside India.
EGM can be.
Why did you write that? With a foreign company, it's a EGM can be conducted. AGM should be in India only.
So for the government company, of the government, EG, they can conduct anywhere.
Correct.
Outside India.
Yes, if it's a central, if it's a government company with the prior approval of government, it can be conducted anywhere. That's there. Correct. Clear up? Yes, sir. Okay, that's your proxy. That's your quorum. 105, 106. What is 106? Restriction on voting power. What is 106? Can you restrict a voting power of any person?
Yes, sir.
If it's silent in articles, can I restrict?
No.
It's silent.
So should it be given in articles?
Yes, sir.
It should be given in articles. It should be given.
Yes, sir.
On what and all grounds they can restrict the voting power?
Didn't pay the call money.
If he has not paid the call money, or what if he has not paid some loan? Can I restrict the voting right? It's a ICSI bank. I have taken loan. I have not repaid the loan. I am a shareholder also. Can ICSI bank restrict my voting rights?
No.
Insolvent, okay. I am not repaid. Genuine missing of EMI. Can they restrict my voting rights?
No.
Yes or no?
Yes, no.
Yes, people. They can restrict the voting rights. Gottalla? Tom. Hey, you can't restrict them. Any other lien, any other way the money is due to the company, calls. No other way, no other purpose you can't restrict. But this, yes, possible. Provided it is authorized by your articles of association. 106. Okay, 107. Voting by show of hands. By default, everything will be by default be conducted by show of hands unless a poll is demanded in the meeting. That's your voting by show of hands. Okay. And one person is equal to one vote in the case of voting by show of hands. Next one is people e-voting, poll and postal ballot. What is e-voting, people? When is e-voting required?
When the members are unable to attend it offline.
In the case of listed companies and a company having 1,000 or more members, 1,000 or more. So 1,000 you need to give a mandatory e-voting. Okay. Non-applicability. When will the e-voting start? When will the e-voting end? How many days the minimum e-voting should be open for? I think it is 7 days. Correct, 7 days, no?
3 days.
3 days, 5 days,
4 days.
4 days.
2 days.
How many days? 2 days. So people remember, e-voting should be open for a minimum period of 3 days. It has to mandatorily close 5 p.m. before the date of the meeting. If today is the meeting, yesterday at 5 o'clock you need to close down your e-voting. Clear? Hey, kebab.
Come away.
You're awake. Non-applicability. Nidhi company not applicable. Institutional investors this is not applicable. Okay. Notice of meeting can be sent directly website, newspaper, advertisement. Okay. Contents of notice you can clearly give login ID, password, time. Where is it? Shall be open minimum for 3 days at 5 p.m. on the day preceding the date of the meeting. And you need to appoint a scrutinizer. Scrutinizer is basically, it should always be a professional only. No, Ananta, what do you think? No, people. It is not always a professional. It can be any other person who is not an employee of the company. Yes, sir. It can be CA, CS, CMA, advocate in practice, or anyone in the employment. Possible questions. He gets the access to all the details, scrutinizer's report, proxy forms, register of members, everything. And accordingly, he will he will give a scrutinizer's report. In the class, we had seen the scrutinizer's report also. They will say after the end, how many votes in favor, how many discarded. Remember, Scrutinizer to be prepared not later than 3 days of the conclusion of the meeting. You should conduct it within 3 days of the conclusion of the meeting. Result to be posted on company's website, agency, whoever gave the scrutinizer's thing, on that website as well as on the stock exchange. Clear? Okay, that is your e-voting. Next one, people, is okay, drill of poll only. What is poll, people? What is poll? Poll. Can a resolution passed by e-voting, can it be revised? Can it be taken back? E-voting. Can a poll be taken back? A poll is always conducted by demand or chairman feels. Now whenever I have demanded, can I take it back?
Yes, sir.
Possible. Now I know, sir. It's a poll can be withdrawn. Who should withdraw the poll? Is it all the people?
The one who made it.
Only the people who made it? Okay. Chairman of on his own can go for a poll. Who can demand? It can be chairman, or it can be made by a company, by chairman on demand made by company having share capital. Any member or proxy holding 1/10 of the total voting power or rupees 5 lakh or more paid up. Such people can demand for a poll. Whichever is less, nothing is there. It can be 1/10 or 5 lakh or more paid up capital. In any other company, any member or proxy holding 1/10 of the total voting power. Correct? They can demand. When can I demand for a poll after the resolutions are already decided? Answer is yes. Even after the show of hands result, you can demand for a poll. Poll can be withdrawn by the people who made it. Again, scrutinizer, everything will come as it is. Poll to be taken forthwith. If it is adjournment, again this is also important. What, sir? Whenever you need to conduct a poll has to be conducted immediately in 2 cases. If it is for adjournment or if it is for deciding the chairman of the meeting. In any other case, the poll has to be taken within 48 hours of the demand of making the meeting. Basically, within the 48 hours of you making a demand, the poll has to be taken. Okay. Polling paper shall be in the format MGT 12. Scrutinizer shall count and report in the format MGT 13. Yes, the report will be submitted to the chairman within 7 days of the taking of the poll. Clear? Yes, sir. Okay, done. Next one, sir. Postal ballot. What is the postal ballot? 110. Is it mandatory? So in some cases, based upon the resolution, postal ballot is mandatory. One we already saw, shifting of registered office beyond the city, mandatory. Object clause, mandatory. So wherever it is clearly written, you need to pass that resolution by postal ballot only. What is a postal ballot? Earlier, they used to give on a postal card with the resolution, with the 2 tick marks to be put. A box was there, yes or no. If you say yes, yes. If you say no, no. Postal ballot has to be repaid within 30 days from the day you receive, from the day the notice is sent. 30 days you need to reply for the postal ballot. If at all you send it beyond people, that vote will be considered as invalid. Correct? Hello. Okay. Postal ballot can't be used for following business. Which business, sir? Ordinary business and all the business where the auditors and the directors have the right to be heard. Which are the meetings where they have right to be heard? Section 115, special notice, wherever they are being removed. Correct, no? Exemption of postal ballot, it is not applicable for OPC and any company having up to 200 members. So technically for whom are they telling?
Private companies.
For both. Public also can have, no? Okay. Following items shall be discussed only in postal ballot. What is that? They've given you a big list. Buyback. This is better you see it from all the respective places and you need to remember that. Correct? But try to remember. If they ask it, you should be able to remember it. Clear? Buyback. All these things will come. Small shareholder. Shifting of register office. Object clause. Alteration of your MOAs. Everything will come. Correct? DVR. Gills provision. Correct. Sale of undertaking. Section 180 subsection 1. Scrutinizer's report, same thing. CACS, they only will come. He shall submit the report not later than 7 days. Results to be declared on the website along with the scrutinizer's report. That is section 110. What is 111? Circulation of members' resolution. A company is already conducting a meeting. Can't I add my resolution also to that? Possible. You give a request, we will see. Sir, now how many people should give? How should I give? Meaning, member, okay. Who can propose, sir? Same as EGM. Whatever limits we saw in EGM. Having share capital, not having share capital. 1/10 of the voting power, 1/10 of the capital. Now these people have to make the request. If valid people, you can conduct your, you can add your resolution to the meeting already, which is being decided by the company. Okay, it has to be signed by all the members. Sufficient money should be deposited for meeting the circulation expenses. It can be newspaper, etc. Time limit, people. Requisition requiring notice of resolution. You need to give it at least 6 weeks before the meeting. Meaning, if there is any request for which you need to give a notice, then you need to give that information at least 6 weeks prior. In any other case, people, you need to give at least 2 weeks prior. Correct? So 6 weeks prior and 2 weeks prior. After depositing, if AGM is called before 6 weeks, so you told me to give the notice at least 6 weeks prior, but I gave it. They conducted the meeting next 2 weeks only. It will be considered as deemed to be valid. Correct? Okay. Company shall not circulate the resolution if central government on an application made feels that rights are being abused to secure needless publicity. Correct? Now Matthew will say, sir, I want my profile to be read in the company's AGM. Needless publicity. So if that is what, if they think, any other person. Yes, sir. Clear? So central government can say, you need not have to forward it, do not take it up. Clear? Okay, done. Next one, people, section 112, 13, 14, done na? 112, 113 was body corporator and governor and president of India. What is 114? 114. 114, other sir, lunch time now, hogitu. What is 114? Ordinary resolution or special resolution. When you look at something as special resolution.
Other than ordinary.
Other than ordinary.
Ordinary resolution is up to
Public company, private company.
it is more than 51%.
मेरा सोल मेरा बॉडी छोड़ के ऐसा चले गया वो. हाँ, yes sir. हाँ.
Ordinary resolution is where
Simple majority. What is special law?
more than 75%. More than 75%.
The number of people voting for the resolution should be at least 3 times the people voting against the resolution. Ing bariyadu matte sir illa sir that person did not do fair valuation another. Same words to be written. Okay now. Hey, he's at least talking the kababu. Sir? Hey, sir? Okay. Okay, section 115. What is section 115? Da? Special notice. Some things, people, for taking this decision, you need to give a special notice. Technically, when will this happen? When it is required to appoint an auditor other than a retiring auditor. Sir, we don't want him, sir. Or retiring auditor not to be reappointed. Sir, do not extend his tenure. We want someone else there. Or, sir, to remove the director before the expiry of his tenure or appoint another director in the place of the removed director. We don't want them, sir. So, removal of auditor or director and appointing someone else in their position. The shareholders will ask for a special notice. So, special notice should be signed by the members individually or collectively holding minimum 1% of the total voting power, or shares on which minimum 5 lakh is paid up. Whichever is less or higher, nothing is there. Clear? Pakana exam ಅಲ್ಲಿ this and all ಗೊತ್ತಲ್ವಾ? ಇಲ್ಲ? Okay. Sending notice to the company. By when should I send, sir? Not earlier than 3 months, sir. Not later than 14 days, sir. Meaning, if the date of the meeting is 30th of September, you can't give it more than 3 months prior. That is 30th August, 30th July, say 30th June. You cannot give it before 30th June. But you have to at least give 14 days before. That is by at least say 16th of September. At least before 16th of September, but not before 30th of June. You have to give your special notice. So these people will write one letter, love letter. Sir, you are lovingly. We don't want this auditor or director to be reappointed or appointed. And they will give this request. Understood? Pakkana? Okay. Company to give notice to other members. Individually try, if possible, at least 7 days before the meeting. If not possible, what will you do? Give it in the newspaper. Valid. इल्ली एक ये बटन ये रिमोट है, इसको हम ऐसा ऑपरेट कर सकते हैं.
It's warm.
It's warm, huh?
Yes, sir.
Till I will increase it.
No, sir. You have to.
Other decrease. I'm taking class. Thank you, da. Thank you for this recognition. I will cherish this throughout my life. Yes, sir. And everything is clear days. Agreed? Yes, sir. Virtual meetings nimgilla. Procedure for you had a virtual meetings and all. Ide Vishnu. Virtual meeting. What is virtual meeting, people? Online meeting. So there you will see that software advantage and all. What is the advantage? Brief requirement to conduct a virtual meeting. What and all you want? Laptop, speaker, printer, kushka. Coffee, tea, water bottle, printouts. Yes, okay. Advantages, you can conduct more than one meeting you can attend more than one meeting in the same day if at all conducted. Cost saving, environment friendly. Ella gottalla nimge BCom. You can write off. Difficulties in holding virtual meeting. Online, audible, visible. Correct? Internet issues. We cannot have the OS supporting everyone. If at all I am conducting, I have to give an option today even for Android and Apple. Not everyone will eat kushka. Okay. Procedure for video conferencing. So how will the people, okay, one question, a person is attending a virtual meeting from outside India. What is the procedures you will follow in such meetings?
You have to give a declaration that no one is around you.
Okay, the person there should give a declaration that no one is present around him or her. Differently abled person can take support allowed. Okay, and how do I sign my attend? He has to tell where he is attending from. Okay. How do I sign the attendance register? A person authorized by the chairman or a CS can sign that particular attendance register. These are all important questions. They will ask you. Yes.
Could you please repeat?
ನಿನ್ ಕುಷ್ಕಾ ಜೋಕ್ ಅಲ್ಲಿ ಅದೇ ಕುಷ್ಕಾ ಜೋಕ್. Yes, sir. So if at all a person is not able to sign the register, how do you sign it? A person on behalf of him, a CS or any other person authorized by the chairman will sign on behalf of the person who is not attending the meeting. It will be considered as a valid vote. Okay, and roll call. A chairman will take a roll call. You need to tell whatever you said. You need to introduce yourself from where you are attending and all that aspects. Clear? Yes, sir. People, and tell me one thing: is video conferencing optional or mandatory on the part of the company?
Mandatory.
Mandatory.
Mandatory. You can't do audio with this.
Allah Guru.
I know.
Okay. Okay, video conferencing is mandatory. Yeah.
Mandatory.
Okay, people. Now my question is, people. Audio visual means a director. One director is asking, I want to attend the meeting through AV means. One director is asking.
The board permits.
Now my question is it mandatory for the company to provide audio visual or video conference
Yes,
facility? Only one director asks for it.
Yes, sir.
Is it mandatory
Even the
or is it optional on the part of the company?
mandatory.
Every company shall tell in the notice of the meeting an option available for the director to attend the meeting either personally or through video conferencing. Shall. Sir, now should I intimate that I am attending the video conferencing for every meeting? Should I intimate once in a year? So if you attend, Vishnu, full. If you inform in the beginning of the year, it is valid for throughout the year. Correct? They can ask you that and this roll call. Important, remember and go. I don't think anything else they'll ask here. Here, hello. Akana. That is another. Okay, what is the 117 to 116 we saw? That is your adjourned meeting. On the date of the adjourned meeting will be considered as the date of the resolution. What is 117?
Agreement.
Resolutions or agreements, whichever you pass a special resolution or wherever you are taking the approval of directors using 179 power of board, all this has to be intimated to ROC in form MGT 14. That was 117. What is 118? Minutes of the meeting. What are the rules with regards to minutes of the meeting? You have to conduct minutes for every meeting, different minutes for each type of meeting. And if at all it is in loosely held form, you need to bind it periodically, not more than at least 3 years once. And every page has to be initial, last page at least has to be signed. And it has to be continuously numbered. And the meeting should clearly capture the place, the date, the number of people present. And minutes of the meeting will always be in the past tense. And once entered, the minutes cannot be tampered, altered, mutilated, torn. Can a chairman arbitrarily exclude anything from the minutes? Arbitrarily?
Yes, if it is not in accordance with the.
Kebab bante! Kuska became kebab. Bol ba.
If it's not in accordance with the agenda,
हाँ.
or if it's derogatory in nature.
हाँ.
Derogatory in nature.
Yes?
Or if it is against, if it is defaming the company.
If at all it is
Defaming the company.
Yeah.
defamatory,
To the company.
detrimental to the interest of the company, and anything which is irrelevant, immaterial, can be excluded arbitrarily by the chairman. Possible. Here are possible question from exam point of view. Okay. What else? 121 reporter, 122 is your OPC. They need not conduct a meeting, but if it's a board, if at all more than one director, then meeting has to be conducted mandatory. Remember, important. Clear? Correct? Okay. That was your general meeting. Yes, sir. Here and here, bro. Yen Guru? Did you get you? DJ na? DJ na? तो नीनो निन जोक्स होगा मेरा दिमाग को किरकिरी करता है तो okay people your favorite chapter people chapter 6 yes people the debentures and deposits. I said it's okay, why should we do marathon for this? You said sir we can manage. I said I will also do that. I said no sir, we know everything line by line. Correct, no? Okay. So debentures people, yes. I think in the initial they have given what is long-term debt to short-term debt, what are different types of debentures, secured, convertible, non-convertible. I hope those things are manageable. We'll directly go to the debentures part. But initially they would have given you what is the power of directors to borrow. Ultra-wires transaction all is there. Restrictions on power of board can come. What is the maximum our directors can borrow without the special resolution? Paid up share capital plus free reserves plus securities premium according to section 181C. Correct? That is the maximum aggregate of paid up share capital, free reserve, securities premium. Anything beyond this, old plus new, that is existing plus proposed, should be after passing your special resolution. If it is beyond that, agreed? Okay. Yes, people. First deposits. First only deposits. First we'll do debenture, no? Huh? Okay, small debentures. Will okay, debenture people, tell me people. Section 71. Can a debenture have voting rights? Can a company allot debentures with voting rights? Is it allowed? Good till after. No people, a debenture can never carry a voting right. Not possible. Okay. And you tell me, should the debenture, okay, should a company appoint a debenture trustee? Is it required?
Yes, sir. If it is process
What is that limit?
500,
More than 500 or up to 500?
if it reaches 500,
Reaches, meaning the moment it is 500 or beyond 500. Sir, ಗೊತ್ತಾಯ್ತಲ್ಲ yes sir.
public notice is given.
Public notice is given. Basically, if you are going for a prospectus, public offer, or wherever it is a secured debenture, or wherever it is for the number of people, we saw one case law also. Correct? Tell me number 500. Matthew is trying to search the answer. ಇಲ್ಲಿ ಬರುತ್ತೀರೋ? We didn't write that 500 thing. We saw it in the book.
Debenture trustee.
Okay, we'll see the debenture trustee provision only. Okay. Yes, people. And when should you appoint a debenture trustee? Before allotment or prior to allotment? You need to appoint the debentures before debenture. You need to appoint the debenture trustee before you issue prospectus. You need to enter into a debenture trust deed within 60 days of allotment. You need to enter into a debenture trust deed. Correct? Okay. Whenever you are doing a debentures, you need to create two types of funds or accounts. What are two types of funds or accounts called as? DRR. One is called as DRR. Next one is called as DRF. What is DRR? Debenture Redemption Reserve. Law says people wonder what happened. The company wants to utilize the debenture redemption reserve fund to declare dividends. Can they utilize it? DRR account. Can we utilize it to declare dividend? Buyback. This is only called as statutory reserves. Yes, sir. The amount available for the purpose of distribution as dividends, the profits, from that you need to create something called as DRR. How much will you create a DRR? 15% or 10?
10%.
10 or 15?
10%.
DRR is 10. DRF is 15. When will you create DRR? How much will you create DRR? By when should I create? By 30th of April of previous year. I need to create DRR, no? Yes or no?
Here they are going to redeem.
By when should I create DRR? This 10%. 30th April only, no?
31st March.
By when? People, it has to be created every year, people. It is 30th April is DRF. DRR is a 10% on what will you create? DRR 10% on what?
Total
Of total debentures? Total outstanding debentures you will create a DRR. Total outstanding debentures. DRR 10%. DRF will be created on 15% of the debentures maturing during the year. You need to create it as a fund and you need to create that by 30th April of that year. So whatever the debentures that is going to mature in the next year by 31st March, imagine by 31st March 2025, there are some debentures that is going to mature I need to create that by 30th April 2024. 15%. Correct? And who need to create DRR? Only one person had to create DRR is what I think. What do you think? Two people have to create DRR. Only one only. Who? Bottom person, sir. ಈ ಬರೀರೋ ಅಂದ್ರೆ ಬಾಟಮ್ ನನ್ನನ್ನು ಹೂ ಶುಡ್ ಕ್ರಿಯೇಟ್ ಸರ್ ನಾನಂತೂ ಅಲ್ಲ ಸರ್ ಎನಿವನ್ ಎಲ್ಸ್ ಕ್ಯಾನ್ ಕ್ರಿಯೇಟ್
Unlisted company.
ಅದರ್ ಅನ್ಲಿಸ್ಟೆಡ್ ಕಂಪನೀಸ್ ಓಕೆ ಎಸ್ ರಿಮೈನಿಂಗ್ ಅನ್ಲಿಸ್ಟೆಡ್ ಕಂಪನೀಸ್ ಸರ್ ಎಸ್ 10%, DRF 15%. One more. Where is this? NBFC, HFC, remaining listed companies, they also need to create 15. Correct? And DRF is always created on the total deposit debentures maturing during the year by 30th April. Clear? Yes or no? ಏನೋ ಒಂದು I don't know, sir. I'm in the process. Anant means forever. Your preparation in company law is becoming like that. Forever it is doing. Okay, clear? Okay, where can I invest people? DRF, I should invest somewhere, no? Kaha? Nandan, where will I invest? Scheduled commercial banks? Government securities? Something they are written unencumbered. What is unencumbered? No charge is created. Basically, no one should have a say over it. It should always be free from any of the charge. No one should be asking for it. Mansilayo. Adalla, idalla. Nanna step out Mansilayo. Okay, clear? Yes, you will be investing it in where is it? Scheduled bank, unencumbered securities of government, unencumbered securities mentioned in Indian Trust, unencumbered bonds issued by companies under Indian Trust Act. Correct? You need to invest them in here. And the debentures, what is the maturity period? It has to be redeemed within 10 years. Infrastructure companies can go up to
20 years.
Yes.
Siriki Vitamanale 30 years. Okay. Then now, that's all debentures. Anything else? Debenture trustee. When will you conduct a meeting? The debenture trustee should be conduct a meeting. Whenever a debenture holder asks for it, I'll conduct a meeting. How many people should ask? 1/10 of number of people outstanding debenture holders.
Outstanding debenture holders.
ಏನೋ ಒಂದು ಹೇಳ್ತೀವಿ ತಗೊಳ್ಳಿ ಸರ್. ನಮಗೂ ಗೊತ್ತಿಲ್ಲ. We also don't know. We will tell. ಏನಿದೆ? What will we lose? Correct ನೋಡ? Till now it was accessible ನೋಡ. Meanwhile it will log out. ಇದೊಂದು ಒಳ್ಳೆ ಹಿಂಸೆ ಗುರು. Cold,
What disturbs marathon to
It's
us,
not
bro?
cold.
It's not.
Okay, wait.
Hello. This email is logged out. Can you help me log in? The classroom ID. Yes. I just have to download.
You also.
This is content. I want classroom. One second. I'll see if there is classroom. You can tell me the example. You can tell me the. Sorry. Oh, it's logged in. Yes. Yeah. Thank you.
You don't like. Nice. But
ಏನೋ ಮ್ಯಾಥ್ಯೂ ಜೋಕ್ ಏನೋ ಟಿಲ್ಡ ಹೇಳ್ಬಿಡು
from an hour. So he's telling if I drink this, I'll become Elon Musk. We have to talk.
See, it's just like out of the blue. That it's not like very carefully crafted kind of.
Even American.
Hey, now what we are not will write and comment jokes. Naturally crafted.
Brewery.
That day we were asking the examples of artisans in the class. Any artisans? He gave we didn't know what do they call for the people who do this brass items and
I didn't say welding or something.
Matthew said, sir, welding.
It was somebody else. That's why it was-
You only that English will be yours only.
Okay.
It was not you.
No. What do you want?
Then you know what brass makes.
Called.
Tell that, hey, English. Metalworking. You racist. Okay.
Saying so, I said.
Don't make the mask one joke.
Normal. No, isn't it? No, but
Okay, people, debenture trustee. Disqualifications of debenture trustee, people, important. I can ask you a question. Who cannot be a debenture trustee? A person who beneficially holds shares in the company. So a shareholder cannot be a debenture trustee. Is a promoter, director, KMP or any other officer or an employee of the company or its subsidiary associate, basically the entire cash. You cannot be a debenture trustee. Is beneficially entitled to money paid by the company otherwise than as remuneration payable to the debenture trustee. So for being a debenture trustee, I'll get remuneration. If I'm getting paid for any other purpose, I cannot be a debenture trustee. Is indebted to the company. I've taken loan basically to the cash. I'm indebted. I cannot be a trustee. Have given guarantee. If that person doesn't pay, I should pay. I cannot be a debenture trustee. Has any pecuniary relationship with the company amounting to 2% or more of its gross turnover or total income or 50 lakh rupees or such higher amount as may be prescribed, whichever is lower during the two immediately preceding financial years or during the current financial year. What do you mean by that, sir? We are having a contract. We might be a raw materials to them, amounting to 2% or more of its gross turnover or total income or 50 lakh. 2% of turnover, total income or 50 lakh, whichever is lower during the two immediately preceding financial year, meaning we are doing a contract with them. If the contract value is coming to this amount, they are telling you are not allowed to do it. Yes, sir. Is relative of any promoter or director or KMP. Relative of any director, promoter or KMP cannot be a debenture trustee. Yes, sir. So that debenture trustee should be appointed whenever there is a public offer, whenever there is a secured debenture issued, and whenever you are issuing it to the number of people exceeding 500. 500 not required. That is a case law I had explained you. They did exactly 500. Yes, sir. Okay, duties and all that. What are the duties? I'll tell you whatever is important. See that and go. Appointment of a nominee director. When will a debenture trustee go and appoint a nominee director on the board? Something should have happened. What has that happened? 2 consecutive default in payment of interest. We will take a step to appoint a nominee director. Second one, default in creation of security for debentures. You said it's a secured debenture. You have not created a security. I will go on. I'll appoint a nominee director. Default in redemption of debentures. Even one default. On the date of payment, if I don't pay, again I can get a right to appoint a nominee director. Clear? Yes, sir. Okay, next. Meeting of debenture holders is important. Whenever a request in writing signed by debenture holders holding at least 1/10 in value of the debentures. So if at all people holding minimum 1/10 of the total outstanding value of debentures, if they make a request or on happening of any event, the debenture trustee himself feels, I can conduct a debenture holders meeting. Remember, they can ask you debenture, they will not ask you a complete question. There will be sub questions. They will ask you what is the provision for debenture holders meeting. When can a nominee director be appointed? Can a debenture trustee absolve himself from any of the any of the actions done by the debenture trustee due to his own neglect? Can he absolve? What do you mean by absolve? Can he escape from the liability? Is it allowed?
No.
In the debenture trustee, it is signed that if at all the debenture trustee does anything, even it can be negligence, I will not be responsible for any of such losses. It is written in debenture trust deed. Company has signed, the debenture trustee has signed. Tomorrow the loss happened.
Void.
It's not binding.
Void.
Such agreements will be considered as void. But my question is, can he be absolved? Can you be, what is it?
Removed from that.
No.
Escape.
Can we let him go away? Can we,
No, sir.
possible? Is there a way?
No.
No way at all?
No.
Not possible at all?
He is responsible.
Possible, people, after passing a special resolution. You can call for a meeting. If they are agreeing, it's okay. Then we don't have a problem. Correct? That question they can ask you. They can ask you, what if such clause is there in the agreement? What is the effect? Void. But to escape, do I have a point? Do I have a way out? Yes, you have a way out. 3/4 consent has to be required. Clear? They can ask you. They can ask you debenture trustee. Who can be? They can ask you, can this person specifically be a debenture trustee? They will never ask you to write a definition of debenture trustee. Clear? Yes, sir. And they can ask you, this is also important, casual vacancy. Sir, whenever there is a casual vacancy, the board only will fill the casual vacancy. Correct?
Yes, sir.
However, sir, such vacancy is caused by resignation. He left. In such case, the vacancy shall only be filled with the written consent of the majority of the debenture holders. If it's a resignation, in any other case, if it's a winding up, imagine debenture trustee was a company, they wound up. The board will automatically fill someone else there. If it's a person, death, I can directly fill someone else there. But if it's a resignation, why did he leave? So you need to take the majority of the debenture holders approval before you fill the vacancy, not for him to leave. Now tell me the removal. Can a debenture trustee be removed? Yes? Any approvals required? How many? 3/4 the majority. 3/4 the majority. Allah people, 3/4. Yes, sir. Huh? People, I am your mind in your exam. I am nothing but the representative of you in your exams. That's what your mind says, no? Yes or no? The debenture trustee may be removed from office before the expiry of his term only if it is approved by the holders of not less than 3/4 in value. Correct? I'll tell you one more. I don't think it goes to that extent. Vacancy shall only be filled with written consent of majority of debenture holders. People. It is number of people. Whereas this
Is value.
yes, sir, Matthew, I'll ask you one question. To conduct a meeting, 10% was in value or number? To conduct a debenture holders meeting, 10% people have to give a request. The 10% is in value or number? Value, Pakka. Okay, correct. Debenture trust deed, written instrument legally conveying a it shall be in the format SH12. What is DPT2? DPT is deposit. DPT2, when I'll ask SH12, it's debenture trust deed. Then what will DPT2 be? Deposit trust deed. It will usually be the names of trustees exempting apitalla. Inga par in the provision ek bar odre. Any provision contained trust deed shall be void in so far as it would have the effect of exempting a trustee from indemnifying him against any liability for breach of trust where he fails to show the degree of care and due diligence. However, liability can be exempted. The liability of the debenture trustee shall be subject to such exemption as may be agreed upon by debenture holders holding not less than 3/4 in value. If they say we are okay, leave him. Clear? Huh?
Yeah.
This is like okay. Then deposits. You want the definition of deposits? Tell us, okay. What is not considered as deposit? Start any amount received by central government, state government, any other source but guaranteed by central or state government, any amount received from local authority or any statutory authority, local authority or BBMPs, BDAs, all of them. Statutory authorities is your regulators. Any amount received from foreign governments, foreign international banks, multilateral financial institutions, etc. Banking company, BFI, commercial paper provided according to RBI. Any amount received by a company from any other company, intercorporate loans or deposits. Subscription to any securities, 60 days to be allotted, 15 days to be returned, refunded. If not, failure will lead it to deposit. Next one, any amount received from a director of a company or a relative of the director of the private company, provided they need to give a written declaration that it is my own funds, I have not borrowed it from any place. This has to be disclosed in the board's report, this declaration. Clear? Okay. Next one, amount raised by issue of bonds or secured debentures provided. Secured debentures provided. What is that? It has to be secured on first charge and intangible assets illa. Compulsorily convertible within 10 years and market value of the property should always be more than the value of the loan. Okay. Any amount raised by issue of non-convertible debentures, only condition it has to be listed on the recognized stock exchange. Amount received from any employee, what are the conditions? Not exceeding his salary, annual salary, and it should be non-interest bearing. Hey, Tilda, Ananta. Non-interest bearing amount received or held in trust. Any amount received in the course or purpose of the business, what and all will come? For goods or supply of services provided, it has to be delivered within 365 days. But certain exceptions were there. What is that? Litigation. Because of court case, if I was not able to deliver the goods within 365 days, that period is not counted. Correct? Gauri? You change in it? I know it's good. So sorry. Yes,
Business as usual, sir.
as security deposit for the performance of contract, correct? Security deposit, you will bike 200 rupees you deposit, no? Advance received under long-term projects. What is long-term project? Construction related and all, you will pay, no, not considered, provided it is adjusted in the total payments. Advance for providing future services. For warranty, maintenance, what is that? In your washing machine, 3 years, 5 years warranty period is there, no? Provided, what is the condition? Whatever is practiced as per the customs, what is prevalent, that period or 5 years, whichever is lesser.
As an advance received and allowed by sectoral regulator. TRAI allows you to take beyond 1 year. You take insurance. You take as an advance for subscription towards publication, whether in print or electronic. Adjust. What is this, sir? Sir, you take magazines. No. If at all your magazine is coming to an end, you have to clearly intimate any excess amount should be either refunded within 15 days of when the magazine actually comes to an end. Any amount brought in by promoters themselves or by the stipulation financial institution. What is this, sir? The promoters bring in money. Technically, should I consider it as deposit? No. But why did I bring money? You should ask me that first. Why? Because the bank said you have applied for a loan. The loan amount is 100 crore. 100 crore I can't give. 15 crore you bring as down payment. 85 crore I will bring. That 15 crore is not considered as deposit. Because it's a down payment. As per the stipulation of financial institution. Stipulation is a condition. Clear? Any amount accepted by Nidhi. Amount received by way of subscription in respect of a chit. Chitted. Chit. Amount brother, ನೀನ್ ತಗೊಂಡಿಲ್ಲ. In 100 chits, 50 chits. Any amount received by the company under collective investment scheme, capital market will see. Convertible note, very important. What is convertible note? Any amount received by a startup, compulsorily convertible into equity or redeemable within 10 years. Lump sum of minimum 25 lakhs in a single tranche received by a startup. All conditions should be there. One also not there. You come here, I'll hit you. Clear? Okay. Startup. Agreed? Online? ಮೆಡಿಟೇಷನ್ ಮಾಡ್ತಿದ್ಯಾನೋ ಇನ್ಹೇಲ್ ಎಕ್ಸೆಲ್ ರೇ ಕುಷ್ಕ alternate investment fund, domestic mutual funds, etc. Why? Because they are all regulated by SEBI. Okay, taka, tell me now. Feeling cold, huh? Matthew will do, but we will not have anything to do from the next batch. Already that vein is not working. Matthew, okay, nada? Is okay, na? Yeah, as if you are like this now. Your one eye is already in Goa. Okay, na? Hey, I'll raise. Matthew does Dhyana. What a Sujay.
So just reduce the band speed.
One ಇದೆ ಗುರು ಇನ್ನೇನ್ ರೆಡ್ಯೂಸ್ ಮಾಡ್ಲಿ. Okay, then people deposits, people your most confident topic. So section 73, sir, this restriction shall not apply to which restriction? Prohibition of acceptance of deposit from public. That's only section 73, no? Prohibition of acceptance of deposits from public is section 73, no? Yes or no? Yes, sir. That's it. No, that only. But section 73 says you can raise it from members. But this restriction is not applicable for a few people. कौन है वो है banking company, NBFC, HFC, other companies specified by central government. एक attempt में एक bouncer, वो कैसा sponsor, वो शोएब अख्तर 170 kilometers ऐसा बिना helmet ऐसा. They are asked one, not insurance. They have given the name of the company as XYZ Housing Finance Company. They have given big story. And they have asked you whether the deposit provisions of how much is applicable to this company. People wrote 35%. No. Answer was simple. Section 73 is not applicable to these companies. Because it is a housing finance company, it is not applicable. It can raise any number of deposits as permitted by National Housing Bank. Ashtek, answer was that. ಗೊತ್ತಾಯ್ತಾ ಅಲ್ಲ ಗೊತ್ತಾಯ್ತಾ ಫಾರ್ ಅ ರೀಸನ್ ದೇ ವಿಲ್ ಗಿವ್ ಯು ದಿಸ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಥಿಂಗ್ ವಾಟ್ ಇಸ್ ದಟ್ ನೇಮ್ ಆಫ್ ಅ ಕಂಪನಿ ಕ್ಲಿಯರ್ ಲಿಮಿಟೆಡ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ ಯು ರೀಡ್ ದಟ್ ವೆನ್ ದೇ ಆರ್ ಆಸ್ಕಿಂಗ್ ಯು ಸಿಂಪ್ಲಿ ಡೋಂಟ್ ಗೋ ಲೈಕ್ ಎ ಮ್ಯಾರಥಾನ್ ಕ್ಲಿಯರ್ ಚಂದ್ರಮೌಳಿ however any company may accept deposits from its members subject to first one resolution you have to pass it sims why is it written as resolution which resolution should I pass ordinary or special special only no ashte no then why did I not write special there
Doesn't exceed the limit in 179.
if at all it is exceeding beyond your paid up share capital plus free reserves plus securities premium then you need to pass special resolution restriction on power of the board ivatte we did 5 times another 10 times also you guys can listen with the same enthusiasm
That's all.
okay circular people dpt1 what is dpt1 now 73 to a to e what and all is a to e a says people whenever a company wants to raise deposits they first have to prepare a circular that circular before they give it to the members it has to be first given to ROC that is only B circular plus statement now in the statement what and all will be there about the company financial position credit rating total number of outstanding deposits if it's to be raised from public 76 according to that this will also be published in the newspaper how long will that notice will be valid for it will be valid for 6 months from the closure of financial year or the date of AGM same only no whichever is earlier both are same no you can get an extension you can get 15 months the maximum gap between two AGM should not be more than 15 months so it can be before also so that both will not be same always yes sir okay and you will file the statement and circular with ROC 30 days prior to issuing it to the members so now I will give it to the members now members what they will do they will start applying they should also give a declaration what is the declaration we are applying with our own money and not through borrowed funds and how much can they apply sir they can apply for how much depending upon the members how much can you accept the deposits from members 25 or 35
35, sir.
35 percentage of what paid up share capital plus free reserves ante securities premium security that is understood sir okay correct ಯಶವಂತ ಸಾರಿ ಯಶಸ್ಸು ಕನ್ನಡಕ ಕೆಳಗಿಟ್ಬಿಟ್ಟ ಯು ಡೂ ಸರ್ ಐ ಆಮ್ ಲಿಸ್ನಿಂಗ್ ಇನ್ ಮೈ ಇಯರ್ಸ್ ಇವನ್ ಈಸ್ ಲಿಸ್ನಿಂಗ್ ಇನ್ ಐಸ್ ಕ್ಲೋಸಿಂಗ್ ಐಸ್ ಧ್ಯಾನ ಸರ್ ಎಲ್ಲ ಒಳಗೆ ಹೋಗುತ್ತೆ ಡೇ ಅಣ್ಣ ನೀನ್ ಅವೇಕ್ ನೋಡಿದೀನಿ ಬಾ ಅಣ್ಣ ಸರ್ वैसा दोनों हाथ में ऐसा वाटर लेके ऐसा डिप करो वो नहीं वर्क होता तो बकेट में लेके ऐसा ऐसा रख दो ऐसा ओके क्लियर 73 to C DRR what is DRR deposit repayment reserve how much will you have 73 to C how much 10% only no 10 only ಇಲ್ಲಿ ಅಲ್ಲೇ ನೋಡ್ತಾ ಇದೀರಿ ಸರ್ 20% O 10 O 15 A 20 by when will you create DRR ಇದು deposit repayment when will you create by when will you create 30th of April which year of how much 73 to E If company has not defaulted in repayment of any deposits, if any default, company shall certify that it has made good the default and 5 years has elapsed. Exemption, sir, for everyone is 73 A to E applicable. A to E is nothing but procedure. Should everyone comply? No, it seems. Count. Private company, if at all, which accepts from members money not exceeding 100% of paid up share capital. Correct? That means, people, this is nothing but 181C only. If you are accepting deposit within this limit, they're telling you, people, you need not comply with this entire procedure. DPT1, no, all that not required. Sir, what if I'm raising more than that? Then you can try here. If you are a registered startup for a period of 5 years, only place where 5 years is still there. Next one, which fulfills following. What? All. You should not be an associate or a subsidiary of any other company. Next one, borrowing is less than twice of its paid up share capital or 50 crore, whichever is less. What is your paid up share capital? Take a number. Let us imagine my paid up share capital is 5 lakhs. Twice of it is 10 lakh or 50 crore rupees, whichever is lesser. Which is lesser? 10 lakh. So they're borrowing. Now in the company, look at their borrowing, debenture, short term, long term, whatever, add everything. If it is going beyond 10 lakh, then this restriction, this exemption is not available for them. Here, if it is going beyond 10 lakh, whichever is less. Here, yes, okay, next one, not defaulted in repayment of deposits till now. If you are satisfying all this, then you need not have to follow 73 A to E. Meaning no deposits, no statement, no ROC filing, no DRR, nothing required. Correct? Procedure for acceptance of deposits. What is the procedure? First, conduct board meeting. Pass a resolution depending upon the amount you are borrowing. Draft circular DPT1, file it with ROC 30 days prior to giving it to the members. Now DPT1 will be issued to the members. If it is a public, you can also post it on newspaper. Okay, collect the application, declaration also that money is not borrowed, it belongs to them only. Deposit receipt is to be issued within 21 days of receipt of money. They give money, I have to give them something in return, no. For capital you give share certificates, here deposit receipts. Deposit receipts, clear? Sir, once I give deposit receipts, should I enter their name somewhere? Yes. Register of deposits within 7 days from the date of issue of receipts. Remember the timelines. When what is happening. Maintain DRR 20% to submit DPT3 when by 30th June of every year. Basically return on deposits. If company fails to repayment, depositor may apply to the tribunal. The maximum amount deposit we'll see. Yes, sir. Exceptions, the maximum shall not apply to that we'll see. Provisions related to action to the deposit public. Only thing with regards to public. What is the extra thing, people? This is the extra thing. What is the extra thing? Obtain credit rating. If at all you are issuing deposits from public, you have to mandatorily take a credit rating, and it has to be secured deposits. The credit rating should be revised every year until the tenure of the deposits. If you have taken the deposits for 3 years, every year you need to go. You need to ask, how is your credit rating this year with a recognized agency, and it should not be worse than. Credit rating shall not be below minimum investment grade. Imagine like AA or other specified credit rating for FTs by RBI. It should not be less than that. Your credit rating. Imagine like your marks card. B vargu okay. A is like best person. B is like okay. C
Disowned.
C get disowned under D, E die only. Okay. Only eligible company and government company. Who can raise Nandan? Who can raise money from members? Public, private company. Who can raise money from public deposits? Which company? Private or public? Which company can raise money from public? Public company, obviously. Allah. Eligible company. When will a company become eligible? When 1000? Day before the exam, ಬೆಳಗ್ಗೆ 5 o'clock, ಎಲ್ಲರೂ ಎದ್ದೇಳ್ರಿ. Get up at 5 o'clock. Whichever God you follow. Minimum 4 to 5 hours. Because 1 hour, that limit we have passed. Now that request has to be very strong. 4 to 5 hours. Don't eat anything. With upvasa, fasting, go and do the puja. You know puja, no? I mean prayers. Yes. He's saying puja, yes, ade avulu. Eligible company, rule 2(1)(a). It is a public company having a net worth minimum 100 crore or more, turnover minimum 500 crore or more, or pass special resolution. But if it is within 181(c), then ordinary resolution is sufficient. Here, okay, rest and all will be the same. He doesn't have grip on his eyelid only. Adella beyond his control. Okay, what is the maximum deposits he can raise? What is the maximum, da? So, what is the maximum 10-year deposits? We'll see that. 10-year deposits, people, repayment on demand, not permissible, like your savings account. It should always be for a 10-year. And how much is that? Minimum is? How much? 6 months. Maximum is 36 months. But can I take it below 6 months? Gayatri, can I take it less than 6 months? Yes, you can take it, but not less than 3 months. What type of deposits? Short-term requirements can be accepted for less than 6 months, but not for less than 3 months. Remember that. Clear? Okay. It shall not exceed 10% of the paid up share capital plus free reserves plus securities premium. What? Whatever is the deposits you are accepting for less than 6 months, that cannot be more than 10% of paid up capital, free reserve, securities premium. It can be accepted to meet short-term repayment on or after 3 months only. Sir, premature repayment of deposits. What do you mean by that? Sir, I have taken deposits for 3 years. That person is coming and asking in the second year only. Can I repay? Should I repay? Yes, sir. But just that, for whatever is a tenure the deposits have run, you have to reduce the rate of interest by 1%. So, whatever is the completed period, for that, you reduce the rate of interest by 1%. Here, yes, sir, what is the tenure is coming to 15 months. If it is less than 6 months, people ignore it. If it is 6 months or more, people consider it as 1 year only. ಅರ್ಥ ಆಯ್ತು ಆಗಿಲ್ಲ? ಏನೋ ಏರೋಪ್ಲೇನ್ ಬಿಟ್ಬಿಟ್ಟು ಅರ್ಥ ಆಯ್ತು ಅಂದ. ಅಂಡರ್ಸ್ಟುಡ್ ಅಡ ಸುಜಯ್? ಓಕೆ, ಟೆಲ್ ಮಿ. ಅ ಕಂಪನಿ a company has accepted deposits for 36 months. One of the one of the deposit holder wants to withdraw it in 17 months. The rate of interest per year is 12%. How much rate of interest will this person be entitled? The total deposit he made is 1 lakh. ಅದೇನೋ ಹಿಂಗೆ ಗಾಳಿಯಲ್ಲಿ how much? How much? Kushka tell da. How much will I get? 17 months tenure is done. I want to withdraw. How much money will I get? Rate of interest, how much I'll get? All of you understood this, huh? So what are they saying, people? 1 year for sure completed, we don't have a problem. For whatever is the period run, for that 1% will be reduced. So you are entitled for 12,000. It will become 11,000. Now there is another 15 months. There is other 5 months. Now how do I calculate for those 5 months? They are telling you, if at all you have completed 6 months or more, you have to consider directly as 1 year. If it is less than 6 months, in exam they will ask you 18 months. You will remember me. ನಾನು ನೆನಪಾಗ್ತೀನಿ ಹಿಂಗೆ ಒಂದು ಫೋಟೋ ಪಕ್ಕ. Exact 6 you will not know where to take. You need to consider as 6 or more will be considered as 1 year. Less than 6, ignore. Understood? Now it is 15. less than 6 months, that 5 months you have to ignore, you don't have a choice. So you will be entitled only for 11,000 rupees. Pakana? Hello? Ujay? Okay. Sir, no reduction in the rate of interest. When to comply with rule 3. What is rule 3? We'll see. To keep up the requirement, because you have borrowed, we'll see. It is repaid to provide for Navy, military, Air Force, for such people. If at all you are repaying it during emergencies, you need not deduct the rate of interest. You can still pay 1% only. Sir, higher rate of interest. Am I eligible? Yes, sir. Provided. Now imagine out of 36 months, I want to further extend it. Now 24 months is already done. Now I want to extend my deposits with the company. Can I extend? Yes, possible. Provided I need to pay a higher amount. The provided people, whatever is the unexpired tenure, still 12 months more to go. Whatever is your renewal period should be more than this 12 months. So it has to be minimum 2 years, because part will no one will do. It has to be minimum 2 years. Renewal. The renewal will start after the closure of the third year. 36 should complete. After that, another 2 years you have to stay. Then people, for the next 2 years, you will be entitled for a higher rate of interest. Clear? Now imagine people, 24 months is done. 12 months is not yet done. I want to renew my deposits. Now I'll renew my deposits. Provided I should also get higher rate of interest. If you give me same, why will I renew? They will say we will give you higher rate of interest. Provided now only renew it. The renewal period should be more than your unexpired period. Unexpired period is 12 months. Your renewal period should be more than that. That means minimum 24. You do 36 also, I don't have a problem. And that will not start immediately. The 24. The 24 will start after your existing 36 is done. Correct? So for this 36, you will get the same rate of interest only. For the next, you will be eligible for a higher rate of interest. Clear? Hello? Okay. The quantum of deposits. How much deposits can I accept? If you are eligible company, 35% from members. Exception, private company. Other than eligible company. So you can take it from private company, 35%. Yes, if you are eligible company, from members I can take 10, public I can take 25. Government people, 35% I can take from the public only. Correct? Sir, I am a private company. Can I borrow more than this? Can I borrow more than 35%? Yes, it seems. When you satisfy some conditions, what are the conditions? The maximum limit shall not apply to the following clauses of private company. They can go beyond 35%. Who? Private company which is a startup for 10 years. Correct? Next one. If at all you are a private company which is not associate or a subsidiary, borrowing is less than twice of paid up share capital or 50 crore, and the company has not made any defaults, whatever we saw there, same condition. If you satisfy these conditions, people, then the maximum limit of 35% is not applicable to you. They can even borrow 100% also. Clear? Yes, sir. A chocolate open ಮಾಡು ಅಂದ್ರೆ ಹಿಂಗ್ ಮೆಲ್ಲಿಗೆ ತೆಗೆದು ಹಾಕೋಬೇಕು. ಆ ಪಕ್ಕದ ಕ್ಲಾಸ್ಗೂ ಕೇಳ್ಸೋ ತರ ಹಾಕೋತೀಯ. Vishnu is smart, see. When I was scolding you, he opened it off. Not a Vishnu. Okay, next one, people. Register of deposits, details to be maintained. Name, address, PAN, particulars of nominee, depositor. Entry should be made within 7 days. The register shall be preserved for a minimum period of 8 years from the financial year in which the latest entry was made. Here, deposit trustee, he shall be appointed by company for creating secure debentures, secure deposits, mandatory. Deposit trustee, DPT 2. DPT 1 is circular. DPT 3 is return on deposits. Disqualification, who cannot be a deposit trustee? Director of KMP, employee of cash and relatives. Okay. Depositor of company, whoever is depositing, he cannot. indebted to cash. I've taken loan from them. I have to pay them money. I cannot be a deposit trustee. Any material pecuniary relationship with the company, I have any material pecuniary. Pecuniary means monetary. I'm getting money. Being a deposit trustee, if I'm getting remuneration, it's okay. Apart from that, if you're getting anything, I cannot be a deposit trustee. Given by guarantee. Someone has taken loan, I have given guarantee. If he doesn't pay, I should only pay, no? Yes or no? Such people cannot be. Next one, sir. Okay. That's all, huh? Anything else, now? Covered most of it, huh? Huh? Quantum exceptions, tenure, repayment, higher interest. What else? We saw almost everything. Meeting of depositors, same as debenture holders only. Whenever the deposit trustee feels so, or whenever there is a request made by at least 10% of the deposit holders in value, if they make a request, you will conduct a meeting of depositors. Correct? And register of depositors we saw 8 years. That's all, no? That's all, huh?
Yes.
Correct? That's all, huh? Okay. How many are we done?
7.
We finished 7 chapters, is it? Okay. We'll finish off charges, huh? Hey, charges, da? Easy chapter. Charge ಏನು ಇಲ್ಲ ಗುರು. ಸರ್ ಚಾರ್ಜ್ ಅಲ್ಲಿ ಏನು ಇಲ್ಲ, ಬಟ್ ನಮ್ಮಲ್ಲಿ ಚಾರ್ಜ್ ಇಲ್ಲ. Matthew, motivate them, da. Sing one song, da.
Perfect song. Breaks are gone.
Which time? All men, if I say.
Matthew, sing one song, da.
Yeah, the train setter. That's not.
You're not a trendsetter.
Hey, I said it on the first day, sir.
Sir.
No, I can do it.
No. Exclusive.
I self request.
ನನ್ನ ಹೆಸರು ಹೇಳ್ಬಿಟ್ಟು ಅವ್ನು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಬಿಟ್ಟ.
I put a gun on his shoulder. Okay, wait. I don't have a gun. Wait for I'm thinking, no?
Okay, Tagadak. We will quickly. Next chapter we will charges, people. Charges. Kinds of charges. There are 2 types of charges. One is called as fixed charge. One is called as floating charge. What is a fixed charge? Anything that is created on a fixed asset, something which does not change over a period of time. You cannot. What is a fixed charge? Imagine I take a loan on this particular property. Now I do not keep selling my property every day. Now such type of loans or such type of properties you have created a charge on is called as fixed charge. Example, all your fixed assets. Agreed? What do you mean floating charge? Floating charge means, people, every day you have created a loan on this property, but that you keep on selling every day. Example of floating charge is, people, stock. It can be accounts receivable, debtors. Every day it fluctuates until the day where it crystallizes. That is called as crystallization. When does the floating charge gets crystallized? Whenever a receiver is appointed, when a company ceases to carry on the business, company enter into liquidation, whenever the debenture holders or the holders of the security, they take up any steps to initiate a charge. Correct? So when a company goes into liquidation, ceases to carry on business, the creditors or debenture holders take steps to enforce the security happening of any event specified in the deed. 2 consecutive repayments, failure to repay the interest, I will revoke your I will invoke your charge. I will put a clear condition. Correct? Yes, sir. Any doubts in floating charge and fixed charge? 100%. Fixed charge is always on a fixed asset. Floating charge is always on an asset which can be sold and purchased without any approval from the charge holders. I need not ask the lender, sir, can I sell it? Whereas a fixed charge, if you have to deal with it, if you want to sell it or buy it, you need to mandatorily ask the creditor's approval. Agreed? Okay. Next ones are consequences of non-registration of a charge. If I do not register a charge, what is going to happen? There are two things. One is called as void against liquidator, void against creditor. Void against liquidator means people, when you come asking for repayment on the last day, if the company is wound up, if at all you have not registered the charge, you will be treated as an unsecured creditor. First I will repay others, then I will repay the money to you. You will be treated as an unsecured creditor. Yes, sir. The next one, people, is void against creditor. What do you mean void against creditor? Imagine I have taken loan from ICSI Bank against the collateral. This property is a collateral. I did not create a charge. I did not register a charge. Meanwhile, I took a loan from HDFC Bank also. The HDFC Bank went and registered the charge first. Loan was taken by me first. The agreement was mine first. But if HDFC has registered it, people, they will enjoy the priority. They will get the repayment power first. If something is left, then I will get repaid. Yes or no? Okay. Duty to register charge, sir. People, if at all I create a charge on movable property, should I register a charge? Movable property. Movable. On my bike. If I create a charge, should I register it? Intangible assets? Intangible assets. Remember people, yavari thing is included. Example, questions baratte. If the property is situated outside India, if I borrow loan on that, should I intimate my ROC here? Should I intimate?
Yes, sir.
Okay. Remember, yes sir, required. Yes sir. Okay. Next one. Property situated outside India or in India, you have to get it. Sir, who shall authenticate the documents? If the property is situated outside India, you will get it signed by a company seal or a director or company secretary or authorized officer of a charge holder or some person other than company who is interested in the mortgage. It can be surety, guarantees, as the case may be. Property situated in India, 1 or 2, this person won't come. Clear? Okay. Next one, charge shall be registered with register. This part ignore, this part concentrate. Because that timeline and all is done, no, the 300 days and all, concentrate on the right part. Now, whenever I create a charge, sir, I need to register it with ROC. In which form?
CHG1.
CHG1. In the case of any other loan, in the case of debenture, which form?
9.
CHG9. You need to file it within how many days? 30 days from the date of creation of a charge. What if I don't file it within 30 days? You will get an additional time and you need to pay additional duty. And how much is the extra time I get? 30 days, huh?
Yes, sir.
30 days, huh? Okay, I get extra 30 days, huh? Anantu, see here, extra 30 days or 60 days, huh?
30 days. 30 days, sir.
30 days from when? Anant, huh? ನನ್ಗೆ ಹೇಳ ಸುಜಯ್ ಅವನ್ ಹಿಂದೆ ಹೇಳ್ಕೊಂಡೆ ಬಾಡ ನಿನ್ಗೆ ಹೇಳಿ ನೀನ್ ಹೇಳ್ಬೇಡ ಕೇಳ್ದ 30 days from when?
From the commencement of delay, sir.
From the commencement of delay. ಇಲ್ಲಿದ್ಯಾ they have written na? So remember people, 30 days, if 30 days you do not do it, people, you will get another 30 days. But in book they have used 60 days. The 60 days start from here. So technically it's an additional 30 days only. Sir, what if even in this 30 days also I do not register? I'll be entitled for another 60 days. This is 60 days from here. So totally it is 120 days. In exam, remember this. You have to tally that 120 days. How you tally, it is left to you. Yes, next one, sir. But what is the fees you need to pay? Additional fees. Now the last one is ad valorem fees, like a penalty. And that is the amount you need to pay. Agreed? Okay. Sir, and if at all I file CHG1, he will give me a certificate of registration of charge in the form CHG2. Sir, if at all there is any modification, imagine I have given a loan amount. That loan amount, that's not the number. I need to change it. CHG?
Three.
Three.
3, I need to file 3 only, no?
One only you can say, sir.
CHG1 only, creation or modification form is changed, same. CHG2 is something what they give. What is CHG3? Certificate of modification of charge. What is CHG4?
Satisfaction. Intimation of satisfaction.
Intimation of satisfaction of charge. CHG5. Memorandum of satisfaction of charge. CHG6. Appointment of receiver or manager. CHG7. Register of charges. CHG8. Condonation of delay. Asking central government's approval. When will you ask central government's approval?
300 days elapsed.
Whenever 300 days have elapsed from the date of satisfaction of charge. Correct? Yes, Sujay, you have studied this chapter. The simplest answer. No, sir. Nandan, you have studied. Yes, you have studied. No, sir. Nan yadu odilla. Hey, Vishnu, you have studied. Third. Okay. Bidri. Application for registration of charge by a charge holder. What if the company which has taken loan, if they do not file CHG1, what is the next step? If the company does not file, the bank has to file. If company does not file in 30 days, the bank will file CHG1. They can recover the cost from the company. It can be even normal cost as well as additional cost. I can recover it from the company. Here, sir, now what will be the process? The bank will file CHG1 with ROC. ROC will confirm it with the company. Hey, the bank is telling that you have borrowed 1 crore rupees as loan and this property is considered as collateral it seems. Is it true? Have you actually taken loan? He will say yes or no. 14 days time is given. In that 14 days, if you do not reply, it is considered as deemed approval. Here, sir, now what if, sir, I am buying a property on which there is a charge. The person, there is the company, the seller, he never disclosed that there is a charge over it. Can I claim any remedy in this contract that he never disclosed me that the charge is there on that particular property? He never disclosed it to me. No. Can I raise it as an objection?
No.
Why?
It is your responsibility to
public document, constructive notice, correct? Okay, company to report satisfaction of charge. Within 30 days of payment, people, you need to file form CHJ 4 and you need to file it within 30 days. If at all I do not file it within 30 days, now I have timeline, additional timeline. How much? 300 days. If I do not file it within 300 days also, then you can go for condonation of delay. That is the last one. Section 87. So the point will come like this. From here, it will go like this and come here. Correct? And to what extent the central government can give you an approval, there is no higher limit prescribed. But you can go and touch the central government's feet. This is only possible in the case of satisfaction, not in the case of registration. Registration, if you miss 120 days, it's gone. Clear? Yes, sir. Okay. Now, opposite, same thing will happen. When the company is telling I have repaid the loan, now the ROC will check with the bank. He is telling that he has repaid the loan. Has he actually repaid? Bank has 14 days. If they don't reply, it is considered as deemed approval. Sir, now when we are filing CHG4, there only I have given a consent, bank's consent. I have signed there only. Now there will be no additional notice given to the bank. Clear? Yes, sir. Okay. And whenever you are buying any property on which there is already a charge, it is your duty to file it with ROC. Certificate of modification of charge. Sir, Artha Agilla. There is a company called Company X. Company has borrowed money from ICSI Bank. There is another company called Company Y. They are buying the property on which they have given collateral. company Y purchased that property. Now company Y has to intimate ICICI Bank, sir, now I have purchased it. I become the charge creator. This is modification. I will also file CHG1. In X's records, it will be considered as satisfaction. In Y's records, it will be created as creation.
To ROC, you have to file CMG 3 years.
CHG?
3. Modification.
Modification is the return filed by ROC. They say I have taken your modification, I am receiving it, so here is an acknowledgement. Jairam, sir, what is CHG 6? Now I am a creditor, debenture trustee. We have appointed a manager to go and take the possession of the property. Whenever a receiver is appointed or whenever he ceases to be appointed, 30 days, you have to intimate appointment also, cessation also to ROC as well as the company.
Yes, sir.
Sir, I am appointing this person to take control of that asset. Form CHG 6. Clear? 100%? Yes, sir. So this is what will be your charge complete flow. Okay. Any other thing in charge there? Of course, whatever you can do as a company secretary, what is your duties? What and all you will check? What you will check? Basically, you'll check what is the limit, amount, resolutions are passed, NGT 14s, and attachments. If it is 181C, ordinary special, has the company passed it? Whether it is filed within time. So all these things you will check. That's the duty of a company secretary. Correct? Huh?
Sir, page 7.6. Postponement of floating charge.
Postponement of a floating charge. When will the floating charge get postponed? A landlord who distrains for rent, meaning you are staying in my possession. You have not paid my rent. If you don't pay next month's rent, I'll vacate you. I'll put you on road. Now there is a floating charge which is created by ICICI Bank. Now whose money will be paid first? ICICI Bank or the landlord? They are saying landlord's money will be paid first. Why? That's only called as postponement of a floating charge. This is more important. If rent is not paid, he will put you on road only. Correct? Huh? Next one, a creditor who obtains a garnishee order absolute. What is garnishee order? Court order. I'll go and get a court order, pay money, you have to pay money. That's all. So court's order will have the priority. That's what they're telling you. Next one, sir. Judgment creditor who attaches goods to the company and gets them sold. But the goods are what is judgment creditor, people? Similar people, a person who has lost the case and I have some property of yours with me. I will sell it to recover whatever is the money I can recover, like lien. You guys should have heard of lien. So that possession is with me. I will sell it, I will recover the money. Next one is people, the employees of the company as well as other persons in the event of winding up of the company. Simple, Day ICICI Bank's loan is not repaid. Here salaries are not paid. Salaries will be paid first. Kingfisher exactly came here. 2 years pilot salaries were not paid. The supplier of goods to the company under a hire purchase agreement on terms that goods are to remain the correct? What is hire purchase? ಹೇಳಿದ್ರೆ ಎಲ್ಲಾರು ಹೇಳಿ ಇಲ್ಲಾಂದ್ರೆ ಯಾರು ಹೇಳ್ಬೇಡಿ ಇವನೇನೋ ಹೇಳ್ಬಿಟ್ಟ ಮಧ್ಯೆಯಲ್ಲಿ hire purchase is nothing but ownership in the property will be transferred only upon the repayment of the last EMI. So imagine a person has purchased one big asset from me on an EMI basis. I mean hire purchase basis. He has taken it from me and he has also created a charge over it. Nowadays that's mine. If he has not paid your interest, that's mine, not my headache. It's mine. Ownership is in my name. So hire purchase, basically the owner will still have a right when compared to the hirer. That's what they're telling you. Clear? Yes, Okay, see if there is any other thing. Mortgage is always created by the act. Charge can be created by the act or even by operation of law. How can it be created by operation of law? How can a charge be imposed by operation of law? Operation of law means it's not a voluntary act.
Like English.
No, people, it's basically like lean people. What is lean? Now, simple example I'll tell you. I have a bike, people. The bike has to be repaired. I go and give it to a garage and I don't pay the money for it. The garage person will give me my bike. No, no. But why shouldn't he give the? It's mine, no. That is only this. Operation of law. Law says he has a right to hold it until you pay the money for it. That's only called as operation of law. Correct? Yes, sir. Okay. A charge created by operation of law does not require registration. Will the bike person will go and register? No, not required. Mortgage should always be required, registered. It's a fixed term. It's a perpetuity. So here it can be 10 years. This can go. There is no term, right? Mortgage is a transfer of an interest. Charge only gives a right to receive payment. Meaning mortgage people, I give you my patra, tala patra. I'll give you everything. If I don't pay, you have my documents only in your hand. Charge are we giving all that? We are telling the government, sir, I've taken loan. No, on this I've created interest. If I don't repay, you will not get the direct interest. You have to come and stand in the queue. Liquidator will pay you on priority. Correct? Mortgage is good against subsequent transferees. Charge is good against subsequent transferees. Same thing. What is that? If at all I take the loan further on the same property, if I take further loans without notice, without telling, it will not be valid. If I tell and if I take it, it will be valid. That is what is given as with notice. Yes, sir. A simple mortgage carries personal liability. In case of charge, no personal liability. What do you mean by that? Sir, loan amount is 1 crore. The asset value is 85 lakh. I failed to repay. The person will apply to the court, he will get it sold. He recovered 85 lakhs. Still 15 lakhs is to be given. In case of charge, you are no longer liable. There ends your liability. Mortgage, property will be sold. If at all it is shortfall, it will be recovered from you in the case of mortgage. Here, pledge, transfer of physical possession of asset happens. Charge, physical possession never gets transferred. Always, it can be movable, immovable. It will always be movable. That's all. See once. Register of charge should be maintained permanently. The loan agreement. What is the loan agreement? That has to be maintained for a period of 8 years. From the date of satisfaction. From the date of satisfaction. Clear? Yes, clear? Pakana? Okay. Sir, ಇದು ಟೆನ್ಷನ್ ಇದು ಬಿಸಿ ಆಗೋಗ್ತಿದೆ ಸರ್. ಮಂಡೇ ಬಿಸಿ ಆಗೋಗಿದೆ. Okay. How many chapters done? 8. Only 8. 8 only.
But if you want to do one more, you can comment.
Dormant. You will be dormant. Okay, let us not do it for namesake. It's okay. Let us do one thing. Let us wind up for the day. Let us again catch up tomorrow. People, can you guys come tomorrow in the same time only, morning? We'll probably finish it prior to lunch. If tomorrow it's not happening, we'll see if we can take it the third day also.
Evening, sir.
Today they will put leave, sir. They put Monday leave. Tomorrow will be traffic.
9 o'clock traffic will be there.
Sir, just put it in the
Then we'll do 8 o'clock.
Evening you do.
Hey Vishnu, irli bidu.
Many of them go that only, sir. Night will do. Monday leave.
Okay. So I believe we had stopped in the 7th part. 7th chapter was done. And we had also done with, what is that? General meetings chapter was done. Okay. Today we'll start with the dividends, people. When we are doing dividends, remember, whenever we are doing meetings also,
Whenever you're doing general meeting, whenever you're writing your answers in the exam, you need to make sure when you're giving a reference to general meeting, also mention SS2 mandatory. When you're writing a board meeting, give a reference to SS1. When you're giving a reference to the dividends, you can give a reference to SS3, but SS3 is as on today recommendatory, that is voluntary in nature, but not mandatory. That's what we had seen. Board's report is SS4 and SS3 is dividends. These two are voluntary and they are not mandatory in nature. Okay, now sir, coming to dividends, what are the different types of dividends? The different types of dividends are people, one is called final dividend and next one is called as interim dividend. What is the difference? A final dividend is always declared at an AGM. It is always recommended by the board of directors and it is declared by the or approved by the shareholders. Remember, a shareholder can never demand for a dividend. In one of a case law, as well as it's a question as well, they had asked, can a shareholder file a case on the directors on the grounds of operation and mismanagement that a company has not been declaring dividends? Can I file a case? The question was that the answer is no. You cannot file a case just because the directors have not been declaring dividends. Second thing, you can ask for higher dividends, but a board is not compelled to pay higher dividends. And shareholders always have a right to approve lesser dividend than what is recommended by the board. And where does the board recommend the dividend, people? Where do they recommend? It is always recommended in the board report. So before calling you for an AGM, we would have given you something called as board report. In that board report, we would have given people for the year, this is the dividend that we are going to recommend. That is where the rate of dividend will be prescribed. Yeah. Yes, sir. Okay. And what do you mean by interim dividend? Interim dividend means, people, something given between two AGMs. So it is directly recommended by the board and declared also by the board only. That's the beauty of interim dividend. Okay. So coming back to dividends sections. Okay. Section 123. What does it say? Sources of paying dividend. From where and all I can pay money? Out of the profits of the company after deducting depreciation of the current financial year profits I can pay, or of the previous financial years also. So I can utilize my free reserves. But we have condition rule 3 to be kept in mind. We'll see what does rule 3 say. Correct? Huh? When you are paying dividends out of your free reserves, we have maximum limit on what is the dividend we can pay. We'll see what is that. Free reserves does not include statutory as well as revaluation reserve. What is statutory here? Remember, if at all they're asking a practical based question, you guys will be given debenture redemption reserve, CRRs, depreciation reserves, something like that. Those and all cannot be added here. Remember, you can take that from money provided by central or state government. If at all they are providing, from that you can declare any dividend. Before declaration of any dividend, the following should be deducted or set off. What is that? Previous year losses and depreciation of previous years. If at all anything carry forward, you have to first deduct them. Declaration of dividend out of profits of previous year. People, this is important, transfer of money. Now imagine if at all I have earned 100 crore profit during the year. Can I declare entire 100 crore as profit? Can I declare the entire 100 crore profit as a dividend? Is it allowed? If my total profits for the year is 100 crore, can I declare the entire 100 crore as a dividend?
Yes.
Is allowed?
Yes.
Is it allowed? There is no requirement of transferring any minimum amount of free reserves and all. If you want, you can declare everything. But keep one thing in mind. If at all there is deposits you have taken, if you have taken debentures, you have to create DRRs. You have to first transfer money to that and then you need to create you can declare your dividends. But that you need to keep in mind. Is this clear? Okay. Declaration of dividend out of profits of previous year. Meaning, sir, I want to declare 20 crore as my dividend, but my current year profits is only 10 crore. Sir, I want to declare 20 crore as my dividend. My current year I don't have profits at all. Now, in such case, what do? They're telling you can take money from free reserves. If I'm taking money from free reserves, people, then rule 3 will apply. What does rule 3 say? Rule 3 has 3 conditions to be satisfied. So is it any one or all? You need to make sure you have to satisfy all the 3 conditions. Now what is that? Condition number 1. What is the maximum rate of dividend I can pay? The rate of dividend maximum you can pay people cannot exceed average of the dividends declared in the 3 preceding years. So whatever I've declared in the 3 preceding years, it cannot go beyond that. Yes, correct. Sir, this condition shall not apply if company has not declared dividend in the past 3 financial years. Now people will have this doubt also. Sir, what if I don't have data for any of the 3 years? We have not declared at all. Then how do I take an average? In such case, the condition 1 is not applicable. Now imagine this is my first year. You can pay 40% also because you don't have data. Clear? Okay, next one. Maximum amount that can be drawn. Now sir, you are telling that I can pay dividends out of my free reserves. Yes. Sir, very important. So, maximum amount that can be drawn. Now, I'm saying that I can pay dividend out of my free reserves. How much money I can take from free reserves? It's like my hundi. How much I can take from hundi? They're telling the maximum you can draw is 1/10 of your paid up share capital plus free reserves. Add your paid up share capital in exam, macha. You guys will feel is it paid up share or paid up equity? So pay maximum attention and go. Yes, sir. So paid up share capital plus free reserves. Answer, I can withdraw maximum 1/10. Remember people, if at all there has been any current year losses, out of the amount you have drawn, that current year losses has to be first set off. Sir, we didn't understand. Imagine I need to, in the current year I have 10 crore loss. My 1/10 of paid up share capital plus free reserve is coming to somewhere around 15 crore. So the amount I have arrived is 15 crore. 1/10 is coming to 15 crore. My current year losses is 10 crore. What I can utilize to pay dividend is maximum 5 crore. So you have to first set off your current year losses. A question can come here. If you guys remember in our class, we had seen that only. One question was there. Sir, next one, balance in reserve. After such withdrawal, now sir, you are telling I can take maximum 1/10. After taking 1/10, I need to make sure at least some money is left in my free reserves also. How much? They're telling after such withdrawal from reserve, the balance shall not fall below 15% of paid up share capital. Take your paid up share capital. Imagine my paid up share capital is, say for example, 100 crore. In this, sir, 15%, that is my 15 crore. So at least 15 crore should be there in my free reserves after me withdrawing money here. Now my question is, how much did you withdraw here? 10 How much did you withdraw? 10
15 we will try. We will do
10 5 or 15 5 10 15
15.
Matthew, what is your Red Bull saying? Correct. Remember, sir, I've withdrawn 15 year. Because current year losses you have to set off. That's the total amount you have withdrawn. Because the answer we saw was from the total money so drawn. You have to set off your losses. The money so drawn was 15 crore. Yes, sir. Exam, these are all that landmine. Pakka it will blast. Make sure your leg is not there. Clear? There, Matthew. Okay. Next one, payment of dividend. Sir, whom and all I can pay? I can pay to the registered shareholder or name appearing in the register of members. Meaning people, I can give it to BO, I can give it to RO as the case may be. The depository model, it will always be BO. To his order, if he tells me to pay to someone, I'll pay to him. This is only nothing but BO. RO always tells me to pay the dividends to BO. Next one is to his banker. I'll give my bank account details, directly will be created. Dividend can be only paid in cash. Cash here means not currency, it is bank and not in kind. So check is allowed, dividend warrant is allowed, electronic mode is allowed. Physical cash not allowed. Correct? Okay, next one. Dividend shall not be paid if company has not complied with. What is 73? You have basically 73, 74 people. You have done a violation on deposits chapter. They are telling you cannot give dividends. Next one, section 8, companies prohibited from paying any dividends. What is the maximum dividend that can be paid by a Nidhi company?
25%.
25% will be extended. 20%.
25% of what? Equity capital, huh? Then first year should be calculated only on final dividend. Even in interim dividend also it comes, no? Here. The first condition is applicable even to interim dividend also. I'll tell you indirectly. Rule 3 does not directly apply to interim dividend. I'll tell you why also. Because you cannot pay interim dividends out of your free reserves. We'll see. 25% is what you can pay. We'll see. Interim dividends are sources. Surplus in P&L account. How and all I can pay what is that? Interim dividends, sir. I told you what do you mean by surplus in P&L account mean. Profits of current financial year. I hope you guys know what is the surplus in P&L account. Sir, in my previous year end, my total profits was 100 crore. In that 20 crore I have declared as dividend. 80 crore is there. In that 80 crore, 60 crore I have transferred to. I have what is that? Provision I have transferred to free reserves. Still 20 crore is there. If the company does not transfer it or they have not made any provision for the 20 crore, we will show it as 20 crore as surplus in P&L account. What is the beauty of that? For this 20 crore, if I have to utilize, I need not take shareholders' approval for declaring dividend. So directors reserve some money in the surplus account of P&L. Whenever they want, they can declare dividends. Understood? Correct? That's the meaning of surplus in P&L account. Next one is profit of current financial year. If at all in current financial year, if you are making profit, you can declare dividends. Next one, profits generated in financial year till quarter preceding the date of declaration. What do you mean by that? Imagine if at all I want to declare dividends in my month of October. What is my previous quarter? My previous quarter is the second quarter. What is the second quarter? July, August, September. So you take from April till September, whatever is the profits you have made. Using that, you guys can declare dividends. Yes, Sam. So you can use all these things to declare dividends. But remember one thing, people, restriction during loss. So up to your preceding quarter, imagine in the current year, until the third quarter or until the second quarter, we have been doing losses. In such case, the rate of dividend shall not exceed the average rate of dividend declared in the past 3 financial years. So same thing again. So the first condition, whatever we saw there, only that condition will apply here. 1/10 or 15% and all will not apply. Why? Because here I am not touching free reserves. That will not apply to interim dividend. Clear? Pakka na? Because sources here, did we write free reserves? Have we written here? Then why will that condition apply? Rule 3 is only for free reserves, no? Hello? Machas? Okay. Clear? Okay, done. Next one is section 124. What is section 124? I told you section 124 is nothing but timeline or unpaid. What is that? Unpaid dividends account and your IEPF transfer. All these things will come here. Correct? Okay. Declaration of dividend. If I am declaring my dividend today, then what is the law say? Within 5 days, people, I need to transfer the dividend to a separate scheduled bank account. If I am declaring dividend today, I need to transfer the dividends to a different bank account within 5 days. Why this step is there? To make sure that the company does not end up utilizing that money. Once declared, you have to pay. Feeling suffocated? No. Feeling suffocated? No?
A little bit.
Keep a one speed temperature. One speed fan. And keep somewhere on 25 or 26. I think it should be fine. Deposit dividend in separate scheduled bank account. So, sir, within 5 days, deposit in a different bank account. Within 30 days, people, you have to make the payments. Yes, remember, people, if at all I am giving the dividends warrant, dividend checks and all, within 30 days, if at all I give you the check or if I give you the warrant, that is sufficient. I need not have to make the payment within 30 days. If it's NEFT and all, yes, within 30 days, payment has to be made. If it is dividend warrants and all, or if it is a check I am paying, within 30 days, if I send you, that is still considered as compliance only. Clear? Okay. Sir, next sir, within 7 days after expiry of 30 days. Now what is that sir? First within 5 days, I have to transfer it to a separate account. Within 30 days from the date of declaring dividend, it's not 5 plus 35. So 5 30. It is inclusive. It is all from the same date. Correct? Sir, now within 30 days I need to make the payment. Now within 30 days if I am not able to make the payment, sir, within 7 days from the expiry of 30 days, I have to transfer that fund into a different account, sir. That account is called as UDA, unpaid dividend account. To whosoever are the shareholders, if I am not able to make the payment to them, then what I will do, I will transfer the dividend to my account. There is a different account maintained that is called as UDA, unpaid dividend account. It's a different bank account. It will not be a general or your regular current account. So we make sure that you do not utilize that money. Okay, sir. Now, even in the 7 days, you are saying that I am transferring to unpaid dividend account. How long will the money stay in the unpaid dividend account, sir? In the unpaid dividend account, the money is going to stay there for a period of 7 years. Now, even in the 7 years, if at all the shareholder is not coming to claim the dividend, sir, now what do we do? You will transfer the money into IEPF. I'm also explaining the IEPF provision also here only. Now, once the money goes into IEPF, now what I can do? Once the money goes and sits in IEPF, people, now first of all, can the shareholder claim this money back? The answer is yes. My question is, when are you coming and claiming the money back? Is it within this 7 years? Then you can go and claim it from the company only. If it is after this 7 years, you have to write an application to IEPF. Now IEPF will transfer that application to the company. Hey company, I've received one request that they need their money, it seems. Can you look into it? The company will appoint a person called as nodal officer. We had written this in your handwritten notes, the entire process of IEPF. So you will appoint a person called as nodal officer. It can be company secretary. So the nodal officer has to do a thorough research and genuinity, verify everything. If at all he is satisfied people, then he will give his reply to the IEPF authority. Then IEPF authority will unblock your shares. They will also credit back your money also. So it can be claimed. It is possible. Clear? Yes, sir. Pakana? Okay. Next one, sir.
But that won't get, right? It won't generate interest.
It will generate. Yes, yes, yes. Because you'll see, right, what and all can be credited. In that you will see whatever is the money you earn out of these funds, that will also be credited to IEPF, right? Okay, transfer to IEPF. Sir, after 7 years, what and all I can transfer? You're saying if I'm not able to pay dividends, I have to transfer everything to IEPF. What and all I can transfer? You will transfer everything. Unpaid money, that is dividend. Interest accrued, anything on that. 7 years you have kept in the account. Some interest would have accrued, transfer that also. And even shares, sir, because no one is coming and claiming it, even the shares also will be transferred. Clear? Akana? Okay, done. Next one, sir. Section 125, IEPF fund, sir. What is IEPF fund? It's a fund created and established by central government. Sir, for this fund, from where will we get money? You will get money from grants by central government, donations given by government, General Reserve Account of Central Government, amount in IEPF under Companies Act 1956. So under Companies Act 1956, whatever fund we used to use, that has been transferred to Companies Act 2013 IEPF. So that entire fund will be transferred. Next one, interest or income received from investments made out of the fund. Income or interest. So you will receive. That will also be credited to the fund. Next one, disgorgement order money received. What is disgorgement order money? Yesterday we saw unlimited liability, disgorgement order. What is disgorgement order? Any unlawful gains made by the directors or the company, that entire money will be taken back by the government. If at all I take the money, unlawful gain you are saying, that means you are taking it from someone else's pocket. Obviously he has suffered it. That's why you always say there will be LHS equals to RHS. Where is that? Distribution to disgorgement amount to person who have suffered the loss. If I have made an illegal gain there, someone would have lost that money. So we will give that money to them. Next one, sir, unpaid dividend account. Whatever we saw, unpaid dividend amount from 124. Next one is security application money. Where did we see this? Private placement and all. If you remember, if I apply for the shares within 60 days, I need to get an allotment. Within 60 days, if I do not get an allotment, within 15 days, they need to refund the money. Within 15 days, if they do not refund the money, you guys treated that money as deposits. But what if they are not coming to collect that money at all? How long can I keep it? They're telling you keep that also for a period of 7 years. After that, transfer it. See, matured deposits. What if no one is coming to collect the money? Matured debentures, preference shares, interest accrued on all of this. What if no one is coming to collect the money? They're telling you transfer it to IPF. And next one, sir, SBO shares, section 90. What is this? Yesterday we saw, if you remember, if at all a person who is a SBO, he is not disclosing his details. Section 90 we saw the last reference. If at all the person does not disclose the details, the tribunal will transfer all that funds to IEPF in addition to the shares. Correct? Okay. Sir, now what will be the fund utilized for? Now that fund is there, no. What can I utilize that money for? Remember, they may ask you what can the funds be utilized for, or they can give you scenarios. The company wants to utilize for some purpose. Is it allowed? You need to know what and what it is allowed for. So that you guys can write whether whatever they are asking in the question, it is allowed or not allowed. Refund in respect of 7 to 11, whatever they are asking, repay. Shares they are asking, repay. Dividend they are asking after 7 years, repay. Promotion of awareness among investors, educating investors, protection of interest of investors, visa disgorgement order, reimbursement, legal expense against class action suit. We'll see what is class action suit and all. Correct? Authority to administer fund, all this is not required for us. Annual report. Okay, next one we section 126. What is 126, sir? Dividends to be held in abeyance. What is abeyance, people? Abeyance means people nothing but kept aside. Why are we keeping aside the dividends? Because now imagine there is a person called A, there is a person called B. A has transferred his shares to B by signing a form called SH4. Now this request has been given to the company to register the transfer. Now the company legally has 30 days to register the transfer. Now in 15 days, people, it has happened 15 days, the company declared dividend, but the transfer is not yet effected. But the transfer request form is given to the company. Now the question is, should I give the dividend to A or B? Whom should I give the dividend to? Should I give it to A or B? Even we don't know. Technically, they have given us the transfer form. If I don't know, then it's a different story. Now I could have updated my register of members also. But I did not do non-compliance also. Now in such case, what will happen? We'll keep this dividends aside. First, we will clear off it to everyone else. Now these peoples, we will keep it aside. We will take time. We will decide as the case may be. And then we will pay either to the transferor or the transferee as the case may be. Technically, who will be entitled, sir? Because the transfer has not yet happened. The entitlement according to the company will still be with A. But because the transfer has already happened between them, in between them, the entitlement should be always with B. Yes, sir. Pakka na? Okay. So, sir, dividend to be kept aside. So, you'll keep aside, sir. The transfer deed is delivered to the company for registration, but the transfer is not registered by the company. Dividends of such shares shall be transferred to unpaid dividend account if the shareholder has not authorized the transferee of such a dividend and kept in abeyance in relation to such shares, rights or bonus if any issued. So all the rights accruing on that shares will be kept aside. It's again getting colder.
Okay, sir.
Or keep one speed. I think you have kept it maximum speed. It's already one speed. Or increase the temperature.
I don't know. It does not.
Okay, clear. Next one, sir. Punishment for failure to distribute dividend within 30 days. Section 127, sir. Failure to distribute dividends. Is there any penalty? Yes, there is penalty. Company will be liable to a penalty of 18%
Directors can be imprisonment people, maximum 2 years, fine 1000 rupees per day for default. Correct? Huh?
1,000.
Nice. I said 1000 only. Liable for punishment, correct? But sir, every case there will be a liability, sir. There is exemption. What is that? If at all I could not pay the dividend due to operation of law. What is operation of law? Death has happened, insolvency has happened, and that's why I'm not able to pay the dividend. It's okay. Next one, shareholder direction of payment could not be complied and same has been communicated. What is that? A shareholder told to pay the dividend to out of his 3 bank accounts, he has given an instruction to pay to a particular bank account, but his bank account details he has entered wrong. Now, I was not able to pay the dividend because of that, but the company's duty is to intimate the shareholder that whatever is the instruction you gave, we were not able to comply because of whatever is the error. Until you intimate and you have to communicate. If you don't communicate, it is considered as non-compliance only. Next one, adjust against some due from shareholder. Imagine you have to pay some call money. You have not paid. We can adjust it against that. Dispute in right to receive dividend. Section 126. You are fighting. 2 brothers are fighting, or as the case may be. Obviously, I cannot pay the dividend. Next one is non-payment is due to not to the default of the company. Company did not make anything. It is some other reason. As long as you did not make any default, people, then you will not be liable. Dividend once declared will always become a debt on the company and it cannot be revoked. Yes, Sam? Pakkana? Okay. We'll just randomly see. There are the difference between interest to dividend and all. I'm not going in that. IEPF we saw. IEPF authority and all. Preservation of checks and warrants, everything has to be preserved for a period of 8 years because it will always be acting as a what is that? If someone comes and says that you have not declared, you will always have a what is that? Evidence, or else you will be liable. Next one, sir, prior intimation in case of listed company. Important. What is this? I think Chandramouli only got this question. Prior meeting of the board in that pick and speak. Correct? In some cases, when some decisions are being held, you guys have to intimate that to the stock exchanges in advance that we are going to discuss about these things in the company's meeting. Now, when is that? They are telling you people, the listed entity shall give 2 working days, excluding the date of intimation, basically clear days, prior intimation to stock exchange about the meeting of the board in which declaration or recommendation of dividend is to be considered. Correct? Yes or no? Remember, important. Types of company. Section 8 company can pay dividend. They can.
No. Prohibited.
Nidhi company. Can they pay dividend? How much? 25%. I told you the rest of it has been amended. Correct?
25% of what?
Their capital only. Can it paid up capital or paid up equity? Dividend is always a return for the equity shareholders. So it is 25% is on your whatever is the capital you hold. Yes, sir. And why don't you think it is paid up share capital? Why do you think it is only paid up equity? Why? Because in Nidhi you clearly wrote Nidhi company can never issue preference shares. So there is no point of paid up share at all. Nidhi company will always have paid up equity only. At least at the time of 2013, 14 and all it was there because in 1926 it was allowed. So transition period people might have had preference but the time period is also over. So today it is only equity. Producer companies can pay 2 types of return. One is called as limited return, next one is called as patronage bonus. One is for your share. Next one is for, now what is producer company? That agriculture related people coming together, they starting a company. Now patronage bonus means what people? Now a person can be giving 10,000 kgs of tomato. Now shareholder I give dividends, okay.
but one farmer is working way too hard. I can't give the same return to everyone, right? So in return, for whoever has given us more yield, we are going to give them more return. That is called as patronage bonus. Limited return is the dividend you are giving. The patronage bonus is the return you are giving on the yield or your association with the producer company. You have been with us for 15 years, 10 years, as the case may be. Here are company is limited by guarantee. Can we give a? Can we give a? If it's a Section 8 company, you cannot give. Correct? See, a company limited by guarantee is primarily used for non-profit. Correct? If you are using it for non-profit, you cannot. But if in a general scenario, can you? Yes, you can. Correct? Procedure for declaring dividends. What is the procedure? First, you will conduct a board meeting. Before conducting a board meeting, if you are a listed company, you need to intimate 2 days in advance to the stock exchanges. After conducting a board meeting, you will be proposing the recommended rate of dividend in your board's report that will be given to the shareholders. In the AGM, the shareholders are going to declare the dividend. They are going to approve the dividend. Once it is approved, then you need to follow everything. Within 5 days, open a separate bank account. 30 days, make the payment. Within 7 days, if at all any dividend is unclaimed, transfer it to UDA. If at all it is not collected in there also, within 7 years, you need to transfer it to IEPF. Correct? Yes, sir. And what are the procedures you will follow? Print all the dividend warrants, dividend certificates, what is that? Dividend checks, preserve everything for 8 years. All that you will follow in the procedure. Correct? Yes, sir. And closure of register. Section 91. Required noda. Why do you have to close registers? To know the record date, to know the entitlement. Or else how will I know? Every day it will be changing, no? Yes or no? Now keep these things in mind. Same thing will go for final dividend also. EPF, Secretarial SS3. Okay. Resolutions practiced are very, very important from exam point of view. Clear? Okay. That is your 8th chapter. 9th is done, Ada? We did not do 9th chapter? Sure? Okay. We didn't do 9th. Sure? Okay. Chapter 9 people, accounts and auditors. Accounts and auditors. So first one, sir, every company shall maintain books of accounts, books and papers, financial statements. Financial statements definition important. What does financial statements include? It includes balance sheet. It includes P&L. For a Section 8 company, it will be called as income and expenditure account. You will include cash flow statement. Some companies are exempted from maintaining cash flow. Who and all? Startups, small companies, dormants, correct? Remember, important. Statement of changes in equity, explanatory note. Okay, next one, sir. General requirements in preparation of books and accounts. When I'm preparing my books of accounts, what are the general requirements? First is it should be giving you a true and fair view. It should be prepared every financial year. The transactions of registered and branch office both are to be kept once in a quarter. The branch office should give their summarized returns to the principal office. If you guys have to understand, imagine Arivu, Bangalore is there, registered office, Chennai is there, Coimbatore is there. Once in a quarter, they need to give us a summary of what is happening there, income, expenditure. And once in a year, we will consolidate everything and we have to file it as a part of combined profit and losses of our main office. I will not be filing 3 different P&Ls and all. Remember. Correct? Okay. Accounts must be kept on accrual basis on double entry system. Place of maintenance of books of accounts. Where you keep it? At the registered office of the company. But can I keep it in any other place? Yes, sir. Provided I need to pass special resolution only. No, I just need to pass board resolution. Remember, sir, intimate ROC. Now, whenever I need to keep my books of accounts in some other place, can I keep it? Yes. Just that you need to pass a board resolution. That's sufficient. Sir, and remember, do not get confused this with register of members. Register of members, you need to keep it even within your city. You need to pass special resolution beyond your city. 1/10 of the members, correct? Should stay here. That stay and all will not come into picture. And wherever you want to, you can keep. But 1/10 of the board resolution. That's all is required. Special is also not required. Do not get confused. Yes, okay. Sir, and I need to intimate ROC in a form called as AOC 5. Sir, last year we had kept our books there. No, it's not no longer there. We have changed our location. We need to intimate ROC in form AOC 5. The next one, sir, books of accounts of branch officer. Whether in India or outside, the book shall be kept at branch office itself, provided summarized return shall be sent to the register office at least quarterly intervals. Correct? Okay. Next one, sir. Inspection by directors. Can I go and check them? Any director can inspect the books during the business hours. So during the business hours, I can go and inspect the books of accounts and all that. He can inspect the books of subsidiary also, provided I need an authorization by the board of directors. Meaning, my board has to authorize me to go and check the subsidiaries books. Directly, I cannot go and check. Sir, what if the financial information is maintained outside India? Of imagine any branch office or any other office, I want to go and check. Can I go and check? They're telling why the simply expense no. Instead, ask them. They will only send it to you. It has to be given to you within 15 days. Remember, the request has to be made directly. You cannot make it through any agent or anything. You should only make the request to the company. I want to check the books of accounts. Can you give me a copy?
Yeah.
Here, okay, point. Okay. Period of preservation important. I need to preserve my books of accounts, vouchers and all for a period of 8 years. Remember, in section 130 that will be important. Sir, what if central government tells no, this company has to maintain it for throughout their life? Because in the past you have a very worst track record. In such cases, I will have to maintain my books of accounts even for a period longer than 8 hours. For whatever is the tenure told to me by central government, I need to preserve it for such period. Correct? Okay. Next one, sir. Person responsible to maintain books of accounts important. They can ask you a question. End of the day, if something goes wrong, whom will I question? I can question with regards to books of accounts. My managing director, whole-time director in charge of finance, chief financial officer, any other person authorized by the board. So, end of the day, the responsibility to maintain the books of accounts is the responsibility of these people. If something goes wrong, these people are the officers in default. The penalty will be on them. Section 129 speaks about financial statements. Simultaneously, we'll see that also. Financial statements has to be circulated with the notice of general meeting. You guys should have seen that also. You written that? What and all you need to send, by when should you send? Financial statements, the board's report, the auditor's report will be sent to the shareholders 21 days prior to the date of the meeting. Along with the notice of the general meeting, you will also send financial statements, audit report, board's report to the shareholders. Correct? Yes, sir. Okay, I'll send everything, sir, 21 days prior to the date of AGM. Agreed? Okay. Sir, financial statements will be in which format? The financial statements will be in the format AOC 4. If at all XBRL, AOC 4 XBRL format will apply. If at all consolidated financial statements, if you have to file, then the format will be AOC 4 CFS, consolidated financial statements. Correct? Okay. Sir, how to maintain financial statements? True and fair.
company has to comply with accounting standards. Sir, is it mandatory to comply with accounting standards? Standard answer is yes. But if at all I am not able to comply with it, you still have an exception. What is that? You need to give a clear disclosure, as in why did you not comply with this accounting standard? You have to tell. We had to follow straight line method. We have followed written down value. You have to clearly say I have not followed accounting standard. You have to clearly say the reason, and you have to say what is the net benefit you have gained. Meaning, if you have done WDV, this would be the effect. If you have done SLM, this is the effect. What is the financial difference that you have made? You have to disclose all this. Where will you disclose all this? You will disclose all this in people board's report. जय श्री क्या गुरु நீங்க yes okay clear next one sir shall be in the format as per schedule 3 of companies act. What is the format of our financial statements? It is given in our schedule 3 of companies act. Non-applicability, sir, this section will not apply to insurance company, it will not apply to banking company, it will not apply to company engaged in supply of electricity, any other company for which financial statements are specified. So if any other company is there, if the board has authorized if they have given you how to maintain your financial statements, you maintain according to that. Yes, sir. Next one, board shall lay full documents in AGM. Sir, what and all, sir? Financial statements, the company, I have to also give consolidated financial statements of all my subsidiary and associated companies to be prepared as per the accounting standards. So a company in the AGM, now for example, people, let us take Tata Motors. Tata Motors has, now they have shareholders. I am a shareholder of Tata Motors. I'll be going to their AGM. In their AGM, they're telling me the company's financial statements they have to give. Okay, they will give. In addition to the company's financial statements, they will also give me a consolidated financial statements of all the 97 subsidiary and associate companies put together. If you remember in the class, we had seen that one report where all the financial statements were there. So that also should be given to me. Why? Remember, end of the day, the logic. We have given the money to the Tata Motors. Tata Motors is further investing in various companies. So end of the day, the entire accountability is towards me only. It is my money. So sir, they have to give me something called as consolidated financial statements in the AGM to all the shareholders. But is it mandatory for all of them to give a consolidated financial statements? Is there any exemption? Yes, there is an exemption. When, sir, it is an unlisted company or it is not in the process of listing, whether in India or outside India. So for a private company or a public company, you guys can be exempted. Next one, it's ultimate or intermediate holding company. What is this? I told you the structure. Imagine Walmart, Flipkart, and say for example Myntra. There is a chain. They're telling you if Walmart has already filed a consolidated financial statements, again Flipkart need not file because it's going to be the same. Next one, sir, it is a wholly or partly owned subsidiary of another company and all its members have given no objection on non-presentment of CFS. Now, for example, we are having a holding company. The holding, for example, take Tata Motors. I am a Tata Motors shareholder. I have said I don't mind even if Tata Motors does not give me the consolidated financial statement of its subsidiary company. I have given a no objection. Then if I have given people, it's absolutely fine. We need not worry. We need not have to prepare CFS. Clear? Okay, next one. Exemption by central government. Central government can think that any of this company need not have to follow 129. On so moto, they can say you need not have to follow. Next one, on an application by a company, and if it thinks that it involves public interest, central government only can say you need not have to follow section 129. Should every company comply with accounting standards? Any company have any exception to comply with section?
level 1, level
What is level 1, level 2?
2 in accounting. Level 1 means they have to follow all the standards.
There are exceptions. Now, as you guys have seen it in accounting standards, there are some accounting standards which is not applicable to some companies. It is according to that. Yes, company law as such here it is silent on that, but yes, you need to refer it on a complete, as a wholesome view. Yes, it cannot be the same for all the companies, right? Okay, next one, sir. Reopening of accounts, section 130. What is reopening of accounts? If at all, any of the authorities feel that some companies have not complied, probably they think that there is a mismanagement, or they think they have not prepared their financial statements accurately. There is some fraud that has happened, potential fraud. Then what does SEBI has? SEBI or any other authority, they have a right to file an application to go back in time and reopen those accounts and check if at all everything filed is accurate or not. I can go back in time and I can get it done. That entire process is called as section 130. Now, how is that done? To reopen and recast its financial statement, an application to be made by. So, see, these people, if they think a company has not done its financials properly, if I think, now it can be SEBI, central government, income tax, statutory authority, any other person concerned. I think in the exam, in the class, we had seen Satyam computers. They had inflated their financials. SEBI thought they have inflated. We have to go back in time and we have to check all their records. How many years can they go back in time? They can go back beyond up to 8 years, but not beyond that. The reason is because they need to maintain the books of accounts only for a period of 8 years. Beyond that, you will not have records. Correct? Okay. I can go back up to 8 years. Now, sir, if I have to go back, can I just go back in time, sir? Is it a time travel machine? Illa people. To go back in time, you need to file an application to a competent court or tribunal. Tribunal here is NCLT. What is competent court? What are the companies outside India? Then you will have to go to that court only. Correct? Okay. Before passing an order, it shall give notice to these people only. For example, SEBI has given an application that the company has overshot its financials. Now the tribunal will say, IT, income tax, SEBI is telling that these people have inflated their financials. Are you okay with it? For IT, for a second it will be a heart attack. Because if at all it is inflated, that means they have paid more IT. Now if at all they are recasting it, if they are rechanging it, then that means IT will go down. That means you have to refund the money. Correct? No. So IT might have objection. We never know. They will also try to prove no, what they filed is right only. Correct? They will try to prove. Okay. Only reason for reopening. Accounts were fraudulent. The company's affairs were mismanaged. Not on either reason. Note, you can only reopen for 8 years, not beyond that. But if at all CGS specifically ordered for you to maintain your accounts for more than 8 years, you can go even beyond 8 years. The next one is called as section 131. What is the difference between 130 and 131? 130 is done by the authorities. 131 is done so moto, voluntarily. We had seen Margaret company. Correct? When you have only screwed up the financials, you will have to change. You don't have a choice. You might have done a mistake, typo, error. Yesterday also one student had come. Sir, I made a mistake, sir. What to do? It's common. 100%. It will happen. He was crying and saying, sir, what to do, sir? Because you will feel onus. You will not know how to go and tell it to your senior. So they have filed different figures in the financial statements. So now it is going and sitting there. It's again a tedious process. You have to go to the tribunal. Can intern go? No, you have to tell your senior. Now senior should go and stand in tribunal. The tribunal people also will say, can't you guys see and apply? It is not the easy thing. And it's a cost only, no? You should bear everything, no? Then you can't tell it to your, that is one thing. Second thing is, imagine, can you show your face to your client? The whole purpose of them coming to you is to make financials properly. If you only screw it up, what can you go and tell? That's a problem. Okay. When to do? If board thinks financial statements or board's report, they do not comply with section 129 or 134. That means whatever the sections they are telling you, true and fair, accurate, it is not accurate now. What to do? Now it is not complying. The maximum duration, remember, if at all it is authorities, you can go up to 8 years. If it is voluntary, you can go up to only 3 years. How? Company to apply to tribunal, tribunal will again give it to all the authorities. If at all they do not reply, then it is an NOC. Then you can file an application to tribunal. Tribunal will give you an order. The tribunal's order you will forward it to ROC. Sir, it can be reopened only once in a financial year. You need to clearly give reasons for reopening in your board's report. Yes, sir. Why did you reopen? What made you reopen and all that. Limit of revision, remember you can't change everything. If at all you have given the financial statements to the members, if you have given it to ROC and if at all it is adopted in the shareholders meeting, then the revision shall be restricted to as long as you have to comply with 129, 134. Whatever is required, only that is allowed, not anything beyond that. Next one, you can make any consequential necessary alteration. What is consequential necessary alteration? Related to one another. If at all, correct. This is once again it will come in managerial director's provision. Correct? Remuneration. What is the maximum remuneration you can pay? Overall is 11%, 5%, 10%, 1%, 3%. Now what if depends upon executive, non-executive. What if this only is changing? I would have paid more, no? Consequential alterations. You have to make, you don't have a choice. Now, can I reduce my director's remuneration? You have to. It is a consequential alteration. Agreed? Okay. Next one, sir. Section 132. What is 132? 132 speaks about NAFRA, National Financial Reporting Authority. What is the main purpose of NAFRA? To advise, to issue accounting, auditing standards. They consult ICSI. They work together and they come up with your accounting standards and all that in consultation with ICSI, and CG ultimately passes it. Sir, and what is the one more thing? They monitor the the professionals, the work of the professionals. Will they monitor everyone other? Illa, only of a few people. And who are they? We'll see that. Chairperson and such part-time, full-time members not exceeding 15. They might not ask. But yes, as long as you are a chairperson or a member of NAFRA, simultaneously you are not supposed to work anywhere else. And even after you cease to be a member or you cease to be a chairperson, for the next 2 years, you are not supposed to be associated with any of the practicing firms or any such things. Correct? Functions of people make recommendation to CG on formulation of accounting and auditing policies and standards, monitor and enforce, oversee the quality of professionals. Okay, which professionals, sir? See, power to investigate, service of auditors of companies and body corporates governed by NAFRA. Meaning what, sir? Whoever are the auditors of certain companies and body corporates, their work will be investigated. Not every auditor. Only auditors of few companies and few body corporates. Now, which are those companies, sir? First one, whether you are a listed company, whether you are in India or outside India. So, if at all I am an auditor of a listed company, imagine Infosys. Now, my work will be investigated. Next one, if you are an auditor of unlisted public company, having paid up capital of minimum 500 crore, turnover of 1000 crore, aggregate of deposits of minimum. Can you just check this down? What we have written in the book? Okay. Sir, paid up capital of minimum 500 crore, turnover of minimum 1000 crore, or aggregate loan on minimum 500 crore. So what is this, sir? Nothing but if at all there is an auditor of any unlisted public company, if it's an unlisted public company having these limits, this auditor's work will be investigated by NAFRA. Next one, insurance company, banking company, company engaged in electricity, or any company under special act. If there is an auditor of that, we will be investigating that auditor. Next one, banking company or company or reference made by central government in public interest to NAFRA. Meaning what, sir? Technically, if there is any body corporate or any company, central government says from tomorrow add him also to this list. Today there is nothing, but tomorrow if central government feels, I think you should also take care of this company also. If central government recommends people, NAFRA will take care of such auditors as well. Next one, sir. A body corporate registered outside India, a body corporate registered outside India, which is a subsidiary or a associate of 1 to 4. What do you mean by that, sir? Imagine there is Jaguar, sir, which is a subsidiary or associate of 1 to 4. Listed company in India. It's there, sir, listed company ka subsidiary which is outside India. Correct, and if its income or net worth exceeds 20% of net worth of such company or such body corporate. What do you mean by that, sir? Meaning people take Tata Motors, so take Jaguar, everything, add. If at all its income or if its net worth, every company is put together. If Jaguar alone is earning 20% of its net worth or if its income, if Jaguar alone is giving it to you, something like unlisted material subsidiary companies, then people, you need to make sure the auditors of them also will come under NAFRA. Correct. Yes, sir. Is this clear? Pakka na? Okay. Next one, sir. NAFRA rules shall continue to apply for 3 years after it ceases to be listed or exceed the limit mentioned in point 2. Meaning what, sir? Imagine there is a company that is coming under these limits. Sir. Imagine 500 crore. I will repay my loan someday or the other. After I repay, this rules will not apply to me. They're telling you it will apply to you after 3 years after you cease to follow any of these limits. Every such body corporate shall inform the particulars of their auditors in Form NAFRA 1 within 30 days of commencement of these rules. Okay. If you are a general auditor, normal auditor, you will be filing your details in Form ADT 1. If NAFRA is applicable to you, you are also applying in Form NAFRA 1. Correct? Remember, penalty, sir, if at all the NAFRA people, if at all they do investigation, and if it is proven that you guys have done something non-compliance, NAFRA can impose penalty or no. And what is that, people? If at all it is an individual, imagine in a firm, is your audit firm or are you a sole proprietor? If at all you are a sole proprietor, minimum can be 1 lakh. It can go up to 5 times of the fee you guys have received as a penalty. In case of a firm, minimum is 5 lakh. It can go up to 10 times the fees you have received. Aggrieved person can always go for an appeal. Next one, sir. If at all you guys have done non-compliance, and if I feel that you should be imprisoned or you should be debarred, or you should be your certificate has to be suspended, I can do it accordingly. Debar the member or the firm from being an auditor, internal auditor, or you cannot take up any auditor. You cannot take up any valuation for a minimum of 6 months up to 10 years. I can debar you. Here, okay. Audit and annual report, because NAFRA is also a body corporate, their audit will be done by CAG. Just like any other government company or any other government body corporate. Clear? Okay, next one is financial statements, people. Financial statements. Who shall authenticate the financial statements? Important. Remember, a chairperson, if authorized by the board, or 2 directors. In that, if at all there is an MD, then MD has to sign. And if at all you guys have CEO, CFO, CS, all 3 shall sign if they are appointed. Remember, exam point of view, it is important. They will give you names and ask. Whoso and all signature is important and mandatory according to the law. Next one, sir, OPC people, only 1 director signature is sufficient. Next one, contents of board report. You will write literally everything, people. All ESOP, DVR, sweat equity, revision, voluntary revision of financial statements, everything you will write, people. Yeah, CSR and all that. Director's responsibility statement important, meaning whenever you have prepared your financial statements, the directors are under one responsibility. What is that responsibility? You have to give a specific declaration. When you prepared your financial statements, what is that you guys have kept in mind and what is that you guys have followed? I think Director Responsibility Statement, we did not write here for you. We wrote it under Annual Reports chapter. Under directors, there we have the director's report, we have written it there. Correct? We'll see it off here only, I'll again not do it there. Okay, so in director's report, people, I'll be mentioning that when I'm preparing my annual accounts, have properly followed all my accounting standards. If I have not followed, I have to give reasons for deviation and financial gain made. Directors have selected proper accounting policies that will give me true and fair view of my accounts. Next one, maintenance of adequate accounting records. 8 years, what are required to be maintained? I'm maintaining everything. Accounts are prepared as per going concern basis. Listed companies has adequate internal financial controls to stop every possible fraud and all that. Devise proper systems to ensure compliance with provisions of all applicable laws. What is that, sir? Whatever is now imagine for a listed company or for any company for that matter, there are so many laws applicable to them. What is the guarantee that the company is following every law applicable on them? So make sure there are proper devices to make sure the company is following every law. And that system is in place is what you guys are signing. That's the declaration. And these 6 things in total is called as director's responsibility statement. Exam point of view, important. They can directly ask you what is director's responsibility statement. Clear? Okay, next is section 139. How do we appoint an auditor, people? It depends upon your first auditor or your subsequent auditor. First auditor, people, if at all you are a government company, how is the auditor appointed? If at all government company, people, within 60 days of incorporation, first responsibility is on CAG. If CAG fails, people, within next 30 days, director shall appoint. If directors also fails, people, within 60 days, the member shall appoint. Even if members also fail, people die. In case of any other company, people, after incorporation, within 30 days, people, board shall appoint. If board fails, people, within 90 days, the members shall appoint. Sir, subsequent auditors, people, in the case of government company, every 180 days, every year, after the closure of financial year, every year, people, the CAG only will appoint in the case of government company. In case of other companies, people, an auditor who is appointed this year, he'll be valid for a period of at least 5 years. That's the tenure. Correct? Yes, sir. If at all audit committee is there, audit committee will recommend the appointment. If at all audit committee is not there, the directors only will recommend. Remember, people, cost auditor and secretarial auditor will be appointed by the directors, but statutory auditor will be appointed by the members. It forms part of ADDA, appointment of auditor, whereas cost auditor as well as secretarial auditor will always be appointed by the board. Yes, sir. In cost auditor, you will see that provision also. Appointment will be made by the board, but remuneration shall be ratified by the shareholders. Remember that. They can ask you. Okay, that is your people. See here. Such appointment to be filed with ROC in form ADT1 in 15 days of appointment for some specified companies. Which are that specified companies that listed in India or net worth, turnover, aggregate borrowing, banking, and all. Correct? NAFRA. In NAFRA 1 within 15 days. But there we wrote 30 days, no? Here we are writing 15 days. Why? There 30 days within commencement of those rules. This is ongoing basis. Yes, that is transitional provision. Clear? Today what is there? Today this is there. 30 days is done. Correct? Okay, next one, people. Tenure and rotation. Sir, first of all, can one auditor be auditor of the company forever? Possible, Possible, for Arivu, the same auditor is only the auditor. ever since they incorporated. Then, so for not every company this restriction is there. For a few companies there is a rotation. That is, you cannot have the same auditor forever. Which are those companies? You are a listed company, unlisted public company having capital of 10 crore or more, private company having paid up capital of 50 crore or more. All companies having public borrowing of 50 crore or more. Okay, sir. Manner of rotation. If at all you are an individual people, the maximum tenure you can be appointed is one term of 5 years. Can I be reappointed? Cool off period of 5 years. What if I am a firm? I can be appointed for 2 terms of 5 years. Can I be reappointed, sir? Yes, there has to be a 5-year cool off period. Correct? Yes. But remember, people, a firm with a common auditor cannot be appointed. Correct? And you can have more than one auditor also, it is allowed. You can have that rotation, it is possible. Okay, next one, sir. Casual vacancy, people. In case of a company whose audit is done by CAG, within 30 days of casual vacancy, CAG shall fill such vacancy. Within 30 days of, if at all CAG fails, board shall fill the vacancy. In case of other companies, people, remember, casual vacancy can happen in many ways, right? Death also is a casual vacancy. Casual vacancy will be filled by the board. But if at all casual vacancy is due to resignation, then the members have to subsequently ratify this particular appointment. Remember that, and go important from exam point of view. So, sir, within 3 months, within 30 days, people, board shall fill the casual vacancy. If casual vacancy is due to resignation now, then within 30 days, board shall fill. But within 3 months, the members has to approve. But remember, people, the auditors appointed here, they will hold the position only up to the next AGM. In the AGM, they will have to retire. Correct? Okay. Reappointment of retiring auditor. Can I reappoint the retiring auditor? On a normal note, yes. Yes, a retiring auditor may be reappointed at an AGM if he has not been disqualified. I can reappoint him. He has not given his unwillingness. He has said, I don't want to continue. Then I cannot. A special resolution is passed not to reappoint him. Then you cannot. No auditor is appointed or reappointed. The existing auditor shall continue to be the auditor. Now imagine in our case, people, Arivu, 5-year tenure is done. He is not disqualified. Rotation provision does not apply to us. Now what do we do? Automatically the same auditor will get reappointed as well. We have to file. Because it is an appointment only, right? We have to file. Yes, sir. Okay. Removal, resignation of auditor. Can we remove the auditor? Yes. Provided we need to ask someone. Who? Central government. Which form? ADD 2. Removal of auditor before expiry of his term. Pass board resolution within 30 days. You need to apply to the central government in form ADT 2. If CG also agrees, then call for a general meeting. Within 60 days of approval, pass special resolution. Remember, you need to read special notice provision also here. Removal only, no? Section 115, no? What if shareholders are giving request to remove? Correct, no? So, try to read that as well. Resignation by auditors. Can I resign? Yes, sir. Should I intimate someone? Yes, sir. Whom and all I will intimate? I will have to intimate company. I will have to intimate ROC. If at all you are a government company, you will also intimate CAG. Inform ADT 3. What is ADT 4?
If his reporting is not more than 1 crore.
Reporting of fraud, if at all amount exceeds 1 crore, where will I report it to? MCA? Central government? Chief Secretary of MCA?
Central government.
Chief Secretary of MCA. That's how you need to write. You will intimate in form ADT 4. You will file it as a form. You will also give it in a sealed envelope. Okay. Eligibility, qualification, disqualification of auditor people. Qualification. A CA, a firm, majority of partners to be a CA. They can be appointed. Remember, it has to be a sole proprietor. Partnership firm is allowed. LLP is allowed, but you cannot be a company. That is your disqualification. A body corporate cannot be auditor. Officer or employee of the company. Your own officers or your own employee cannot be an auditor. That's like you correcting your own papers. partner or employment of officer or employee of the company. What is that, sir? Imagine in my company, whoever is the officer or employee. In my company, there are officers. Imagine my director. My director has a partnership firm. In that partnership firm, if he has any partners working along with him, now imagine Reliance. There is Mukesh Ambani, the director. Mukesh Ambani has one more partnership firm. Let us imagine. In that partnership firm, if at all there is any auditor, imagine if there is a partner, that partner cannot be an auditor of this company. If Mukesh Ambani has some other company, any employees working there cannot be the auditor of my company. Clear? Okay. Person who can a friend be auditor? Yes, there is no disqualification as such. A person who renders services under section 144. What is given in 144? Investment banking or what is that? Investment consultants. You cannot be what is that? Outsourcing of financial services and accounting management services. Correct? Investment advisory services and what is that? Actuary services. If at all you are doing all that, people, then you cannot you cannot be the auditor. Agreed? Yes, sir. Okay, person who renders service under section 144. A person or firm has direct or indirect business relationship with cash. Meaning we have a business relationship. We have rented a property. Now, for example, people, there is Prestige. Now, Prestige, anyone can rent their property. Even I rented. My question is, that's a business relationship. To know that, the first question, is it your ordinary course of business? Renting of a property, if it's my ordinary course of business, what is the rent you give it to an outsider? I give it at 40k. How much you are giving it to the auditor? I'm giving it at 40k only. Arm's length basis, ordinary course of business, it is not considered as a disqualification. You can still enter into a contract. That's the meaning of ordinary course, and that's the meaning of arm's length basis. Whatever is the money you take from an outsider, you have to take the same money. Second thing, people, it has to be a regular course of business. If that is what you did it to your auditor, then it's absolutely fine. I told you the example of a Geo, SIM card and all that. Next one, people, a person is relation or a partner. If at all you are holding any security in cash, security, any share in cash, then people, you cannot be a auditor. Provided, sir, if at all you are a relative, you can hold up to 1 lakh. An auditor cannot even hold 10 rupees also, disqualified. Correct? Sir, security by relatives. Is all the relatives put together 1 lakh? Yes, everyone put together it is 1 lakh, not individually. Next one, sir, indebted to cash. Meaning, sir, I have taken money, I have to repay loan in excess of 5 lakh, disqualified. Guarantee excess of 1 lakh, disqualified. Meaning someone has taken loan, but I have given guarantee. If he doesn't pay, I will pay. Next one, person whose relative is director or KMP. A person whose relative is director or KMP. Meaning, people, if Mukesh Ambani is a director, Mukesh Ambani's relatives cannot become an auditor. Okay. Next one, person or partner holding more than 20 companies as auditor. Meaning the maximum one partner can take up audit assignments cannot be more than 20. But in this 20 people, some companies are not included. What are those? Dormant company, small company, OPC, a private company having a paid up share capital less than 100 crore. These companies are not counted in this limit. Meaning you can be an auditor of 100 small companies also. Correct? Okay. Next one, sir. Vacancy in office, people. It has to be filled. Casual vacancy, if anything, you should fill it. Okay. Same thing will again apply. Okay. If at all there is any disqualification, you will have to vacate the office. It will become casual, again it fill it again. Reporting of fraud, people. If fraud is 1 crore or more, people, within 2 days of the knowledge, people, 1 crore or more. So 1 crore is here. Less than 1 crore will come as your board's report. So if it is more than 1 crore, people, the day the auditor gets to know about it, within 2 days, he has to file a report to the company. The company has to reply within 45 days. My report and the reply, I have to forward to the central government. Exactly to whom, sir? To the secretary MCA in sealed envelope and by an email in format ADT4. What and all I will forward, sir. His report, reply, and if no reply, I'll mention that also. Sir, if it is less than 1 crore, sir, I'll clearly tell to the company, I'll give it to the audit committee or the directors. In the year, you guys have, there is a fraud. Nature, what type of fraud it is. Next one, amount involved and the parties involved in the fraud. Remember in your director's report, you need to give all these three plus one more. What is the remedial action you have taken? Because the auditor has pointed out the mistake. What is the remedial action you have taken? You need to give it in your board's report. Correct? Yes, sir. Okay. Remember. The same process is for cost and secretarial auditor as well. Correct? Okay. The next one we'll see of cost auditor. Cost records, cost auditor, and secretarial audit. Okay. Next one, sir. Cost records people. Rule 3. Everyone should maintain cost records. No, it is mandatory for companies engaged in production or supply of goods and services. Example, telecommunication, electricity, drugs, pharmacies, all that. Having, not everyone, overall turnover of rupees 35 crore or more in the preceding financial year, they have to include cost record in their books of accounts. Correct?
Yes.
Okay. Next one, sir. Format and content people, your cost records will be in the format CRA1. What and all I need to maintain in my cost record? Cost of operation, cost of sales, your profit margin, and production cost, all that. Exception, micro and small enterprises are exempted from cost records, MSMEs. Next one is cost auditor. That is like books of accounts. This is cost auditor. Applicability, companies covered under Rule 3 and Rule 4, they have to mandatorily get their cost records audited. Procedure people, how? Board of director will appoint, remuneration shall be fixed by the board, but it has to be ratified by the shareholders. That is important. Notice of appointment shall be filed by with CGA in form CRA 2. That's the appointment. Within 30 days of the board meeting or within 180 days of commencement of financial year, whichever is earlier, you guys need to appoint the cost auditor. Tenure people till the expiry of 180 days from the closure of financial year or till he submits the cost audit report. Remember, the cost audit report has to be submitted within 180 days of closure of financial year. So technically, it will not go beyond 180 days. That's a tenure. Every year you will appoint the cost auditor. Removal people, if board thinks they can file, they can remove him and they can fill the casual vacancy and then again file, they can CRA 2. Removal, again power is given to the board only, they can remove. Same with secretarial auditor also. You can be removed by the board only. Next one, sir, cost auditor. Who and all should get their cost records audited? Cost auditor. Sir, I can categorize this into two sectors. So one is regulated sector and next one is non-regulated sector. Regulated sector people, who and all will come here? Companies having overall turnover of all their products and services of 50 crore or more and aggregate of individual product or services people 25 crore or more. What is this example I told you? Pharmacy, Apollo. Apollo will have what is that? Service also, operations, your OPD, lab tests and tablets, everything will be there. Overall people 50 crore, everything put together. Individual people 25 crore, meaning only services, only goods. If that is the case, then this cost record will apply to you. Cost audit has to be done. If you are a non-regulated sector people, overall turnover of company of all products and services 100 crore, aggregate people 35 crore or more of individual one. Then people cost audit will apply to me. Exception, it will not apply to whom and all. Revenue from exports, if it is 75% of my total revenue, I am into exports, then cost audit will not apply to me. If at all I am operating in SEZ, cost audit will not apply to me. Engaged in generation of electricity for captive consumption. What is captive consumption? I am not selling it. I am utilizing it for my own purpose. Solar panels I am having. So if that is the case, then this particular thing will not apply to me. Yes, sir. Sir, cost record, when should I submit, sir? I have to submit it people within 180 days of closure of financial year. I'll have to submit in the form CRA 3. I'll give it to the board of directors of the company. they will have to further forward it to the central government in CRA for XBRL. Correct? Yes, sir. Okay. The last one is secretarial audit. That's the by default format for that. Yes, sir. Okay. Next one is secretarial audit, sir. Secretarial audit, for whom and all it is applicable, people. First of all, we'll see of applicability only. For every listed company, who will do a secretarial audit? A practicing company secretary will take up a secretarial auditor. Who will appoint you? Board of directors only. Yes, sir. And secretarial audit is given in which form? MR3. Okay. It is always addressed to the shareholders. Every unlisted public company having paid up capital of 50 crore or more, turnover of 250 crore or more, every company having outstanding loans and borrowings from banks and public financial institutions of 100 crore or more, for such companies, secretarial audit shall apply. Correct? Pakana. As per listed company, we wrote something else also. What is that? For listed company people, listed companies, secretarial audit will apply. Along with that, for listed companies, all the material unlisted subsidiaries also secretarial audit will apply. Listed companies and material subsidiaries, unlisted material subsidiary companies, for them also you need to get your secretarial audit. And we wrote one more thing also. For listed companies, there is something called a secretarial compliance report. What is secretarial compliance report? What is secretarial audit report?
If they have followed all the forms they have taken, all the laws and the
No, what is secretarial auditor?
audit, means they check whether it is.
Secretarial audit people, you will check whether the company has complied with all the laws applicable on the company or not. That's the role of a PCS. But for me, imagine people, some 50 laws will apply. Have I followed all the 50 laws? I will check. In the case of secretarial compliance report people, I will check whether all the SEBI related guidelines, laws, regulations has a company complied with. Secretarial compliance report is applicable only to a listed company. And what is secretarial compliance report? It is a report given by the PCS only, saying that whether the company has followed with all the SEBI related requirements. It can be law, regulation, it can be act, it can be guidelines, it can be notification, amendments. Only SEBI related. Okay, na? 100% na? Okay, that is your secretarial compliance report. Okay, that's all. Anything else? Clear? We have covered most of it.
Yes, sir.
Okay. Remember. Okay. Next we'll take up which one? Chapter 9 done, na?
Yeah.
Chapter 10 only we'll do off, huh? Okay. Compromise arrangement, amalgamation we'll do what? Big one, huh?
So we have not written it. You have given us.
I mean, this, I think I've given you chart. Yes, sir, we'll do this one, we'll do another chapter. Okay. Easy chapter, huh?
No.
This is not easy, huh? We'll do easy chapter or what?
You can do that 11.
Dormant company will do, huh?
That inspection inquiry and
Ask your friends. At least compromise they will remember. I know inspection inquiry is a complete bouncer only. Huh? Okay, we'll do of dormant company. Children chapter will do of.
Yes, sir.
Okay, we'll do dormant company. We'll take a small break. Okay, people. Dormant company people, chapter 11 now. What is dormant company? Any company people which is formed for a future project and which does not have a significant accounting transaction, and a company which is incorporated to hold any asset or intellectual property and it does not have a significant accounting transaction. whether formed for a future project and no significant accounting transaction, or formed for holding an asset and no significant accounting transaction, you will be called as a dormant company. And any other place, yes, sir, a company which is inactive. When will I become inactive? If at all it is not carrying on any business or operations or not made any significant accounting transaction in the last 2 previous years and not filed financial statements and annual returns during the last 2 financial years, people, you will be called as a inactive company. Sir, now my question is, sir, what do you mean by significant accounting transaction? Technically, what is dormant company? People, dormant company means nothing but I have been registered, but currently I don't have any business operations happening in the company. Why should I do all the compliances? So there will be some ease of compliances. I will be exempted from some requirements like board meeting, cash flow statements. I'm exempted from all of this. It's end of the day benefit only, no? So you can apply for dormant status. Provided your company should not have any significant accounting transaction. Now, what do you mean by significant accounting? They are telling me significant accounting transaction means you are spending some sizable amount. That means you are working. Then why should I give you dormant status? So they defined a significant accounting transaction means a transaction other than these. So whatever is given here is not significant accounting transaction. If there is any transaction other than this, it is a significant accounting transaction, you cannot get dormant status. Yeah. Okay. First one, what is that? Payment of fees to ROC. Payment of fees to ROC. If at all you have to make any filings, you have to pay some fees, right? Charge. You would have paid some fees. Forget about that. For doing this dormant status only, you need to pay fees. Now, should I consider this as a dormant status or not? Is it allowed or not? They're saying it is allowed. You have to pay. It is part of your regulatory requirements. It is not significant accounting transaction. Next one, payment made by company to fulfill requirement of this act or any other law. For example, professional fees paid, audit fees paid. Audit is still mandatory even when you are under dormant status. Financial statements does not include cash flow statement, but what about P&L? What about balance sheet? Someone has to give you a nil statement that there is no operation. Someone has to give you, he will take money. Allowed. Correct? Yes, sir. Next one, sir. Allotment of shares to fulfill requirement of this act. Remember, when dormant status is going on, you are free to file PAS3. Allotments can be done. It is fine. It is allowed. And change of directors can it happen? Change of director can also happen. Allowed. Remember, clear? Maintenance of office and records. I can pay electricity. Possible. Some minimum thing will come. Rent. Possible. I have to pay. So those things are allowed. Yes, Sam. Any other things, sir, it is considered as significant accounting transaction. If it is significant accounting transaction, I cannot apply for a dormant status. Correct? Okay. Compliances to be followed by dormant company. It should have minimum number of directors. Required. They can ask you. It should still have the word public, private, OPCA. Mandatory. Correct? Yes, sir. They can file dormant status company. Return of dormant company to be filed annually in MS3A. What is return of dormant? What is the maximum term a company can remain dormant? Dormant means inactive. 5 years. 5 consecutive financial years. Beyond that also, if I am dormant, people, I might end up striking off my company. Beyond 5 years, you cannot continue. Now, what is the guarantee in these 5 years? There is no significant accounting transaction. When you applied, you did not have. But in this 5 years, there can be, right? Every year, you need to file a form called as MSC3. Again, it has to be audited by CA. I have to pay. Correct? So, next one, conduct minimum 1 board meeting in a year. Next one, company shall file return to ROC in case of change in directors, allotment of securities. DIR 12 and PAS 3 allowed. Correct? Half of the calendar year. In a year, 2 board meetings. Again, same thing. Maximum gap between, minimum gap between 2 meetings should be at least 90 days. Okay, application for dormancy status, sir. How can I become dormant, people? I can become on my own or I can become mandatory by ROC. When failure of your filing of your financial statements and your annual returns, ROC only can give you dormant status. Okay. One people on my own. How to apply people? Which is a form da? MSA? One. Conduct board meeting and approve the resolution and call for a general meeting. Obtain the statement of affairs from a CA. Nil statements. 0. Conduct a general meeting, pass special resolution, file MGT 14 within 30 days because MGT 14. MSC 1 with ROC. Attachments people, copy of special resolution, copy of statement of affairs which is given by CA, declaration by directors and other necessary documents if any. If ROC is satisfied, he will give you MSC 2. That's only nothing but a dormant status. Now when a dormant status is given people, what are the grounds considered by ROC when giving you dormant status? First one, whenever any inspection, inquiry or investigation, chapter number 12, if that is happening people, dormant status not allowed. Next one, prosecution is pending against the company, hearing, case is going on. Public deposits are outstanding or default in payment. Section 76, you have taken deposits from public. Outstanding loan can apply for getting an NOC attachment in MSC 1. Any outstanding loan, you can apply, but you need to get an NOC. No dispute in management or ownership supported by certificate. You should be in talkative terms. Listed company in or outside India cannot apply for dormant status. Default in paying outstanding workman dues not allowed. Outstanding taxes, duties, cess and all if you have not paid not allowed. Maximum allowed period is your 5 years, beyond which people can be stuck off. Yes, sir. So within 5 years you have to apply for active status. Which form? MSc 4. Correct? Okay. Remember all forms important. Next one, sir. ROC people. If company has not filed financial statements or annual returns for 2 consecutive financial years, ROC can allot you dormancy status after giving a notice and entry company's name in register of dormant. Correct? Okay. Next. How do I seek active status people? MSc
Active state.
MSc 5 is a certificate given. Dormant company voluntarily will file form MSc 4 and MSc 3. What is 3? Statement of affairs given by CA. Correct? No? Basically statement of affairs. Yes. ROC, he shall change the status to MSc 5 certificate of active status. Mandatory active status, if at all company has violated or if ROC only gets to know that you have been functioning, then we will give you active status. Correct? You guys want a break or what do we do?
Yes, sir.
You break, sir. My God. Okay, go. After the break, we'll do some heavy chapter. Then these companies will come under section 232, 232. Mergers will come under 232. Imagine there is only compromise. You guys will come under 230. Correct? Yes, sir. Now, one of a student was also asking, sir, there is one of the student was also asking me, what is that? How is it different from capital reduction? Compromise, that is also capital reduction only. Capital reduction is also like that only, no? We are calling for a meeting, we are discussing NCLT, special resolution, that is also similar only, no? 66. That is also somewhere similar only, no? Then what is the difference between that and this? Here, there we did not see creditors. Capital reduction, you know, capital. It is always the shareholders. Here, creditors can come, debenture holders can come, everyone can come here. That's the ambit is huge here. Getting a point, huh? Okay. So what has happened, sir? Let us imagine we have taken a debt, we are not able to repay. We have to restructure our debt. Basically, I am asking Vijay Mallya, sir, 9,000 crore I need to repay. I cannot repay 9,000 crore. Can I pay 5,000 crore and can we settle this ano? Now, if that is the case, if the banks are okay with it and if the company is okay with it, people, now what you guys enter into is called as compromise. Clear? If a compromise application includes merger,
or if it is a merger, you guys will follow this and 232. Yeah. Okay, we'll see. Power to compromise or make arrangement with C members and creators. Correct? Huh? An application filed by applicant. Who can the applicant be? Company, creditor, member, liquidator in case of winding up. Now all these companies, all these people can file an application to NCLT. Sir, we are planning for a compromise. Please consider it. So we are planning for compromise, arrangement, takeover. Takeover is basically added recently, 5 years back. Between company and between whom is this compromise? Between the company, Kingfisher. Let us imagine Kingfisher is only applied. Between Kingfisher and creditors or class of creditors. Creditors include everyone. Class means only one particular. Or members and class of members. Yes, Sam. So, sir, we are entering into a compromise, arrangement, or a takeover. Okay, sir. We will file an application with the NCLT. Along with the application, sir, we have to disclose all the material facts. Why? What? Give me your financials. Give me your creditors. Give me your audit reports. Give me entire details. Scheme of corporate debt restructuring. You are considering for a restructuring, right? Show me how does it look. So you give everything. And consented by 75% of the secured creditors in value, including creditors' responsibility statements, valuation reports, etc. What is valuation report? As on today, what is the value? It can be share, it can be the company, everything, have everything handy. Protection for other secured and unsecured creditors. NOC. What if they do not agree and all that? So we are giving an application to NCLT. Now what will NCLT do? NCLT will tell the company to conduct a meeting. Ivella yak macha panchayati. Call for panchayati. Call everyone. Let us sort it out. So people, NCLT shall order to conduct a meeting for which a notice of meeting shall be sent to. To whom and all should I send? Subsections important. Section 230, subsection 3 says the notice of calling the meeting should be sent to creditors, mitro, members, our mitro, debenture holders individually. In addition, sir, 235 says, what did authorities do? I have to give it to them also, no? Give it to Yapar even, SEBI, IT authorities, ROCs, stock exchanges, sectoral regulators, Belpore, Anna Oktira, Anna, come here, give it to everyone. You never know, they can have a no objection. Now, sir, if at all people, 233, 235, if at all they have, these people will have meeting, we'll come back to them. But these people are not allowed in the meeting. So, but if they have any representations, objections, they have to give their objections within 30 days. If no objections are given, then consent is presumed. Agreed? So 230, 233, 5 is giving notices. Next one, sir, 236. Now, sir, the scheme is to be approved. How many people should agree for the scheme to be approved? Sir, we need to get to two things, much important. Majority of person representing 3/4 in value. Majority of person representing 3/4 in value. Similar to your shorter notice consent. Correct? Majority also. There. That also. This also. That also. This also. Correct? Majority number 3/4 in value. So now imagine if there are 10 people. 6 people have to at least agree. And then 6 people should hold at least 3/4. Okay. Sir, if it is creditors compromise, creditors will agree. Members compromise, members will agree. Okay. Sir, what if I am not okay with it? Can I object? Yes, it seems. How many people should object, sir? If it is members, members holding 10% of shareholding, they have to object. If it is creditors, sir, minimum 5% of total outstanding debt. This app is good, hey. शेयर बनाने गए हमारा हैंड राइटिंग ऐसा एलिवेट होता है अब ओके ஓ மேட்ச் த ஃபாலோயிங் ஆன் ஸ்ட்ரெயிட் லைன்ஸ் வில் கம் டுடே வை எப்படி ஓகே now people next one members 10% should object the scheme If it is creditors, 5% should object the scheme. Okay. Now, sir, tribunal may dispense with calling of a meeting of creditors. Meaning, I have to conduct the meeting of creditors. No, I can say do not conduct. When if 90% of creditors in value agree for this compromise well in advance, they're telling people you need not conduct a creditors meeting. Correct? Why? Because the approval you need is just a majority number and 3/4 in value. When I'm getting 90%, then why do I have to conduct? Sir, where should I give this? Wherever you're giving this application, no. NCLT, there only you guys have to give this particular approval by your creditors as well. Understood? Pakkana? Okay. So if that is the case, people, then the conducting of the meeting can be dispensed with. Okay. Now, sir, all the notices shall also be placed on website and newspaper as well. Okay. Now, sir, if where is it? Such approved scheme shall be forwarded to NCLT. Assuming they agreed it, we forward it to them. We agreed for the creditors had to be repaid 9,000 crore. We agreed to, we negotiated to 7,000 crore. The creditors agreed. Now the agreed scheme will be sent to NCLT. NCLT will order for go ahead. I'm happy with it. Now people, whatever NCLT says, that will be final. So sir, if scheme is converting preference to equity, imagine if that is a scheme. Then an option is given to the preference shareholders. What? Dividends, cumulative dividends. If at all it is not paid, an option will be given to the shareholders whether you want to take it now, take it in cash, or you can even convert that arrears of dividends also to equity. That option will be given to you. Second one, protection of any class of creditors. If they say, sir, yo, what if 7,000 also tomorrow they again come and says compromise? So make us secured creditors. If I say you have to give next one, if scheme results in variation of shareholder rights, macha, scheme results in variation of shareholder rights, you have to follow section 48. How do you do it? Issued share capital 3/4 or consent special resolution affects other rights, 10% scheme, correct? Objection. Scheme is approved by creditors, proceedings before BIFR shall stop. Today BIFR is no longer there. Board for Industry and Financial Reconstruction is no longer there, of course, now. Exit offer to dissenting shareholders, people who do not agree, you have to give them a way out. Within 30 days, file everything with ROC. This is section 230. Correct? Yes, sir. Okay. Now, sir, I have approved the scheme. NCLT has approved the scheme. Now, what is a guarantee that the company is following everything as per the scheme? What is the guarantee? Now, sir, NCLT has a power to supervise the scheme. If at all I get to know that the scheme is not being implemented as it is, there is some changes required. NCLT also has a power to modify the scheme. If I think, hey, you can operate whatever I do today, agala kano. If at all I think that people, then I can say, macha, just leave it. You maga bitpudu. Bittudunga. Understood? So people, that time you will end up in winding up. I have this option to wind your company. So sir, section 231, power of tribunal to enforce compromise and arrangement. Section 231, NCLT has a power to supervise the implementation, supervise the modify. Next one, people, satisfied that company cannot do this, it may order for winding up. Now sir, next one, sir, 232. 232 people, whenever two companies enters into mergers or amalgamation, sir, you have to comply with section 232. So whenever an application is filed under section 230, if at all there is a merger involved in an application, you need to follow 230 also and 232 also. Correct? Yes, sir. Okay. So where an application made under section 230 involves merger or amalgamation of companies, which involves transfer of undertakings, properties, liabilities of transferor to transferee, then the tribunal shall direct to comply with 232 also and 233 to 236 also. What is 233? Giving of individual notices to your creditors, debenture holders, shareholders. What is 235? 235 is giving notice to the authorities. What is 234? Meeting. What is 236? One is consent, one is objection. One is 3/4 in, majority number, 3/4 in value. One is 10%, 5%. Objection of the scheme. All that will mutandis will apply here as well. Clear? Hello? Nandanu, start recording madwa. Okay. Yes, sir. Next one, people. In addition to notice specified at 233, the following documents shall also be circulated. There we saw no CAA, valuation report, creators, all that. In addition to that, draft of the proposed terms of the merging companies. What is this? For one share, what will you get? What value it is done? Share swap. If I take your equity, what will I give in return? Everything will be discussed. What are one idea? Best example, no? What will each of the companies get? Now you take mine. I had shares in Vodafone. Now what will I get in settlement? How many shares? All that they have to keep in mind. Now what will be my control? In Vodafone mine was 50%. In Vodafone idea will it be 50? Obviously no. So all that will form part of this particular scheme. And all of us should be okay with it. And that shares are so terribly falling. Now though it is terribly falling. But we can't do anything. Confirmation of the draft scheme with ROC. We have to file it with ROC. What is this? The ROC will be seeing effect of compromise on shareholder, KMP, promoter, non-promoters. What is this? I can also say this is nothing but explanatory statement also, no? Yes. Valuation report. Effect of compromise on shareholders, KMP, promoter, non-promoter. Valuation report. Supplementary accounting statements. You have to basically give all the documents. Tribunal is satisfied, sir. The tribunal will make an order that yes, you can go ahead with the merger or amalgamation. From the day of the tribunal's order, what and all will take effect? From the day of the tribunal's order, people, they will have an effective date as the merger or amalgamation day. From that day, all my assets will become the assets of the transferee company. Liabilities will get transferred. Employees will get transferred. Any pending cases will get transferred. Charges will also, everything will get transferred, sir. What about, let us imagine transferor company was a listed company. Transferee company is an unlisted company. Now, because transferor company is getting merged with transferee company, will the transferee company become a listed company?
No.
The answer is no. You have to specifically apply for the listing status. Agreed? And of course, we will give you the proportion of allotment of shares. What you will get, what I will get. In short, it's nothing but purchase consideration. Transfer of undertaking, allotment of shares, and continuation of legal proceedings, dissolution without winding up. What is the dissolution without winding up? Today, Vodafone and Idea, individually, do they exist? No, because everything has been transferred to VI. Now, is there liquidation? Did it happen there? No, everything transferred here. Individually, all the liabilities became this. All the assets now belong to Vodafone Idea. Now, what happened to Vodafone individual, Idea individually? They just shut down their business. That's all. Correct now? Transfer of employees. If transferor is a listed company, same thing. Exit option to dissenting shareholders. The fees paid by authorized capital. Correct? Vodafone authorized capital, let us imagine, was 100 crore. Ideas authorized capital is 100 crore. Now, Vodafone Ideas will become 200 crore. I need not pay my stamp duty and all again. Correct? Okay. Now, sir, the certified copy of the order of tribunal shall be filed with ROC for registration within 30 days. Same thing, no? Whenever any authorities give you an order, you have to forward it to ROC. We generally use the form INC 28. The scheme shall indicate an appointed date. What is the effective date? The scheme will have it from this day the merger will take place. Until the completion of the scheme, every company shall file statement with ROC every year certified by PCA, PCS, PCMA, indicating whether scheme is being compiled as per the tribunal order or not. Every year, imagine it takes 2 years. Have to say, sir, everything is going on as per the order passed by tribunal. That is 232. Any doubts? Any doubts? No. Sir, next one 233. At times, we might have people, some small companies or startups or holding company and its subsidiary company. In such cases, why should I follow 232? Don't I have a shortcut? They have given you a shortcut, sir, for merger. That merger shortcut only is called as 233. 233 is nothing but people a fast track merger. So can every company come under 233? Hey, illada, every company can't come. Only a few companies can come. Which are the few companies? Earlier it was holding company and its wholly owned subsidiary. 2 or more small companies, that is what was earlier. Now they have added startup also to that list. So it can be between two startups, or it can be between a startup and a small company, as the case may be. Clear? Yes, sir. Okay. So now they can enter into a fast track. Yes. What is the advantage? Time saving. You need not have to follow that majority. All that time is saved, provided you guys know that your scheme will not be denied by your shareholders. If that is the case, you can go through easily. If not, people, 233 will not be a fast track route. Clear? Sir, I have one question, sir. Imagine I'm a small company. Imagine if I'm entering into a merger? Should I come under 232 or should I come under 233 if I'm a small company? 233? Remember, it's always an option you have to choose. You can come under 232 also, you can come under 233 also. How is that, sir? What if you'll be seeing here, you need to get 90% approval and all. But under 232, 75% is sufficient for me. So if that is the case, I can go under 232. Correct now? Okay, now see here. What is the procedure? Every company, imagine sir, there is a merger happening between two small companies. Let us imagine XYZ and ABC. Every company, transferor and transferee, shall formulate a scheme. Such scheme shall be sent for objections. It will be sent to ROC, liquidator, and person who shall be affected. It can be creditors, shareholders. For every one, we will give it this particular scheme. And transferor will also give, transferee will also give. For vice, sir, we are giving it for objections or any suggestions. Now let us imagine ROC or liquidator, they will give us some suggestions. Change this, change that. We will consider that people, such suggestions will be considered and we will make alteration. And now we will consider that in general meeting and such scheme shall be approved by members holding 90% of total number of shares and majority representing 9/10 in value of creditors. So now once whatever the suggestions they have given, we will take it in our meeting. I'll have to take their approvals. Now once I take their approvals, now because our people can also suggest some changes. Now I'll consider those changes also. Now I will forward my approved final scheme to ROC and liquidator and to the central government. If ROC and liquidator find some mistakes still, they will give their objections to the central government. If at all they don't have any objection, people, then they will show no objection. If there is no objection, people, then CB shall issue a confirmation. You guys can go ahead with the merger. Then people will take that and will forward that central government's order to ROC. Sir, what if ROC and liquidator shows some objection? CG will also think, is this particular merger in the public interest or is there anything getting violated? We will also consider that. If CG is also satisfied, no, as ROC liquidator rightly said, there has to be opposition. Then CG will say, do one thing, don't come under 233, that is, don't come under shortcut, come under your long route only, go through 232. Sir, net effect, what is the difference between 232 and 233? People remember, 232 is always like a court route. You have to wait for your hearing date. Time taken is more. 233 is still with governments. CG can outsource it to RT. It can be done instantaneously. That's why we call it as fast track. Compared to a court, government is always a little more faster and reachable because you know court, you know how many cases will be pending. That's not the case with CG. Clear up? Yes, sir. Okay. Now, sir, the registered scheme shall transfer property liabilities. The charges shall continue. Exit opportunity for people you do not agree. Authorized capital, all that will get adjusted as the case may be. Company can at its discretion follow 230 or 232. Here for 233. or 232. Clear? Yes, sir. Okay. Next one, sir. Section 235. What is 235, sir? Power to acquire shares of dissenting shareholders from scheme, that is contract approved by majority. What is this, sir? Now let us imagine people, there is a company. Let us take for example, there is Big Basket and there is Tata. Tata wanted to acquire Big Basket. Now they gave their proposal, they gave their scheme to Big Basket. We want to acquire you. Are you guys interested? Now Big Basket people said yes, we are interested. But how many people said yes? We expected some 51%, 52%. But Big Basket, 90% of the people showed interest. We are okay. Please acquire our company. Now people, whenever Tata is acquiring as high as 90 percentage, law says, then do one thing, the 90 is a very high percentage. Try your best to acquire the next 10 percentage also. Because tomorrow the 10 percentage people only will do kirkiri. Correct? No, minority. Everywhere they are reflecting. Instead, avoid these disputes. Acquire of that also. That is only people 235. We'll see that. That's why we are calling it as dissenting shareholders. Here, dissenting means they did not agree. 90 agreed, right? So now, Tata will try their best to acquire the rest of the 10%. Here, yes, sir. Now, how will that take place here? A scheme involving transfer of shares. Correct? Big Basket is transferring their shares to Tata. In a company which is approved by majority. Majority is also how much? Holders of 9/10 in value have agreed for this particular transfer. In such case, people, now what will happen? See here, 9/10 received in 4 months. Tata made a request to Big Basket. We are okay to buy your company. Are you guys interested? From the day we made a request, within 4 months, we got a approval from you guys. 9/10 of the people agreed within 4 months. Sir, what if 9/10 of the people did not agree in 4 months? That's all people, 235 comes to an end. Getting the point? If at all 4 months you get 9/10, only then you will go forward. Okay. Sir, now 9/10 we got in 4 months. Now what we will do? Whenever you get 9/10 people, within the next 2 months, after expiry of 4 months, we will give another notice saying, people, hey, you dissenting shareholders, because we have got an approval from such majority people, what will you guys do? Tomorrow you will only show some kirkiri, reconsider the offer. Why don't you guys also transfer it? A specific offer is given to them. They have 2 months time to transfer their shares. So within 2 months, people, what is it? Transfer within 2 months after the expiry of 4 months, transferee company shall send. Tata will send another notice to acquire the shares of the dissenting shareholders of Big Basket. Agreed? Yes. Okay. Within 1 month of transferee company giving notice, I have given notice now. Correct? I hope you are getting, people. 4 months. 4 months is done. Once 4 months is done, 2 months time is there for me to give the notice. Now within 2 months, I have given the notice. Within 1 month, people, the dissenting shareholders, within 1 month of transferee company giving notice, they may apply to tribunal. Now imagine, people, the 10% people, they are not okay. We want to continue. Why are you saying get out? We want to continue. They can go for a tribunal and they can go for an appeal. If tribunal people passes an order, hey, why are you simply behind them? Leave it. They will be on their own. If tribunal says so, that's all, people, the section comes to an end. Meaning tribunal will say, hey Tata, don't acquire that minority people. Don't do it. Don't acquire the dissenting shareholders. If that is the order, people, Tatas won't acquire the dissenting shareholders. If at all tribunal says, no, dissenting shareholders, tomorrow you guys only will come and waste my time also. If I feel so, then I will tell you to transfer. You have to transfer. You don't have a choice. Here, so according to what the tribunal say, people, the dissenting shareholders will have to take a call. Yes, sir. Now, sir, see, the transferee company is entitled and bound to acquire those shares on terms of approving shareholders. Meaning, whatever the 90% people, whatever we gave it to them, The same thing we'll give it to the 10% people also. If the value we paid them was 200 per share, we'll give you also 200 per share only. Clear? Yes, sir. Okay. Now see here. Sir, procedure. The transferee company shall send notice plus instrument of transfer. This is for that dissenting shareholders. The transfer on behalf of dissenting shareholders shall be expected by a person appointed by transferor company. What is this? Even after tribunal telling the transferor company shareholders are not selling, what we will do? We will only appoint one agent. He will carry on the procedure on your behalf. This is nothing but people. We take you, we hold your collar, we push you out. Correct? Huh? Same thing happened in IEPF also. Correct? Huh? Okay. Separate bank accounts will be open to keep the money and consideration, and you have to make the payment within 60 days. Transfer company shall register the transferee company as holder of those shares, and within 1 month from registration, intimate the dissenting shareholder about such transfer and consideration. So there can be people who are no longer alive. IEPF also can come into picture. What will happen to all that? All that will be liquidated. We will let you know, sir, this is cold, this is closed, it is done. We'll transfer the funds. Imagine if the shares are with IEPF. What we'll do? We'll pay that compensation to IEPF only. It's mandatory. You don't have a choice. Clear? Yes, sir. This is 235. Any doubts? Hello? Pakana? Okay. Now, sir, now see of section 238. What is that, sir? Simple thing. Any offer or any scheme that comes under 235, before Tata gives it to Big Basket, there is a rule. What is that rule, people? You have to first show the scheme to ROC. If ROC agrees, people, only then you can forward the scheme to the transferor company. If ROC does not agree, sir, ROC objects, ROC says no, then you can always go for a tribunal's approval, meaning you can go for an appeal. Correct? Yes, sir. So remember that. Simple, that is 238. What does 238 say? Any scheme that is to be transferred or it has to be sent under 235 should be first shown or should be first approved by ROC. If ROC says any objection, people, you have to you have a right to go for an appeal with the tribunal. You have a right. Here, yes, sir. This is 238. Next one, sir, 236. What is 236, people? Purchase of minority shareholding. In class, we had discussed this. What is the difference between 235 and 236? In detail. What is the difference between 235 and 236? We had seen that 235 comes into picture only when there is a transfer involved. That's why we have used the word called as dissenting shareholders. We have not called them as minority shareholders. When does 236 come into picture? Imagine I had taken some convertible preference shares or convertible debentures in the past. Now the conversion is happening. Now the conversion is making me holder of 90% of shares of your company. Conversion is making me, not a transfer. Or imagine, people, there was a company A, there was a company B, there was a company C. All of them were holding 30% in one company. All these companies are now acquired by one company called as Company Z. I purchased them. They are all holding 30% in a company called as Company D. Now Company D became my company. I am holding 90% in Company D. Now whoever the rest out people, the left out people, they are called as what? Minority shareholders. Understood? Pakana. Again the logic will be now same. Now what will Company Z do? Company Z will send a notice to Company D. Macha, I am a majority shareholder in your company. That is, I am holding 90% of your capital. Then 10%, hey you, I will push you guys also out. Tomorrow don't do kirkiri. Just leave the company now only and go. Now this is only called as what, people? 236. 235, there is always a scheme. 236 will happen because of change in shareholding. It can be swap, it can be merger, or people came together. Because of that, your shareholding changed. In such case, people, 236 will get triggered. What else is the difference? 235 gives you an option for going for an appeal. 236 does not give you an appeal at all. They went to tribunal, no. 236 you can't go for tribunal appeal at all. It is a mandate. You have to squeeze out. You don't have a choice. Understood? Pakana. Okay. See here. When acquirer or person acting in concert or any person or group of person becomes a registered holder of 90% or more of issued equity share capital, it can be by amalgamation, stock exchange, conversion, however it can be, but not transfer. Correct? Okay. They shall notify the company their intention to buy the remaining equity shares as well. Correct? Okay. It's becoming hotter. Hey, ಯಾರೋ ಅವ್ನು AC operator ಸರಿ ಇಲ್ಲ ಅವನು. Nandano, you have to keep on juggling the right temperature. ಯಾರಾಯ್ತು? Okay. The majority shareholders shall deposit money in separate bank account to be opened by transferor company and same should be dispersed to entitled shareholders within 60 days. One more difference, no? There you did not transfer your funds prior into an account. Here you are transferring. If not possible within 60 days, disbursement can continue up to 1 year. Meaning what people, you need to pay off ideally within 60 days. What if it is not possible within 60 days? You can take it up to 1 year. Sir, but in some cases you can take it up to 3 years also. When, sir? Imagine whenever the shareholder has died. For you to find the nominee, it has taken time for you to find the nominee. In such case, you can make the payments up to 3 years also, it is allowed. Correct? Okay, next one, sir. The transferor company shall act as a transfer agent between majority and minority. Meaning, I will make sure, I will convert all the minority shares. I will only appoint one agent. He will transfer everything to your company. That is a majority shareholder. The minority shareholders will be paid the money and sent out. Sir, and the last one, sir, what is that? Sharing of additional compensation. If shareholders holding 75% or more minority equity shareholding, what is that? Imagine, sir, the 10% was minority. Yes, sir. Imagine in this 10%, there are 8% people and there are 2% people. This 8% people went and they spoke to the majority people. They bargained for a higher compensation. It is a duty of the 8% people to share that higher compensation with the 2% people as well on a pro rata basis. If you guys go and negotiate a higher price, it is your duty to share the compensation with the minority people as well. This is minority in the minority. Correct? Artha agilla. Pakkana? If you guys can relate it in the class, you will understand. The words used are shareholders holding 75% or more minority equity shareholding. So in our case, majority is 90, minority is 10, and in that 10 they are saying 75%.
Yeah.
Correct? That's what I am saying as 8 and 2. Correct? Hello. That is your section 236. Correct? Okay. What is section 237? Tomorrow, if a government company thinks, hey, you company, don't go separately, go together, walk together. They will walk together going forward. That's all. What is that, sir? A central government people, by a official gazette notification, can order for a merger of or amalgamation of 2 or more companies in the interest of public. They can do it. Correct? Yes, sir. However, people remember, before passing any order here, we will consult the shareholders. After that only, we will be giving a official gazette notification. But if at all there is any person who has an objection on the order passed by the central government, they can always go for an appeal. Correct? Yes, sir. You can always go for an appeal. Yes. Remember, any order passed under this section should always be laid in both the houses of parliament. Correct? And remember, as far as possible, the government will try to keep your interest in that amalgamated company similar. Because 2 companies are coming together. Whoever are the shareholders of company A, whoever are the shareholders of company B, their shareholding should be similar as far as possible. in company AB. I will try to take care of that. Sir, what if it is not possible? I will try to give them a reasonable compensation. This is 237. Here are 238 we saw. What is 239 and 240? One is foreign companies people. This will apply mutatis mutandis subject to RBI approval. What is 240? If at all you want to destroy any of the transferor company's documents, can I destroy? You can destroy provided you need to take CG approval before destroying any of the transferor company documents. Correct, all of you? Yes, sir. That is 239, 240. Any doubt?
Even that 8 years of
To destroy of the old company, you need to take CG approval. Even after that 8 years. The company is only come to an end. Who will keep the documents? So I am telling you, you have to take the approval and then close the documents. Clear? Yes, sir. Okay. And one more thing, people. Whenever we saw this transfer, amalgamation and all, which and all are the laws applicable for mergers, amalgamation? Which and all are the laws applicable? One is Competition Act. It should not create monopoly. CCI approval is required. And SEBI, SAST. If you are a listed company, there is a law called as SAST. You cannot acquire beyond 1% without following certain approvals. So SAST listed company. And FEMA will apply if at all there is a cross border and stamp duty. If at all we saw right on the scheme of the court, should we pay stamp duty? We saw various cases also, but in one of the Supreme Court case they have given that even the order of the court will also be considered as instrument. It is subjected to stamp duty. You need to pay stamp duty on the order of the court as well. Yes, and what other thing? In listed company also you saw one more thing. Which was that? LODR. Whenever before you go for what is that? Compromise arrangement, you will file it with NCLT, right? In 230. Before that, people, you need to file it with stock exchange. That's what they're telling you. You have to get a no objection letter or an observation letter from your stock exchanges. So imagine before two listed companies enter into a merger, I need to file an application to my stock exchange, NSE. Sir, do you have any problem? They will either say yes, that's called observation letter. They will say no, that's called as no objection letter. Now this observation letter or no objection letter will be valid for a period of 6 months. Within the 6 months, they have to go and apply for tribunal for your rest of the procedure. Understood? And remember, this particular no objection letter or observation letter is not required if at all this merger is between the holding company and its wholly owned subsidiary. Clear? Yes, sir. And stamp duty we saw. Okay. And people, what else we saw in this chapter? Operation and mismanagement. Class action suits. Okay. We'll see of operation and mismanagement. Sir, can Section 8 companies come under Section 237? Possible. Possible. Clear? Okay. What is prevention of operation and mismanagement, sir? Operation and mismanagement. What is this, people? Whenever I feel that the company is not conducting its affairs in the interest of the public or the shareholders or the creditors, few people have a right to file an application saying that, sir, I'm going to the tribunal and I'm saying that, sir, the company is not conducting the affairs in the best interest. They are doing all fraud only. Can you please look into it? You can go for operation and mismanagement. Now, how many people can go? For what can we go? And where can we go? And who and all can go? Sir, operation and mismanagement is given in two sections, 241 and 244. In 241, they have given Who can go? It is given that a member can go and government can go. But how many can go? It is given in 244. Sir, if a company is having a share capital, at least 1/5 of the total number of its members. Now, if a company, sorry, not having share capital, a company is having share capital, minimum 100 members or minimum 1/10 of total number of members. Imagine the total shareholders in my company is only 2000. 1/10 comes to 200. 100 and 200, whichever is less, 100 members. Imagine the total number of members in my company itself is 200. 1/10 is 20. 120, whichever is less. So, sir, minimum number. This is number of members, sir. This is in value. Here I am telling how many people are required. Here I am telling how much should they hold. Difference iruka? Iruku. Members or members holding minimum 1/10 of the issued share capital. They can file an application. Where, sir? I can file an application to the tribunal in case of operation and mismanagement. Again, I told you what is operation and mismanagement. We think that the affairs of the company are not being conducted in the interest of the company. We feel something fraud is happening. You guys can go and appeal in section 241 to 244. Okay, sir, why can we go? See, company affairs have been conducted prejudicial to public interest, oppressive to any member, or not in the interest of the company, or material changes has taken place in the management or control of the company by alteration of the board, manager, or in ownership or in its membership. Meaning, sir, till today we thought Big Basket, we were comfortable with Big Basket. Now today Kingfisher is coming and applying, sir, we are not okay with it. We feel if they come in, sir, the company will definitely do frauds. Pakka. We are not okay with it. You guys can go and appeal it in 241 and 244. In one of the cases, the people have applied for, the company has not declared dividends every year, and we think it is operation and mismanagement. Can it be a case of operation and mismanagement? No. That was a judgment, it's a case law. Clear? Okay, and after this we'll see Foss versus Harbottle. Due to such change, it's likely to affairs will be conducted prejudicial to the wrong. Okay. Sir, can central government also file a case under operation mismanagement? The answer is yes. When so moto, central government can only file when person in management of affairs is guilty of fraud. We think they are not doing it properly. Business not conducted as per the sound business principles. Caused serious injury to the interest of trade or industry. Bank, yes, bank. Business carried with intention to defraud creditors or members. Kingfisher, Satyam. Yes, all those people. So we will file an application to the tribunal. Now, tribunal is also of the opinion the affairs are conducted prejudicial as stated above. Yes, even I am convinced. To wind up company would unfairly prejudice such members, but facts justify making winding up. Meaning what, sir? Generally, in we have a saying in all our regional languages. They say that ನಂಗೆ ಬರ್ತಿರೋ ಕೋಪಕ್ಕೆ ನಾನು ನನ್ನ ಸಾಯಿಸೇ ಬಿಡ್ತೀನಿ. Generally in movies they say you would have done something in the movie. Yeah? Generally this conversation will happen between heroine and heroine's mother. Heroine's mother will tell heroine, for the anger I am getting, no, I should actually kill you. But what to do? I can't kill you. Correct? Same thing. Tribunal thinks, hey, for whatever you have done, you deserve winding up. But what to do? I can't only think of you as a director. I have to think for creditors. I have to think for members. I have to think of on behalf of all of them. What to do? So that's what tribunal will do. Tribunal will choose alternative measures. They will pass alternative orders. Alternative orders like, hey, you managing director change. Investigation can be ordered. Hey, you directors come down. I'll replace the board, as the case may be. Correct? See the powers of tribunal. What will tribunal order for? 242. Regulate the conduct of affairs of the company. Appoint directors who will directly report to the tribunal. I can impose some costs. The next one, purchase the shares. Hey, you 10%, you 40% people, you are doing all this unfair thing for the 10% people. You guys acquire them. Yes, I can give you like a basically exit opportunity. Reduction of share capital. 66. Restriction and transfer allotment. Going forward, you are not supposed to sell your shares. Termination, set aside or modify. Hey, you MDA. Hey, old time director, managing director. You remember in KMP provision, compensation for loss of office, that will not come here. That is only section 243. I am removing you. Technically, I should pay compensation according to KMP chapter. But remember, if based on NCLT's order, if I am removing you, then you will not be eligible for any of the compensation. Correct? Huh? And not only the people, you cannot be reappointed in this company. You cannot be reappointed in any other company also. I can pass it as an order. Setting aside or any of transfer delay of goods within 3 months, meaning I think in last 3 months you guys have made fraud. I will set aside, meaning I'll cancel all those contracts. I have this right. Next one, sir. Removal of MD, managing director, manager. Recovery of undue gains are made by managing director, manager under what is this? Disgorgement order. Whatever is the order you made, I will take the money from you. I'll also pay to the people who have suffered the loss. Here are, sir, and such order passed by NCLT shall be filed with ROC within 30 days. Yes, sir. Hey, yes, operator. Yaar guru need yes, operator. It's still cold, huh? I think it's fitting, no?
After raining the
Not only rain, it will be like you will also feel suffocated. There has to be air. See, if we have AC remote getting operated, 24 1 speed or 26 2 speed is always ideal. Okay, next people, there was one more thing, people. Majority versus minority. What is the rule with in majority versus minority? Majority has to prevail or minority has to prevail? So in your book, you can see a transition. What was the scenario before Companies Act 2013? What is the scenario today? In Foss versus Hair Bottle, that is the first ever case law. 2 people filed a case on the company that the directors are conducting the affairs of the company in not best interest of the company. In that case, the court held, hey, why the minority? 2 people are coming and filing. If you guys want me to take an action, let the majority come and file. If I start hearing out every 1%, 2%, that means the court will become a big truster. Every day I will have hundreds of applications. That cannot happen. So in Foss versus Hair Bottle rule, majority's rule was upheld. Minority cannot do anything. If directors are acting according to the majority shareholders' interest. So futile suits were avoided in Foss versus Hair Bottle. Vague, vexatious suits. Correct, huh? Correct, huh? That was Foss versus Hair Bottle. We saw various cases after that also. Even in Indian courts also it was held in the same way. If majority have agreed with it, the courts will not poke its nose into the regular affairs of the company's business. But ultimately in one case, I think ICSI Bank versus Parasurampuriya. That's a case, no? Parasurampuriya case only, no? It was held that the banks, they were holding some 3% of shares, but they had given lot of debt. They felt the company is doing mismanagement. Now the company said, sir, majority, sir, what, sir, 3% people and all are coming and filing a case, sir. In this case, first time they said, in the Indian scenario, the financiers will act as a backbone. Financial institutions act as a backbone. Even though they hold a minority stake in the company, but you cannot say that for the 2% they don't have a value. And the first time it was held, the case was taken up. Until then, the case only was not taken up. Correct, huh? Yo. How to go back? Yes, sir. That was a case law. The case law was ICICI versus Parasurampuriya. This is the case where financial institutions, if you guys remember today, they can ask you with cases, remember, or they can ask you some 3 judicial precedents for this particular majority versus minority rule. Foss versus Hair Bottle also important. Remember, these cases are also important. Rajamandri Electric Supply Company versus Nageshwar Rao. In this is the case where it was held. If the company is acting as per majority's decision, minority shareholders cannot do anything about it. Here are.
So that case, the ICSI case, so that only because it's applicable to finance, like a banking company.
Today, minority is supported, right? That is what we saw in all these cases. Operation versus mismanagement, 1/10. You can file 100 or 1/10 the total number of members, whichever is less. India is still minority only, no? 236, 235 dissenting shareholders.
Yes, sir. This is what, so they only prevailing for the minority.
Correct, yes.
But only for the ICSI case for the minority.
Yes, correct, yes.
So can we conclude out of this that for the banking institutions or anything in finance, can we say that the minority also will be this?
That was not the only concern. That's what I'm saying. You're saying, can we say that the financial institutions will have a special preference?
Yeah.
It may, but I'm not saying minority does not work on the rule of financial institutions. It can be you also here. Clear? Because minority is not nothing with debt. It can be less than 10%. Correct? Okay. That's all. Class action suit. I think class action suit is there. What is class action suit? How many people has to file class action suit? What is class action suit? People with same or common concern. We can all come and cry together instead of crying differently. Victims. When we have same set of problems, so victims are same. Instead of filing multiple cases, the whole purpose was that, especially it was felt in the case of Satyam. Everyone were cheated. Now we can't go and file differently. Everyone can't go and file a different case. So that time in Companies Act 1956, we did not have a provision under Companies Act to file a common application. So in 2013, they felt a need. We have to introduce a common point where group of people can be filing a case instead of individually. As a group application, you should be able to file. That's called as class action suit. Imagine tomorrow you feel that I'm not teaching fair. All of you, instead of going separately and filing a case with management, together you can file, right? That's only called as class action. Together you are acting. Clear? Yes, sir. Okay. So how many people can go and file, sir? So company having a share capital, if you are a listed company, then the requisite number of members would be A or B, whichever is less, similar to whatever we saw. At least 5% of total number of its members or 100 members, whichever is less. Or this is number, value. Members holding not less than 2% of issued share capital. Sir, what if depositors at least 5% or 100 depositors, whichever is less, or depositors holding 5% of total deposits? The numbers are same here also, correct? At least 5% or 100 members or 5%. This is same. It's same percent here. Correct? So remember one, you can remember three. Yes, so company not having share capital, sir, 1/5. What are the reliefs you can go and say? Sir, the company is going ultra wires articles MOA. You guys can go and say class action suit. Sir, we have agreed on one resolution, but the directors are acting against that resolution. You can go under class action suit. And what else? The company is going contrary to the provisions of this act. You are going against this act or any other law. I can go and file a class action suit. Sir, we have passed the resolution suppressing the material facts. We have passed a special resolution, but you have not given us material facts to take a decision. I can still file a class action suit. Sir, I can claim compensation, damages, sir. From whom and all? Sir, this auditor is there, no? He has signed fraudulent financials. You can claim compensation from the auditor. So the directors are there, no, sir? The directors have conducted the affairs of the business in a fraudulent way. I can claim compensation from them. Sir, when they are issuing prospectus, experts have signed wrong statements. I can claim compensation from them. Yes, sir. All this can go under class action suit. Clear? Yes, sir. Okay. What happens? The application is filed. Class action suit. What is class action suit? If at all 10 applications are there, everything will be combined into one application. And you guys only can nominate one amongst you as a lead applicant. What if you guys are not able to nominate one amongst you as lead applicant? Tribunal will nominate one amongst you as lead applicant. Once a class action suit is filed, anything similar to this case will again be combined with this case only. Correct? Statistics and all. That's all. Huh? Anything else we should see in this chapter? That's all, no? Huh? I hope I have covered majority part. Yes? Okay. We'll do one small chapter. Huh? Dormant is done, 10th is done. CSR will finish it off, huh?
Yes, sir.
Yo. Right, everything went off, huh?
Take a picture.
So everything closed off.
There is a open.
We'll do of CSR, huh? Even I am hungry, da. I'm somehow terribly hungry. Or should we go for lunch and come? Actually, we'll go for lunch and come, da.
3:45.
Huh?
Till 3:45. We have more time to this even.
1:00.
We'll see. We'll come back by 1.
Yeah.
Huh. Let's start the next chapter, people. Let's start off with easy only, huh? Let's do chapter 13 only. Okay, we'll take up one easy chapter. Okay, chapter 17, people, CSR. Okay. The first thing, people, applicability of CSR. What I would suggest is do not order for the next 3 to 4 days. Order after probably Tuesday or something. I have made some changes. So I'll be sending the revised copy to them and they'll be uploading it on their website. It might take some 3-4 days. I'll be sending them the revised copy today or tomorrow. Assuming it will take so much of time. Yeah. So place it after
Even
that.
the same thing for setting up.
Setting up of it also, I'll again be doing it the same.
Together.
I'm preparing simultaneously. Yes. Applicability, people. Every company having a net worth of 500 crore or more, CSR people start CSR, turnover of 1000 crore or more, or net profit of 5 crore or more. For them, CSR will be applicable. You need to constitute a CSR committee. Earlier, there was a rule which says that once a CSR is applicable, it is applicable for the next 3 years. That rule they deleted. So indirectly now what is the effect? This condition is to be checked for every financial year. It became now that is not a specific rule they have inserted. The 3-year part they have removed. So this became the rule now. Agreed? And next thing, sir, amount to be spent does not exceed 50 lakhs. The CSR committee shall not be applicable. So imagine my 2% is coming to somewhere around 40 lakhs. It is still CSR expenditure. They are telling you need not form a CSR committee as such. Now, why do you form a CSR committee? What is the complete process of that CSR thing? How to order? I'll tell them to share the link. Yeah. I'll tell them to share the link. Yeah. If not, even on the marathon will be live on YouTube on Monday. You guys can. I'll put a description on that also for you to directly order. There also you can order. Okay. CSR committee people composition. The committee shall consist of 3 or more directors, in which at least one shall be an independent director. It is like 2 plus 1. Next one, in case of private company, obviously Independent director provision is not applicable to them. So only 2 directors are sufficient. In case of foreign company people, at least one member of committee shall be a Indian resident. And how many people are sufficient? Here also 2 only. But one member has to be an Indian resident. See, here they do not emphasize on a fact of director. It can be any person also. Agreed? The board's report shall disclose CSR committee, who, what and all. And a CSR applicable to a Section 8 company, yes. Subsidiary company, yes. Holding, yes. Every company, if you are there, yes. Foreign company, yes. But only for your Indian operations. I'm not speaking about your head office. Whatever branch you have opened. If you have opened a project office, for that the CSR provisions shall apply. Yes, sir. Okay. The roles and responsibilities, they formulate the CSR policy, CSR expenditure. They will select the CSR activities as the case may be. Sir, what are the activities which is not considered as a valid CSR expenditure? What and all? Normal or ordinary course of business. Exception was R&D, and that was the time is also done. 3 years time was given. And the next one is sponsorship activities, and next one is marathon runs, and next one is if any amount is spent outside India, and sports was an exemption, and political contribution is not allowed, charity is not allowed, and if any amount is spent on the employees alone is not considered as CSR. Any amount spent on the employees ka families is not considered as CSR. And COVID related, we had seen some exceptions also, and new things have also been added for the CSR. What are the new things that have been added, people? One is as a part of 75th independence, Har Ghar Tiranga, this thing, and Azadi Ka Amrit Mahotsav, they have added the production mass supply of national flag is also considered as a CSR. And R&D. If anyone who is associated with the labs that is given in Schedule 7, if you can associate yourself with them and you can come up with CSR vaccine, drugs, or any medicine related to CSR, that can also be claimed as valid CSR expenditure, even though it is your daily or ordinary business. And yes, oxygen and ventilators was also considered as valid CSR expenditure. Apart from that, what else will come as CSR? Your slum development, hunger eradication, empowerment of women, old age homes, rural developments, and all these what is that? Rural sports development, and old age homes, orphanages, reservoirs, and historical monuments. All these things will come under CSR expenditure. Correct? And okay. And what is CSR expenditure, sir? How much has to be spent? The company shall spend a minimum of 2% of average profits of the company during the 3 immediately preceding financial years. And sir, administrative overheads shall not exceed 5% of total CSR expenditure of the financial year. What do you mean by that? Imagine this 2% is coming to somewhere around, say, 10 lakh rupees. Administrative expenses means, people, it's nothing but to take care of the CSR. You might be doing some site visits. The directors can be coming. They might be meeting over in a particular place. You might be claiming some refreshments. You might be doing your own activities there. Now, for that, you will be paid. Now, what is that I can claim as administrative overheads? They are telling you it cannot be more than 5% of your CSR expenditure for that financial year. Now, that is what? 10%, I mean, is 1 lakh, 5% is 50,000. Up to 50,000, we will allow it as a valid CSR administrative overhead. Correct? And we have seen what is administrative overhead, what is not administrative overhead also. What is not administrative overhead? We had seen that as well, if you guys remember. Administrative overheads. Okay, see here. It includes expenses incurred by the company on general management, overseeing, administration, excludes Meaning that 5% does not include these things. What? CSR designing, CSR implementation, meaning what? I can have a school. I'll be paying for the teachers. Now, is the teacher salary coming under administrative overhead? Answer is no. That comes part of your CSR expenditure only. Evaluation and monitoring. They're saying it doesn't come under this. Yes, sir. All of this will come under your regular CSR expenditure. Okay. Surplus arising out of CSR. Can I spend it? It has to be put it back into the same CSR activities. Excess CSR spend. Can I carry it forward? Yes. Up to a period of 3 financial years. Can I acquire a capital asset? Yes. It should be in the name of the Section 8 company and not in the name of your company. Correct? What do you mean by that? How do I implement CSR, people? Implementation of CSR. How do we implement CSR? To a Section 8 company, trust, society of my own, or someone else having 3 years of track record, or any statutory company. Hello? 17.3. Implementation of CSR. A company established as Section 8 company, trust, society. Meaning what? Let us imagine for Reliance, CSR is applicable. How can they implement the CSR? They have to spend, right? I told you Reliance's CSR expenditure will come to 1,300 crore to 1,500 crore per year. Now, how do they spend that money? They're telling you can form your own Section 8 company, or you can form a trust, you can form a society, and you can spend that money. And sir, that Section 8 trust or society, it should be exempt or, Section 8 and all, which is registered under Section 10, 23C, 4566A. I told you what is that also. Universities, hospitals. If it is that, you will enjoy it. Or you are registered under Section 12A and approved under ATG and what is that, sir? I told you. If at all whoever is getting donations, they should also get exemption. So if you are registered in all such places, you can give money to them, they can spend on behalf of you. That's first way. Second way is called a company established under Section 8 established by central government and state government. In previous thing, Reliance only registered their own Section 8 company. It's called Reliance Foundation. Or I can go to a Section 8 company which is registered by the government, central government or state government. I can go there. Or third one, an entity established by Act of Parliament or state legislature. Basically, I am speaking about a statutory company. Second thing was a government company. The fourth one, it is incorporated by a random person, another person. Reliance Foundation, Reliance Industries has incorporated Reliance Foundation. Now imagine if Arivu CSR gets applicable to them. We will give to Reliance Foundation, we will not spend. It's not ours, right? So we can give it to an outsider, provided when I am giving it to a third party, such party should be in existence at least for a period of 3 years. Correct? A track record of 3 years. Yes? So that's how you implement. Okay, next one, mandatory CSR registration. Earlier it was not there. Amendments at 2021, they got it. 2021, 2022. What is that? Earlier these people, Section 8 to Trust to Society, they were not accountable at all. Today, you cannot give it to any Section 8 company. You should also file an application with the ROC under a form called as CSR1. And you should register yourself. Only to such entities you can give money. Only they are recognized. Correct? Yes, sir. That's what we saw. Next one, sir. CSR expenditure. Next one, people, unspent CSR. What is unspent CSR, sir? Now, whenever I'm taking up a project, I can take up two types of project. One is a single year project. Next one is called as a ongoing project. Also called as ongoing project and a multi-year project. What is a single year project, people? I'll take up a project this year. I'll finish it off this year. I don't have a problem at all. Ongoing project means, people, it's a project where I cannot complete it within 1 year. Now, for example, Adani has taken up conversion of the Dharavi slum into a Pakka house.
So that's the project. 101% it cannot be achieved in 1 year. It might take 2-3 years. So what is an ongoing project? Ongoing project means people, the year in which you started. Now let us imagine in 22-20, let us imagine 23-24. If I take an average, I get something, 3 years average and all. Imagine CSR was applicable to me. So 24-25, I have to spend the money according to my 3 previous years average, correct? 2%. Now 24-25, I started Dharavi slum. I mean that Kacha to Pakka house. Leave this period, leave this 1 year. 25, 26, 26, 27, 27, 28. You will have time till 27, 28. So the project technically gives you 4 years. So sir, now how do I do? 23, 24, I get to know that CSR is applicable to me. So what do they say? Now once CSR is applicable to you, you need to open a different bank account. Within 30 days, people, you need to transfer the entire money into a different bank account, different separate bank account. So that accountable, you do not end up using it. So such amount shall be transferred to a separate account within 30 days from the end of the financial year. 24 CSR applicable to me. Within 30 days is 30th April. 30th April transfer it. And you start. You go up till 31st March 2028. Now, even then, if the money is still not spent, they'll give you 30 days time. That is 30th April 2028. Even by 30th April 2028, if still money is unspent, transfer it to any of the funds mentioned under Schedule 7 of Companies Act. I hope you guys understood this timeline.
Can it be here,
After transferring.
yeah?
That after transferring, it's not.
No. This money,
Hmm.
can it be again be
Unspent, okay, but where is it now? Is it with you or you have sent it to Schedule 7? With you, you can spend. You have 3 years time, right? That's why 3 years you have time. In that 3 years, if you have not spent, then you have to transfer it to Schedule 7. Then that is not under your control. Correct? Huh? So next one, not an ongoing project, people. So 23-24, CSR applicable to me. I have to spend it in 24-25. Sir, what if in 24-25 I have not spent? You will be given 6 months time, sir. 6 months time is 30th September 2025. Within 6 months, you have to transfer the entire fund to Schedule 7. You have seen FAQs also I have shown you. Sir, now can I still 6 months I have time. In that 6 months, can I keep spending? No. By 31st March 2025, you have not spent. You are under an obligation to send it to 30th September 2025. You have to send it to your separate account. I mean, you have to send it to the Schedule 7, any of the accounts. Okay, understood? It is clear? 30th September 2025. Any doubts here? No? Pakka? Okay, done. Sir, non-compliance, sir, penalty. You want it? Penalty, will leave it. Okay. CSR reporting, sir. First one in board's report. You'll be giving CSR composition, CSR activities, what and all you have spent, everything will form part of your CSR reporting, board's report. Next one is website disclosure on composition of CSR committee and also CSR policy and projects. You will also be have to disclosing everything on your website. And next one is people, every year along with your AOC 4, it goes as an addendum, attachment. What? CSR thing. You have to give it as an attachment, right? Yes, sir. That is also attachment. Yes or no? Annual disclosure. You would have written CA. Under disclosures, you would have written 4. Reporting, you would have written 4. Written, illa. What is the first one you have written? Second one?
second one is the website disclosure.
Third one?
Third one is report on CSR. That according to ROC, we have to file an AOC XBRL and attachment CSR 2.
Correct, Yes, CSR 2 goes there, no? AOC 4 attachment only, no? कहाँ है इधर?
Impact assessment. I mean, some changes would have happened. I might have felt it is easy for me to write it down that day. I would have written it down. That's how it works. Alright? Impact assessment, people. Companies with average CSR obligation of rupees 10 crore or more in the 3 what is the impact assessment report? Impact assessment means people are just spending money on the society, ano. But is it being helpful to someone? That we don't know, no. That is why we are saying they have built a hospital, da. In that hospital is someone getting treated. That I need to know. So they introduced one more amendment, people. That is only called as impact assessment. What is the impact your CSR project has made on that particular society? So companies, is it applicable for everyone? Everyone, Allah. A company which is having the average CSR obligation of 10 crore or more in the 3 preceding financial years, every year I have been spending 10 crore at least. Then for me, in that 4th year, the CSR impact assessment report is applicable. Okay. Sir, now, what should I do? Nothing, people. Call some independent agency. Call them and call them here. They will come. They will come with reports. They will interview your patients. They will give you FAQs. They will speak to your employees working there. They'll ask them how many people will visit you. What is the age group? They'll ask them what are the pros and cons. They'll consult everything. They will prepare a report and they'll give it to you. Understood? Sir, now for all the projects have to do, not for all the projects. You only have to do it for the projects which is having a project outlay of at least 1 crore or more. What do you mean by that? Imagine my total CSR expenditure to coming to 10 crore. In that 10 crore, what am I doing? I'm spending some money on, what is that we saw? Vantara of Reliance Foundation. They started that, what is that? Animal adoption and something. Zoo alla rescue, something like that. Rehabilitation. Zoo and rehabilitation center has a difference between medicine and drugs. Yes, so they started Bantara and they started Kantara. Yes, sir. No, sir, like this, they started something also. What else? My education, no, slum development, everything. Sir, for Vantara, they spent 5 crore. For Kantara, they just spent 60 lakh. And they got 500 crore profit. Okay. Now, for 60 lakh Kantara, imagine it is on rural development. Now, should I make an impact assessment for Kantara? The answer is no. Because my impact, what is the total cost I've spent there is less than 1 crore. So the impact assessment should only be done for those projects which has a project cost of at least 1 crore or more. Sir, today only I started. Should I get my impact assessment done? Na?
No, please.
Allah, you need to get to the projects which are at least 1 year old. If you have started today building Mestri will go and talk, how is the climate? People are visiting, what will you go and talk?
What is the difference between 10 and 1 crore?
10 is your overall project outlay. Now in this 10 you can spend everything on one project only, you can spend on 10 projects also. Now when I am spending on 10, should I do impact assessment for everything they are doing? Do it only for those projects which has a outlay of at least 1 crore.
This 10 crore is for 1 year, sir.
One financial year. Clear? Yes, sir. So two things to be satisfied. One is 1 crore or overall 3 years track record, 10 crore. In a year, you need to do this only for those projects on which you are at least spending 1 crore. And the project should at least be 1 year old. If you satisfy all this, then yes. Sir, now, Matthew asked a question that, sir, should I pay anything to that agency who is doing that impact assessment? Of course, no, Matthew, they are not Section 8 companies. They will take money. So Matthew asked, sir, that money from where can I pay? They say you can pay it from your CSR expenditure only. Oh, sir, then I can pay my entire 2% to them only. And Yashas says that, why did you do CSR? The maximum allowed is people 2% of CSR expenditure or 50 lakhs, whichever is higher.
In the book, it says
What did we write?
Higher.
Whichever is higher.
Let's see.
See, this was 5%. They have made it as 2%. Amendment. This was lower. It has been made as higher. Again, amendment only. Clear, huh? Yes, huh? Okay. Anything else than CSR you guys want to know? Is fair enough? Not ongoing project. Penalty have not. Computation of net profit. Something you should exclude from net profits. What is that? Imagine there is an Indian company. When I'm calculating my net profit, I have to exclude two things. One is my overseas branch office profits I need to exclude. Second one is if at all I've got dividend from any of those Indian companies on whom CSR is applicable and they have complied, those things has to be excluded in the profits. Correct? Huh? Okay, CSR was the this annual action plan and all. CSR reporting. What is CSR National Awards? The 4 awards for the excellence in CSR based on CSR spend. In a year, whoever is having the highest spend, the government gives you a recognition by conducting CSR awards. 5 awards for CSR projects in aspirational districts, meaning those districts which are not doing good. So I have notified them, spend there. I'll give you award at least, you will get recognized. 11 awards for CSR projects in national priority areas, education, it can be environment, sustainability, all of those things will come there. 3, social stock, yes. And next one is people, 3 separate awards for micro, small and medium enterprises. Specifically, they have made a classification for MSMEs because obviously they will not be able to participate here. But they should also want something, right? So MSME. What is social stock exchange? The social stock exchange is a concept where recently they have made it. If you are a company who wants to raise money from the public just to spend on these CSR activities or any such thing, you guys can go and list yourself on a stock exchange. That stock exchange is called as social stock exchange. What are the securities that get listed on social stock exchange? It's called as zero coupon, zero principal bonds. Basically, you will not get your return, interest, dividend, nothing will be there. You will not even get back your principal amount. That's why it's called zero coupon, zero principal bond. Simple, Chandramole. When you are giving donation to some orphanages or charity homes, will you get it back? But is it accountable? This is accountable. That's all. What? Child care. Child labor. Yaro Matthew. Okay. Then that's all CSR. You want me to touch any other topics? I have not touched that reporting. But reporting also we saw what is that annual action plan and all I didn't do. Reporting we did the 4 things. Website we saw impact assessment, CSR 2 and boards report that we did. I think annual action plan alone I did not do. Correct?
Yes.
Nothing but you need to give a clear picture of what you are going to do and how you are going to spend and as the case may be. Okay, that's your 17th one. Next what will you do? 13th is done.
Yes.
12 we'll keep it to the last. Probably whenever we take a next break, we'll take a 5 minutes or whenever the time. And if we வந்ததே இப்போ ಸಲೈನ್ ಇದು ಸರಿ ಮ್ಯಾಥ್ಯೂ ಹೇಳಿದ್ನಲ್ಲ ಮ್ಯಾಥ್ಯೂ ಯು ಹ್ಯಾಡ್ ಫುಟೆಡ್ ಅಂದ್ರೆ ಸೊ ದಟ್ ಡೇ ಐ ಡಿಂಟ್ ಹ್ಯಾಡ್ ಎನಿಥಿಂಗ್ ಐ ಡಿಂಟ್ ನೋ ವಾಟ್ ಟು ಡು ಸಿನ್ಸ್ ಐ ಹ್ಯಾಡ್ ಕಿಟ್ ಕ್ಯಾಟ್ ಅವೆಲ್ಲ ಆಡ್ಸ್ ಹ್ಯಾವ್ ಅ ಬ್ರೇಕ್ ಹ್ಯಾವ್ ಅ ಕಿಟ್ ಕ್ಯಾಟ್ ಅವೆಲ್ಲ ಇಟ್ಸ್ ಆಡ್
That was before. I didn't know it was going to take that long.
You should have taken one.
No. See,
Don't tell me you didn't know it will take so long. Someone very wise here advised you. It will take time, Matthew. Matthew, sir, no, sir. I have DL test. 2 o'clock they have given me appointment. 2 o'clock it will be done. I said, Matthew, you are somewhere, da. Angela, Allah, there are some 500 people will come. Matthew, it will happen in corporate way. Thoda? Okay, we'll do 14 chapter. We'll start off with director.
Done already, right?
What did you?
Yeah, good. Yes, sir.
Who will give you deal to early, na?
Huh? Yesterday I'll show you.
Hey, what we do here after 2 months, Matthew?
I don't know if something for you.
Okay, chapter 14 we will directors. Directors. Yes, as per section 149 we will the board of every company is considered individuals only. Can we have body corporate as directors? Not possible. It should be only individuals. Can I transfer my office to someone else? So I till no.
DL है कि क्या है बता.
Such office shall not be assigned to anyone. If assigned, it shall be void. Correct? One more thing for alternate director. They can ask you a question. If I am going out of India for some time, can I appoint someone in my position and go? The board has to approve. This is the point. You can never assign your office on your own to anyone. Okay. DIN people. So if a person has to be appointed as a director, the director identification number is mandatory. You can get DIN in two ways. One, you can obtain it from a newly incorporated company or already existing company. Imagine today if I want to become a director of Infosys, which is already registered. Now I'll come under second route. I'll have to file form DIR3. I'll have to obtain a DIN. On the DIR3, the company's directors or CS, they have to sign. I need to have a proposed appointment letter. Only then today you can appoint a DIN. Until some time it was not the case. Here next one is SPICE form. In SPICE, up to 3 directors DIN you guys can allot. You can get it. Yes, okay. Now what are the attachments you require for DIN, sir? In DIR3, if you are an Indian, PAN, photograph, ID proof, residence proof, board resolution, and the form signed by C, propose director, that is I will sign. And CS in employment of Infosys or MD or director or CEO or CFO of existing company, meaning Infosys. Mandatory. Clear? Okay, if you are a foreigner, PAN not required, but passport becomes mandatory. And not only that, people, you need to get it done by Indian Embassy. You have to get it certified or apostille. What is apostille and all? I told you in the class. I showed you that if it is US and all, it looks beautiful. That gold seal and all. Change in details, sir. I told you, no, change in details. What if astrologer told change your name and all? So intimate ROC within 30 days of change. Inform DIR6. Can I cancel or deactivate my DIN?
Yes.
Yes. When will it happen? If at all you have a duplicate DIN.
Obtain fraudulent.
If you have obtained fraudulently in case of death, lunatic, unsound or insolvent. Can I surrender my DIN? Possible, but that is the main essential condition. You can expect a question here also. What is the essential condition? Your DIN should have not been utilized to sign even one form in the past. Even once you have signed even one form, you cannot deactivate your DIN. Impossible. Why? Deactivation is like cancelling your records. How can I cancel your records? So I want your records to be still alive. On application filed by DIN holder to surrender, inform DIR5 along with declaration that he has never been appointed as director and said DIN has never been used for filing any document. Clear? Yes, sir. Okay, next one. What is director's KYC? What is the guarantee that the macha is still alive? What if someone has died and someone is appointing or filing everything in their names and details? So what did they do? They have introduced something called as DIR3 KYC. Every year, first time you would have done DIR3 KYC. Meaning you would have given all your details. You would have. This is the 2019 amendment. They said whoever is the director, who is holding DIN, you guys have to file a form called DIR3 KYC. You will get OTP verification on your email and mobile number. You do it, it is done. Once DIR3 KYC is done,
Going forward, there is something called as DIR3 KYC web. It's not like a form, just the OTP will be generated. You guys can just enter the OTP, the authentication is done. 0 rupees, no filing fees also. But if at all there is any change in the details, like imagine your email ID changes or your number changes, you have to again file DIR3 KYC and again from next year it will be DIR3 KYC web. First time DIR3 KYC, next time web. Changes, again KYC. Again you can continue with web. What happens in KYC? Where you have to go to any professional, they will self-attest your, you need to self-attest your ID proofs, and even the professional will also sign your documents. That I have seen. This Aadhaar card owner is this person only. What is the guarantee? If not, you know our Aadhaar cards. Now, for example, in my Aadhaar card, I might look like Matthew, or all of us are same, or I can look like Nandan.
Pictures are very.
Now Matthew and Chandramouli, we are all same in our Aadhaar card. Yes or no? So what is the guarantee that it is mine only? Yes or no? Yes or no? We might be similar in our Aadhaar cards. They say no, not required. You have to get it authenticated by a professional. Agreed? Yes, sir.
If there is any changes in KYC, we have to pay any fees.
You have to again file DR3 KYC, and again you can continue with DR3 KYC web. Exam. Next one we will. Types of directors. What are different types of director? First one is called as resident director. Who is a resident director? A person who has stayed in India for a period of at least 182 days during the financial year. Exam. What if it's a newly incorporated company? You will take it proportionately. Yes, what do you mean by that? For 365 days, you have to stay 182 days. What if the financial year itself is 180 days? You need to do cross multiplication. Here, my God, accident. Kismat is fine. Okay, next one is women director. Taratamya, discrimination. Okay, every company, every listed company.
Therefore, I guess I don't know. I know what you gave.
Listed company and public company having paid up capital of 100 crore or more. I'll tell you one thing.
Yes, sir.
When the class started, it was only me and Nandan. Forget about me. Papa Nandan. Imagine how he would have felt. I asked Nandan, is it only you and me? Nandan said, yes, sir.
That is so.
And then, yes, all of you came. Okay. Turnover of 300 crore or more. So, any one condition to be satisfied, a company shall appoint a women director. We saw recently, it is applicable to a top 1000 listed companies based upon market capitalization. Basically nothing but market price of the share multiplied by number of shares of the company. Whichever is coming in the top 1000, they need to appoint at least one independent women director. Okay, next one is small shareholder director. What do you mean by small shareholder? Small shareholder means a person who holds a share of 20,000 what? Rupees what? In value what? Share value what? Face on nominal, book, market. Adan eldre. Because if I say not more than 20,000, what if it's a partly paid share? So that is not the scenario. So you need to take it as face value. A person who holds shares fully paid Allah. It is face value not exceeding 20,000. That's all. Market value partly paid is irrelevant. Yes. Now such people, what will they do? They will make a request to the company. Sir, nam kadendanu oba irli. One person, appoint. So his company is under an obligation to appoint.
No.
Yes or no?
No.
Hey, yes, sir. Biddidda. Hallak biddidda. It is an optional. Why, Matthew? Why do you think it is optional? What makes you think it is optional? Allah. It is because of the word used may. Every listed company may, upon a notice received from minimum 1,000 small shareholders. Oh, hi da.
Come in 3:45 also.
College ada? Go behind da. Eyes will go. 1 feet distance illa. Climb on it and go. Anant. Climb on it and go. Yes, people. Minimum 1,000 small shareholders or 1/10 of total number of such shareholders. Macha, 1/10 of total number of such shareholders. Such means such may people. We are speaking about the people such small shareholders only. Whichever is lesser, they shall appoint a small shareholder director. So order 20,000. I told you market to partly but irrelevant. Tenure maximum of 3 years. He can be reappointed, right? No. Biddide mata. Okay, I can be a maximum. Okay, I think I can be a small shareholder director of maximum 2 companies. What do you think, Yashas? 2 companies. Possible, not possible? Possible. I can be a small shareholder of maximum 2 companies. But remember, the second company should not be a competing company. Once I clear my 3 years tenure, can I be reappointed? Can I be reappointed, Matthew? Yes, you cannot be reappointed.
He's not eligible for retiring for rotation.
Ah.
No, I mean, for the count.
ಅದಕ್ಕೂ ಇದಕ್ಕೆ ಏನ್ ಸಂಬಂಧ? ರಿಟೈರ್ಮೆಂಟ್ ಬೈ ರೊಟೇಷನ್ ಇಸ್ ಡಿಫರೆಂಟ್. ಎವ್ರಿ ಇಯರ್ 2/3 1/3 हम अभी तक वहाँ नहीं आया बा. वो प्रोविजन आएगा रुक. ऐसा क्लियर? बच्चा स्मॉल शेयर होल्डर cannot be reappointed. Can be reappointed.
He can be reappointed and he is also not supposed to be associated complete.
He can be reappointed.
Can't.
See, ನಾನು ಎಷ್ಟು ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳಿದೆ. He cannot be reappointed. He cannot be reappointed ಅಂದ್ರೆ ಓಕೆ ಕರೆಕ್ಟ್. ವೆರಿ ಗುಡ್ ನೇಮ್ da. Like split personality, speed personality. Additional points is counted in total number of directors. Can he be an independent director? He provided he satisfies 149 subsection 6. Such director may or may not be a shareholder, not liable to retire by rotation. What is retirement by rotation? 2/3, 1/3, as the case may be. Can anyone tell me that complete provision? Retirement by rotation. Here.
Total number of directors to include independent directors.
Allah.
First,
The question is it applicable to all the companies? Every listed company. Public company it is not applicable, no? ಅಲ್ಲೇ ಅಲ್ಲೇ ಆಯ್ತಲ್ಲ ಇನ್ನೇನು. For a private company it is applicable. Public company or some limits are there?
yeah, limits.
Limits are there, Pakka. Or is it for all public companies?
Public, for all listed companies it is mandatory. For the listed companies it has some.
Public companies it's there,
Yes, sir.
So okay, tell me one thing. For public companies by default, I mean listed companies by default, there is liability of retirement by rotation,
Yes.
Okay, we'll see. Additional director people, okay, different types of director. What is additional director? Whenever the directors think they need an additional director on the board, they cannot wait until the date of AGM. They will take him in between. That's what I told you. It's also called as regularization. You will take him as an additional director in the general meeting. You will make him a normal director. So remember, his tenure as an additional director will only be for a period of 1 year. That is until the date of that AGM. And the power to appoint an additional director should always be given by the shareholders in AOA to the board. So AOA should always authorize. Remember, AOA is a common point for 161. Next one is called as alternate director. What is alternate director? Alternate director means people whenever there is a director who is not in a position to attend the meeting, or he is not able to take care of the company's duties and all, such person who is absent, in his place the rest of the board will appoint another director. Such director is called as an alternate director. What are the conditions of the alternate director? He should not already be a director there, or he should already not be an alternate director there. Such people cannot be alternate directors. And remember, the tenure will be whatever is the such director, original director will be the tenure of this director. Correct? Huh? If original director returns, the reappointment, everything will apply to him only, not to the alternate director. So AOA should authorize, he should not already be a director. He is appointed in the position of director, absent for a period of minimum 3 months. Important. Nominee director, AOA. Whenever we have taken any financial assistance and all, we will appoint a nominee director. I cannot remove. The power to remove or appoint is with the financial institution only. What is the casual vacancy, people? Whenever a director appointed by the shareholders in general meeting, if at all they vacate the office, such vacancies can be filled by the board of directors. Remember, if additional director leaves, I cannot fill a casual vacancy of additional director, because it is not a director appointed by the shareholders in a general meeting. It should be appointed by the shareholders. Only then casual vacancy will come into picture. Correct? He shall hold office up to the casual vacancy. Up to AGM. Remember that. Okay. Next one, people. Maximum number of directorship that a person can hold. A person can be a director of maximum 20 companies. Further can be bifurcated into 10 public companies. And rest of it, even 20 can also be a private company. But if it is 10 public companies, it can be maximum. The rest of the companies can be 10. But some companies are not counted in this particular limit. What are those companies? One is Section 8. Next one is dormant. So a person can be a maximum director of 20 companies. In that, maximum listed companies is 7. I can be a maximum independent director. I can be a maximum director of 7 listed companies. I can be an independent director of maximum. Independent director of maximum. Huh?
3.
Correct. 7 listed companies only. Provided if I am a managing director or a manager or a whole, I'll tell you. If I am a managing director or a whole-time director somewhere, in Reliance, Mukesh Ambani is a managing director. Such person can be an independent director of maximum 3 companies. Now imagine I am an independent director only. I am not a managing director anywhere else. I can be an independent director of 7 listed companies. If I am an MD of in any one company, I can be an independent director of maximum 3 companies.
He is the MD for him, I guess 3 years.
3 companies. Clear? Yes, sir. Okay. Contravention 2000 rupees per day, maximum of 2 lakh rupees. That's the penalty. 2000 rupees per day, maximum of 2 lakh rupees.
So for all these directors, there should be DIN.
Yeah, if at all you need to be a director, DIN is mandatory.
So for then alternative directors and casual vacancy is the DIN needed.
Yes. The moment you are a director, you need a DIN. It is mandatory. You don't have a choice. Yes, people. Next one, people. Independent director. Okay. Independent director, people. For whom and all independent director appointment is mandatory. Independent director, people. If you are a listed company, independent director is mandatory. Now here also, I'll take you to the next chapter. What is that? In independent director, people, what is the composition? It depends upon whether your chairperson of the company is an executive or a non-executive director. If the chairperson of a company is the executive director, then minimum half of the board, 50% of the board shall be independent director. If the chairman of the company is a non-executive director, then 1/3 of the board can be independent director. But the chairperson is the non-executive director. Non-executive means a part-time director. Such non-executive director is related to any promoter. Then people, half of the board only shall be independent. Correct? The minimum number of directors people in a company, how much? Public company is 3, private is 2, OPC is 1. But if at all you are coming under top 2000 listed companies, the minimum number of directors is 6. Again, a recent amendment. Top 1000, we saw women director. If listed company has SR equity share, then half of the board shall be independent. There was one rule. They have introduced this rule only as amendment, and this rule was deleted also. That is also an amendment only. Yeah, that's why I have kept it, and I have also done tick tick tick.
Sir, today we'll go into the section of written for top 500, at least one women director.
You have written women director.
For top five.
ಅದು top 500 2019 from 2020 onwards top 1000 listed companies shall have independent women director. The entire transitional provisions will be like that. Directly they will not say for everyone. So they first say for top 500. That is 2019. I can also write 2000 from 2019 it is top 500. From 2020 it is top 1000. See, one is done and dusted. When we are giving the total limits are around 7. And everyone had 2019 one limit, 2020 onwards one limit. It will become 14 limits. And obviously, people, the chances of asking a retrospective questions are less. It's a done away transitional provision. So, my experience, I have not seen a retrospective provision. Not required. But book is, do you have that provision? The answer is yes.
Two provisions.
Huh.
Top and listed.
That's what I'm saying. Effective 2019 top 500. Effective 2020 top 1000.
Both things are no.
Abba. Okay. Clear. Done now. Okay. Independent director, sir. So, sir, in listed company means 1/3 it seems. Here 1/3 we need to read it with chapter 14 now. Sorry, chapter 15 now. Correct? Depending upon executive and non-executive director of the chairman. Sir, public company having paid up capital of 10 crore or more, turnover of 100 crore or more, aggregate of loans 500 crore or more. Correct? Hey, 50 crore or more. Exceeding 50 crore for them people, your independent director provision shall apply. Remember, if independent director provision apply, for them audit committee will also apply. For them nomination remuneration committee will also apply. Remember, limits are the same. Sir, if I am that company, then minimum 2 independent directors shall be there on my board. Correct? And once applicable, you should see these limits for at least period of 3 years. Okay, next one, exemption for unlisted public company. If you are a joint venture, wholly owned subsidiary, or a dormant company, even though your limits are coming somewhere like that, you need not have to appoint a independent director. Vacancy of an independent director needs to be filled within 3 months or next board meeting, whichever is later. Tenure people, I can be appointed for 5 consecutive years. I can be appointed for 2 terms, provided there has to be a cool off of 3 years subsequently. Correct? Yes. So I can be appointed for two terms, post which there has to be a 3-year cool off period. Correct? Okay. Independent director definition should we go through? We'll go through? Okay.
I got an independent for that.
Which you didn't speak at all.
I spoke.
That is unbiased.
Unbiased.
Independent directors means a director who is unbiased. Hey, company law answered. Company law. I thought at least you will say 1/3 or 2 directors or limit or anything.
Remuneration, I didn't say that, sir. That saving fees and remuneration are separated.
Remuneration.
That day, when you told that word, no. That
Yeah,
word.
you understand now.
We understand.
An independent director. Okay, what is the definition of independent director? An independent director means people are director other than managing director, whole-time director, or a nominee director. Has to be there in your answer. He is not a nominee director, he is not a MD, he is not a whole-time director. What do you mean by that? An independent director can never be a whole-time director. He is always a non-executive director. Correct? Huh? Okay. So, what is independent director? Who is in the opinion of the board? Man, person of integrity, possession, yalla. Okay, Anna Bond. Next one, such individual shall not be a promoter or related to the promoter or director of cash. So you cannot be a promoter or related to promoter or director of cash. Okay. Such individual who has or had no pecuniary relationship other than remuneration. So, various people will ask this question, can an independent director receive remuneration? Answer is yes. You can receive remuneration as a percentage of commission possible. As such director or having, so apart from that you should not be receiving anything is what they are saying. Or having transaction not exceeding 10% of his total income with cash or their promoter or director during the 2 immediately preceding financial year. What do you mean by that? They're telling you who has or had no pecuniary relationship other than remuneration as such director or having transaction not exceeding 10% of his total income. I cannot be making any transaction also with them exceeding 10% of my total income. Imagine my total income is coming to 10 crores. Now in that 10% is 1 crore and I'm doing a transaction worth 1 crore with them. Then I cannot be an independent director of that particular company. That's what, not exceeding 10%. 1 crore, 1 rupee. Yes, sir, I am giving you the example of 10%. Clear, huh?
Does that include bills?
Which one?
One-
It includes any transaction, monetary only, no? Fiduciary, I mean, pecuniary only, no? Yes, yes, pecuniary. Pecuniary. Next one, people, none of whose relatives are. People, relatives are. Relatives cannot, what? Hold any security in cash during 2 immediately preceding financial year or during the current financial year. So, current also, last 2 years also, you cannot. Relatives cannot hold security. Exception it seems, provided that relative may hold security or interest in the company of face value, not exceeding 50 lakh rupees. Do not get confused between this and auditor. Auditor's relatives, how much they can hold? 1 lakh, 1 lakh, not exceeding 1 lakh. Face value, market value.
Okay.
Or 2% the paid up capital of the cash or such higher amount as may be prescribed. So up to 50% rupees or 2% of the paid up capital. So at times what can happen? I can be holding, if imagine it is as big as Reliance. That day we saw net effect will be 0.0. But Anna Bond is a big person there. So we have to cover both. They have covered both. Here is indebted to the cash in excess of amount of 50 lakh rupees, same thing, 2 years or financial year. Guarantee, same thing, 50 lakh rupees, 2 years or current financial year. Or has any other pecuniary transaction amounting to 2% or more of its gross turnover or total income, singly or in combination with transactions referred to 1, 2, 3. What do you mean by that? Everything put together. 1, 2, 3, singly or in combination, meaning alone or together, take everything. They're telling you amounting to 2% or more of its gross turnover. If such person is associated with you, then you cannot make such relative your independent director. Few people ask me, it means who, sir, here? You're talking about the company, not him. It is individual end of the day, independent director. Correct? Huh? He must not either directly or any of his relatives hold or has held the position of KMP. He, his relative, wife and all cannot be a KMP or has been employee also. But exception is there. What is that? Relative can be a employee. So software engineer, they can ask like that. Wife is an accountant. Can she become an independent director? Answer is yes. Correct? Huh? Yes or no? Is or has been, meaning you cannot be a KMP, you cannot be an employee. What if your relative is a KMP? Can you be an independent director? No. Your relative is a software engineer. Can you be? Understood? Pakana. Is or has been an employee or proprietor or partner in any of the 3 financial years. Proprietor partner means I'm speaking about us. Practicing firm, law firm, audit firm. So I am a sole proprietor. No, we are partners. They are telling you cannot. Neither your partners can, nor your interns can do any of the below things. So imagine if you want to be appointed as an independent director, your partners are also cannot have any of the interests given below. Even the employees working under you also cannot become independent director if you are the PCS of that firm. Understood? See, where is that? Where did it go? Who? Either hello though. He must not either directly or any of his relatives. It is done, no?
Box.
Employee, proprietor, partner. Any of the 3 financial years immediately preceding the financial year in which he is proposed to be appointed of firm of auditors or company secretary or cost auditors. Everyone covered? Or any legal or consulting firm, only advocates, for them they have given a particular limit on their turnover. Had any transaction with cash amounting to 10% or more of the gross turnover of such firm, meaning sir, I am a legal consulting firm for the cash. Out of my total turnover, 10% I am getting from cash only. My partner, me, my employees cannot be a independent director of that company. What a 5% you can be. Understood? When the attempt is very difficult, that day they will ask you this. But I don't think that day would come. I don't know. Holds together with his relatives 2% or more the total voting power of the company. Total voting power. Again, no, hold secure. There also we saw, no? Holds together with his relatives 2% or more of total voting power. Here they are specifically speaking about equity. There it was security. Debentures will come, preference would have come, everything is covered there. Here only equity. Is a chief executive or director by whatever name called of any non-profit, Isha Foundation, if you remember. Imagine chief executive of Isha Foundation is Sadhguru. So Sadhguru cannot be independent director since when any non-profit, imagine Isha receives 25% or more of its receipts from the cash or promoters or any of the associate holding subsidiary. Or that holds 2% or more of the total voting power of the company. Meaning what, sir? In total Isha Foundation, they get money, donations, charities and all. Out of 100 crores they get in a year, 25% or more. Meaning, sir, 25 crore or more is given by Reliance only. Now, who is the chief executive of Isha? Sadhguru. Sadhguru or whatever name you call is what they are telling. Chief executive or any name you call, see? Correct, So Sadhguru. So any name you call, you are considered as what? Obviously, if not chief executive, where will you call? Correct, no? Sadhguru, sorry, cut, edit. I mean, I'm just saying. Okay. Now, sir, they're telling Sadhguru cannot become independent director in our company. Understood? Asomat. Or if at all Isha Foundation is holding 2% or more of the total voting power of Reliance, again also same condition will not apply. Or who possess such other qualification. Jihad. Understood? Declaration, people, every first meeting you need to say that I'm independent. Every financial year you have to say. Whenever there is a change also you need to say. In the first meeting after the change, they can ask you a question. Correct? Remuneration, we'll see in this only. Executive, non-executive director, we'll cover it there. And remember, for independent directors and all, they need to take a D&O insurance in all that part. They need to clear an exam also. They have to enter their name into data bank. They have to, but few people are exempted, provided you're under the rank CS, CS and all having 10 years experience. You guys need not have to write or take up the exam. You guys can be exempted from taking up the independent exam. Independent director examination. Correct? Self-assessment is not applicable to you. Agreed? Appointment of directors. Proposed director shall give his consent. DR2. Director shall be appointed in general meeting. Ordinary resolution is sufficient. DR12 is the form filed for appointment or resignation or removal, whatever it is. Means to change in director. Not removal. Retirement. Am I audible, people? Okay, retirement or rotation da? ಹೇಳ್ರಿ ಇವಾಗ. Limits for all the public companies, people, only condition is, people, when AOA does not provide for retirement by rotation for all directors, your AOA should clearly say all the directors shall retire by rotation. If they do not say, if your AOA is silent, then the rule is out of your total directors, 2/3 of the directors shall be liable to retire by rotation. In that 2/3, 1/3 shall retire by rotation. In that meeting only, if they are well enough people, they can be reappointed. If they are not good enough people, then you will leave them. Generally, what happens, people, to leave them also you will pass ordinary resolution. Basically, to remove them and not to reappoint, you will pass ordinary resolution. To reappoint also, you will pass ordinary resolution. Sir, I do not want to reappoint. I do not want to fill the vacancy also. You will leave the position vacant. For that also, you need to pass ordinary resolution. Yes. Yes, so, if imagine in my company, there are in total people 9 directors. First thing, all directors has to retire by rotation. If that is there in AOA, then this provision will not apply. If it is not there, 2/3 of 9, that is 6. In 6, 1/3, that is 2, shall retire by rotation. Understood?
But that excludes independent.
Which one?
Independent is not.
Correct.
So that
No. It is all the other directors. No, small shareholder director will not come here. Proportional representation director will not come here. Nominee director will not come here. Yes, okay. A single resolution, can we appoint all the directors in a single resolution? Not possible. But you can first pass a resolution unanimously if they all agree to appoint all the directors in one resolution. Then you can appoint everyone. Correct? And who will be these 2 directors also? Whoever has been in the office for the longest time, not the age. Whoever is a senior, they will appoint, they will have to leave first. If at all it is same, then you will have to draw it chit. It is lucky draw. Correct? Okay. Next one, we will right of person other than returning director. Section 160. Someone had got this chit. I think they kept it again in speak. Yes. Section 160. What is section 160, people? Right of person other than retiring auditor to stand for directorship. Now, for example, I want to appoint, say for example, Hema as director. Correct? Now, can Hema be a director without being a shareholder there? Can you? Or should the shareholder only always nominate a person? Okay, people, let us say Hema is not a shareholder also. Can she nominate herself to become a director of Infosys? She is not a shareholder.
yes, sir.
Can she nominate herself? So you need not be a shareholder to give a request also. But the request person who is requesting should be a shareholder. Okay, remember, any person or member intending to propose him as director or random person, Belpuri, you can come. Provided now you only failed, sir, that means anyone will come and appoint. Correct? Anyone will just apply. To avoid that, people, we have introduced something called as 1 lakh rupees as deposit. In the case of Nidhi company, it is 10,000 rupees. Now 14 days before the general meeting, I have to deposit 1 lakh rupees saying I also want to stand for directorship in your company. If you get at least 25% of the valid votes, gets more than 25% of the total valid votes, or if you get appointed, then that 1 lakh rupees gets refunded. If not, that 1 lakh rupees is gone. Here, the company shall forward your request to all the members by giving an individual notice. If not possible, we will give it in the newspaper. We will also publish it in the website. Clear? Then vacation of office of director 161. 167. 167 speaks about vacancy of office of directors. When will have to leave? 167 speaks about you are already a director, you are leaving the company. When should you leave? When you are absenting yourself from the last 12 months for all the meetings. Then macha, just to leave. Disqualified by an order of the court or tribunal passes an order. You will see these people when you are doing inspection, inquiry and investigation. Remember, incurs any disqualification under section 164. What is this? Non-filing of financials and all other parts. You are becoming insolvent, all that. Coffee poser thing. You do not pay call monies and all that. Convicted of any offence, imprisoned for minimum 6 months. 5 months, 29 days, disqualification don't come. It has to be 6 months. Removal as per provision of this act. Someone has removed you, fine. Section 115. Ceases to hold office in that company. So, ex officio. Because of that office, you got a position here. If you leave there, you have to leave here also. Sir, now 164. Under 164 people, it's nothing but disqualification. When you are being appointed, you will see this. 167, you are already appointed, you have to leave. In case of? When he is leaving and going. Yes, you can at least pass an order that it will be left vacant. At least that has to be done. Next one, sir. Director's default 161, company's default. In 161.1, director is only doing a default or something in his personal life is happening. 164.2, professional life. 164.1, unsound mind, personal life. Undischarged insolvent, personal life. Pending insolvency application. Convicted of an offence and imprisoned for minimum 6 months and 5 years not elapsed. So you are imprisoned for a minimum 6 months. If you are imprisoned, cool off period is 5 years. Yes, but appi tapi macha 7 years you are arrested. Life you are ange martobudu. Yes, any example? We need to see. Now imagine if I cannot call convict, but now Darshan's thing can come. If at all he is a convict. But the case is going on. That's why he got bail. Or else he was in jail for 137 days. Correct? No? That is like 4 months and some days. Okay. Not paid call money. Convicted with offence dealing with related party. Does not possess dinner. Holding more than allowed directorship 2010 no 7 no. Disqualified order passed by court or tribunal. We'll see in investigation. Disqualification is not being director of company. 164.2, professional. Company has not filed financial statements or annual returns for 3 continuous financial years. Remember, vacancy. If at all anything happens in 164, as per 167, you have to leave, right? That is what you saw here. Correct? No? Incurs any disqualification. But remember, if at all a company is not filing financial statements and annual returns, in the company where the failure happened, your vacancy will not be happening there. Your vacancy will happen in all the other companies you are a director. There you have to continue, because if you leave, who will file that financial statements and annual returns? So your duty is to first stay there and finish that scenario. Can I be reappointed there? The answer is no. Now imagine I am a director of Reliance. I did not file financial statements or annual returns for 3 consecutive financial years. I am also a director of Infosys Arivu. Because I did not file in Reliance, I will have to leave my office from Infosys and Arivu. But in Reliance, I will continue. But imagine my 5-year tenure is done. Can I be reappointed in Reliance? No. That is disqualified. Understood? Huh? That's a whole provision. They can ask you, remember, deposits you fail to repay, debentures interest repay, pay declared dividend repay. Such failure continues for 1 year, you are disqualified. Yes, sir. For 5 months, 6 months, and all, they have given you time. Resignation of director people, which form? DIR? 3
12 only.
12
That's good.
11 ಅಂತ ಏನಾದ್ರು ಬರುತ್ತಾ ಬರುತ್ತೆ ಸರ್ a director whenever he resigns he will intimate to the company will intimate it to ROC inform DIR 12 but what if the company does not forward, what if I think so, if they forget my details are still reflecting on the company's website, I can also forward, director may whichever is within 30 days of resignation I can also file my resignation to ROC DIR 11. Sir, what will be the effective date of resignation? If at all you have specified a date in that notice or the date of receipt of notice by the company, whichever is later. I have written on the date letter that my effective date of resignation is 15th of November. But you got the letter on the 21st of November. The effective date of resignation will be 21st of November, whichever is later. Clear? Done. Loan to directors, people. Beka? Okay, last section, Mavada. No, loan to directors, somewhere on here, guilt. Okay. First of all, can we give loan to directors? Some yes, some no. We cannot give directly, we can give it to interested people. And some ways like, imagine we give it to our employees as their annual, you'll be eligible, right? Like some salary advance and all. In the same way, if you are giving it to them, allowed. You cannot even give something called as a book debt. What is book debt? Book debt is credit. Now imagine I'm a TV company. I'm giving this TV on credit. Macha, give when you're retiring. Can I give? It's a debt only. That also you cannot do. A company cannot give that benefits to the directors. So it is not allowed. Is it recording? A director of a company or a director of holding company, we are not allowed to give partner or relative of a director. We cannot give any firm where such director or relative is a partner. So I cannot give it to my director. I cannot give it to my director of holding company also. My partner or relative of the director, I cannot give. Yes, next one, any firm where such director or relative is a partner. Mukesh Ambani as a partnership firm, to the partnership firm also I cannot give. Mukesh Ambani and imagine Anant are in one, Anant, student Anant, only beda, Chandramoli. No sir, Chandramoli and Mukesh Ambani are partners in one partnership firm. We cannot even give it to Chandramoli also, that's here. And we cannot give it to Anant Ambani also, relative. Understood? Pakana? Okay, but it is allowed itself where a company may provide to a person in whom director of the company is interested. And who are those people? It's basically body corporates. A private company in which director is a director or member, we can give it. A body corporate in which 25% of total voting power is held by a director or 2 or more director, you can give it. Body corporate whose directors are accustomed to act in accordance with the director of lending company. Meaning what, sir? My company's directors are controlling another company. Company A's director is controlling company X's directors. Telling you can give it. Provided procedure, pass special resolution, and these companies has to utilize that money for their principal purpose. Principal purpose is nothing but their object clause as given under MOA. They have to utilize only for that. They cannot utilize for anything else. So I can give it to a private company I can give it to a body corporate in which 25% of voting power is held by director or two or more directors. A body corporate whose directors are accustomed to act as per my directors. Non-applicability of this, sir, it does not apply to loan given to MD or whole-time director. Technically, we shouldn't give, but we are giving. Remember this and go. They will ask 100 people here. It is allowed only for whole-time director and whole-time director and managing director, to no other director. Rest and all will fall here only. This is one of the questionable points. Correct? Huh? As a part of condition of service extended to all your employees. For all your employees, you're giving salary loans. You can give it to your MD also, whole-time director also, because they are also employees only, no? Or approved by members by passing special resolution. Call your shareholders. If they agree, then give it. What's your problem? Next one, company giving loan, guarantee or security in ordinary course of business. What do you mean by that? I'm a banking company. My ordinary course of business is to give you loan. And I'm giving it to you in my ordinary course. You as a customer, I'm giving it to you. Not you as a director. Allowed. Given for due repayment of any loan, you take it. You can give it to anyone else. And interest charged on such loan is not less than prevailing yield of government securities. If government securities, imagine you have taken 1 year loan. The government securities return is around, let us imagine for 1 year, they are giving you 8%. Then the interest on loan shall not be less than 8%. Any loan or guarantee or security can be given by holding company to its wholly owned subsidiary, allowed. Same thing, to its subsidiary company, allowed, provided they use it for their principal business activities. All these provisions shall not apply to which? A government company and a private company whose share capital should nobody should have invested, whose share capital basically no body corporate should have invested money. Yes, sir. And next, borrowing is less than twice of its paid up share capital or 50 crore rupees, whichever is less. My paid up share capital is, let us imagine, 20 crore. Twice of my paid up share capital is 40 crore and or 50 crore, whichever is less. Which is less? 40 crore. In your company, the borrowing should be less than 40 crore. Yes, same. If you guys remember that private company, section 181, 73 2 A to E, and what is the maximum deposits that can be raised? Both places. No default in repaying of such borrowings. Nidhi, loan given to director in a capacity of member, because Nidhi member only, no? Yes or no? Okay. That's your directors, huh? Till what time we can take?
Till 3:45, sir.
No, not you. I'll ask them. You guys until the syllabus is over.
Hello.
Yes, sir.
Till what time the class is available? Is there any class which is available like even in the evening? Yeah. You can let me know. I'll be taking the class in the break. I'll just check. And you can also let me know if this class is available. Huh?
Okay, perfect. Okay, 15 people, board composition and powers of the board. We saw composition, done. Restriction on power of board, done. Illa? 180 we did not. Okay, what is restriction on power of board? Section 179 technically gives you power for the board. You can do whatever you want. Call monies, invest, raise money, borrow monies, and invest, all that you guys can do. You guys can do all of that in 179, but 180 says up to a restriction. There is a limit. Beyond that, you cannot do. So 180 says, people, for these 4 things, you have to pass a special resolution. What are the 4 things, people? If at all you want to sell, lease, or dispose whole or substantially the whole of the company's undertaking. Imagine your assets you want to sell. If I want to dispose, if I want to lease, if it's a big chunk. See, regular contracts and all, you will not involve shareholders. But I'm saying it's a sizable amount. Then you need to consult me. Understood? Huh? Now imagine tomorrow once we establish, the Chennai office might become a very sizable unit. If you want to sell away the Chennai office to someone, I'm not saying Arivu, Chennai office. That becomes an undertaking. For that, you would need a shareholders approval. That's the meaning. Clear? To invest in securities, the amount of compensation received from merger or amalgamation. Meaning what, people? When you are receiving some compensation, when there is merger or amalgamation going on, if you have to invest that money in a particular way, instead of giving it to the shareholders immediately, I'm investing it somewhere. You have to do it, people. You need to do it only after passing special resolution. The third one, to borrow money. Directors has the power to borrow money, but how much? Up to your paid up share capital plus free reserves plus securities premium. Add everything to whatever amount it comes. It can be old plus new, which you have already borrowed, which you are proposing to borrow. Everything put together should not exceed this. Up to that, okay. Beyond that, you need to pass special resolution. But remember, in this, short-term requirements won't come. Temporary loans. Temporary loan means something which is repayable within 6 months. Clear? Next one, to remit or give time. We'll see this in 197. To remit or give time for repayment of any debt due from director. Okay, contribution by board. There are 3 contributions you can make. One is called charitable funds. What is the maximum we can give it to charitable funds? We can give it to 5% of its average net profits for 3 preceding financial years. 5% of my 3 preceding financial years average profits I can take it, sir. But can I give more than this? Yes, people, you need to take prior approval in the general meeting. So what are they telling people? Up to 5%, directors only have the power. Correct? So next one, sir, political contribution. Section 182. Now political contribution, can anyone do it? Few companies are restricted from doing political contribution. Government companies and newly incorporated companies. When I say newly incorporated, a company who has not yet completed 3 years of existence, less than 3 years of existence, these 2 companies cannot do political contribution. Okay, and what amount we can do political contribution, sir? What is the amount? There is no amount, there is no limit prescribed, just that everything should be in a proper banking channel mode, NEFT or electronic system, but not in cash. Correct? Yes, sir. And the amount shall be disclosed in P&L account that have contributed so much during the year. The last one is National Defence Fund. Do whatever you want as per the board of directors thinks fit. Correct? Okay. Next, so audit committee people will do this off in this only. Yeah. Audit committee people, for whom an audit committee is applicable? 10 crore, 100 crore, exceeding 50 crore. For them, audit committee is applicable. Yes, sir. Okay. Now, the members of audit committee, the audit committee shall consist of minimum 3 directors with independent directors forming majority. I'm not touching LODR, we'll only concentrate on Companies Act. So 3 directors shall be the composition. In that, independent directors will be forming the majority. Financial literacy, the majority of the members should be financially literate with the ability to read and understand. Include its chairperson shall be person with the ability to read and understand the financial statements. As per LODR, one expert has to be there. Here there is no expert as such. Correct? Everyone should be financially literate. Members of audit committee, including its chairperson, shall be person with ability to read. Basically, all of them should be financially literate. As per LODR, at least one should be a financial expert. Correct? Okay, next one. Chairman should be an independent director. As per Companies Act, silent. Role of audit committee, what do? They appoint auditors, review their performance, omnibus approval as per related party transaction, wherever there is a review of their performance, salary negotiations, all of that will be taken. Financial statements, the first thing will be presented with audit committee only. If imagine there is a fraud, you will first write it to audit committee only. Everything, the first point of contact will be the audit committee. Okay. Next one, sir. Power of audit committee call for the comments of auditors. Okay, that's okay. Frequency. When do you meet people? How many times? Does not provide. Companies Act does not provide for any company's meeting. It is all as per SEBI LODR only. According to SEBI LODR, it is similar to your board of directors meeting. Minimum 4 in a year, 120 days. Same concept will come there also. Quorum. Companies Act again is silent on it, people. So what do we say? You refer to the act. Act is silent. You refer to the. We'll see that. You refer to the act. Act is silent. You refer to AOA. AOA is also silent. Then refer to SS1. As per Secretarial Standards 1. When nothing is given anywhere, then all the directors has to be present to form a quorum. Correct? Possible question they can ask you. Okay, next one is vigil mechanism. What is vigil mechanism? People whistleblower. Basically against victimization and safeguarding against the victimization of employees. If they want to disclose something which what they know, what if they disclose and people might take some they might demote them, they might throw them out of the company and all. To avoid that, we have this. You will see this similar thing also in uh, chapter 12, victimization. There is a section there also. Huh? 2 and 8. Yes, every listed company and the companies accepting deposit from public, the companies which have borrowed money from banks and public financial institutions in excess of 50 crore rupees, for them people, vigil mechanism becomes mandatory. So they shall establish a vigil mechanism for the directors and employees to report their genuine concerns or grievances. Complaints, if any, you can go and say. If you say what if they remove you from the job, that's why we have this. They will try to protect the interests of the employees so that they can report whatever frauds they know without you guys taking any action against them. Correct? So against the they get direct access to the chairperson of audit committee whenever they want to do. Secretary of basically CS will be the secretary of audit committee. Okay. Omnibus. Okay, next one is people nomination remuneration committee. Same as independent director. Yes, constitution of committee people. There shall be 3 or more non-executive directors, with 1/2 shall be independent director. Audit committee majority shall be independent director. Chairman does not provide anything. Can the members of the company, can the directors be the members of? Can the chairperson of the company be the chairperson of nomination remuneration committee? Can the chairperson of the company be a chairperson of the nomination?
No, sir.
Can be appointed as member?
There was a box, sir. Chairperson of the company cannot be the chairperson of NRC, but he can be a member of NRC. So what is the role of NRC, people? Role of NRC is what? You can appoint directors, you can evaluate the performance, you can, what is that? Salary negotiations, review performance of their independent directors and all that part. Correct? Frequency nothing, quorum nothing. Same thing will apply. Stakeholder relationship committee, when does it important? Company which consists of more than 1,000 shareholders, debenture holders, deposit holders, or any other security holders at any time during the financial year. Even one day it was there. Then people, you need to form a stakeholder relationship committee. Understood? Okay, as may be decided by the board of members, chairperson shall be a non-executive director. The stakeholder relationship committee shall consider and resolve the grievances of security holders of the company. The company does not. Okay. What is the risk management committee, people? Risk management committee. What is the risk management committee? Huh? Majority shall be directors. Even a non-director can also be a member in risk management committee. Okay, minimum 3 members people. Majority of them shall be directors, including at least one independent director. If you have first of all, risk management committee is only applicable to who? All listed companies.
Top 1,000 listed.
Top 1,000 listed companies. Sir, in case of listed entity having outstanding SR equity shares, outstanding SR equity share, at least 2/3 of the committee shall comprise of independent directors. Chairperson shall be mandatorily the director. Other member can also be there, no? Meetings are at least twice in a year. The quorum shall be 2 members or 1/3 of the member, whichever is higher. At least one director should be there in the meeting, not independent. At least one director. The meeting of RMC shall be conducted in such a manner that the continuous basis, not more than 180 days, shall elapse between any 2 consecutive meetings. Meaning, maximum gap between 2 meetings should not be more than 180 days. Yes, sir. Okay. The last one, sir. Internal audit people. Oh, Gills is there, huh? Okay, Gills, Takaraga, tell of the. What is Gills, sir? What is the maximum I can do, people, Gills, sir? Gills have not added to this.
100%.
No such bifurcation is there. What is the maximum you can do? 100% of paid up share capital plus free reserves. 60% of paid up share capital plus free reserves plus securities premium. Okay, I have not added this. Huh? Okay, 100% of free reserves plus securities premium, 60% of paid up share capital, 60% of paid up share capital plus free reserves plus securities premium, or 100% of free reserves plus securities premium, whichever is whichever is more. So whichever is more. Yes, sir, didn't even know what question I asked. Because I said this, he said more. Okay. So what is skills are nothing but whenever a company wants to give any guarantee, or it wants to make any investment, it wants to make any loan, or it wants to make any security. Yes, yeah, Krolav. It wants to make any security. In such case, people, what should happen, sir? Now I just need to see people whether it is within the limit or it is beyond the limit. What is the limit, sir? Add your gills, add your guarantee given by the company, investment made by the company, loan made by the company, security given by the company. Adding everything, it should not be more than this. If it is within that, then what are the approvals you require? Only board resolution. If it is within the limit, if it is beyond the limit, you need to pass ordinary or special, Ada?
Special resolution. Special resolution. Special.
Hey. Which resolution, da, Kanna? Oh, special, sir. Special, sir. Huh? Yes, Sam. So if it is within the limit, you need to pass board within the limit. Board, beyond the limit, special. And remember, sir, whenever you are passing a resolution, sir, you need to check the limits. 60% of its paid up share capital, free reserves plus securities premium, or 100% of free reserves plus securities premium. Everything put together, everything is added. Gills. In your balance sheet, when they are giving an exam, check the balance sheet. If there is already some loan given, that you need to subtract. So whatever is eligibility you will get. If the eligibility is beyond what they are proposing, you need to pass special resolution. Correct? And if at all there are any loans you have taken, you need to mandatorily take your PFI approvals, your public financial institutions. But when this PFI approval not required, you shouldn't have made any default and The amount proposed to be borrowed is within the limits. What is the limit? Again 60 and 100%, whichever is more. If it is within that limits, then PFI approval not required. Correct? Huh? Okay. Sir, you need to disclose everything in the financial statements. Prior approval of financial institutions. Sir. See, the prior approval of public financial institution where a subsisting shall also be obtained when, if at all there is subsisting, meaning your loan is going on. Exception, prior approval of PFI shall not be required where existing bills plus proposed does not exceed the limit, and there has not been any default. Correct? If it is beyond the limit, required. Default, required. Sir, next one, sir. Rate of interest, people. It shall not be lower than whatever is the closest government yield. Yes, sir, it has to be close to that, not less than that. You should not make any default in repayment. Maintenance of registers, people. How long will you maintain? It shall be maintained for a period of what years? How many? 8 years? How much? Register of guilds. How long will you maintain it? 8 years. Allah. It shall be preserved permanently. It shall be preserved permanently. Form MBP. It shall be in the form. It shall be in the form MBP2. What is MBP1?
Interest of director.
Disclosure of interest of directors. Shareholding and all you will give, no? Okay. Sir, okay, that is your permanently. Okay, next one. Non-applicability not leaving. Okay. You want non-applicability? Investments to be held in company's own name. You cannot hold investments in. Imagine my money. The investments should be showed as MBP2 only. You cannot show it in someone else's name. But there are exceptions. We saw that exceptions. One is BO. Next one is to maintain the minimum number of shareholders. Now imagine if there is a wholly owned subsidiary and if it's a public company. Wholly owned subsidiary means entire 100% is with me. Public company means at least 7 shareholders should be there. So it is okay to satisfy the limit. You are taking 6 dummy shareholders. You can only give them money. They will be holding it on your behalf as authorized representatives. That is an exception. And that SBI and all to collect dividends and to transfer the shares. Remember, done away and dusted provision. Related party transaction. Some more related party transaction has not added. Okay, tell me people, what is related party transaction, people? Section 276. Now, first of all, what do you mean by a related party? For a company, a related party means all its directors and relatives. Directors, relatives. KMP or his relatives. So basically, director or KMP or their relatives. That's how we would have written in our notes. A firm in which a director, manager or his relative is a partner. The right way is to see that only. Or else it will be like this only. Is a firm in which my company, we are seeing whether that partnership firm is a related party for us. So, my director, Reliance company's director, manager or their relatives, if they are partner there, that partnership firm is a related party for me. A private company in which a director or manager or his relative is a member or director. So, imagine Arivu's directors or Arivu's manager or Arivu's relative. If at all they are a shareholder or a director in any private company, that private company will become our related party. Sir, what if it's a public company? A public company will become our related party where the director or manager is a director and holds along with relatives more than 2% of its paid up share capital. What do you mean by that? Imagine for Arivu, there is a XYZ Limited. Arivu's directors is also a director in that XYZ Limited. and he's also holding shares of 3%, then that public company becomes a related party to this Arivu Private Limited. Correct? Huh? Any body corporate whose board of directors, managing director or manager is accustomed to act. So if there is any other body corporate who is listening to my directors, or if my directors are listening to someone else's directors, that company will also become related party. That is these two. Next one, sir, all our holding companies, subsidiary companies, associate companies, and subsidiary of such holding company, meaning common subsidiary company. There is company A, I am a subsidiary company. Another company is their subsidiary company. Even these two are also related party. These two are also related party. These two are also related parties. Correct? Huh? Yes, sir. And sir, investing company or venturer. Investing company or venturer company means, imagine venture capitals. Someone who has given us money, investments. They are also considered as what? Related party. And along with that, sir, all my relatives also. Now, what do you mean by that? Here they have used the word director or is relative. What do you mean by relative? Relative means people. It includes mother, father, brother, sister, son, daughter, son's wife, daughter's husband, stepper. Step daughter is not there, rest all steps are there.
Step adopted.
Father, stepfather, mother, stepmother, brother, stepbrother, sister, stepsister, son, stepson.
Except stepdaughter, everything.
Except stepdaughter, everyone are there, sir. Huh? That's all, I'll remember. Huh? Online, is it clear now, Vada? Online now. Online now. Online. Confirm karo thoda. Clear, huh? Clear, huh? Okay, done. Yes, sir. So, sir, now, once it is the related party transaction, so what? If it is a related party transaction, then people, they say, we have some transactions here, we have some limits here. Agreed, huh? We have some transactions here, we have some limits here. If at all it is coming under these transactions, board approval is mandatory. If it is going beyond some limits, ordinary resolution becomes mandatory. Correct? Huh? Yara special. So, if at all it is a transaction, if you touch the transaction, if it's a related party, and if it is these transactions, board's approval is mandatory. If it is the same transaction but beyond one particular limit, board approval is also required, ordinary resolution is also required. Yes, Sam. Now, what is that, sir? Sale, purchase, supply of any goods or materials between two related party transaction, board approval required. If at all the same thing, if the value of such transaction amounting to 10% or more of the turnover of the company, meaning my total turnover is 100 crore, the sale purchase of raw material is coming to 11 crore, then people, board resolution required, ordinary resolution required. If it is between two related party transactions. Correct? Huh? Next one, selling or otherwise disposing of or buying property of any kind. Meaning there is a business transaction between properties. I'm buying or selling. Sir, 10% or more of the net worth of the company, that is the value. Then they are telling you people, ordinary resolution required. What is less than that? Board resolution sufficient. Leasing of property. My company's property, I am leasing. Did we see it somewhere?
In setting up. Leasing of property.
Leasing of property. Did you see it somewhere? No? If you remember, Jai Ji. Thank God it is a labor loss. Okay. So, if you remember, I told you one special purpose vehicle. Holding company will take an asset They will try to manage that plant and machinery. I will buy in my name. I will give it as a rent. That's what related party only, no? People are doing it. So there you will be enjoyed. Here they are telling you, tell and enjoy. Yes, okay. Rendering of any services directly or through an agent. Again, 10% or more of the turnover. Next one, sir. Office of place of profit in the company. Basically, the place of profit we had seen. Anything apart from those requirements. Exceeding 1% of the, monthly remuneration exceeding 2.5 lakh. If it is beyond that people, again, you need ordinary resolution. Underwriting people exceeding 1% of net worth. It will be considered as ordinary resolution. Yes, sir. And what else will come in related party transaction? First is board, next one is ordinary. Whenever it's a public company, people, if at all you're a related party, you're not supposed to participate in the quorum also. You cannot vote also. You'll have to walk out. But if it's a private company, people, in such companies, you can disclose, you can be counted in the quorum also. You can disclose and vote as well. Correct? That's one thing we saw in related party transaction. Remember, when you are passing ordinary resolution, if it's a public company, as a shareholder, even I am also interested. Mukesh Ambani, he is only holding 51%. You're telling me to pass ordinary, I will easily pass. My own thing, no. So they're telling you cannot participate. You will not be counted in quorum also. If 90% of them are interested, then yes. You do not have a way out, then all of it will, you guys can continue because it is closely held companies. Correct? Yes, that we saw, if you remember. Okay. Okay, this is the thing. See, no voting by related member. A member of the company who is related party shall not vote on the resolution. However, this provision shall not apply to a company in which 90% or more members in number are relatives of promoters or are related parties. You are all related to one another. Then what is the point of sending out and all? You guys say it is okay. Omnibus approval. What is omnibus approval? Whenever there are repetitive transactions, people, which is occurring every year, every month, or as per the intervals, you should actually go to audit committee, board, or ordinary. Everything is required. But this audit committee, can we have a shortcut? They're saying yes, people, possible. If at all a transaction is repetitive in nature, you guys can go and give your requirements. The audit committee can give you something called as omnibus approval, meaning people, it's a blanket approval. Remember, sir, omnibus approval, if you need it, you need to give certain details. Sir, what if I don't have details? Without details, also omnibus approval can be given, provided the approval cannot exceed a amount. How much? 1 crore rupees. Omnibus approval cannot be beyond 1 crore per transaction or aggregate in everything in a year. Per transaction 1 crore rupees. Cannot be more than 1 crore rupees. Omnibus approval can be given. And in omnibus approval, we give the value, nature of transaction, parties, everything. It's like a certificate given. Using that, you guys can do. It will be reviewed quarterly once, yearly once. Yearly once. It shall be reviewed annually. Yes, okay. Sabas, 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 beta. बहुत बढ़िया. Okay, done now. Okay, now what else is pending now? Taka see and tell me which is pending. Huh?
Done yesterday.
Annual report is pending.
12 is there, 18 is there, 19 is there. 12, 16, 18, 19. 12, 16, 18, 19. Okay. 16 will finish off and go. Meeting of boards only, nothing is there. We'll finish it off. Taka, taka, taka. Chapter 3 is left. 12, 12.
Fetch.
Ema.
EH3 is written. What is that?
I gave content ko dekho. Chapter number ko nahi. Yes, sir. Okay. That yellow bottle is like this ಮೆಜೆಸ್ಟಿಕ್ ಅಲ್ಲ ಮೆಜೆಸ್ಟಿಕ್ ಅಲ್ರದಲ್ಲ ಪಬ್ಲಿಕ್ 5-8 people will drink in that one bottle. Okay. ಹೋಗಿ ಏನಾರು ಮಾಡಿ. Okay, people. ಪಾಪ ಚಂದ್ರಮೌಳಿ. That's
I did.
you got bottle, huh? I'm telling you to get a different bottle, so I refilled and drank from a same water. Allah. That's your duty.
The least I could do.
Told them at Christmas you'll give a bottle.
For your class, we have to get the 25-liter Bisleri can, or you have to gift it to Chandramouli. In previous batch, there used to be one student. First day, I got shocked. She used to bring a bottle, 3-liter capacity. 3 liter. I shocked. Again, water bottle can. Imagine a person holding and moving 3-liter water can. Yeah? Okay. Huh? Okay. Correct. Okay. Meeting of board and its committees. Simple one. We'll finish it off. So, board meetings, people, what is that? Within how many days of incorporation you have to conduct your first board meeting? Within 30 days of incorporation, you have to conduct your first board meeting, and subsequently, a company needs to conduct at least 4 board meetings in a year, in such a way that the gap between 2 board meetings shall not exceed 120 days. And whenever you are writing board meeting, you will also quote SS1. Sir, for a board meeting, you need to give a notice of a board meeting. The notice of a board meeting shall be given at least 7 days prior. Remember, clear days is not mentioned here. So 7 days prior, date of the meeting excluded. You can include the date of giving the notice. Because they have not given 7 clear days. What else we can do? Correct? What will be the quorum of the board meeting, people? The quorum shall be
2 directors or 1.
2 or 1/3, whichever is higher. Whichever is higher. What if the quorum is not present? What if the quorum is not present? Same thing, it gets adjourned to the next week, same time. Can we have a board meeting in a shorter notice? What is the criteria? At least 1 independent director should be present. Remember, shorter notice in general meeting, there is a minimum number of requirements. Some minimum number of people should agree for it prior to conducting. That's not the case with board meeting. Board meeting, at least 1 independent director should be present in the meeting. What if even independent director is not present? After the meeting is done, you have to circulate the resolution to everyone. At least 1 independent director shall ratify the resolution. If not, the shorter notice will never be valid at all. Correct? And the next thing is that what if I do not have independent director at all in my company? I'm a private company. Majority of the directors has to ratify. That's all. Correct? Yes, sir. Okay. Subsequent board meeting. Okay. OPC, smaller, dormant, registered startup. 2 board meetings in a year, such that minimum gap between 2 meetings should be at least 90 days. Notice of board meeting, 7 days, shorter notice, independent director, if not a majority. Notice should always have pre-decided dates. Notice shall always give an option for the directors to attend through video conferencing. Roll call provision and all, yesterday only we saw, again I am not going through. Quorum, people, 1/3. Quorum of top 2000 listed companies from 2000 shall be 1/3 or 3, whichever is higher, including at least 1 independent director. Any fraction shall be rounded off as 1. Any fraction means 3.33 means not 1. You have to round it off as 4. One of the doubt asked in one of the batches. Sir, it's unfair. No, sir, they said. What do I say? Okay. Quorum to be present throughout the meeting. In case of Section 8 company, what is this? In case of Section 8 company, quorum shall be 8 members or 25%, whichever is less. 8 members or 25% of total strength, whichever is less. Subject to at least minimum 2. When to connect board meeting, people? Whenever you want. Original meeting can be connected any day. Urgent meeting any day except national holiday. Interested director, he shall not be present or counted in the quorum of board meeting. What do you mean by interested director? In the resolution we are passing, it can be related party or I have some interest over this particular transaction. They are telling I cannot vote, I cannot be counted for quorum also, I have to leave. Exception, this shall not apply to a private company. Tell it, you will be counted. However, if interested director exceeds or equals to 2/3, the total number of directors not less than 2 shall itself become the quorum. Correct? Next one, passing of resolution by circulation. What is resolution by circulation? Instead of physically conducting a meeting, you guys can give an email or a postal card or whatever you want. You guys can give an option to vote instead of physically conducting a meeting. But just that you need to keep one thing in mind. What is that? If minimum 1/3 of the total number of directors require for a physical meeting, then the resolution cannot be conducted by circulation. You have to conduct a physical meeting. So if at all total 9 directors are there, if 3 directors says that we need to discuss this in a physical meeting, you cannot discuss this over an email. You have to conduct a physical meeting over that. Correct? Yes, sir. Okay. Matters covered in 179 cannot be discussed over circulation. 179, power of board, specifically to be discussed in a physically conducted meeting. You cannot do it through circulation. Not possible, not allowed. Clear? The resolution shall draft. I should give it to all the directors. Correct? Should I give it to the alternate director also? Who left India? In his place, we have appointed someone, no, temporarily. Should we give it to him also who has left India? We have to give it to the person who is appointed as an alternate director. We have to give it to all the directors. We have to give it to him also. What if he comes? The day he comes, this person has to come to an end. Said resolution must be passed by majority. 9, 5 agree, it's a resolution. But however, remember, if 4 have not yet answered, there are chances them asking for physical meeting. So you cannot take it as a valid resolution. Even if majority have agreed. Correct? If minimum 1/3 of total number of directors require physical meeting, means a resolution passed through circulation shall be noted and forms part of subsequent meeting. Clear? Pakana? Hello? Okay. And what else was there? Video conferencing mandatory, roll call, that entire thing I'm not going through again. Yesterday we discussed over that only for a long time. That's all? Okay. That's your board meeting. Okay. You want a break? Yako? Can an original meeting be conducted on a national holiday? Unfortunately, yes. Even I don't know the logic, but answer is yes. Okay, go for a break and come. 10 minutes, or 15 minutes. Sir, you know what I know, sir. Okay. Go and come. I'll see if class is available little more. We'll finish it off today only. Go for a break and come. Okay, next people, let's do chapter 12 now. Three more chapters pending. Taka will try to wrap it up by 4:35. 5 will be yes, easily. Because 5. It may go up to 5:15 also because 2 lengthy chapters are there. But we'll try to finish it up. Chapter 12, inspection, inquiry and investigation. So as we saw in the class also, what is inspection, inquiry and investigation? You'll be filing so many forms with ROC. Whenever at whichever point of time, ROC will generally be inspecting. Once in a while, random, we saw the scrutiny also. They can take it up. So at any point of time, after looking some 3-4 forms, ROC feels this form is not right. Something is quite skeptical in this form. I'm not sure, but I know something is might be wrong. So what will ROC do? ROC will go physically to the office. He will start conducting an inquiry. What happened? Can you show me other documents? So section 130. You have reopened the books only for one financials. Now I've started doubting there is a big problem in your entire financial system. Now I understood that. Now I'll start conducting my inquiry. The day I'm convinced people, then I know the last stage will be called as investigation. Inspection, you do not know. You are just doing your duty. Inquiry is a follow through of inspection. When you're doing inspection, you think you need to go deeper, you go to inquiry. Inquiry is a stage where you talk to people. You look into more and more documents. Investigation is the last stage where seizure of reports can happen. I know that something is wrong. Prosecution can happen. Freeze of things can happen. Assets, I can get into other related company of yours. It started with you, but it will not end with you. That all will take place in the investigation part. And your search, investigation, inspection, inquiry, and investigation. Understood? At whatever time or whatever point I feel that the fraud I'm thinking of is not something small in nature, I feel it's really a bigger one than what we anticipated, then I'll directly go to section 212, that is SFIO. Serious Fraud Investigation Officer. So they will take up that. Satyam, all these things were done under SFIO only. Okay, let us see how does it happen. Everything starts with section 206. On scrutiny of any document filed by a company or any person, you'll be filing. CHG1, you'll be filing. AOC4, you'll be filing. Any other person, DIR11, director file. CHG1, charge holder can file. Not always you only, right? By ROC, require further information or explanation. So you have filed, he needs more. By a written notice, he can require the company. Registrar is telling the company, I want further information and can you give me more documents? It is a duty of officers, section 206 and 207. That's a connected section, if you guys remember. You have to cooperate and all that. So duty of officers to coordinate, cooperate, give all the details he is asking for, and we'll see. ROC may, by written notice, request for further documents, books of accounts, books and papers in such time with the company. The company may either give no information or you may give information but that is half and half, inadequate. ROC is satisfied, you have given information and ROC is satisfied, happy about that. The affairs are satisfactory, I don't have any problem. There ends the case, there ends the disclosure. Everything comes to an end. Sir, if at all there is inadequate or no information is my problem. In such cases where no information is furnished, company and officer shall be liable with fine of 1 lakh and 500 rupees for continuing default, for every continuing day of default. ROC may order for inquiry. It started with inspection, now we are going to the next step, inquiry. After giving an opportunity of being heard, after being satisfied on the basis of information available, whatever you guys gave, on representation made by the person that business is carried on in a fraudulent or unlawful way, or grievances of investors are not being addressed on any of these grounds, based upon the information, or customers, your investors are filing more and more complaints, you are not addressing them at all, or I got to know that yes macha pakka fraud, I got to know. Then people, if a word fraud is there, 447 ange magic ICSI chip inge Fevicol gottalla. Wherever fraud is there, 447. If central government is satisfied, it may order for inspection and inquiry of books and paper of company. It shall direct a registrar or appoint an inspector to carry out such inspection or inquiry. I told you inside the class only when we are doing people, the power to order inspection or inquiry is there with the ROC, is there with the Somoto, it's also there with the central government. Correct? Huh? We had some places CG has given, we'll be seeing that. Tribunal route, this you can take it as together only. Next one, tribunal will also come. Yes, sir. That route will also come. So up to 2 lakh rupees, CG has delegated the power to RD. Okay, we'll see. If you guys remember this, CG has delegated its power to receive report to RD for punishment less than 2 years. Correct? Huh? Okay, we'll see that. So, sir, inspection started. I felt that if it is required, we are still in 206 in the inspection stage. We might ask for further information and all that. And towards the end, we are speaking about inquiry. Correct? Huh? Okay, in 207, what is happening? Conduct of inspection and inquiry. So we are till now checking the documents available with me as a registrar. Now I am coming to your office. So sir, duty of directors, officers and employees present there. Produce all document whatever is asked. Information giver, assistance, you can't say, you can't say all that. Correct? Power of registrar or inspector similar to civil code, meaning I can basically what? Summon you, ask for any documents, witness, all that, whatever civil court has, I'll have all that power. Inspect the books of accounts as the case may be. During the course of inspection or inquiry, I can take copy of books of accounts. I can even mark, I can make an identification marks there. Everything is allowed. Sir, now when you are reading this, also read 218. What is 218? Whatever you said. Employee protection. Now you are saying that all of you should cooperate. What is that you will give for the employees who are cooperating? So they are telling you protection of employees during investigation. When they are helping, you should also protect them, right? They should not be demoted. They should not be removed from their jobs. They should not be, imagine they're working in the morning shift. You cannot put them in a night shift. You cannot give them a coffee or tea in their tea break. What, Matthew? Correct? No. So, sir, during the pendency of any proceeding against affairs of the company, online able to see here, audible? Online audible, okay. Now we will see here protection of employee during investigation. So what they are telling you, during the pendency of any proceeding against the affairs of the company and such company, body corporate or any person, company, body corporate or any person, if they propose to discharge or suspend or punish the employee, that can be like reducing his rank, demotion, change terms of employment, morning, night shift to day shift, salary components being changed, your incentives can be reduced, whatever is the scenario. Sir, 218 I told in the class, they tell that we protect you, nowhere they protect you. What do they say? They're not telling you can't do this. They're telling if you want to do all of this, you apply to the tribunal, we will tell you can do it or not. No, they will apply. Now, tribunal people, they have some time limit to reply. What is that? Tribunal has to respond to the request of the company or body corporate or any person. They have to respond within 30 days. What if they do not respond? It is considered as deemed approval, meaning you remove. Now, you know tribunal, obviously it is very free, no? Yes? So, see, we are assuming that they will help you, but almost it is like checkmate for them only. Clear, okay? Now, sir, object the decision by post. What is that, sir? Now, tribunal shall say such company, body, or person is. They can say people no. You cannot remove him. How can you remove him? Tribunal can say no. I'll pass an order in the favor of the employee. But remember, such body corporator, such company, such person, if they are dissatisfied with the tribunal's objection, they can always go for an appeal with appellate tribunal. I told you again, what is the problem here? Only the company can go, not the employee. If at all they have given the ruling in favor of imagine favor of company. If employee is not okay with it, an employee cannot go for an appeal under section 218. That's a problem with the 218. Here, yes, sir. Okay.
What if the employee is the company?
He is a suspect in the case. Possible. Now that is where this will come. You saw one more thing also, right? Wherever it is or was, we'll be seeing it. Wait, I'll show you. Which section is that? Okay, I'll tell you what exactly I was talking about. I tell you. Basically, what is it? Imagine I removed you. But if I get to know that imagine I removed you in 2024. Now it is 2026. I want to check, or if I want to take any details from you, I still have a right to inquire you. I still have right to do investigation on you. You are legally bound. So the words used in the law is or was. If you are an employee or if you were an employee. Yes, sir. Clear? Okay. Now, sir. 208. Report on inspection made. 206. Inspection started. 207. Went to inquiry. Inspection inquiry. It was still going on. 208. Report on the inspection made. You closely went and saw. You felt, sir, no, sir, company is clean. No, sir, company is not clean. No. You can say either that or you can say either this. So, sir, 208. Registrar or inspector after inspection. People, what is this registrar or inspector? Remember, under this chapter, the right to conduct the inspection or inquiry can be done by either registrar or you can appoint a inspector to do that. It can be that or him. You would have written down in our notes also. It can be him or that. So, registrar or inspector after inspection or inquiry under 206 and 207 submit a report. Submit a report. It may include reasons and need for further investigation. ऐसा begin हुआ, ऐसा करके ऐसा चले गया. 206 inspection, inquire in investigation. Understood? Okay. So further 210. We'll see what is the 210. 210 is like Sangama. All the friends meet. Okay. To the central government. CG has delegated the power to RD. So I am giving my report, my inspection report I am giving. To whom I am giving? I have to give it to CG. But the central government has delegated the power for whatever is the non-compliances you have pointed in your report. Sir, he has done that, this, that. If at all the imprisonment people is not exceeding 2 years, up to 2 years, basically less than 2 years, the matters will be decided by RD. If it is going beyond 2 years, people, it will go to central government only. Clear? Yes, Pakana? Okay. If it is more, it shall be forwarded to central government. Clear? That's also on model. Okay. Next one, people. 208 done. Okay. Search and seizure, section 209. Now, what is 209, sir? ROC or inspector believes that. Now, what is that? Now, let us imagine, people, when I am doing my inspection or inquiry, I believe that there is a company. You remember that all our movies they will show, no? Whenever there is any such IT raids and all happening, the documents, cash and all will be inside the wall, inside borewell. So, sir, they are about to destroy, sir. They are about to secret it, falsify, sir. Aisa jal gaya, sir. Now I want to stop it. Now what do I do? They are telling people. We saw it in one diagram also. ROC, sir, he gets to know that people is running. There is a fire. They are just burning everything. ROC ange siren account. He'll be coming here. But when he comes here, people, the law says, hey, ROC, where are you going? He's telling, sir, I have to put off the fire. Important evidence. ROC, I told you, no, you cannot go directly. You have to ask me, approval is required. No, you have to take special court's approval, people. If special court gives you an approval, then only you can go and you can stop this particular event from happening. Yes, sir. Special court, it is always nominated by central government. Yes, sir. Okay, see here. Company, KMP, Director, Auditor, CS, PCS may destroy, mutilate, alter, falsify, secret the books and papers relating to them, can make an application to special court. Who? ROC or inspector. They can make an application to special court. It shall order for entering such place. Hero style, gottala, lock agirate. They will go and kick the door. They can knock also. You never know, they might open. And search and seize necessary papers after allowing company to take copies. The seized papers must be returned within 180 days plus. If at all you want it, people may call it for further period of 180 days. If you think you need for another additional, you can also have it for another 180 days. Clear? 209. 210. Investigation into affairs of the company. Now under this chapter, people, there are too many types of investigations. Correct? If you remember, the different types of investigations are 206, 7, 8, 9, ಆಮೇಲೆ under this chapter, sir, there is different kinds of investigation. Correct? These are different kinds of investigation. Yes? Okay. Now try to read it here, people. Try to correlate everything and read. If not, it will become a little complicated. Central government is of the opinion it is necessary to investigate the company's affairs. So I'm thinking I have to go to the third step, final step. Company is into some random thing. We have to sort it down. So CG is satisfied that an investigation is required, people. In such case, what happened? On receipt of report from ROC or inspector in section 208. Correct? 206, 708. There they said no, you have to go for investigation. So you're coming from the general route 206, 708. Okay. Or a special resolution is passed by the company. So moto, voluntarily. We are requesting, sir, please do an investigation of our company. We are thinking this company is act through, something has happened here. You have to investigate. So you're going voluntarily. Next one, people. In the public interest, so moto by central government. Central government on its own is telling no, we have to do something because the company seems to have messed up their affairs. Or people, order is passed by court or tribunal to investigate the affairs of the company. Why will tribunal come and say from nowhere, investigate the affairs of the company? Someone should have come and told the tribunal. So someone has come and told the tribunal. Who is that? That is given under section 213. Now go to 213 quickly and come. What does 213 say? Investigation into company affairs in other cases. Correct? When is that? Tribunal on an application made by company or any person. Who should make an application? So someone has gone to the tribunal and told, sir, please protect us. Something is happening in our company. Who is that? If at all the company has share capital, members holding minimum 1/10 of the total voting power or not less than 100 members. Company not having share capital, not less than 1/5 of the person, that is 1/5 of the members. Sir, if these people are making a request to the tribunal, what are you going and making a request? Sir, we are going and telling that business is conducted in a fraudulent way, or it is being conducted for unlawful purpose, or sir, it is being conducted with an intention to defraud the creditors or members. Sir, person connected in the formation or management of the company are being what is that? They are being guilty of offense or fraud or misfeasance, as the case may be. Yes, sir. Next one, sir. Members are not given all the information which they reasonably expect. They are not giving it when we are asking it, sir. After giving an opportunity of being heard, CG may appoint an inspector to investigate into affairs of the company. 210. Understood? So here we have made a request to the tribunal. People have made request here to the tribunal. Correct? People have made request to tribunal. Tribunal is satisfied. Tribunal is telling to CJ, hey, like this, someone has come and asked for investigation, da. You take up this matter. After investigation, it is proved that they are guilty of fraud. Fraud is there means 447. So now tribunal, people have come and asked. Tribunal is telling CJ. Now that's why we are coming to 210 again. Understood this part? Huh? Order is passed by court or tribunal to investigate the affairs of the company as per section 213. Now go back to your main material. Investigation of the affairs of the company is necessary as per 210. Correct? Huh? Sixth one, as per the order of tribunal. So investigation can happen in various ways. Correct? Huh? Yes, Sam. Okay. Next one, sir. Now, people, applicant shall deposit a security of not more than rupees 25,000 towards investigation expenditure. Refund if results in prosecution. Now, what is that, people? If you remember here, if at all you are coming through this route and if you are coming through this route, you need to deposit the initial money for taking care of the investigation expenses. And how much is that money? That depends upon the turnover of the company. That money will not be beyond 25,000. That is what is given in section 214. Sir, everyone should give a no. Whenever voluntarily you want to do investigation or whenever you want to go through tribunal's route, you need to deposit a money sufficient for investigation. And how much is that, sir? Not exceeding 25,000. Here, that is what is given in section 214 also. Here, Akkana, I hope till here it is clear. Okay. Now, sir, 212 will again come back. 213 is done now. Okay. Now, sir, come to 216. Investigation of ownership of the company. Or wait. Okay. Now, sir, see here. People, investigation of ownership of the company. Now, what is that? Central government may appoint inspector to investigate and report on true persons who are or have. Again, investigation is coming. Now, why is so many investigations coming? Go back to your material. 216, investigation about the ownership of the company. Correct? People, till now, we are doing investigation because of so many things. In one place, we thought based upon the reports you have filed, forms, we conducted inspection, investigation, we felt that form or that financial aspect, there is a fraud. Here we are thinking the ownership, there is a fraud. In tribunal's route, they are thinking the company is not conducting the business in the best interest for them. They are doing fraud. Every place there is a different motive. Getting the point, but every place it is ending up in investigation. So, sir, in 216, what are we trying to find? We are trying to find the ownership. Someone is doing, they basically BOSBO will come here. We are thinking, sir, the person who is known to the world, but the person who is operating this company are not the same. I think so. CG will conduct investigation to find out the hidden owners. Benami transactions, we try to avoid it. 216 is here. CG may appoint inspector to investigate and report on true persons who are or have passed beneficially interested in success or failure of the company. You have been there, you went, or you are now there. I'll catch hold of you, Benami. Next one, being able to control or materially influence the policies of the company. Puppet show. You are operating the company. Next one, beneficial interest in shares, BOSBO. Someone is holding beneficial, but the registered owner is different. Now, in such case, people, during investigation under section 216, NCLT can impose restriction on securities up to 3 years. What is that? We'll see. So, sir, contravention will lead to fine and imprisonment. These provisions shall apply to foreign company also. Now, I getting now people under section 216, CG shall start an investigation to find out who is the true owner. Now, when I am finding out these people, I can also go to tribunal and I can say, sir, I'm trying to find the true owner, sir, but that person is running away. He's selling all the shares now. Sir, can you please tell him not to sell? Please. People, read 222 with this. What is 222? Restriction on transferability of shares. Correct? Imposition on restriction upon securities when it appears to tribunal. See here, in connection with investigation under 216 or on complaint made by any person in any other scenario. Tribunal feels such facts cannot be found unless certain restrictions are imposed for a period not exceeding 3 years. I can restrict people for a period of 3 years. I can tell you cannot sell, transfer, you cannot do anything with regards to your shares. Anyone contravenes people, there is a penalty. Penalty for now, let us leave it. Let us not concentrate on penalty. Is clear? Pakana? Yes, okay. That is your 222 and also 216. Any doubts here? No? Okay. Now 217. Procedure powers of inspectors. Now, sir, when this entire process is going on, what is my power? What and all I can do? So that power is given in section 217. For whom? We are speaking about the inspectors. Duty of officers, which we already seen. Whatever he asks for it, you have to give. It's your duty. For the employees or the officers or the directors, whoever is being investigated, you have to cooperate. Correct? Power of inspector, we saw same as civil court. I can keep the documents in my custody. 180 days. Another 180 days. The inspector may examine anyone on oath. Correct? Pakkana. The inspector can say, I will examine anyone on oath belonging to the company except any other body corporate. Meaning, I can inquire anything about your company because you are under that limelight. Reliance is under limelight. Can I go and inquire Geo? Can I go and inquire Geo? If you want to do it, you have to take a prior CG approval. So where is that prior CG approval given? That prior CG approval is given in section 219. Now see here, investigation into affairs of related companies. Now when I was going in search of silver, I found gold and diamond. Sahara case. Sahara, the person who started, the person who ended up in jail was completely different. Inspection never started with the company who did the default. Somewhere in the parent chain, the inspection started. The child chain got caught. Got it? So, sir, I feel during this process, I got to know we need to involve few other companies related to them. I will come under 219. Now, see here. Inspector appointed under 210. Genuine reporter, 212. SFIO, 213. Tribunal route considers necessary to investigate also the affairs of what? Any body corporate which is or was, today it is your subsidiary or it was, today holding or was subsidiary of such holding, the triangle, or any body corporate which is or was managed by my managing director. So my MD, imagine is managing some other body corporate. Oh, macha, then I know that is also involved. Is or was. MD by MD or manager who is or was MD or manager of the company. So basically common MDs. My company's MD, your company's MD, same. Macha, come here. Understood? Next one. Any body corporate whose board of directors comprises nominees of the company. I have given loan to a company called XYZ. Because I gave loan, I appointed a nominee director on the company's XYZ board. So I am controlling company XYZ through my nominee director. Macha, come here, XYZ. My person only, no, there also. Correct? Now, next one. Body corporate is accustomed to act. Puppet. Any person who
MD, manager,
so whether you quit the company and go, you will come here. Perfect? Yes, okay. Subject to prior approval of central government. Correct? You will go there. Now, sir, come back. So that is what you have seen. Now come back, sir. 210 we finished, no? We're doing 217 only, right? So 219. Sir, sometimes what happens, we would have to go in detail investigation, no? 212. For that, you need to take SFIO director's approval. That we'll see later. Next one, sir, if any director or officer disobeys the registrar or inspector's order, penalty is there, need not worry. Next one, sir, people, if at all a director does not disclose or does not cooperate with the inspection or investigation, director shall also vacate his office and disqualified from any company. I told you when we were doing 167, this is there, correct? You'll have to vacate. Order passed. Any examination done on oath shall be written. Now people, I will be interrogating him. I'll write down everything and I'll make him only sign on it. In the court, this can be a valid evidence against him. Next one, sir. CG may enter into a reciprocal arrangement. Now what is that, sir? Now imagine people, there is an employee or director who is sitting in UK. We want to interrogate him or we want some documents. Like Singham style. Our Singham only will go there and bring him. Illa people. In reality, we enter into something called as reciprocal arrangements. When your people come there, my people, now such cases what happens? You please catch hold of my person in your territory, interrogate him, you take the details and can you please pass it on to me? Our court will write a letter to their courts. Their courts will get the information. They will inquire. They will forward the reports to us. We will also do it the other way. That's why it's called as reciprocal arrangements. Akana, we will write. Now what will happen? Our inspector is there, no? He will go to the competent court to India. And he will say, Indian court, can you please get those information? Indian court will write a letter of request to the foreign court. Foreign court will get that information. They will forward it to us. It will be considered as a conclusive evidence. Akana, yes, 217. Any doubts? No? Okay, done. 218, done. 219, done. 220, what is 220? Simple. Seizure of documents by inspector can keep it until completion of investigation. No court order required. 220. I told you also in the class what is the difference between that and this. That is inspector and registrar. This is only registrar. There you need approval. You cannot keep beyond 180 days. Beyond that maximum 180 days. Here no time limit at all. So those differences are there here. Okay, 221 people. What is 221? Sir, whenever the inspection or inquiry is going on, sir, I feel someone is going to sell off the assets, illegal incomes made, disproportionate incomes made. I think he is going to sell it off. Can you please stop it, sir? We can stop it, people, but how do I stop it? Sir, freezing of assets of company on inquiry and investigation. Reference made to it by central government or so tribunal, someone has made a request. From central government, they have made a request or complaint under section 244. What is 244? Operation and mismanagement. Creditor having minimum 1 lakh amount outstanding or any person having reasonable ground, we are writing a request to the tribunal and we are saying that removal, transfer, disposal of funds, assets and properties is prejudicial to the company shareholders or creditors' interest. We are saying, sir, they are going to sell it away. Please stop it. We will not be able to do anything. Sir, tribunal shall pass an order during a period not exceeding 3 years to freeze, impose conditions or restrictions. Isn't it similar to the securities? Yes. Securities will also be freezed for a period not exceeding 3 years. Even assets can also be freezed for a period not exceeding 3 years. It can include your property, it can include your car. I can tell you, you cannot sell it, you cannot do anything until I tell you to do. As a part of investigation, I can stop you from doing all of this. Correct? 221. Now, if you go back to your book and see, investigation of affairs related to companies, I'm speaking about subsidiary holding, 216 we saw, and 212 we are to say. Okay, 228 people, whatever BOPO, all the provisions of Indian whatever we saw will also apply to the foreign company as well. This chapter applies to foreign company as well. That's what is 228. Correct? Yes, sir. And the last thing pending is people 2 and 12. Now what does 2 and 12 say, sir? 2 and 12. SFIO. 2111 is nothing but constitution of SFIO. 2112 is SFIO. When CG is of the opinion on the basis of report received under 208, the first initial report or special resolution by a company, so moto, public interest, sir, request from Department of CG or SG. CG only voluntarily is making a request to SFIO. In such case, CG may assign such investigation to SFIO. The director of SFIO may designate such number of inspectors for investigation. What is the beauty of SFIO? In India, whenever there is any serious frauds we think has taken place, we will take the matter to SFIO if it is finance related. Now imagine if already there is an inspection going on by ROC or some CBI is doing some investigation. Any inspection investigations going on should stop and it will get transferred all the files to SFIO. You cannot start, or if already started, it should be transferred to SFIO. He holds the maximum and ultimate authority. Clear? Huh? Okay, next one. Once assigned to SFIO, no other investigation agency shall initiate. If already initiated, to transfer it to SFIO. Clear? Huh? Company or officers or employees shall provide full assistance to investigating officers. Same thing. Offences under section 447 are cognizable. What do you mean by cognizable? Da? There is no warrant required. I can arrest you without warrant. Yes, sir. That's why we call it as serious. If it is warrant required, then that means children. No warrant means it is serious. That's why we are saying, hey, you go and arrest an inspector. Don't request any warrant and all. Sir, and not that only people, non-bailable. You cannot be sent out on bail. But sir, Taratamya, there is discrimination. What is that? If at all you are a adolescent, meaning you are less than 16 years, you are a sick or infirm, and you are women. So these people can be sent out on bail. Sir, what about men? Says Chandramouli. We say that you can be sent out on bail, just that the opponent lawyer will be given an opportunity to be objected. He will say, sir, no, Chandramouli should not be given bail. Why? My God, sir, serious criminal he is. If at all the public prosecutor, basically the opposite lawyer, now he will put his, his defense. If CG is also satisfied that, you cannot be sent out on bail, then they will not give you bail. But if CG is satisfied, hey, Chandramouli, good person, then people, you can be sent out on bail. Yes, sir.
Sir, Matthew was saying something.
Any officer not below the rank of Assistant Director of SFIO authorized by CG has sufficient material in position and reason to believe such person is guilty of offence. Now what people, this person can arrest a person, allowed. He may arrest such person and inform him about reason of arrest. Who? Officer not below the rank of Assistant Director of SFIO. Next one, sir. Arrest people. Such arrested person shall within 24 hours be taken to special court. Our movies and all they will show, no. Judicial magistrate, metropolitan magistrate. Such officer who arrested shall immediately forward to SFIO in sealed envelope a copy of order and material in possession. What is the grounds I arrested this person? Simultaneously, I'll give it to SFIO also. I have arrested this person. Okay. Next one, sir. SFIO shall submit report to CG because CG only gave it started with here only, no? Who gave the job? That's why we are reporting to CG only. Now, CG, if at all they want, they can keep on asking, hey, keep intimating me every half an hour. That time we will pass interim report. Or we can give one report after completion. It is called as investigation report. Investigation report, CG may after examination of investigation report direct SFIO to initiate prosecution. Prosecution is we are still coming from our end. Now hearing will happen. Correct? Huh? So for example, this murder case and all when it is going on, we'll collect our evidences. All that arrest only, they would have been arrested, but we will be collecting evidences and all. But finally we'll go to court. That is prosecution. Such report may be obtained by any person by making an application to the court. You apply, I can get the report. You have to apply to the court. If the report states the presence of fraud, by any person, CG may file an application to the tribunal for passing disgorgement order, which makes them personally and unlimitedly liable. Disgorgement order. So you need to pass a disgorgement order, meaning all your assets made will be taken away from your end. Here, this is your SFIO section 212. Next one, sir, 219, 221 we are done. 222 is also done, na? Securities. Okay, 223, Inspector's report. Inspector's report, interim or final report to central government in writing. We saw now only interim or final. Such copy of a report may be obtained by members or creditors, any person by making an application to central government. There we saw that to get a copy of a report, you need to make an application to the court. Here they are telling to get a copy of the report, you have to make an application to central government, which is right. People, that is SFIO alone. This is one vertical, this inspection is the usual vertical. 210, your 213, your 208, that inspection is going on. No, where did you give that report? That report is coming here, 223. If you want a copy of that report, you need to file application with the CG. SFIO report, court, remember. Sir, report of inspector should be authenticated by seal of the company or certificate of public officer having custody of the report. Note this section shall not apply to 212 because there it is SFIO, that is court, different route altogether. 224, actions to be taken in pursuant of inspector's report. Understood? 208, 210, 213, inspection, inquiry, everything started. Now in 223 we got the report. Now sir, we are taking action against the report. I hope you are getting the chain. Okay. If any company or body corporate is liable to be wind up under this act or IBC, in such case people, sorry, where is it? Based on report at 223, it appears to CG, any person being guilty of offence for which he is criminally liable, CG may prosecute such person for offence. I can even arrest you as the case may be. If at all you deserve to be wound up, if winding up is already initiated, we will put it in 2x. CG may present it for winding up to the tribunal on application made by or under just and equitable grounds. So here you are already under winding up. Here we think you should be wound up. So CG will write an application to the tribunal. Why? The power to liquidate is not with CG. The power to liquidate is with the tribunal. So CG will write an application to the tribunal. Tribunal, after all the inspection reports, we are getting to know that this person has to wind up. So sir, just and equitable grounds applied under 241, 244, operation mismanagement or both or suo moto by CG for recovery of damages, recovery of property which has been misapplied. So basically we can take the money from you, that is possible, and we also can give you winding up order. CG shall be indemnified by such company or body corporate against cost incurred by it. You have to pay the money. If fraud has been committed, CG may file an application to the tribunal to pass an disgorgement order. That we have seen all the places. 225, inspection cost. Who will pay the expenses of investigation? The first thing, people, immediately central government will bear the entire cost. Except under section 214. What did you see under 214? 25,000. So moto, voluntary and tribunal route. You guys have only paid. That is taken care by you. If it is not that route, the first money will be paid by central government. But later someone has to give them. Who? Will see. Then reimbursed by following person. Who? Person convicted. If someone has been proven, you did, Satyam only did the fraud. Collect money from him. Any company or body corporate, 219, connected companies, subsidiary holding, take the money from them. Any company or body corporate managing director or manager, people connected, take from them. Applicants for investigation where inspector was appointed on section 213. Tribunals, basically, again it will come to 214 only. Take it from them. Correct? Voluntary winding up of company shall not stop investigation proceedings. 226, it will go on. Legal advice not to disclose anything except the name and address. So, for example, you are a professional. Should you give away all the details? No. Whoever is under investigation, his name and address, give that much, more than sufficient. You need not disclose any other details. except his name and address. You are being protected. Shivaji, professional ethics. This chapter shall apply to foreign company as well. Penalty 447. Na? If at all anyone gives false statement to someone tries to destroy the documents, you will be liable under section 447. Clear? Yes, that is this particular chapter. Section chapter 12. Basically, try to remember. 206 you started your inspection. 207 you do basically you duty and all, inspection and all. 208 report. It goes to search and seizure was under your 209. 210 again investigation will come, and 211 is nothing but setup establishment. 212 is SFIO. 213 again your tribunal route, people coming and applying. 214 is your expenses, and 25,000 what you are in giving. Again 216, 219, 228, all of things will come under investigation. Only 216 connected people, 219 connected companies. So all this again will come under investigation only. So we just saw that flow only, if you see. But what I would suggest is, when you guys are also studying, open the video and sit when you're studying this. Yes, sir. Pakana, especially the video which we did in the class, where we try to interlink everything. Okay. Done now. Okay. So we are done with this. Last thing that we are left with is people. Came the end. Last two, right? 18 and 19.
Want to go?
Take it to the later. No, I don't think. Any day I want.
No,
Matthew,
that is not
go on
good.
from the
Please,
ACSI.
please, not me.
Just break it.
Break your
Website closure. This was not there for annual return. We need to do boards report. Okay, there is nothing much in chapter 18. We'll finish off taka. Chapter 18 people, annual report. Basically, in annual report, people, we have so many things, that is annual report, boards report, annual return, website disclosure, policies. In our syllabus, we don't have website disclosure and policies, so leave it. Sir, annual report, sir. Every company shall prepare an annual report. Basically, a listed company has to prepare an annual report. Private companies and all, annual report is not required. Annual report is more information which is in detail, which covers board report, which covers various other things. But if it's a private company, you will be giving something called as board's report. Yes, sir. So in annual report, what and all will be there, people? It is a report provided by public companies to disclose their corporate activities in the past year to evaluate firm's performance. As per SEBI LODR regulation, listed companies shall submit annual report to stock exchanges, to the public, by publishing it on the website, to send to the shareholders along with the notice of the general meeting. So you'll be giving a link in your email, or a direct attachment will be sent to you. Sir, what and all details will be there, sir? You will have audited financial statements. You will have CFS of your associate and subsidiary companies and all that part. Consolidated financial statements. Additional information, what is that is this? Cash flow statements, director's report, we'll see what is that. Next is that only business responsibility report for the top 1000 listed companies. Next ones are related party disclosure. Everything, whatever the transactions you have done with your related party transactions will come here. Management discussion and analysis report. This is nothing but people in your company. What has been the strength of this industry, weakness of this industry, like SWOT analysis for the entire industry, and what has been the strength and weakness for your company. What has been a threat, what has been an opportunity, and how did your company perform with various aspects like turnovers, debtor turnover ratio, stock turnover ratio. What is stock turnover? In the last year, for the raw materials to get converted to stock, for the stock to get sold, what is the time taken? Debtor turnover ratio, sales happened, you gave credit, and within how many days did you guys collect the money? So you guys will try to anticipate all that, and you guys will come with the proper data. All that will be given because it will help us to calculate the performance of the company. Okay, sir. Next one. Corporate governance report. Corporate governance is nothing but people. We saw in the class, if you guys remember, we give the entire details about the directors, their meetings, when did they conduct, the gender, the what is that, industries they are from, the meetings they attended, their attendance, where are they from, the mix, statistics, everything about the directors. If you remember, what is the composition, how many listed, how many unlisted, which sectors they are from, Indians, foreigners, entire mix you will give in corporate governance report. Which and all are the committees they are chairperson, which and all committees they are members, how many committees are they present on, everything you will give in detail. We saw that also. If he has attended the meeting, did he come in person, did he come through what video conference, they put that logo and all, audio visual means. And if you remember, their shareholding, their salaries, everything will be disclosed, right? Sir, see, corporate governance, number of meetings, disclosure on independence, they are chairperson, members of committee, attendance, composition, everything will be given. And various committees and directors compose meetings, general meeting, remuneration of directors. Remember 197. In that also we'll see what is that, remuneration of top 10 employees. Correct? All that will come here. Sexual harassment prevention policies, number of complaints filed during the year, redress, outstanding, and all that part. Next one, demat suspense account. What is that, people? Number of shareholders and outstanding shares in suspense account. What is demat suspense account? Nothing but untraceable. IEPF will come when there is dividends declared. What if dividends is not declared but we are not able to reach the shareholder? We will be giving the details under suspense account. So beginning of the year, how many people were there during the end of the year? How many people we were able to reach out and we delivered? All that will be given in this particular thing. Here, Ram? Yes, sir. Okay. Next one, sir. Board's report, director's responsibility statement. We saw all things. I'm skipping here. We have already seen there. Next one, sir. Disclosure and issues with regards to DVR, sweat equity, lock-in, no. What is the valuation, no? And explanatory statement should disclose everything. What is the lock-in period? Correct. What is the consideration other than cash? What is the know-how, value addition, IPR the employee has given? Accounting treatment, consideration other than cash, everything. ESOP also same thing. Vesting period, granting of thing, lock-in if any, everything will be given. Voluntary revision of financial statement, section 131. Reasons for voluntary revision. 130 is by the authorities. 131 voluntary. CSR disclosure. What is this? Committee. What is the activities taken? People, remuneration of directors. 197.2. IEP of disclosure. And next one, dividend disclosure also will come under board report only. Prevention of sexual harassment. Signing of board report. Who will sign? If authorized by the board, chairman will sign. If not authorized, 2 directors and 1 shall be MD. And one more thing also. Remember, people, if at all there is something very important, and after the closure of financial year, but before circulation of board's report, during this period, financial year ends on 31st March 2025. Director's report is sent on, let us imagine, 25th of August 2025. Between this period, if anything important, significant financial aspect has taken place, that should also be disclosed in your board report. Remember, I think I made you write specifically that part. Okay, annual return, people, when should you file? Taka taka. it has to be filed in the format MGT 7 for a normal company, OPC and small company 7A. It has to be in the every year it has to be filed within 60 days of completion of your AGM or due date of AGM. Yes, sir. And if at all it is not, AGM is not held, you need to still file it along with the disclosure that what is the reason for not conducting your AGM. Same thing will apply to your AOC 4 also. Provisional financials, they will consider it as ROC. And next one, if at all you are a foreign company, your annual return will be in the form FC 4. Yes, sir. And annual return is basically a disclosure of non-financial matters. AOC 4 is everything with regards to financial matters. And who shall sign your annual return? It shall be signed by directly. It shall be signed by director or CS. If at all there is any director and CS. If at all there is no CS, then a practicing company secretary. Whereas if you are a small and OPC, CS of the company, if no CS, director is sufficient. PCS signature is not required. Here there is an amendment, annual return. How many annual returns you can sign and all that. For us, it is not applicable. Forget it. For next attempt, it will be applicable. Yes, sir. Annual return of listed company and company having paid up capital of 10 crore or more or turnover of 50 crore or more shall be certified by PCS in form MGT 8. What is that? We will go in detail, point by point of annual return. We will check whether this has been filed properly. This has been filed properly. Everything is accurate. We will give an extra certificate that is only called as MGT 8. Yes, sir. Okay. Non-compliancer, minimum 10,000, maximum 2 lakh. Okay. Need not go in detail. That's okay. Website policy disclosure is not there for us. Forget it. It's okay. MGT 9, extract of annual return, which is again, there has been that, what is it? Few companies are exempted from even giving it as a attachment in your annual return. Correct? Yes, sir. Okay. AOC 4 is financial statements. MGT 7 is your non-financial matters. Change in directors will be given in MGT 7, not in AOC 4. List of all your subsidiary companies and its activities will be given in MGT 7, not AOC 4. Activities. Yes, sir. Clear? Okay. Okay. You guys want a quick 5 minutes break? Probably another 35 minutes will finish it off. But effectively, if you want to listen, take a 5 minutes break and come. Okay, go and come. Taka go and come. PG approval, you can appoint such person as your managing director. Anytime adjudged as insolvent or undischarged insolvent. In such case, people, you cannot go for MD. Anytime suspended payment to creditors or you have made a compromise with them, anytime convicted of an offense and imprisoned for more than 6 months. If you see everywhere, it's almost the same. Subject to provisions of, one more thing is there, additional as per part 1 of schedule 5, there are some additional conditions also. So schedule 5 has multiple parts. Part 1, part 2, part 3, part 4, part 5, as the case may be. Part 1 speaks about appointment. Part 2 speaks about remuneration. Now under remuneration, again under part 2, there are various sections. Section 1, 2, 3, 4, 5. Correct? Okay. Now what are the different parts they say? According to schedule 5, part 1, you should have not been sentenced to imprisonment even for 1 day. Or fine exceeding 1,000. So 1,001 rupee under 19 acts. SEBI, FEMA, Competition, Companies Act, every act is there here. So even if you have been arrested for 1 day here, you cannot be appointed as a managing director. Because this one was in general, right? Convicted. We didn't say in your personal life also you could be arrested. These are related. Correct? Okay, next one, detained for any period under coffee posa. Any period, even 1 day also. Coffee posa, money laundering, basically foreign exchange, smuggling, correct. It's a conservation of foreign exchange,
that money laundering. Sorry, of smuggling things and all. Okay. To be resident of India, exception company in SCZ. Rest and all, you have to be a resident in India. If you have to be a managing director. Old-time director, managing director, manager. That's what they generally say, right? Okay, subject to provisions of section 197, we are speaking about procedure. How do we have to appoint people? There are two forms you file. One is called DIR12, MR1. DIR12 because they are directors. MR1, managerial remuneration, basic managerial remuneration only. That's why we are filing MR1 within 60 days. MR2 will come only when you are taking CG's approval. Wherever you take CG's approval, for example, imagine you are paying them more remuneration than what is provided. You will take CG's approval. More than 70-year-old, you will take CG's approval, as the case may be. If appointment of MD, whole-time director, manager, generally what happens, you need to be also appointed in the general meeting. Imagine today you appoint in the board meeting, and before you appoint in the general meeting, imagine it's 2 months, 3 months. In general meeting, if they do not appoint you, if they do not agree on your appointment, whatever is the actions you have done between the board meeting and general meeting will not be invalid. It will continue to be valid. It will bind the company. I told you the example of Varisu and all, etc. Next one, sir, maximum managerial remuneration. What is the maximum managerial remuneration I can pay? The maximum I can pay is 11% for all the directors put together. And for executive directors, 1% can be paid maximum 5%. More than 1%, I can pay 10%. For non-executive directors, if there are also executive directors, I can pay 1%. If there are no executive directors, I can pay 3%. So schedule 5 can be further classified into like this. Part 2 speaks about remuneration. Section 1 when you have profits. Section 2 speaks when you do not have profits. We have until section 3. Correct? Huh? So remember this bifurcation. Okay. Now sir. You have it
We
done.
have
Sorry,
19.6.
sorry.
Okay. Yes, sir. Overall maximum managerial remuneration people. In case of 197 people. In case of adequate profits, what is the total remuneration I can pay? At any point of time, if you have enough profits, sufficient profits, your remuneration cannot exceed 11% of net profits of that financial year. Macha, not previous, same financial year. I think Abdul had asked some question here. Okay, provision to pay more. Can I pay more? Yes, you need to pass a resolution and you need to comply with Schedule 5. Schedule 5 is nothing but you need to comply with Schedule 5, Part 2, Section 1. Sir, second provision, individual limits. This is a group limit. Individually, how much I can pay? When there is only one managing director, whole-time director or manager, you can pay up to maximum 5% if they are executive directors. If there is more than one, everyone put together, I can pay 10% together. Sir, but my company will also have non-executive director also. So, other than whole-time director, manager. Now, if my company has non-executive directors also, executive directors also, if both are there, then the maximum I can pay to my non-executive directors cannot be more than 1%. Sir, if at all there are no executive directors, everyone are non-executive only, then I can pay up to 3%. Clear? Yes, sir. Okay. Sir, can I exceed the limits? Yes. How? Pass special resolution. Sir, what if I have taken any loans from PFIs, banks and all? Then they are telling you prior approval of PFI bank non-convertible debenture or secured debenture if company has defaulted payment in any time. If no default, sir, then these approvals are also not required. This part, any doubt? Clear? Okay. Sir, remuneration. Okay. In case of inadequacy of profits. Now, if it is inadequacy, people, I am going to schedule section 1 when I had profits.
Section 2, when I don't have profits. Huh? No, half will come. Okay, section 2, what does it say, people? Part 2, section 2. Part 2 again has two limits, A and B. A is general, B is for professional directors. A is for rest all the directors. How much I can pay? It depends upon effective capital of the company. If your effective capital is negative or less than 5 crores, then maximum I can pay managerial remuneration for all your executive directors, non-executive directors. How much I can pay to my executive directors? Per director it is, per person. Yearly remuneration. I can pay up to 60 lakhs per person per year. If my effective capital is 5 crore to less than 100 crore, 99.99, I can pay 84. More than 100, less than 250, 120 lakhs. More than 250, 0.01 percentage plus 120 lakhs. So 0.01, take over and above how much ever is 250. Let us imagine my effective capital is 500 crore. For the first 250 crore, I will pay 120 lakhs. For the next one, 250 crore, I will pay 0.01%. 0.01% into 250 crore. How much ever this comes. That is the total amount I can pay. Clear? Sir, what if I am a non-executive director? Technically, it will be divided by 5. Most of the cases, but in some cases, the points can come. See that and write. So up to 12 lakhs, 17 lakhs, 24 lakhs, 24 lakhs. So remember one more thing. What if I was appointed for part of the year? Still can I pay say 60, 84 as the case may be? No, you need to take it pro rata. This is per annum. You need to divide it by 12 and accordingly per month is allowed. Clear on? Yes, sir. Sir, can I pay more than this? Possible. How? After passing a special resolution. Sir, now my question is a normal director. In some cases, what happens? There will be directors. They are not taking day-to-day decisions, but they are given that position due to the respect they earned. Imagine there is a professional director. It can be a doctor. He has been with us for a very long time and he is a director. He is contributing more towards his profession than the directorship. Can we pay him a salary? See, for operations, we will be paying him. That's a different thing. Can we pay him a salary for being a director also? The answer is yes, it seems, provided he satisfies these conditions. So, a professional director can be paid as per limit A. Limit A is this. We can pay. When, sir? First one. A managerial person in professional capacity can be paid as per limit A, provided if he is not having any interest in the company holding subsidiary company. Any interest means you should not have any shareholding. Sir, what if I have little? Little means it is allowed, provided you are holding it as an employee. Up to 5% of the share capital is allowed. Beyond that, people, you cannot get limit A salary. Not allowed. Next one is not having any interest or related to directors, promoters. You cannot be related to them. Of company holding subsidiary company during the last year or after the date of appointment. If you have been related to them, then no, you cannot get the salary as per limit A. So basically, we are paying directly on the merit basis. Next one, sir, graduate level qualification with expertise. Literate. Specialized knowledge in that field. Doctor, obviously, MBBS. Sir, to pay as per limit A and B. Now, A and B, if I have to pay, have to satisfy certain more conditions. What is that? Such payment is approved by board, and if you have nomination remuneration committee, they should also approve it. Next one, company has not committed any default. If default, then prior approval. Same thing again, PFI, banks, debenture creditors and all. If I have to pay as per limit A, I need to pass ordinary resolution. If I have to pay as per limit B, I need to pass special resolution. These resolutions will be valid for a period of 3 years. Statement to be given along with the notice. Because I am passing special resolution, ordinary resolution, you have to give entire details about the company, the person, why we are paying, what is the company's scenario, even in losses, why we are paying. You have to justify everything when you are calling them for a meeting, like your explanatory statement. Clear on? Okay, done. Next one, sir. 197.4. Remuneration paid to directors. And one more thing. What is the sitting fees allowed? We can pay sitting fees up to 1 lakh rupees. Is it per year?
Sitting.
Per meeting. So per meeting, irrespective of the, is it board meeting or is it a committee meeting, you will still pay them. It is 1 lakh. Can I pay different sitting fees for different people? Whatever you are paying for your normal directors, independent directors and women directors should receive the same. You cannot pay less. Clear? Huh? Okay. Remuneration paid to directors shall be inclusive of payment towards all services. Whatever he has worked, everything is inclusive, provided some things are exempted in this money. What is that? If at all you have worked in professional nature, what is that? For your operations, that is different, you can pay. NRC plus directors are of opinion that such director possess requisite qualification for practice. Same thing, both have to be satisfied. Sitting fees people 1 lakh, correct? Interest correct?
One meeting will include one meeting also.
Yes. Because it's a continuation of original meeting only, no? And second thing, sir, is sitting fees counted in the limit of managerial remuneration? No. Two things are not counted. What are that? Sitting fees and okay, three things.
It received from its cash. It's holding or subsidy.
No, one is in
Professional.
professional capacity and this one and insurance premium paid towards your insurance policy. Mode of payment I can pay monthly as a percentage of net profit or partly by both. And if such director is excess remuneration without approval. Now what this is what we saw. What if, sir, I have to pay a percentage, 5%, 10, no, 11, no, 1, no, 3 as per the current year profits. But I will know what is my current year profits only at the end of the year. At the end of the year, I got to know I paid more. Now what do? You'll be given 2 years time to recover the money. Sir, but can we exempt this, sir? This provision is covered in two places. One is 180 subsection 1 clause D. If at all you want to waive off any money to be paid by the directors, you need to pass special resolution. Same thing here also. Whenever the money becomes due, within 2 years from the day the money becomes due, you can pass special resolution and you can waive off the money. If not, you cannot waive off. Any excess remuneration paid should be collected back by the company, mandatory.
Can we net off?
No, you have to see, that is possible. But you are not waiving it away. Next year also you'll pay salary, this year also that cannot happen. Okay, because 2 years time is there. That can be possible. That becomes accounting treatment. The company shall not waive any refundable money, but provided within 2 months you pass a special resolution. But if you have made any default, prior approval is also required. PFI bank. Sir, and with regards to remuneration, in your board report, you have to give some details. It seems. What is that? First one, 5.1, 5.2, 5.3. Ratio of remuneration of each director to median remuneration of employee. What is that? Give in your director's report how much each director earns. What is your median employee salary? What is median? Take your company's payroll, higher to low, medium. What is the middle center one? Give his salary. And next year, if the director's salary goes up, if median salary goes up, compare the ratio. Is it proportionate? His salary is going up 40 times. His salary is gone up by 0.5 times. Then something is not right. So, percentage increase in remuneration of each director, percentage increase in remuneration of this and comparison. Okay. BR board reports shall also include names of top 10 employees in terms of remuneration, who, if employed throughout the financial year, receives minimum 1 crore 2 lakhs. If they are receiving such remuneration, you need not be an MD, but your details will also be given. Sir, what if I am not employed for throughout the year? Then if you have if you have been part of the company for even 1 month, 2 months, with a net salary of 8,50,000 per month, even you will also be, your details will also be given in the board's report. Drawn remuneration in excess of that drawn by, you will also give the details of those employees who have received salary more than their directors, managing director, and also hold not less than 2% of shares of the company. Both should be there. Then you will give details of them also. Sir, the next one, the board report shall indicate the details of employees which shall include designation, what and all I'll give, his previous employment, the date of commencement, percentage of equity shares if any held, name of director or manager if such employee is related to any. Next one, sir. One and premium paid on insurance. This is what I said. Is premium paid on insurance, is it taken as a part of your managerial remuneration? The answer is no. But imagine if at all tomorrow we have taken insurance policy in your name. If you are proven guilty, the insurance company pays the payment. That time, whatever insurance premium we have paid, it will form part of your managerial remuneration. Yes, sir. Not by default, but it only forms part only after it has been proven guilty. From managerial remuneration, they may receive any remuneration from holding company, subsidiary company, allowed penalty. I'm not going into that. Schedule 5, Part 2, Section 3. What is Section 3? Sir, whatever is given in Section 1 and Section 2 may be paid in certain special circumstances. What is that, sir? In Section 1, Section 2, we have seen limits. Section 1 says 11%. Section 2 says inadequacy of profits. We saw how much can be paid maximum. Section 3 is telling we can pay more than that, it seems. What is given in Section 2 and Section 1? We can pay more than that. When such excess remuneration is paid by some other company, not my company. And which company? Foreign company or some other company has taken its approval of shareholders in general meeting for such payment and treats it as per the remuneration of 197 as per its limits. So it is paying as, see, if I take as per my company's limit, you are getting more. But as per that company's payment, when that can happen, people, when a holding company is paying to its subsidiary company. Possible, huh? So according to holding company limits, I am paying. It is allowed. It is allowed, is what they are telling. Next one, sir. Next one. Newly incorporated company up to 7 years from the date of incorporation. Nothing but like a startup. I have to allow you to pay. If not, people will not be with you. SIG company, BIFR approval. These two today it's no longer existing. It generally comes, sorry, not these two. This and this no longer exists. It generally comes under NCLT only. Imagine you are a SIG company or a resolution, your company is under insolvency, IBC. People will be in a hurry to leave such companies. Why should someone stick with you? Unless and until I pay you more. That's what they're telling. Inadequacy of profits. Inadequacy, there will be nothing. That's why they're in insolvency in bankruptcy code. I should still allow you to pay. That's what they're telling you. Sir, to pay excess remuneration as Section 3, you need to satisfy these conditions. What is that? Managerial person is not receiving remuneration from any other company except in KSA, foreign company and such company. To pay excess remuneration, I need to get an auditor certificate, CA, CS or PCS, that all secured creditors and term lenders have given NOC. For paying more, they don't have a problem. And they shall also certify that there is no default on payment of creditors and deposit holders. First you pay that and then you can take extra. Next one, this is not there for you. This is not there for, okay. Compensation for loss of office, this is what I saw. Section 202. We saw in 167 also, SFIO also. Whenever I am removed you for whatever you have done. See, generally what happens, people, when we have appointed a managing director for 5 years, we are removing him in the 3rd year. He has not made any fraud, but we are removing him. Generally now recessions are happening. You might remove layoffs. You might remove. Who will cover his back? You know the amount he is getting. How will he manage his salary? Remember, whenever there is a layoff, you need to pay some money. A general employee will receive 3 months, 6 months salary. Only then you can remove him. If not, you cannot remove. Mandatory. So even if you want to remove your employees today, you should be having that net cash of 3 months payment of so many employees. If not, you cannot remove them. Here, so now I am telling I can remove my director. Yes. I need to pay some compensation. Yes. But for how many years? So imagine if I have removed him, if I am appointed him for 5 years. 1 year is done. 4 more years to go. So for how many years I have to pay salary? They'll say 4 years, that is remaining tenure, or 3 years, whichever is lesser, higher, higher or lesser, higher. Logically think whichever is lesser. Yes, sir. Sir, but how much I pay? You take whatever as, now imagine you have been with the company for 2 years. Take 2 years average salary. Whatever average you will get, that multiplied by your tenure or 3 years, whichever is less. Clear up? Okay, next one, sir. Compensation shall not be paid in the following cases. People, first of all, not everyone will get compensation. MD, whole time director, manager, CS won't get, non-executive directors won't get, independent directors won't get, only these 3 people. Exam, that can be also a question. Chandramouli is like, sir, CS go baratala, sir. 3 months, 2 months you might get, not 3 years and all. Yeah? Compensation shall not be paid in following cases. When people, director resigns due to reconstruction or amalgamation, he only resigned. Then why should we pay? Where such director resigns from his office. This is new company. Basically, amalgamation. We offered you a job in the new company. You resign from that company, or you resign from the existing company. He is vacated due to 167, meaning your own fault. Company vacated, company is being wound up due to negligence, day, landmine. Because of you only company is being wound up. Director has been guilty of fraud or breach of trust, negligence or mismanagement in conduct of affairs of the company holding subsidiary. Correct? This only can come your SFIO inspection inquiry. Director has instigated in termination of his office. He has only done something, people, which results in termination of his office. Correct? No compensation shall be paid if after you are removed. After 12 months, if the company goes into winding up, or before 12 months, if the company went into winding up because of you, it will not be given.
Reason is not whispered.
If the company goes into winding up 12 months before or after the date of directors cease to hold office and assets are not sufficient to repay the shareholders, we are not able to pay them only in compensation. Yes, sir. Next one, people, KMP. When will you appoint a KMP, people? Rule 8 of appointment and remuneration of managerial person. It says every listed company and companies having paid up share capital of 10 crore or more. Rule 8A, CS has to be appointed of company, private company, having paid up share capital of 10 crore or more. Correct? Yes, sir. MD, CEO, whole time KMP. Okay. 2031. Can a company appoint chairperson and MD and CEO at the same time? If articles of association of agrees provides me to appoint, then I can appoint the same person as chairperson and a CEO, or a chairperson and a managing director as the same person. Yes. So generally I cannot appoint, but if I want to appoint, your articles has to provide. Or the company does not carry on multiple business. Single business you can appoint. Sir, what if I am carrying on multiple business? Then they say, if you are a public company having paid up capital of 100 crore and more, annual turnover of 1000 crore or more, and companies engaged in multiple business, for every business you are having CEO, then you can have the same person as chairperson and MD. Clear? Key points in KMP. Person can be a KMP of maximum one company, exception of subsidiary company. You can be a KMP of your company as well as subsidiary. I think in our class I told you also. Always people try to. Okay, forget. KMP can be director in other company also with prior permission of BOD. KMP can be a director of other company, but first to take your prior approval of BOD. Here they have not given that, but generally they will not allow you. Can be a, that's why BOD approval, right? Can be a MD of 2 companies? Yes, maximum 2 companies, provided all the directors present in the meeting has to agree. So one person can be MD of 2 companies. Vacancy, it shall be filled by board within a period of 6 months. KMP is also appointed in the general meeting or board meeting? Board meeting. It is power of board. MR1 within 60 days. KMP. Secretarial auditor, which we have seen. Yes, sir. So I've tried to cover as much as possible in your remuneration part also. So that's it, people. I hope we touched all the chapters. We have seen everything, and I hope we have seen majority points wherever it is there or to be discussed. And that's it from my end, people. All the best for your company law. YouTube people, all the very best. And wherever you get your result, whether it's a pass or failure, do not mind in letting me know. It would be always a great pleasure to know your results. So thank you so much, and we'll see if possible. I'll be uploading the amendments by next week. Try to watch that as well. It will be uploaded on YouTube. Do not forget the previous amendments are already there. June 2024. Watch that. In addition to that, watch this as well. Yep. Thank you so much. See you all. Bye bye.